Sometimes, though, even leading questions and outright pressuring of prisoners didn't get them to say what the investigators wanted to hear about a given suspect's actions. In these cases a slightly different tactic was employed to get them to cooperate. When one very frightened prisoner was interviewed right after the retaking, he dutifully identified a fellow prisoner whose photo investigators kept trying to get him to name as Roger Champion. Investigators were very interested in gathering evidence against Champ because troopers had marked him on the day of the retaking as a leader of the rebellion. According to this witness, however, Champ was a really good guy. He had actually saved his life in D-Yard. His fellow investigators, however, kept pushing this man to say Champ had done something illegal. Ultimately frustrated, one investigator exclaimed in disgust, "I don't want to hear anything about that from them niggers 11. When strong-arm tactics still proved ineffective, they switched their approach. Should this witness help them, investigators suggested, they would, in turn, help him get paroled. 12 In addition to enticing the witness with the possibility of parole, they also promised to make prison life easier for him in the meantime. As this man later testified, one of Simonetti's own, non-BCI investigators, Ernest Milt, actually put $5 on his commissary account 3 different times, and he said that this investigator had done the same for at least 3 other would-be prisoner witnesses. 13. Prisoners were susceptible to the promise of early release, and in time some were paroled after cooperating with Fisher's committee. 14. No one from Simonetti's office decried this practice in which prisoners and ex-prisoners have been subjected to pressure to cajole them into being witnesses for the state. 15. Nor did anyone intervene when the investigators began offering not only parole, but also commuting sentences and granting pardons. 16. State prosecutors merely doubled down on such sweet carrots with some strong sticks. Should a prisoner change his mind later about testifying on behalf of the state prosecutors readily reminded him that the penalty for refusal to testify is 4 years for contempt of court. 17. Perhaps the greatest incentive for a given prisoner to support prosecutor efforts was neither avoiding a beating nor securing the promise of parole, but was instead the threat of being indicted himself. As stated in a prisoner lawyer's affidavit, many of the Attica investigation's witnesses testified for the state because of, among other things, the generalized threats of future indictments. 18. This was exactly why prisoner David Hightower ended up cooperating. Investigators first visited Hightower on September 19, 1971, when he was in bad shape, having been severely beaten during the retaking 6 days earlier. Genuinely thinking they were there to investigate wrongdoings he might have witnessed, Hightower proceeded to tell them about an incident he claimed to have seen in the hospital in the hours after the retaking, a black prisoner being killed by 3 correction officers. 19. Not only did the investigators refuse to take this information down, but they also made it clear he was to repeat this story to no one. 20. As Hightower later swore under oath, the agents from the BCI promised that if I cooperated with them, I would be able to get out of jail quickly. They promised to help me with medical treatment for my eye but threatened to indict me for a crime of sodomy that I allegedly committed in the yard if I did not cooperate with them. 21. Threats, whether overt or subtle, and bribes, whether immediate or promised, worked wonders. Whether or not a prisoner had any knowledge of the event in question or believed that state prosecutors had the wrong man in their sights, they often ended up cooperating. As prisoner rights lawyers pointed out, one such man, Willie Locke, had been interviewed by one of the state's chief investigators, Ernest Milt, at least 5 different times during an 18-month period, and, he insisted for more than a year that he knew nothing about the death of the 2 inmates found dead, Hess and Schwartz. 22. However, after being subjected to unrelenting long drawn-out pressure, with the judicious use of both stick and carrot, Locke eventually agreed to become a half-hearted prosecution witness. 23. Rather than worry about exactly how Simonetti was building his cases against Attica's prisoners, as 1971 War on Robert Fisher focused on the fact that, in his view, Rockefeller's office was not giving his investigative effort sufficient funding. It particularly irked him that state funds had also gone to the McKay Commission, and he felt that his investigators' job was much tougher than theirs. Rockefeller's attorney Michael Whiteman agreed that Fisher's request for funding should be reviewed by Budget and Counsel's office, and, on July 5, 1972, Fisher finally heard via Robert Douglas that Rockefeller had approved his request for more funding, although it would be limited to the next 3 months. 24 Eventually, by December of that year, after many back-and-forth battles over his budget, Fisher was able to net the Attica investigation a permanent investigative staff of between 10 and 20 men. Meanwhile, the prisoners were trying to cope with the investigation in any way they could. 33. Seeking help. 50-year-old George Jones was so depressed by how he was treated at Attica following the rebellion that at 4:45 a.m. on November 19, 1971, he asked a CO to put him on the sick call list for the next day. Shortly before 6 a.m., he was found hanged in his cell by his bedsheet. 1. Most of the men at Attica tried instead to protest all that they were enduring through subtle and small acts of rebellion. They refused to eat or shower, take their medications or get haircuts. One man refused his meals as well as his medications on both October 13 and 14, just as he had done on September 18. On October 16 he again refused his meals. Then, on October 17 yet another prisoner refused noon meal and said he would not eat for 30 days while scores of others refused showers. By the 20th of that month even more prisoners were declining to eat their evening meal or to take medications and showers. Such quiet and largely individual protests continued well into December. 2. Other Attica prisoners fought back more publicly by trying to seek help in the legal system. Many individual prisoners tried, for example, to sue the state for damages. 3 By December 14, 1971, 506 Attica prisoners had filed notices of intent to file claim, for still others exerted pressure on lawyers such as William Hellerstein and Herman Schwartz to keep fighting on their behalf not to give up after Judge John T. Curtin refused to grant a permanent injunction against prisoners being interrogated without legal counsel and against their physical abuse. When they had sought this injunction, with inmates of Attica v. Rockefeller, these lawyers were prepared to keep pushing Curtin. For starters, they kept presenting Curtin with additional accounts indicating that prisoners' rights were being violated in the hope that he would again issue at least a temporary injunction. Curtin ultimately did hold hearings on September 30, October 4, and October 5 to consider their new evidence. There he heard testimony from Vincent Mancusi, Clarence Jones in his capacity as a member of the Goldman panel, Arthur Eve, and 6 prisoners, including Frank Lott, Roger Champin, and Herbert Blyden. To the prisoners' dismay, though, Curtin still concluded on October 6 he could not issue an injunction, in view of the steps being taken to protect the inmates' constitutional rights and personal belongings and the absence of evidence of continuation of physical abuse. 5. And so, prisoners' lawyers filed an appeal with the Second Circuit. They also tried to take the issue of the men's Sixth Amendment rights being violated straight to the U.S. Supreme Court. They asked Justice Thurgood Marshall to weigh in, but he wanted the whole court to hear it. The U.S. Supreme Court, however, declined to issue a stay on October 12, 1971. Attica's men, and their lawyers, didn't give up. 5 more prisoners, this time including Jerry the Jew Rosenberg, also sought injunctive relief in the court of Judge Curtin, charging that their civil rights were being violated, both because they were still being held in segregation and because they had no legal protections during Fisher's investigation and had been given no notice of any charges against them. 7 In this instance Judge Curtin issued an order on November 12, 1971, to force Attica's officials to respond to the charges. And respond they did. Attica's deputy superintendent, Leon Vincent, testified in Curtin's court that 38 convicts at the prison were being held in segregation and denied privileges because they were a threat to the institution. 8 But he said that no one's civil rights were being denied because these men got out in the yard about once a week on the average and had time to walk around it 3 times before they were led back to their cells. 9 After his testimony, Curtin again decided to take some time to make a final decision on these men's fate. 10. From the perspective of the prisoners and their supporters, Curtin had let them down. In their view, this was how things always worked. As they explained it, this tortuous process of delay, appeals, and procedural haggling was precisely the same type of legal response that contributed to the atmosphere of total distrust and frustration that led to the uprising of September 1971. Yet again, these prisoners' pleas to be let out of solitary ultimately went unheeded. And yet, the prisoners' various legal efforts to get a judge to take their side at Attica had hardly been wasted. On December 1, 1971, the three-judge panel of the Second Circuit Court of Appeals, ruling on Cuddon's original denial of injunctive relief back on September 14, finally issued its decision. Although this higher court refused to grant a preliminary injunction that would have barred state authorities from questioning all Attica inmates concerning the recent prison uprising until the inmates had consulted lawyers, it did overrule Cuddon on the issue of protecting prisoners from physical abuse. 12. The author of the decision, Judge Walter R. Mansfield, was unequivocal not only that the prisoners had proven they had endured unimaginable abuses, but that such barbarism must stop immediately. Mansfield wrote that the abuse his court had learned of far exceeded what our society will tolerate on the part of officers of the law in custody of defenseless prisoners, and though these men were incarcerated, they were still entitled to protection against cruel and unusual punishment by the Eighth Amendment. 13. The appeals court's ruling read as a particular castigation of Cuddon's original decision on this issue. Because prisoners are at the mercy of their keepers, the court opined, preliminary injunctive relief should have been granted against further physical abuse, tortures, beatings, or similar conduct. 14. Cuddon may well have been relieved that he had been overruled on this issue. Indeed, some had speculated at the time that Cuddon had written his decision as he had that there was abuse but then not granting the injunction so that he would be easily overruled by a higher court. As attorney William Hellerstein saw it, he gave us a way to appeal at 15. The truth was that Cuddon was between a rock and a hard place when it came to Attica. The very same week he was overruled by the appellate court, Cuddon had received a letter from a group calling itself Women in Support of State Correctional Employees, saying that they would hold him directly responsible for any injuries or deaths to correction employees or inmates at Attica Correctional Facility or any other correctional facility that results from any injunction or decision made by U16. Once he had been overruled by the Second Circuit Court of Appeals, though, he had no choice but to issue an injunction no matter what Wives threatened, and on December 14, 1971, he did. As he stipulated, defendants, their agents and employees, including state police and Department of Correctional Services personnel, are immediately prohibited and enjoined from subjecting inmates at the Attica Correctional Facility to physical abuse, torture, beatings or other forms of brutality, from threatening such conduct or from authorizing, sanctioning or permitting such conduct, and it is further ordered that plaintiffs be permitted to maintain as a class action their claim for injunctive relief against brutality. 17. And yet the abuses continued. A mere 2 weeks after Cuddon's directive to Mancusi, attorneys from the National Lawyers Guild again had to go back to Judge Cuddon and ask him to hold Attica's cause in contempt for ignoring his December 14 injunction. 18. They also wanted federal monitors. In hearings held within Attica Prison before U.S. Magistrate Edmund Maxwell, much evidence of contempt was heard, including an incident when Richard Clark had tried to read the injunction allowed to fellow prisoners in an elevator. A guard cursed him with a racial epithet and ordered him to stand with his nose against the rear wall of the elevator. When Clark refused, he was then confined to a cell for 24 hours a day. 19. Another incident involved a prisoner being repeatedly subjected to racial slurs, threats and beatings. Another, Frank Big Blacksmith, had been cursed, threatened with death, threatened with physical torture and almost constantly harassed by more than one guard. 20. And Maxwell seemed relatively sympathetic to their plight. When prisoners, including Richard Clark, told the judge that 4 COS had very purposefully stationed themselves near the thick steel door and barred windows of the room to intimidate them as they were meeting with him, these COS were directed to leave by Maxwell. 21. Although Judge Cuddon was more dubious, and deemed these legal claims of contempt sketchy, he was willing to amend the injunction on December 23 so that it more specifically enjoined prison personnel from physical abuse, torture, beatings or other forms of brutality, including verbal abuse and racial slurs, from threatening such conduct or from authorizing or permitting such conduct. 22 Regarding the issue of whether the COS were in fact acting in contempt of his order, Curtin stated that he would need more evidence to issue such a directive. 23 Various jurists' ambivalence toward Attica's prisoners in the fall and winter of 1971 made prisoners vulnerable to the investigation being conducted by the BCI and to the indictments sought by Simonetti's office. Because the courts had failed to put an end to days and months of interrogation techniques that, according to prisoner advocates, included not only open intimidation, physical torture, threats of indictment and counter-promises of early parole, but also such improper police methods as naming a photo before showing it to a witness for identification, state investigators were, by the close of 1971, well armed with evidence, much of it false, coerced, or corrupt, to take to a grand jury. 24 A mere 13 months after the start of their investigations, the state was ready to seek criminal indictments against more than 60 prisoners. 34. Indictments all around. An Attica grand jury had been convened less than 3 months after the prison's retaking, and Simonetti's office was eager to present the evidence it had collected to this body. This grand jury had been seated in the town of Warsaw, which was in the same county as Attica and housed quite a few COS. State officials had defended this choice of site, a mere 10 miles southeast of the village of Attica, by noting that there is no provision in the law for a statewide grand jury. One Supreme Court Justice Carmen F. Ball of West Seneca was named to preside over this special term of the state Supreme Court in Wyoming. 2. Within 6 hours of hearing this news, attorneys for the prisoners from the National Lawyers Guild, NLG, had moved for a change of venue. By late fall of 1971, the NLG had a substantial presence in the area and felt strongly that the men at Attica would not have a fair hearing in Warsaw, since the jury would necessarily be all white and its members would undoubtedly be personally acquainted with some of the prison guards. Judge Ball dismissed the request. 3. He also refused to let the NLG lawyers representing prisoners ask vital questions of the prospective jurors about their views on the rebellion or connections to the prison. Thus, when the grand jury first convened on December 8, 1971, not only was it an all-white jury of 13 men and 10 women, but 9 out of the 23 admitted having friends who worked as guards at Attica, and 2 of the 9 had friends who were held hostage, one of whom was killed. 4. Furthermore, the foreman, Raymond Becker, had been a close friend of one of the dead hostages and ran the Attica school bus system, which also employed prison guards. 5. Of all the crimes that had occurred at Attica, prosecutors were most interested in indicting any prisoner involved with the death of William Quinn, the correction officer who had died from the injuries he had sustained in Times Square on the morning of the rebellion. They were also determined to prosecute the men who had been involved in killing prisoners Barry Schwartz, Kenneth Hess, and Michael Privitera in D Block, and they wanted to charge every prisoner who had been involved in taking a correction officer hostage with the crime of kidnapping. Finally, state officials wanted to levy numerous other charges against prisoners for acts ranging from sexual assault to wielding a makeshift weapon. To get indictments against these men, Simonetti was depending on the testimony given by prisoners interrogated over the preceding months by BCI and his own investigators. And to help ensure that they cooperated, Simonetti wrote to the chairman of the Wyoming County Board of Supervisors, insisting that we should make it as simple as possible to get such inmate witnesses into the grand jury to testify and then out of the courthouse without chance of exposure to the public or press. 6. The result was that those prisoners who had agreed to testify on the state's behalf were brought to the jury fully hooded so that the public couldn't see who they were, and, once they had testified, were immediately transferred to other institutions, as the prisoners put it, allegedly for their own protection. 7. Most of the men who had agreed to offer evidence had no intention of backing out. They either were expecting the reward of early release from prison once they had testified, or feared the consequences if they didn't. As one prisoner put it, "I knew that the things I was saying were untrue, I knew that I was lying, but once he had agreed to testify, no one bothered him." 8. Another witness said, after the terror he'd experienced at the hands of the troopers in D Yard, by the time attorney generals, or whoever it was, the BCI came to see me, I would have testified to my mama doing something. 9. There were a few prisoners who did have second thoughts about lying to the grand jury and tried not to testify after all. When Flip Crowley was about to be called to the witness stand, he became plagued with guilt. As soon as he arrived at the courthouse he asked to see his lawyer, Barbara Handschuh, hoping that she could help him get out of testifying. Instead of allowing him to speak to his attorney, however, a state trooper pulled a gun on him, a very large gun, and looked at me, and looked at his partner and said, "Hey, did you see that nigger try to jump out the window? Who did you say you wanted to see?" Fearing for his life, Crowley cooperated with them. Sure enough, he was later informed that prior to my coming in, they members of the parole board were not disposed to rule favorably, in my way, but after testifying I come quite highly recommended. 11. Yuri Newport, another prisoner who later filed an affidavit saying he had been tricked into testifying for the grand jury, also had second thoughts and tried to contact his lawyer, also Barbara Handschuh, to see if she could prevent his being subpoenaed by the grand jury to give testimony that he didn't believe was true. 12 He heard nothing. He complained repeatedly about not having representation. Officials responded that he didn't need a lawyer, nothing he said could hurt him, and that if he went along with them, in return he would be transferred to Napanoch, a medium security prison, where it would be much easier for him to serve his time. 13 10 days passed, and he still hadn't heard back from Handschuh. Newport became more apprehensive and frightened. Then someone from the Bureau of Criminal Investigation told him that neither Barbara Handschuh nor any other lawyer was going to help him, and, because Newport was by now in a sufficiently scared state of mind to believe the suggestion, he did testify before the grand jury in August 1972.14. It turned out the letter Newport had asked a CO to mail to his lawyer wasn't sent until the day after he testified. 15. Even former members of the Observers Committee were being pulled into the grand jury proceedings. As Arthur Eve wrote to his fellow committee members, something of an emergency is developing because some members of the committee have already been called by the Wyoming County Grand Jury in connection with the Attica indictments. 16 What was most disturbing to him, as well as to prisoner support organizations and lawyers around the state, was that there appeared to be highly selective presentation of testimony to the grand jury, and that no witnesses who had given contradictory testimony to the investigators early on in their probe were being called to testify, so the grand jury didn't even know such contradictions existed. 17. State prosecutors were particularly careful to not allow any contradictory evidence before the grand jury when trying to make cases against the prisoners accused of murder. With regard to the killing of Barry Schwartz, state investigators spent endless hours grooming 4 prisoner witnesses, Dallas Simon, Warren Cronin, John Flowers, and Willie Locke, to say that they had seen one of the members of the rebellion's security team, Shango, Bernard Strobel, commit the crime. 18 Given that grudges existed between men in prison, as in any insular community, state investigators didn't always need to use coercion to get one prisoner to turn against another. Johnny Flowers told fellow prisoner Ed Kowalczyk while they both sat in a holding pen waiting to go before the grand jury that he was going to get Shango, and was eager to testify against him, simply because he was pissed at him because of an argument they had had when Schwartz had been removed from D-Yard and locked up in the cell. 19. The jurors never learned that some of the witnesses they heard from had been nowhere near the scenes of the crimes, nor were they told that many of the state's witnesses had told multiple versions of whom they had seen commit these crimes. By December of 1972, little more than a year after it had first been convened, the Attica grand jury was ready to hand down the first of 2 major sets of indictments. 20 From then on the Attica investigation was awash in funds. While Simonetti may have felt that he'd had to fight tooth and nail to get funding for independent investigators, after the indictments were handed down the amount of money given his inquiry grew exponentially. 21 Records indicate that from April of 1972 to March of 1973 he drew $1,910,000 from state funds. From April of 1973 to March of 1974 his office spent another $2,065,000, and between April of 1974 and March of 1975, it went through another $4,546,000.22. By 1974 Simonetti would have a full-time and fully funded staff of 20 specially appointed attorneys general, 28 special investigators, and 27 clerks, stenographers, and accountants. 23. Ultimately, the grand jury sitting in Wyoming County returned 42 separate felony indictments. The first 30 were filed in December 1972, and 12 more followed that charged 63 prisoners with 1,289 crimes. 24. A journalist for The Nation noted, despite the fact that 10 hostages, as well as 29 prisoners, died from the state's gunfire, the grand jury has not yet found sufficient cause to indict a single trooper or guard. 25. The state's indictments began with charges for the murders, or attempted murders, of Koss. Indictment number 1 was for the murder of William Quinn. The next indictments were for the attempted murders of hostages Frank Klein and Ron Kozlowski, who were both cut on their necks when the prisoners around them were shot down, and additional murder charges for the killings of prisoners Hess, Schwartz, and Privitera. Then there was a litany of charges: kidnapping, assault, unlawful imprisonment, possession of weapon, sodomy, and sexual assault, and more. More than half of these indictments carried a life sentence should the state secure a conviction. And the state, which was very determined indeed to secure those convictions, now began gearing up to prepare for the trials. Interestingly, other high-level parties also began mobilizing to gather information that might help to make these charges stick. According to a December 20, 1972, memo that the Buffalo office of the FBI received from W. Mark Felt, the acting director of the FBI in D.C., and later admitted Watergate whistleblower Deep Throat, had just received a request for the criminal background of the individuals indicted whose names have been publicly disclosed. No one was to know that the FBI was involved in any way in these cases. Felt stressed discretion, and cautioned the Buffalo office that this matter must be obtained in a most circumspect manner. 26. Pressed to reveal who had made this request, Felt disclosed that it was the Vice President, Spiro Agnew, who was interested in what type of individuals, as to criminal history, were involved. 27. Between December 1972 and February 1973, any Attica prisoners who were named in the state's blizzard of indictments but had already been released either via parole or because his sentence had been served were rounded up, mainly during the Christmas holiday, and were placed in prisons throughout the state to await their arraignment. 28. To be sure, Simonetti's office had worked around the clock to indict an extraordinary number of prisoners, and by doing so had clearly suggested to the American public that all that had gone wrong at Attica was down to them. But state officials had underestimated how determined those same prisoners were to defend themselves and to make sure that this same public heard their side. In fact, from the moment that the Attica grand jury had been convened back in November of 1971, a massive prisoner defense effort had gotten underway too. It was nowhere near as well funded as the state's Attica investigation, but it was as determined. Part 7. Justice on Trial. Ernest Goodman. Detroit attorney Ernie Goodman knew of the Attica prisoner uprising of 1971, but he was too busy arguing his civil rights and civil liberties cases to imagine lending his services to any of the 62 prisoners indicted in upstate New York. For many years Goodman had been spearheading the legal efforts to ensure that protesters from Mississippi to Milwaukee got a fair trial. Goodman, however, was not what the media would characterize as a hippie lawyer. He was older than many of the people now flocking to the legal profession to effect social justice. He was born in 1906 in the tiny town of Hemlock, Michigan, and moved to the big city at the age of 5. Life for this Jewish kid was hard. Confined to what was effectively the Motor City's Jewish ghetto, he grew up in a clapboard structure where they often had bed bugs and insufficient heat. Still, the Goodmans held their heads high, kept a kosher house, attended synagogue regularly, and hoped for a better future for their kids. In 1928 Ernie Goodman made his parents proud by getting a law degree from Wayne State College. From that year forward his mission was to fight for social justice through the legal system. In 1937 Goodman was instrumental in forming the National Lawyers Guild, NLG, which was the nation's first racially integrated bar association. Over the decades he would be involved in some of the nation's most important civil rights cases. In the 1930s he worked on the Scottsboro Boys' defense. In the 1940s he supported NLG efforts to prosecute Nazis at Nuremberg. In the 1950s he helped represent the Hollywood 10, the Rosenbergs, and blacklisted artists such as Paul Robeson. In 1951 Goodman joined African-American lawyer George Crockett Jr. to form the nation's first integrated law firm. By the 1960s he was immersed in school integration cases as well as in the NLG's efforts to set up offices in the South in order to provide legal support for civil rights activists there. By 1974 Ernie Goodman was trying to slow down a bit, hoping that his lawyer sons would continue the fight. Yet, when he was asked to come defend an Attica prisoner, he just couldn't say no. In Goodman's view, Attica was, like Scottsboro, an egregious example of the state's attempt to frame African American citizens. 35. Mobilizing and maneuvering. No sooner had the Attica prisoner indictments been announced in December 1972 than it became clear that Special Attica Prosecutor Anthony Simonetti was eager to get these to trial quickly. Knowing this, prisoner supporters stepped up existing efforts to provide a strong defense. Back in the spring of 1972, as prosecutors were presenting evidence before the grand jury, former Attica observer Arthur Eve noted worriedly to the remaining members of the Observers Committee that two of their biggest priorities would be preparing for the trials and drumming up funds for the defendants' bail and legal defense. With virtually no such monies yet raised to provide help to 62 men now facing 1,289 criminal charges, the Attica brothers, as they were collectively known, this task was daunting. Back in September of 1971, a number of lawyers had come to Attica from organizations such as the American Civil Liberties Union, the Legal Aid Society, and the National Lawyers Guild and had created an Attica Defense Committee, ADC. The good news was that by December of 1972 there was still a dedicated corps of young men and women from the ADC in the area determined to make sure that Attica's indictees had representation. As dedicated as this group was, though, by 1972 it was comprised of more student volunteers than lawyers who had passed the bar. As significantly, there was no one in charge who could take on the responsibility of coordinating the larger defense effort. The ADC suspected that the state's cases wouldn't be that strong, since so much coercion had gone into securing its indictments. In fact, state prosecutors would eventually drop almost a dozen indictments, even after a trial date had been set, because their evidence was so shaky. Nevertheless, a tightly coordinated defense effort needed to be marshaled, and quickly. The first major step in doing this was to bring as many lawyers as possible back to upstate New York. The National Lawyers Guild's annual convention in 1973 would be the ideal place to put out a call. Point 1. The NLG had always been centrally involved in the nation's major civil rights campaigns, including doing important work in the summer of 1964 when it sent 67 attorneys and countless law students to the South to provide legal support for the Freedom Riders and other civil rights initiatives. The NLG had two significant causes to address at the 1973 convention: Wounded Knee and Attica. Assigning lawyers was simple. A line was drawn down the middle of a huge map of the United States, and it was encouraged that everyone on this side of the line goes to Attica, everyone on this side goes to Wounded Knee too. By making sure that every Attica and Wounded Knee indictee had a lawyer, the NLG believed, the state wouldn't be able to turn the defendants against one another to help the state win convictions. In the summer of 1973, the NLG began another so-called summer project and scores of lawyers and law students moved into communal houses in upstate New York, one of the most crowded being located in Victory, near Auburn Prison, where the majority of the indictees were being held, and began working together on the broader defense effort. By the fall of 1973, attorneys were arriving from cities around the country, including Chicago, Detroit, San Francisco, Boston, and New York. This network of lawyers and law students would soon be filing myriad pretrial motions as well as beginning the arduous task of investigating the state's claims against the Attica brothers. Before any of these efforts could be coordinated, the Attica Defense Committee would need an official director. Dan Pokita, a lawyer already on the scene in early 1973, contacted his friend Don Jelinek out in California to see if he'd be interested in the job. Don Jelinek lived in the Bay Area. Agreeing to be the legal coordinator of the ADC would mean moving across the country for the indefinite future. But the Attica brothers were a group of men in dire need of strong legal representation. And so Jelinek arrived at the communal house, in fact a large converted barn, in Victory on March 7, 1973. He quickly realized the challenge he was in for, managing 20 to 30 people, living and working together, all with very different views about how the defense should proceed. Everyone did agree on one matter: the Attica legal defense effort needed a more formal, more effective, organizational structure. To this end, on September 21, 1973, the Attica Brothers Legal Defense, ABLD, was born. Recognizing the myriad strategic sensibilities and political viewpoints in play, the ABLD was clear in its commitment to doing both the legal and political work that needed to be done to help the indicted men and, as important, that defense funds would be shared so that all lawyers could work under this one umbrella organization. Point 3. The future success of the ABLD hinged on including not just prisoner lawyers, but also local community organizations from the area such as Fight and Build out of Rochester. The leadership of Fight was irked that although they had bailed out many of the Attica prisoners, some of these same men had then been heard criticizing the group for not being radical enough. Point 4. Fight's and Build's leaders, including former Attica observer Reverend Scott, needed to be treated with a bit more respect to feel comfortable lending a hand, according to Don Jelinek. Point 5. By setting up both a political office and a legal office in New York City, as well as opening official ABLD locations in Berkeley, Rochester, Detroit, Chicago, and Syracuse, the ABLD was able to win the support of these more mainstream organizations, as well as satisfy the radicals. What the ABLD really needed if it were ever going to take on the state of New York in court was cold hard cash. 4 major bar associations offered funds to help the Attica defense: the Association of the Bar of the City of New York, the New York County Lawyers Association, the New York State Trial Lawyers Association, and the New York State Bar Association. Point 6. But this funding never approached that of the state. ABLD lawyers couldn't even access monies that were legally allotted for public defenders because the judge presiding over the calendar for all of the Attica cases, Carmen Ball, had decided not to release legal fees to any in-state attorneys until their trial had finished and refused to pay any fees to out-of-state attorneys. Point 7. In Ball's opinion, those lawyers were contributing their efforts voluntarily with no expectation of reimbursement from the state. 8. And so, although the state had allocated $750,000 for the defense effort, compared with $4,500,000 for the prosecution, by May of 1974, a year into the organized defense efforts, it had yet to release any of these dollars. Point 9. Given that the ABLD was trying to pay for the legal assistance of 18 defense attorneys and fund at least 28 investigators, all working around the clock, this was a harsh blow. Point 10. Without money for payroll, and with the state routinely refusing to hand over materials expeditiously even when required by law to do so, the ABLD relied heavily on volunteer labor to track down everything it needed. The prosecutor's office dragged its feet giving the ABLD the names of the many Attica prisoners whom it was relying on as witnesses, so ABLD volunteers spent some 800-odd hours of office work simply on the identification, classification, and organization of those photographs of Attica inmates. 11. Fundraising quickly became another full-time job of the ABLD. Point 12. A key source of funding would come from those Attica brothers who, having managed bail thanks to community groups such as Fight, could travel to campuses and community centers to speak about their defense efforts. Some of the men who had been less visible during the rebellion itself now took an active role in fundraising. One such was Attica brother Akil Al-Yundi, who was the featured guest at an event at which movement celebrities Amory Baraka and Afeni Shakur also spoke. Point 13. Similarly, Frank Big Black Smith drew a huge crowd on the campus of Eastern Michigan University on September 12, 1972. 14. Big Black had been paroled in August 1972, was then indicted and released on bail, and, after going back to Brooklyn and getting married, he came to Buffalo determined to work hard on the Attica defense. His talks around the country generated a great deal of support for the Attica brothers. Point 15. Even if one of the indicted prisoners couldn't himself show up at a given event, organizations from coast to coast found ways to hold fundraising benefits or vigils on their behalf. Point 16. Attica brothers such as Akil al-Yundi also approached various groups to suggest how they might help raise money for the defense through their own activities such as leafletings, pamphleteering, buying pamphlets, buttons, the holding of bake and cake sales and drawing up petitions to be sent to the courts, the Governor of New York State, the President of the United States, state senators, United States senators, congressmen/women, and the United Nations to help us win 17. Even the prisoners who were still locked up, but not facing indictment, tried to assist the Attica brothers' defense effort. One prisoner wrote to the organization Resist expressing his concern for the many men now facing serious charges, and he requested that its newsletter print the ABLD fundraising address in every issue till the trials are over, as well as give a grant of $1,000 to the Attica Brothers Defense Fund. 18 Thanks to suggestions of this nature, a variety of publications ended up helping ABLD fundraising efforts. The Syracuse Attica Coalition, for instance, published a lengthy piece called Attica is All of Us, which was chock full of information on the brothers, and also promised that all profits from the sale of this brochure go to the Attica Brothers Defense Fund. 19. As an organization, the ABLD made regular pitches to anyone it could think of who might give money to help the Attica brothers. Don Jelinek, legal coordinator of the ABLD, wrote in one November 1973 letter that help is desperately needed. To mount the kind of defense that is required will take hundreds of thousands of dollars. Please write the largest check that you can. Your contribution is important. Attica needs your support. 20 In another instance, the ABLD asked very specifically for $4,575 seed money to begin preparing the defense of those charged with the Attica Rebellion of September 1971. 21. A number of community and religious organizations also made pitches on the ABLD's behalf. The Task Force for Humanity in Criminal Justice implored countless legislators to appropriate more funds to the Attica defense. A few offered support, but others forcefully indicated that they wouldn't consider spending one dime to help defend these Attica criminals. 22 When New York elected a new governor, Malcolm Wilson, in January 1974, the American Baptist Churches of Monroe Association boldly asked him as well to use the good services of this office to ensure adequate funding for the use of the Attica inductees, but his office was loath to get involved in something so politically charged. 23. Media celebrities and other wealthy people were more willing than elected officials to make the Attica brothers a favorite cause. At one fundraising party held in an apartment at 610 West End Avenue, attendees were promised that famed Black Panther Angela Davis would be in attendance. 24 Other Attica bashes were held in swanky New York apartments and in posh houses in Amagansett, Long Island. 1. At writer and media personality George Plimpton's house on August 20, 1972, boasted 75 guests and had been organized by the wife of Viktor Rabinovitz, a lawyer known to take on dissident causes. 25. By mid-1973, with publicity on the rise and monies finally trickling in from various sources around the country, the ABLD was able to begin its Herculean defense effort in earnest. There were by then about 56 people on staff who, when possible, were making about $50 a week for their round-the-clock work. 26 In addition to living in the house in Victory, Attica lawyers and volunteer workers also occupied at least 5 other communal houses in Buffalo. One of these, set up by Chicago-based ABLD lawyers, was referred to as the Linwood House. It had 6 huge bedrooms plus a large space on the 3rd floor that everyone called the dormitory because it could sleep 9 to 10. At least 2 dogs roamed freely around the house while Attica defense work went on day and night. Another house on the same street, also filled with ABLD volunteers, was known affectionately as Little Linwood. On Auburn Street yet another house was filled with Attica lawyers and volunteers, this group primarily devoting its energy to the issue of securing fair juries for the trials. At the house on Mariner Street, Big Blacksmith lived with various defense volunteers, and at the communal house on Ashland Street, still other legal volunteers lived and worked around the clock. There were many tasks that these defense workers had to accomplish quickly, since any of the 62 Attica brothers' trial dates could be set at any time. The ABLD first needed to find and interview witnesses either to crimes that the brothers were accused of committing or to crimes committed by law enforcement, since, it was hoped, jurors' attention could be focused on those two. The ABLD also needed to file as many motions as possible, in as short a period of time as possible, both to force the prosecution to turn over critical discovery materials, and also to bury that same prosecution in paperwork. They wanted the state of New York to be forced to defend everything, from the coercive tactics it used with witnesses in building its cases, to the specific charges it had leveled against a given Attica brother, to the jury pool it was counting on to convict those same men. By the summer of 1974, after nearly a year of working feverishly to file countless discovery motions, motions for dismissal, motions to change venue, and motions to get the Attica brothers still imprisoned in HBZ released into the general prison population, the ABLD succeeded in its goal of burying the prosecution in paperwork. The stack of papers was so large that Simonetti's office needed a dolly to wheel the papers before the court. 27. The ABLD was particularly eager to learn the fate of two motions it had filed, one to change the venue of the Attica trials, and the other to force the state to turn over any evidence it planned to use. The ruling on the change of venue turned out to be a partial success. Whereas the judge refused to consider moving the trials to New York City, as some in the ABLD had hoped, he would move them further from the prison to Buffalo in Erie County. Buffalo, at least, was a big city and it had far more racial diversity, as well as a major university. The result of the ABLD's motion for discovery was an even clearer triumph for the defense. This motion, argued for more than 5 hours before the court on July 10, 1973, was critically important because, as Don Jelinek explained, if granted by the court, prosecutors would be required to turn over massive information, facts, documents, and tangible evidence in preparation for the trial. 28. Whereas the venue motion was argued before Judge Harry Goldman of the now disbanded Goldman panel, this discovery motion came before Judge James O'Moore, a man completely unknown to the ABLD. To its relief, though, while the Attica defense didn't win access to all of the evidence that the prosecution had, it nevertheless won a remarkable amount. Even better, Judge Moore ordered that the prosecution must copy all of this material, with separate batches for individual lawyers, at its expense. Since the state had levied nearly 1,300 crimes charged in 42 indictments of 62 prisoners, who, in turn, now had at least 70 lawyers working for them, state prosecutors were dismayed by the many hundreds of copies of everything they would now have to produce for the defense. 29. Although it had enjoyed some success with certain key motions, the ABLD also experienced some serious setbacks. For example, its motions to disband the Attica grand jury so that no additional Attica prisoners could be indicted failed. 30. As important, none of its motions to dismiss cases were initially successful either. In one such motion to dismiss more than a dozen indictments, defense lawyers had argued that their clients' right to a speedy trial was denied and, more serious, that the grand jury had used illegally coerced testimony to indict their clients and, thus, that the evidence before the grand jury was not sufficient to establish offenses charged. 31. None of these arguments swayed the judge. Attica brothers such as Big Black took the failure of the ABLD's various motions to dismiss as simple confirmation that the judges were working hand in hand with Special Prosecutor Simonetti and his political masters, chiefly the former governor of New York, Nelson Rockefeller. 32. Many other Attica brothers shared this suspicion, particularly those who had been locked up in Auburn's segregation wing since their indictment. Although several of these men had managed to get out of segregation by being paroled or making bail, including Big Black and Champ, most remained. By 1974 over 80 of Attica's men in the HBZ at Auburn had been there for at least 9 months, and none of their motions asking to be released to the general population, those who had been indicted or not, were successful. Auburn's superintendent had merely to let the judge know that at least 22 former Attica COS, 3 of whom had been hostages in D-Yard, were now working at Auburn, and also that 42 of Auburn's own COS had been assigned from Auburn to assist in the restoration of order at Attica, to persuade him that it simply wasn't safe for his staff to let the former Attica rebels out of segregation. 33. The good news was that every person who had come to upstate New York to help in the ABLD defense effort was determined to keep fighting to get all of Attica's men out of segregation and to get all of them who'd been indicted acquitted. There remained, however, significant differences of opinion regarding exactly how this latter fight should be waged. 36. A House divided. The very first meeting of lawyers committed to defending the Attica prisoners, in Buffalo on September 13, 1971, it was clear that there were serious tensions: generational, political, cultural, and strategic. Liberal lawyers like Herman Schwartz and William Hellerstein had fought bitterly that evening with younger, more radical law students and lawyers over how best to help the prisoners. As Hellerstein remembered it, he was simply trying to figure out what we could do legally to help the men inside, but there was much conflict in the group because others felt that, in addition to legal work, people needed to be organized politically around what was happening to the men in Attica. 1 As Schwartz explained his position, we were not as interested in the politics as we were in the issue of civil rights and civil liberties unto themselves too. But over the next few years, both legal and political work around Attica did manage to happen in concert, and all lawyers involved with Attica worked hard to do whatever was needed to represent the men behind the walls of Attica and Auburn. Minimizing factionalism was a key motivator when activist and more mainstream lawyers alike came together in 1973 under the auspices of the Attica Brothers Legal Defense. Agreeing to hire one person to coordinate that defense reflected their optimism. Nevertheless, tensions between more mainstream lawyers such as Don Jelinek and the more radical lawyers and young law student activists repeatedly threatened to undermine ABLD cohesion. By and large, it had been the younger, more radical elements, the forces that had resisted men like Hellerstein and Schwartz in 1971, that had stayed on in Buffalo, both collecting evidence to help the Attica brothers and also keeping media attention trained on their fate. These men and women had always been suspicious of more establishment lawyers, fearing that they would forego the politically powerful lessons that could be taught and learned from Attica. This was exactly what lawyers such as former Attica observer William Kunstler thought when he agreed to act as a defense lawyer for the ABLD, as did another self-identified radical attorney, Dennis Cunningham of the People's Law Office in Chicago. As then law student Elizabeth Fink remembered it, defending the brothers was not just about trying to prove that they hadn't committed a crime, it was also about going on the offensive and investigating the state and its wrongdoings, because politics belonged in the courtroom. 3 As for the upcoming trials of the Attica brothers, the key would be to make as much noise as possible about how these men were being railroaded by the state by making sure, for example, that hundreds of people demonstrated in Buffalo where the trials were to be held. 4. Because not everyone who had come to Attica to assist the indictees agreed with this view, two defense camps existed at all times. One insisted that the attorneys should mount effective and straightforward legal arguments of the brothers' innocence only, and one argued that attention should also be trained on the reprehensible actions of the state both in and outside of the courtroom, and where even the illegal acts of prisoners might be defended as justifiable given the broader repression of that same state. 5. Without question, Don Jelinek included himself in the former group. The focus on the politics of Attica, in his view, was mostly just grandstanding and a distraction from the grunt work of filing motions and doing the legal research that would lead to sound arguments in court. Even worse, he feared, such tactics might end up alienating the very jurors the brothers would be relying on for acquittals. NLG lawyer Ernest Goodman tended to agree with this view and worried as well about the considerable differences of opinion among those working on the Attica defense. He, however, felt it important not to draw a line in the sand and, instead, to really think through how cases ought to be handled, the role of the lawyer, the relationship between attorneys, the brothers, and the legal workers, and the correct approach to a political case. 6. Even the 62 Attica brothers themselves were at times deeply divided over questions of strategy. By 1973, when most of the pre-trial work was taking place in the ABLD, clear camps were developing in the prisoner ranks as well. For example, Big Black was close with some of the more radical attorneys, like Dennis Cunningham, and he argued strongly for making the trials as political as possible. He felt that Attica's main defense struggles should not be waged in the courtroom but instead belonged in the communities and in the street, because the law did not serve everyone's needs on the same level and, thus, there was no guarantee of fairness let alone victory in the courtroom. 7 The system needed outside pressure to respond to injustice meaningfully. 8 Big Black was so disillusioned with the more legalistic strategy of men like Jelinek that he came to create his own defense group, the Attica Now Collective, ANC. This group did not break formally from the ABLD but focused its attention on political work. Eventually this group would include Dennis Cunningham as well as another People's Law Office lawyer, Michael Deutsch, and newly minted J.D.S. Elizabeth Fink and Joe Heath. The ANC published a newsletter called Attica News out of a storefront in the heart of the black area of Buffalo. One of the key missions of this broadsheet was to get word out nationally about the Attica brothers' cases. 9. However, Attica brother Shango Bahati Kakawana, known by the state as Bernard Strobel, did not see things as his fellow indictee Big Black did. Shango had been indicted for the murders of Barry Schwartz and Kenneth Hess. At first he too was deeply suspicious of the state and of his chances within any New York courtroom. Yet as his trial date came closer, he found himself gravitating toward a more traditional defense strategy and would come to rely on Detroit's Ernie Goodman to save him from a devastating sentence. The way Shango saw it, it was impossible to make an effective political point without first winning a legal victory. Further, in his view, fighting for one's innocence in the courtroom through legal channels was political because it was a concrete way for him and the rest of the Attica brothers to challenge their oppression. "I'll accept Attica Now's position," he explained in a public exchange with Big Black, "only if they are prepared to give me other means towards securing liberation." 10 All struggles were legitimate, he maintained, and they needed to take place in the courtroom or wherever oppression exists. 11. The Attica brothers also differed mightily in their opinions of the role that they themselves should play in their own defense efforts. Some, such as Willie Smith, Vernon LaFranc, John Hill, and Charles Pernisalis, were content to have outside lawyers do all of the defense work on their behalf, deferring totally to their judgment. But others felt strongly that they must play an active role in their defense and, although they agreed to have lawyers represent them, they insisted on making any strategic decisions in equal partnership with those attorneys. This was exactly how Big Black, Shango, and Yomo Joka Omawel felt, and they joined with lawyers in their own defense. Legally they had every right to represent themselves, and while more traditional NLG lawyers such as Goodman believed that working alongside pro-SE designated clients made court appearances awkward, lengthy, and at times confusing, the more radical lawyers such as Michael Deutsch held that it was crucial to let the brothers speak for themselves. "This way," he said, "we weren't coaching brothers with rhetoric, they came to it on their own." 12. Whatever their legal standing in their own defense, many of the Attica brothers came to develop close relationships with their attorneys, including some romantic ones, which generated wholly new tensions between the brothers awaiting trial. By 1974 there were significant romantic relationships between lawyer Elizabeth, Liz, Gaines and Yomo, between legal investigator Linda Burris and Shango, and between attorney Barbara Handschuh and Mariano Dallo Gonzalez. All of these men were still locked up and awaiting trial. The relationship between Barbara Handschuh and Dallo was the first to generate suspicions and tensions among the brothers. On one occasion a conflict arose when two defendants were overheard besmirching Dallo, suggesting that he was using Handschuh to save his own skin and cared nothing for the rest of them. In response, one of Dallo's defenders wrote to some of the other men awaiting trial, "I for one feel that there is nothing bro. Dallo would do on a personal level that would subordinate the interest of the brothers/people to his personal interest," but others in the group felt that his relationship with his lawyer suggested otherwise. 13 Attica brother Richard Clark, for example, was openly hostile to Handschuh and, as she reported to Dallo, he unjustifiably attacked with some critical words about her promoting women's rights when she should be worrying about the real struggle at Attica. 14 Whatever jealousies or suspicions her relationship with Dallo generated, Handschuh's myriad motions filed and hours logged on behalf of the other brothers indicated that she was committed to getting all of them acquitted. By 1974 virtually all of the Attica lawyers had come to care deeply for the brothers on a personal level. What the brothers thought about the lawyers, though, was more varied and fraught. Big Black would go on to have a lifelong friendship with his legal advocates, particularly Elizabeth Fink, and Yomo eventually would marry Liz Gaines, but Dallas seemed to be much more ambivalent about his relationship with Barbara Handschuh. Although Barbara repeatedly expressed to Dallo how passionately she felt about him, writing, "I miss you, perhaps more than you know. Te quiero, b." His replies were more political and practical. 15 As one of his letters to her began, "Power b, with the dialectical understanding evolving in the universe, I greet you with a clenched fist of love, power, and solidarity. Palant." In another, he mostly focused on making sure that she had done something for him, get a letter he wrote on Puerto Rican prisoners to the New York Times, and on ensuring that she did not let on to anyone that they were in any kind of romance. To his fellow Attica brothers, Dallo maintained that Handschuh was merely a comrade at arms, who also facilitated Y.L.P. Young Lord's party communications with me and NYC, and who sent him books that were meant for the collective, and he signed his letters to her in struggle, bro. Dallo. 16. Another source of tension and suspicion among the brothers was the fact that some of the brothers had managed to make bail, and were free to speak around the country and work on their own defenses, while others remained locked first at Auburn in segregation and then in the Erie County Courthouse Jail, where they were all moved in 1974. Shango, for example, did not make bail, and as he languished month after month in a tiny cell awaiting his trial, it infuriated him that other indictees such as Richard Clark and Roger Champion were becoming minor celebrities and seemingly living the good life. Worse, he felt that these bailed brothers were exploiting the trauma they had all suffered in order to become famous. As he saw it, the death of the brothers was being opportunized by everyone, and certain men on the outside had begun backstabbing, lying, exaggerating, distorting the facts, projecting false personalities/politics, etc., etc. merely so they could win the attention and favor of outsiders. 17. This sense of betrayal only became more acute when, just as trials were about to begin in 1974, it was discovered that some of the bailed brothers, namely Herb Blyden and Roger Champion, had stolen ABLD defense funds to feed drug addictions. 18 Shango blamed them for causing Big Black to break off into his Attica Now group, since Black now worried that the ABLD couldn't be trusted to protect the defense funds he and others would need. In Shango's view, Attica Now had arisen from the ashes of the burning bank accounts ignited by the greed and lust of so-called Attica brothers Richard Clark, Roger Champion, Herbert Blyden, et.al., media-projected leaders of the Attica Rebellion. In 1974, Attica brother Yomo also formed his own defense camp, an organization called Attica Bond to Free Yomo. 19. By the time the trials got underway, there were 4 major camps operating within the ABLD Big Black's Attica Now, Yomo's Attica Bond to Free Yomo, the Friends of Attica Brother Shango Group, and those not affiliated with one of these groups who were represented by myriad other attorneys who volunteered their services to the defense. 20 Despite these divisions, the ABLD remained a remarkably effective organization. In January 1974, a highly respected black lawyer named W. Haywood Burns replaced Don Jelinek, who seemed particularly to raise the hackles of the Attica Now affiliated lawyers and volunteers, as the ABLD's new legal coordinator. Burns's background was no more revolutionary than Jelinek's. He had graduated from Harvard, received his law degree from Yale, and then served as federal judge Constance Baker Motley's first clerk, as well as general counsel to Martin Luther King's Poor People's Campaign. In addition, Burns was one of the founders of the National Conference of Black Lawyers. However, Burns was much more comfortable than Jelinek had been with allowing the brothers to help shape their own defense strategy, thus, the radical lawyers liked him much better. As a sign of this new cooperative spirit, when Burns took the helm of the ABLD, Big Black became the organization's executive director. Thanks to this new leadership structure, as well as Don Jelinek's hard work throughout 1973 making sure that crucial pre-trial work had gotten done, particularly overseeing the filing of an avalanche of motions that would make later defense work both easier and much more effective, the different defense teams were now able to proceed with the trials as they wished and yet remain under the auspices of the ABLD. Every Attica brother could count on a remarkable and vast network of people in the ABLD who would work both together and separately to make sure every one of them was ready to face state prosecutors when the time came. 37. Laying the groundwork. Before trials were to begin in the fall of 1974, the Attica brothers' legal defense team still had three major tasks to accomplish. First, it needed to ascertain whether there would, in fact, be a trial for every indictee. The prosecution was making noises that it might consider some deals, given that there were nearly 1,300 indictments and 85 different groups of charges, and that this was well on track to be the largest criminal defense effort in American history. Any overtures to dismiss indictments would be welcome. 1 second, if there were going to be trials, the ABLD needed to have completed whatever groundwork could be done ahead of time to make sure that the jury pool would be as representative and reflective of the brothers as possible. Given the high concentration of prison employees in Erie County, this was a daunting task. Finally, the ABLD needed to make sure that all of its lawyers took advantage of every opportunity that could potentially net the Attica brothers exculpatory evidence. Under New York State's so-called Rosario Rule, they could request state-held evidence. They could also request that their clients have something called wait hearings prior to the actual trials. The Attica brothers particularly wanted these latter pre-trial hearings because in them the state would have to disclose how it had identified the defendants, whether their procedures had been above board. 2. Whether all the Attica brothers would in fact go to trial had been a topic of serious discussion between Attica's Special Prosecutor Anthony Simonetti and Don Jelinek in early 1974. Even though Jelinek was no longer serving as ABLD coordinator, he was determined to stay involved. Jelinek and the Attica Special Prosecutor discussed the possibility of plea deals or even the dismissal of indictments. Jelinek had hoped that his talks with Simonetti would lead to what he later referred to as the mother of all plea bargains. 3. To Jelinek's frustration, however, Simonetti kept giving him mixed messages about what would be possible for the brothers. 4. These discussions first began in February 1974 and involved Victor Rabinovitz, former Attica observer Tom Wicker, and Haywood Burns, as well as Jelinek and Simonetti. Initially, Simonetti intimated that a deal might be struck in which no one indicted for their actions at Attica would serve time, including the troopers, if any, who might be indicted in the future. 5. By March 4, 1974, however, Simonetti was backtracking on the issue of jail time for the prisoner defendants. He suggested instead that individual prisoners be offered deals determined by a judge. Jelinek rejected this outright, playing hardball. You know that dismissals are your only route to avoid indicting your people, meaning that Simonetti would never have to indict state troopers. 6. Simonetti weighed his options, ultimately declaring that any prisoner who was interested in a plea deal would have to make it known by April 29, 1974. Jelinek decided to take the decision to the brothers themselves by secret ballot. 7. He was leery of recommending a deal since it wasn't clear what the terms would be, and he wasn't persuaded that Simonetti really had the power to make the deals he was hinting at, but he felt the defendants should make their own decision. 8. However, Jelinek had not previously sought advice from any of the Attica brothers regarding the negotiations that had led to this current deal. This made them suspicious. Big Black announced that if someone wanted to take a plea deal they could, but there would be no secret ballot. And that was the end of that. Trial dates were now a certainty. And so, beginning in May of 1974, ABLD teams were hard at work to make sure that the brothers would have the least biased juries possible hearing their cases. The primary leader of this effort was a 24-year-old member of the National Lawyers Guild, Beth Bonnera. 9. Bonnera had been inspired by a comprehensive 1966 study of juries that suggested a scientific methodology could be used to make sure jury panels were less prejudiced than they otherwise would be when relying on the usual process of selecting eligible voters. She was interested in seeing if this was something the ABLD could use to help the Attica brothers. It was well known that even with a careful voir dire during jury selection, the process in which potential jurors were questioned as to their views and potential prejudices, jurors regularly lied to make themselves acceptable or unacceptable to one side or the other. 10 Jurors' prejudices could matter a great deal to a trial's outcome. Bonnera wasn't alone in thinking that it was possible to do research that would, in turn, impact a jury's composition. In 1971, a Columbia sociologist named J. Schulman had published an article that suggested concrete ways a more open-minded jury could be attained. In one particular 1971 Pennsylvania trial, in which the Harrisburg 8 nuns and priests and a Pakistani journalist, all anti-war activists, were tried for conspiring to kidnap National Security Advisor Henry Kissinger and blowing up steam tunnels under government buildings in Washington, D.C., defense lawyers had used so-called scientific jury selection to great effect. 11 That defense team had worked closely with social scientists to analyze the community from which jurors would come, as well as to develop juror profiles for use in jury selection. 12 When these efforts led to a jury that favored dismissal of all charges against the 8 defendants, progressive lawyers around the country took notice, particularly Beth Bonnera. With the Attica trials looming, her job was to work with social scientists, attorneys, the many volunteers, and community members to put the jury system under the microscope. 13 Thanks to the investigative efforts of Bonnera and her team, the ABLD managed almost immediately to get a court order to inspect the jury commissioner's records that indicated ways in which the jury selection process was clearly discriminatory. For example, the qualification process used in the office included handwritten notations about the race of black citizens. 14 After a flurry of filing motions, the newly formed Fair Jury Project of the ABLD, usually just called the Jury Project, was able to reconstitute the entire Erie County jury pool. Some 115,000 prospective jurors were dumped and a new system instituted. 15 Needless to say, this was a major victory. However, few in the ABLD were naive enough to think that the next pool would be much better. It was still comprised of Erie County residents, many of whom didn't trust African Americans or prisoners. And so Bonnera and her team then began the arduous process, recommended by Schulman's research, of compiling data from surveys of potential jurors that could be used to select as favorable a jury as possible. 16 Such careful and intensive research into what demographic characteristics generally indicated about a potential juror's viewpoints yielded the ABLD some predictable, and alarming, information, but also some surprises. On the one hand, in any sample of the potential jury pool, approximately 23% of the people surveyed felt that they could not accept the court's instructions concerning the presumption of innocence. Almost 42% of those surveyed volunteered some form of demeaning racial stereotype in response to a question concerning black people, and 31% of Erie County voters believe that radicals and black militants should be imprisoned solely because of their beliefs, whether or not a violation of law had occurred. 17 Unexpectedly, they also discovered that New York Times readers in Buffalo were not necessarily good choices for the defense. 18 These kinds of tools for scientific jury selection were already in regular use by prosecutors. As Schulman's Guide to Successful Jury Selection explained, similar research was already regularly conducted by federal and state prosecutors and various commercial investigating services. 19 Such work was much harder for the Attica defense effort, since they had far fewer resources than either group. It took an enormous amount of both time and money to create a large enough community network to know how a potential juror might view prisoner defendants. If a potential Attica juror was a member of the League of Women Voters, for example, the ABLD Jury Project needed to already have a network in place in that community, which they would canvass to see if anyone knew the juror or shared a mutual acquaintance. Contacts would then be interviewed to determine whether the potential juror had any black friends, had ever used racial slurs, and so forth. 20 Undaunted by what it would take to build these networks and score the demographic characteristics of potential Erie County jurors, the ABLD's legal volunteers got to work. They talked to as many people in the county as they could, meeting them outside churches, shopping centers, and sports arenas, and surveying them about their affiliations, religion, heritage, habits, and views. 21 In time, the ABLD Jury Project managed to sample 700 voters from the Buffalo metro area, which had 1,400,000 residents, while keeping the costs down to about $400.00 in basic research expenses. 22. The jury project's systematic research complemented the ABLD's other massive investigative efforts. Many in the ABLD believed that in order to defend the Attica brothers successfully, they needed to know as much as possible about what troopers had done at the prison on the day of the retaking and over the subsequent days and weeks, and also who had ordered and overseen their actions throughout that time. They hoped, in effect, to put the state on trial in the brothers' criminal trials, and also, one day, to use this evidence in a civil case against the state. Such evidence of trooper violence could also mobilize people outside the courtroom to support the brothers. 23. So, while the jury project surveyed Buffalo residents to facilitate jury selection, phalanxes of other young ABLD workers began a sustained effort to interview anyone who had been in D-Yard on the day of the retaking and the days after. The most comprehensive interviewing effort involved National Guardsmen, who had not participated in the retaking but who had gone in shortly thereafter to deal with its carnage. The ABLD managed to obtain a list of about 500 guardsmen who had been called to Attica that day and decided they would send 2 people to a guardsman's house, unannounced, and ask to talk to them. Hoping to document the crimes of the state which we knew existed and were not being investigated by anyone else. 24. In addition to locating the rank-and-file guardsmen who had been in D-Yard, these ABLD investigators also wanted to speak with the National Guard physicians who might be able to provide first-hand accounts of the medical impact of the retaking. 25. The ABLD learned much from the interviews they conducted, including blow-by-blow descriptions of how brutally the state police had treated the prisoners. However, to their frustration, it was difficult for these witnesses to identify the men who had perpetrated this trauma. The guardsmen usually did not know these troopers' names. Given that 3 years had passed and that the troopers had deliberately removed their badges on the day of the assault, it was hard for the guardsmen to remember specific faces from the hundreds of people running around in uniform. C.O.S, S.T.S state troopers, sheriffs, etc. on the day of the retaking. 26. Nevertheless, the project was considered a great success. ABLD workers compiled the interviews, numbered them, and created an index of the 40 or so salient points that had been revealed. 27. The ABLD managed to gather crucial information on what briefing and instructions the National Guardsmen had received, their command responsibilities, the way in which medical treatment had been doled out, the gauntlets and beatings they had seen, and how state officials had ordered them not to discuss any of it. 28. By the time they were ready to begin pre-trial hearings, the weight hearings that were allowed them by law, the ABLD attorneys were well armed. They had requested an enormous amount of material from the state via countless discovery motions and had set up a complex system for organizing and analyzing those materials. 29. Although the ABLD lawyers had little idea which cases the state would decide to try and win, they were already spending a great deal of time in Judge Carmen Ball's courtroom. Virtually every administrative proceeding, particularly the arraignments of the Attica brothers, packed the courtrooms with ABLD supporters who were often boisterous and were constantly watched by a heavy presence of law enforcement both within the courthouse and on its grounds, which led to a great deal of tension. At Big Black's arraignment, for example, he became so frustrated with the judge's seeming disinterest in what he had to say that he had summarily ripped up his indictment and accused Ball of being a full-fledged member of the KKK. 30. The courtroom became so charged in proceedings like this that one young woman in attendance noted in a journal she was keeping, "They've changed the water glasses from glass, breakable a possible weapon, to plastic, almost red in color. Must be at least 50 cops upstairs today. Metal detectors and search downstairs. Each cop has his billy club. Milling around. Fat bellies. Joking, tense, defensive." 31. During the various pre-trial conferences that followed the contentious arraignments and calendar calls, the atmosphere grew steadily more strained. The brothers had already waited a long time for the state to decide whether they would even go to trial. Now in these various meetings it became clear that they would not get all the resources they needed to prepare a solid defense, especially if they were representing themselves pro se. At one particularly prickly pre-trial conference before Judge Ball, Big Black tried to persuade the judge that he needed money to hire an investigator, reminding him that he had nowhere near the resources to prepare for his own defense as the state had to try to convict him. As he put it, the only people that had did any work or was authorized to get any money to do any work, had been the state. How can I prepare, really? 32 Well, Frank, Ball replied coldly, these are all problems that you can put on the record in such form as you see fit and they will be reviewed at a proper time. 33 To the judge's surprise, Big Black persisted. This ain't no joke, Judge. How are you going to tell me that I'm supposed to be ready in 60 days, and the state done took 3 years, Judge? I mean, is that a constitutional right, a violation? What do you call this? 34 This got Big Black nowhere. The Attica brothers did have one additional way to strengthen each of their cases before their trials actually began, thanks to 2 landmark cases, People of the State of New York v. Rosario, 1961, and Brady v. Maryland, 1963, decided by the Supreme Court of the United States. These decisions meant that Attica defendants were allowed to challenge prosecutors' prior determination that certain materials were not exculpatory in case they in fact were. 35 The Rosario material they were entitled to included any statements of state witnesses who would testify at the trial, law enforcement forms that might summarize a witness statement, any signed statements by a witness, and the paperwork prepared by a testifying police officer. In addition, the prosecution was obligated to hand over all of that material before a defendant's trial began. Additionally, under the Brady decision, in recognition of the prosecutor's special access to police and other information, the Attica brothers would be entitled to any exculpatory evidence the prosecution might hold. 36 They were also entitled to any evidence that police officer informants had knowingly lied or that its civilian witnesses might have given false statements or been remunerated for acting as a state informant. 37 However, although all of these rights are legally absolute, ABLD lawyers couldn't count on getting any of these materials. Simonetti didn't even give them a list of possible witnesses his men might call until finally threatened with contempt proceedings, and, according to the ABLD, it still took state officials another full year to comply with repeated court orders by delivering the names of the probable witnesses, as well as other documents to which the defense was obviously entitled. 38 Even when materials were turned over, the ABLD accused the prosecution of supplying intentionally inaccurate inmate identification numbers to thwart defense attempts to locate witnesses. 39 The state dragged its feet so badly on turning over records that Dennis Cunningham wrote directly to Anthony Simonetti on March 8, 1974, to remind him that among the many aspects of Judge Moore's discovery order with which your office has not yet complied is the direction paragraph 10 regarding disclosure of informers in the defense camp. 40. The most important legal tool the Attica defendants had when it came to crafting a strong defense turned out to be the Wade hearings. In these pre-trial hearings, the state was required to show that the procedures it had used to identify the defendants, e.g., lineups, witness interviews, had been proper and legal. 41 If the investigators' procedures were found to have been unconstitutionally suggestive, that evidence could be thrown out. 42 The defense could benefit twice over. In order to show that its work was aboveboard, the state had to give up the names of those witnesses who had identified the defendants, giving the ABLD lawyers the access they so desperately wanted to these formerly anonymous witnesses. 38. Testing the waters. Despite the extraordinary care the ABLD took to prepare for the trials of the Attica indictees, it was allowed to play only a very small role in the first case that made real news, that of Richard Bolello in December 1973. This first case didn't even go to trial because Bolello took a very public plea to charges of kidnapping, coercion, and unlawful imprisonment. Nevertheless, it was a court proceeding that seemed to say to the nation that Simonetti's team was making its cases of prisoner guilt with remarkable ease. Bolello wanted nothing to do with the ABLD defense effort. A white Attica prisoner with mafia connections who was already serving a 40 years to life sentence for a barroom killing, he saw them as political lawyers who really have no interest in anyone. As he explained at his arraignment, he just wanted his own good criminal lawyer one. It seemed to the ABLD that Bolello refused to put his lot in with the other Attica brothers because he feared retaliation from his fellow Italian mafiosi for doing so. Yet Bolello also worried about antagonizing the Attica brothers if he didn't stand with them. Point 2. So concerned was Bolello about making the wrong choice regarding his own defense strategy and which prisoners he was, in effect, siding with that at his arraignment on December 29, 1973, he begged Judge Carmen Ball for a court order for protection. 3. Ultimately Bolello decided to take his chances at going it alone before Judge Ball. Although he constituted quite a pathetic figure as he stood before the court, it was clear that Richie Bolello was not at all shy about speaking on his own behalf. When he finally came before Ball, after spending hours in a holding cell with other Attica defendants waiting to be arraigned, he was obviously seething. "This morning I am shabby in appearance, in shackles," he said to the judge. "We have been in shackles since 7:15 this morning. It is now 1:25, Your Honor." When the shackles weren't removed, Bolello continued more forcefully, "We must be sitting in a room, worse than any animal, the wildest animal in the zoo has no chains on it, we are held worse than convicted people. Has the state put us in a place where we lose the presumption of innocence before trial?" 4. In addition to pointing out the ugly treatment of the Attica defendants, Bolello also tried to impress upon the judge how few resources any of them had to prepare even a modicum of an effective defense. He was entitled to one phone call a month, but in order to track down witnesses and try to prepare his case, he would need access to a phone sometimes 3-4 times a day. 5. Ultimately, Bolello's defense was that he couldn't have committed the crimes of which he was accused because he had been in keep lock the entire time of the rebellion. As he put it, "I shouldn't even be in this courtroom because I was in a keep lock cell that I had no key to. 28 cells away from the front door where they were rounding up hostages, or whatever they were doing. And I am in the courtroom indicted for getting hostages. This isn't even logical." 6. He had naively written to State Prosecutor Maxwell Spunt, begging him to find the corroborating paperwork. "What I am asking for is your personal investigation as to the effect that I speak of. I shall then be able to prove I was in keep lock and I shall be able to prove my innocence." 7. But it soon became clear that no one was ever going to get Bolello his proof, certainly not the same prosecutor who was trying to convict him, and, without that, he decided to plead guilty just to get the whole ordeal over with. 8. Simonetti's office was delighted. If things kept going this way, the future looked bright. The state might not get outright convictions every time, but it could clearly get prisoners to admit criminal wrongdoing at Attica, certainly what Rockefeller had wanted to happen when he launched the Attica investigation. The future was not so bright for Richie Bolello. On his way to a counseling session at the Clinton Correctional Facility on September 29, 1974, 44-year-old Bolello was stabbed repeatedly in the chest and back by another prisoner, mobster Donald Franco's. 9. Although even the FBI knew that this had been a mob hit, state officials still tried to imply that his death might have been on the hands of an Attica rebel, stating suggestively, there was no way to ascertain whether the stabbing was related to the 3-year-old Attica rebellion. 10. Emboldened by Bolello's guilty plea, Simonetti's office proceeded right away to take an Attica case to trial, one that given its salacious nature might be won easily and also serve to undermine any public sympathy that clearly existed for the prisoner defendants. As ABLD lawyer Michael Deutsch saw it, by choosing to try this case before any of the others, the state was really trying to prejudice the media. 11. African-American prisoner William Smith had been charged with first-degree sodomy and the sexual assault of a young white prisoner. He faced a possible 32-year sentence for subjecting James Schleich to sexual contact by forcible compulsion and for having deviant sexual intercourse with James Schleich by forcible compulsion, and the case was to be tried by seasoned prosecutor Brian Malone. 12. 27-year-old Willie Smith's defense lawyer hailed from Rochester and was known to specialize in rape and sodomy cases. He was, however, not particularly close to the ABLD and had not partaken of any of their pretrial work. For example, he didn't utilize any of their jury project research. Worse, many of the ABLD members did not think much of his attorney. In their view, Smith's attorney was totally incompetent, for example, not making obvious objections when he clearly should have. Still, the state's evidence against Willie Smith was so thin, they remained hopeful. Jury selection had begun on September 26 for Smith's trial and, without use of the jury project, there ultimately would only be one black juror. Still, things didn't go at all well for the prosecution. During the first full week of the trial, for example, investigators from the Bureau of Criminal Investigation were called to the stand and, when asked for the notes they had taken while conducting their interviews of the state's witnesses in this case, they claimed not to be able to do so because paper shredders had been installed in the prison for use immediately after each prisoner interview. 13 Then, another BCI investigator testified that, for the first time in his 17 years on the job, he had been ordered not to take notes during prisoner interviews because, he admitted, the NYSP wanted to evade the legal requirement that all such notes be turned over to the defense before a trial as Rosario material. 14 The judge was not at all pleased to hear such testimony and the jurors were bothered by it as well. Whereas the ABLD felt that this information alone should have led to Smith's case being dismissed since the evidence the state was relying on was gathered in violation of clear-cut rules and laws. Ultimately it was a technical error on the part of the prosecution that undid the state's case against Willie Smith. In short, as ABLD lawyer Elizabeth Fink recalled later, Brian Malone made a crucial stupid mistake. In sexual cases back then you needed corroboration. There was a statement that Schleich the victim had made that they admitted under evidence. But they hadn't read rules on evidence which said that they couldn't use this statement as corroboration. 15 Ultimately Justice Frank R. Baker felt the evidence was too flimsy to warrant a jury's consideration and told the jury pointedly that the state had failed to provide the necessary corroboration for the testimony of the alleged victim, and on October 9, 1974, he officially dismissed the charge of sodomy and charge of sexual assault against Smith, thus freeing him. 16 When the news broke, throngs of young people gathered outside the courtroom and enthusiastically chanted, "Free the Attica brothers." 17. Although the ABLD had every reason to celebrate the outcome of this first official round with the state, the behind-the-scenes story of how victim James Schleich had been used by the state's investigators was heartbreaking. There was little doubt that James Schleich, along with his twin brother, John Schleich, had been raped during the first hours of complete chaos in the Attica rebellion. That very day, they had gone straight to the men in charge in D Yard, begging them to find the perpetrators, which they duly set out to do. Even 6 weeks later, when doctors examined the brothers on October 27, 1971, they still were clearly traumatized from being forced into anal sodomy the first day of the Attica riot. 18 What was equally clear, however, was that the victims of this crime had no idea who the men who had hurt them were and, despite knowing this, the state had proceeded with its case, dragging them, and eventually Willie Smith, into a years-long legal ordeal. In extensive and wrenching testimony, James's brother, John, had told the grand jury the story of what had happened to him and his brother on the morning of September 13, 1971.19. He had seen his brother dragged away to a bathroom by a group of men, and then he too was captured at knife point and taken to that same remote location where the two of them were raped by a group of 5 or 6 individuals for about 30 to 40 minutes. 20 As much as John Schleich wanted the grand jury to know that he and his brother had endured a terrible assault during the Attica rebellion, however, he had been clear with the BCI well before coming to that grand jury that they couldn't identify their assailants then or later. When they were shown photographs of Willie Smith, neither he nor his brother had ever indicated that Smith was one of their rapists. John Schleich had nevertheless agreed to testify before the grand jury because he actually hoped it would address the brutality that state troopers had meted out during the retaking. He told these jurors of his dismay and fear when a trooper had grabbed him and aggressively ripped off his St. Christopher medal, and then snatched his watch and hit that as a baseball bat or like it was a baseball. 21 John also wanted grand jurors to know just how terrible it was that the state had placed him and his brother somewhere like Attica in the first place. As he told the jury, he had been placed in this maximum security facility at the age of 19 for a mere parole violation for the unauthorized use of a motor vehicle. His brother had missed his curfew while on parole for the crime of cutting a hole in a convertible top. John had desperately addressed the grand jury. "I want to know if anything ever going to be done about this stuff going on in these prisons. There's a whole lot more kids it happened to. Now, you're the people, you should be able to do something about this. Is that any place for a kid to be, 19 years old, 22?" Instead of trying to respond to John Schleich's questions, the jurors had instead chosen to indict Willie Smith. Needless to say, losing this case was a real blow to Simonetti's office. Still, Assistant Attorney General Simonetti felt hopeful. His team was reasonably confident that it could convince jurors in the next trial up that Vernon LaFranc had used a gas gun to subdue the hostages. Not coincidentally, LaFranc was yet another Attica prisoner who had not worked particularly closely with the ABLD to mount his defense. At his arraignment on December 18, 1972, LaFranc had entered a plea of not guilty. By June 16, 1973, he had retained Don Jelinek so that he might file some motions, but by the time his trial began LaFranc had gone through 2 more attorneys. 23 Fearing that LaFranc's defense wasn't in very good shape, and knowing that the state's prosecutors were extremely eager to recover from their loss in the Willie Smith case, the ABLD tried its best to stay involved. 24. On December 19, 1974, the state prosecutors were thwarted yet again. A jury comprised of 9 women and 3 men issued its unanimous not guilty verdict after only half an hour of deliberations. In short, they had been not at all persuaded by the state's witnesses. As an ABLD newsletter explained, all 3 witnesses for the state changed their stories several times, and their earlier written statements turned out to be lost. In addition, a former prisoner testified that he saw the state's star witness pull Vernon out of a line of prisoners after the assault and beat him to the ground. 25 Several jurors later told the press they believed the state's testimony against Vernon had been fabricated. 26. 2 major trial victories were just what the ABLD lawyers needed to marshal the energy to face the series of far more challenging cases just on the horizon. Such victories were a boon to fundraising, and helped attract several prominent people to put their names on fundraising pleas, including political luminaries Bella Abzug, Julian Bond, Noam Chomsky, Daniel Ellsberg, Jessica Mitford, and Charles Rangel. 27. The next case up would be the most challenging and significant to date for the ABLD and the state's most important case to win. In January of 1975, the state would try the alleged killers of Attica CO William Quinn. 39. Going for broke. By 1974 Anthony Simonetti had good reason to feel that his prosecutors could persuade a jury to convict John Hill and Charles Pernisalis, the 2 young prisoners whom his office had indicted for the murder and second-degree assault of correction officer William Quinn. The case against these 2 Attica brothers, the state hoped, would be its most powerful opportunity to justify why it had, to date, focused its energy exclusively on the riot-related actions of prisoners. They had brutally killed a young man for no reason, and his family, prosecutors would show, remained unimaginably traumatized by this horrific act. Time had moved on for the Quinn family. The baby that Nancy Quinn had been carrying back in September 1971 was now a toddler named Amy, and her eldest daughter, Deanne, was now 8 years old. But time had not healed this family. Not having a husband was not easy in the small town of Attica. Nancy was suddenly without an income and had to ask others for help. She felt deep shame every time she had to go to the local bank and ask if she might have some money from the meager Attica Widows Fund that well-wishers had set up, or had to ask someone else's family to assist her and her girls in some way. What's more, life as an Attica widow had made her a national curiosity. She was always having to take the phone off the hook to stop the incessant calls from reporters and, as the trial for her husband's killing loomed, reporters began showing up at the house unannounced. Her own feelings about the trial were mixed. On the one hand, a trial meant that she would have to relive the nightmare of her husband's death all over again. Yet if the state indeed knew who had killed her husband, and if it could put those men away, then at least she might be able to feel some closure and begin her life anew. The 2 individuals who sat in the courtroom waiting for their trial to begin, however, barely looked like men at all. John Hill, who went by the name Dakajwiat, had been only 19 years old when the Attica rebellion began. At 22, he still looked like a scrawny kid, although he didn't much resemble the young men his age in the village of Attica familiar to either the Quinn family or to potential jurors. Hill was part Mohawk Indian, he had long hair, and looked very much like what the media had dubbed a hippie. That John Hill was now sitting as a defendant in this trial was itself ironic. Hill had been at Attica for less than 2 months when the rebellion began. The way he saw it, he was hardly a seasoned criminal. As a kid he had robbed a sub shop and had been sent to the juvenile reformatory at Elmira. The only reason that he ended up at that maximum security facility was because, when he turned 19, he still had a few months of penance to do. He believed he would be granted parole in October of 1971. When Hill landed at Attica in August 1971 he had been housed in A block, but he immediately began trying to get moved to the metal shop, hoping to learn a real trade before his release. He wasn't particularly politically active, although he did notice that there were lots of very political people in Attica, lots of activists coming in from the street. Black Panthers. Black Liberation Movement. In the short time that Hill had been at Attica he found himself thinking more about things like discrimination. He couldn't get over the fact that so many of the white cops there were very hostile to the non-white prisoners. As he saw it, their racism wasn't at all subtle, but instead very brutal, right in your face. He had been shocked one day when he watched as 2 guys were beaten just for talking in line 4 when the prison had exploded on the morning of September 9. He was not at all surprised. The place was thick with rage at the guards there, so many beatings, so many lockdowns, so much solitary 5 on that morning. Hill had been in a block tunnel at the epicenter of the riot, and he admitted to being part of the huge group of prisoners that surged through Times Square when William Quinn was so viciously beaten. However, from the day he was indicted, he maintained that he had not stopped to beat any guard, let alone beat him so badly that he would die from his injuries. 6. John Hill's co-defendant had been equally young when he came to Attica. Charles Joe Pernisalis was part Catawba Indian. Like Hill, he was a slight 125-pound 22-year-old with longish hair, who had landed in Attica after committing a juvenile offense and, in his case, then violating parole. When the Attica rebellion started, 19-year-old Pernisalis had been at Attica for merely 2 weeks. 7 Charlie Joe, as he was called, had begun his life behind bars when he was 16 years old when he tried to run away from his home in Syracuse and stole a bike from a neighbor's garage. For that offense Charlie Joe received a 2-year sentence at Elmira. When he was almost 19, he was finally released on parole and decided to head to California to live with a group of young people in the desert and start a new life for himself. 8 However, he had failed to tell his parole officer that he was leaving the state, so when he was later picked up by the California police for hitchhiking, he was returned to custody in New York and placed in Attica while waiting to hear his fate from the parole board. 9. No matter how young they were, though, Hill and Pernisalis needed strong representation to face the charges against them. Over the previous years, various ABLD attorneys had made sure that they were properly arraigned and filed motions on their behalf, but for quite some time it remained unclear who would represent them at trial. Ultimately John Hill would be defended by none other than William Kunstler and Margie Ratner, Kunstler's wife. Hill was amazed and grateful by his fortune at securing this help. 10 Charlie Joe was as thankful when he learned that he would be defended by Ramsey Clark, the former U.S. Attorney General, as well as by one-time Attica observer Herman Schwartz and Joe Heath, the ABLD's newly minted lawyer who had been an activist in Vietnam veterans against the war. News of the defense's power team of lawyers sent Simonetti's office into a panic, particularly Louis Atala, who was scheduled to argue the state's case. They would without a doubt need to bring their A-game. Kunstler had already gained a national reputation from his defense of the Chicago 7, and his work in other high-profile cases had shown him to be loud and uncompromising on behalf of his clients. Ramsey Clark was equally famous, but he cut a very different figure in the courtroom. His style was more refined, perhaps even aloof. He was also quiet. Whenever he questioned witnesses, pacing and gesticulating all the while, Clark would stand very close to the stand and, according to one reporter, could scarcely be heard across the room. 11. These defense attorneys were set to face a prosecutor who was also known as a bit of a showman. 12. Attica sported an old-fashioned mustache that is curled at each end, and also argued every point loudly with much gesturing and bravado. 13. Attica had been known to ask witnesses he was questioning to step out of the box so that they might bring the case to life by acting out the movements of the defendants they have described in their testimony. 14. State Prosecutor Louis Attica, left, and prisoner's defense attorney William Kunstler, courtesy of the Democrat and Chronicle. Before any of these lawyers could speak to the jury, however, the ABLD insisted on holding a thorough weight hearing. It was crucially important in this case to make the state explain how it had come to identify Hill and Pernisalis as the men who killed William Quinn, and their lawyers also very much needed the myriad state documents that would be given to them in the process of conducting such a hearing. The weight hearing for Hill and Pernisalis was presided over by Justice Gilbert King, and the courtroom was always full. As one reporter described it, in the spectators section sit the relatives of the two defendants, others are members of the Attica Brothers Legal Defense Organization, and one is an Indian spiritual leader named Mad Bear, who wears a feather headdress in court. 15. The weight hearing took months to conclude, but from the defense's perspective, the time was well spent. They had learned a great deal to indicate that the state's case against Hill and Pernisalis was shaky at best. It became clear, for instance, that a key state witness had only agreed to testify after being harassed and coached. As important, one prisoner had never been asked to testify before the grand jury, even though he indicated that he had crucial testimony that was in fact favorable to the defendants. 16. It also came out that another witness had been interviewed by Attica investigators on February 12, 1973, and made it clear that he didn't want to be there because he had no information to help them. That mattered not. According to this prisoner, investigators told him to sit down. "You bastard, you will stay until I decide to let you go," and kept on peppering him with leading questions. 17. This same witness said that he then asked for counsel but was informed that he had no rights. 18. Another witness stated in affidavits filed in both July and October of 1973 that since his first meetings with the BCI investigators he had been deeply troubled by the interrogation methods they had employed, particularly as he had mounting fear, was under heavy medications because he had been shot 7 times, and, thus, was in a serious state of confusion. 19. He had been hounded and threatened by BCI investigators to say that he had seen things that he didn't think he had seen, but he was scared to death that if he did not cooperate, the police would kill him. 20. Learning that the state's identification of the defendants had often taken place when its so-called eyewitnesses were under serious duress, and that even the statements from some of the state's CO witnesses were contradictory at best, suggested to the defense lawyers that they had a shot at getting this case dismissed. Furthermore, the grand jury had not been able to hear potentially exculpatory material before it indicted Hill and Pernisalis. But Judge King, while not at all pleased with what he had heard over the course of the weight hearing, maintained that there were insufficient grounds to dismiss the cases outright. Jury selection thus began on January 5, 1975. By January of 1975 the city of Buffalo was teeming with crowds of young Attica Brothers supporters from all over the country. In explaining the outpouring of support, the National Alliance Against Racism and Political Repression compared Attica to certain other villages and hamlets that had come to represent for peoples of conscience the world over a name embedded in history for its savagery and intolerable shame. Ludlow and Dearborn and Gastonia, Wounded Knee and Sand Creek, My Lai in South Vietnam and Sincan in North Korea, and now Attica, unnoticeable points of geography, not to be found in an atlas, but never to be forgotten. 21. And though supporters did indeed see Attica in this broader context, they called for immediate and practical redress for those now standing trial. They circulated petitions that demanded all further criminal proceedings involving the Attica Rebellion be immediately ceased, and they held marches throughout Buffalo and the nation on a regular basis. 22. One march on Buffalo originated in a chartered bus leaving Pittsburgh, which cost travelers $10 round trip and culminated in speeches by Big Black, Haywood Burns, Angela Davis, and William Kunstler. 23. These marches, like an earlier one in Buffalo's Niagara Square, were lively with street theater and huge signs that read "Drop the charges now, stop the railroad, and free the Attica brothers." 24 In all the demonstrations there was a sense among participants that Hill and Pernisalis were facing political trials akin to those of the Panther 21 in New York, the Chicago 7, the Vietnam veterans against the war in Gainesville, FLA, Daniel Ellsberg in Los Angeles, Angela Davis in San Jose, California, and Bobby Seale in New Haven, Connecticut. 25 By bringing people out into the streets day after day, the people would make clear that they refused to accept these governmental attempts to continue this openly political use of courts and prisons, just as they refused to accept the government's fabrications. 26. This sort of street activism clearly unnerved Judge Gilbert King. Judge King, described by reporters as a round-faced man with pink cheeks and a pink-skinned bald dome, had no doubt that his courtroom's 42 spectator and press seats would be filled each day and, having the trial covered by the New York Times, the New York Post, a wire service, and one of Buffalo's two papers, the Evening News, might well lead to political theater. 27 The judge in charge of the Attica cases writ large, Carmen Ball, had already taken key steps to make sure this wouldn't happen, ordering tight security in the Erie County Courthouse and even authorizing the hiring of additional security personnel. 28 Anyone who caused a disruption during an Attica proceeding in front of Ball, including a young man who refused to lower his clenched fist in solidarity with the defendants, had been summarily removed from the courtroom. 29 Rumor had it that seats in the spectator section of the courtroom had been removed so that fewer supporters of the Attica brothers could attend. And, according to one such supporter who waited in line most of the morning and had finally gotten in when others left, ample distances between the rows of seats supported this theory. 30. Supporters of the Attica Brothers March, courtesy of David Fenton/Getty Images. The security measures at the Erie County Courthouse were equally unnerving to the many men and women who were summoned to room 301 as potential jurors. This level of security implied, not all that subtly, that the Attica defendants and their supporters were highly dangerous, not at all helpful for the defense team. Still, William Kunstler had always had remarkable success in front of juries, and he was confident that he could, with hard work, secure John Hill's acquittal in front of this one. Also, in part because Ramsey Clark felt it was a good idea, Kunstler was willing to work with the jury project in this case. Unpredictably, however, their willingness to use scientific jury selection techniques backfired. Although investigating potential jurors was not only legal, assuming they weren't harassed, intimidated, or threatened and weren't approached personally, and even though prosecutors also did this regularly, a potential juror told the judge that someone had called him to ask him questions about his views that might shape his objectivity in this case. This accusation halted the jury selection process, and the jury project members were flabbergasted by this claim, vigorously denied it, and believed that someone from the other side had impersonated them to derail their ability to shape the jury in Hill's and Pernisalis' favor. When the trial resumed, Kunstler decided to scrap use of the jury project when picking the remaining jurors. 31 In recognition of how biased the Erie County pool was likely to be, Judge King allowed the defense 10 more peremptory challenges than the prosecution. The prosecution appealed this decision, however, and these extra challenges disappeared. 32 On February 21, 1975, the jury was sworn in with only 2 African American members. The trial began in earnest on February 24. Both men would stand trial together, but the lawyers for each defendant would handle things in their own way. Kunstler was guided by one major premise throughout the trial of his client, whom he called DAC in honor of his chosen Indian name, Dakajwiat. The jury must hear as much evidence as possible about the state's ugly actions at Attica rather than focusing exclusively on the he said of the chaotic events leading to William Quinn's death. This was little surprise to anyone who knew William Kunstler, since every one of the cases he had taken on in recent years had been very much a political case, and each time he mounted his defense accordingly. However, Kunstler's plan to politicize this case did not sit well with some on Pernisalis' defense team, namely Herman Schwartz, who had been battling fellow Attica lawyers for years now on this very issue of whether politics had any place in the courtroom. Schwartz believed Kunstler was about to make a dreadful mistake, because they already had a hostile judge, and this would further prejudice the judge and the upstate jury against both defendants. Whatever the jury thought of Hill and his attorney, he worried, they would also think of Charlie Joe. Ramsey Clark also agreed that it shouldn't be a political case, but he felt it was Kunstler's call as to how to handle his own client's defense. Upset, Schwartz tried to have himself dismissed from the case, but the judge wouldn't allow it. 33. Noting Schwartz's objections, Kunstler proceeded with his plan to bring before the jury examples of trooper brutality, investigator incompetence, and outrageous actions on the part of high-ranking state officials. Kunstler tried to subpoena Nelson Rockefeller himself so that he could tell the jury the Attica story from the top down rather than from the bottom up. Ramsey Clark agreed that having the jury hear directly from Rockefeller might be helpful to both of their cases, particularly since the governor had repeatedly claimed that Quinn had died from being thrown from a second-story window. This would at the very least make it clear that even state officials couldn't get their stories straight regarding what had led to Quinn's death. Judge King refused to grant this subpoena, going on record that he simply would not allow any evidence having to do with the state's actions at Attica to be introduced into the trial proceedings. The state was not on trial, King admonished the defense. And yet, from Kunstler's point of view, it was not just rhetorically or polemically, but literally. One key argument that he had hoped to make before the jury was that William Quinn's death, though clearly due to the head trauma he had suffered on the first day of the Attica Uprising, would have been entirely preventable had the state not been so negligent in giving him care. It had taken an inordinate amount of time for state officials to move him from the prison to the hospital, even with prisoners begging them to come get him off the mattress and to medical care. And once hospitalized, he had received slipshod care. He had never been moved to intensive care. 34. Early in the trial it was clear that King wouldn't budge on this matter, or allow any other tack that Kunstler tried. No sooner had King decided against the Rockefeller subpoena than Kunstler asked him to address a more immediate issue. Kunstler felt that the defendants and the prisoners who had agreed to testify on behalf of the defense were being threatened and intimidated by the many law enforcement personnel the judge had positioned around his courtroom, making the defense's job hard to do effectively. These tactics were of an immoral and illegal nature, Kunstler asserted, and their effect on defense preparation had been disastrous. 35. Kunstler argued that King needed to arrange for all of the defense witnesses to receive protection as they were ferried to and from the courtroom each day. King denied this motion, too. As young ABLD attorney Elizabeth Fink saw it, this was actually a very significant loss in the courtroom. She was helping the defense behind the scenes, and when she had recently visited Charlie Joe Pernisalis in the Erie County Jail, it was obvious to her that he had been badly beaten up. He confirmed that he had been hit in the jaw and then choked to unconsciousness by a jailer. Pernisalis's condition was so bad that Fink had immediately demanded an examination by an outside doctor, who confirmed that he had been seriously assaulted. The doctor for the jail, however, took exception to this physician's characterization of Pernisalis's injuries. Judge King remained unmoved when this matter was brought before him. In fact, he chastised Charlie Joe for the assault he suffered, saying, "You precipitated this incident in the jail by your refusal to follow the normal and accepted procedures that are in force. The ultimate problem lies with you." 36. The defense couldn't have been too surprised by King's lack of sympathy for them. Following a possible security breach a year earlier, the ABLD had enlisted technicians from the Spy Shop, an organization experienced in the means of electronic surveillance, to see if they should be concerned. 37. These technicians agreed to sign affidavits on behalf of the ABLD indicating that it did appear that their members had been under surveillance by an outside party. Eventually, on February 7, 1975, State Supreme Court Justice James Moore agreed to order an investigation into this possible wiretapping of the ABLD phones. He wrote, "Any intrusion by the government upon the confidential relationship between the defendants in these indictments and their counsel would certainly taint the further proceedings to be had herein." 38. Meanwhile, Simonetti's office filed its own affidavit categorically denying any involvement with the FBI in such illegal acts, saying that the people have no knowledge or information concerning any such hypothetical electronic surveillance. In particular, the people have no knowledge or Information concerning any electronic surveillance regarding any telephone instrument of the Attica Legal Defense Group. 39 Then, essentially, nothing happened. The Attorney General's office didn't even investigate whether or not any eavesdropping warrants were issued by any court. 40 Kunstler filed a motion before Judge King hoping that he would hold his own evidentiary hearing on this matter, but that motion was also denied. 41. Recognizing that none of this boded well for his and Clark's chances in defending John Hill and Charlie Joe Pernisalis, Kunstler had also appealed to the judge for more time to prepare their defenses. We have one typewriter, Judge, and we have essentially one legal worker who does typing, who has a part-time job in the city, can only come in at certain times. That's the extent of our modest resources. 42 Again, Judge King stated flatly that this was not going to happen. 43 Time and again Kunstler had tried to get a favorable ruling from this judge and had failed, which, over time, led to some serious sparring between them. As one young man in the courtroom observing the trial put it, the trial often seemed to consist primarily of a conflict between Kunstler and Judge Gilbert H. King, particularly over the range of permissible evidence. And Kunstler repeatedly questioned the integrity of the judge and the fairness of the trial. 44. Meanwhile, and with tensions clearly running high between Judge Gilbert King and William Kunstler, the state had begun arguing its case on February 24, 1975. In short, Simonetti's office hoped to prove that Mr. Hill had struck Officer Quinn twice with a wooden object, once while the officer was still standing and once as he lay on the floor, and intended to prove that Mr. Pernisalis had also hit the officer as he lay on the floor. 45 To that end, Louis Attica had lined up a total of 18 witnesses, although he planned to rely on the testimony of 5 or fewer prisoners and 1 correction officer. 46 The others, including 2 more correction officers, might be needed, but since none of them said they had actually seen either of the defendants hit Quinn, their usefulness was questionable. 47. The witnesses Louis Attica had hoped would make his case most strongly had all said, at some point in the last 4 years, that they could place Hill and Pernisalis near Quinn. First, the jury heard from prisoner witness William Rivers that he saw Hill striking Quinn in the head 2 or 3 times. 48 A week later, Robert Kopech came before the jury, which eagerly listened as he repeated what he had told state investigators in February 1972. That John Hill had actually said to him that he thought he killed a correction officer that morning in Times Square, because as he was hitting him with a club, he just lost his mind and kept hitting him until blood came out of his eyes, ears, and mouth. 49 Attica felt that the state's best witness was Edward Zimmer. He knew from Zimmer's original testimony before the grand jury that he said he had seen Hill hit William Quinn, and also he claimed to have seen him holding a weapon that was consistent with the injuries Quinn's autopsy indicated had been fatal. As he had testified then, he had seen John Hill with a 2x4 strike Mr. Quinn in the upper part of his body. Not in the face. Just below his face, sort of across his chest. Then I saw John strike Mr. Quinn again, only this time it was in the face, I can't remember which side. 50 As important, Zimmer had also said then that he had seen Pernisalis, whom he referred to as Chuck, at the scene of the assault. As he stated, John, Chuck, Mario, and the black inmates that I know, and the other ones that I don't know, were all kicking and beating the officers after they were already down on the floor. 51 More specifically, he went on, I seen Chuck with a nightstick hit Mr. Quinn, it looked like on the back of the shoulder or across his head. And he didn't move after that. 52. Attica hoped that if this jury could just hear testimony from witnesses like Zimmer, his case would be won, particularly since he knew that the testimony he was going to get from the COS who had been in Times Square during Quinn's assault was problematic. They all were willing to say that Hill and Pernisalis had been Quinn's key assailants eventually, but they hadn't always said this, and Attica couldn't be sure that the defense wouldn't bring this fact to the jury's attention. However, Attica wasn't about to let his whole case hinge on the jury's believing the stories any of his witnesses told. He needed to appeal to the jurors' emotions, needed to make clear to them just how brutal the assault on Quinn had been. After bringing all of his people's testimony before the jury, he called Monroe County pathologist Dr. John Edland as his very last witness. 53 There was a certain irony in the fact that Louis Attica now hoped to benefit from the testimony of a man whom his higher ups in the Rockefeller administration had worked so hard to discredit. But calling Dr. Edland made sense given that Attica wanted graphic testimony. Dutifully the Me took the stand and, accompanied by horrifying images that the state had entered as exhibits, reported how William Quinn had suffered from massive bleeding in his stomach, as well as fluid in his lungs. His eyes had also hemorrhaged. Ultimately, he died from fractures to his skull caused by 1 or 2 blows to the forehead. 54 Attica could see that he had indeed impressed upon the jury how terrible this attack on Quinn had been. To a one they looked sickened and appalled. Once the defense began its cross-examination of witnesses, however, the prosecution began to run into some trouble. Kunstler and Clark discredited almost every witness that Attica had called to the stand. Their questioning of prisoner witness William Rivers revealed that he thought he might be transferred, paroled, or even released if he cooperated. 55 More devastatingly, cross-examination of the prosecution's star prisoner witness, Edward Zimmer, revealed that he actually had stated initially to investigators, before they brought him to testify to the grand jury, that he had seen a black man hurting Quinn, a black man who had been kicking him in the face. Later, however, when they asked more about that black man, Zimmer couldn't remember any clear details about what he saw because, he explained to them, it happened 3 years ago, I can't remember everything that happened. 56 Kunstler noted wryly to the jurors that it was remarkable how so very recently Zimmer couldn't remember a single useful detail about who did what on the day of Quinn's beating, and now, suddenly in this trial, he could remember that well. 57 He continued, pulling no punches. Zimmer probably did originally see someone kick Quinn in the face, perhaps even a black man, but this wasn't what the prosecution wanted him to have seen. A kick could not have caused the injuries the prosecution claimed caused his death, and neither of the men the state had indicted were black. And so, Kunstler went on, not only did the assailant suddenly change, but so did the place where Zimmer had seen that assailant's blow land. 58 What is more, he pointed out to the jury, the prosecution's Bobbsey twins Zimmer and Rivers were so helpful in no small part because these guys had been locked in adjoining cells after the rebellion where they could converse after being interviewed by state investigators, and then were bunked together in the Erie County Jail as well as kept at the same motel while prepped for a trial. According to Kunstler, they were a package deal because the state needed both men to support each other's flawed testimony. 59 And, as Attica had feared, Kunstler also made sure to zero in on the limitations of the state's correction officer witnesses. C.O. Royal Morgan fingered Hill when he took the stand in this trial, and yet, on the day after the rebellion started, mere hours after the assault on Quinn actually had taken place, this then 24-year-old C.O. had made clear to the state's investigators that he had been hit badly, things were very fuzzy, and he didn't know who had hurt his friend. Indeed, when he came upon Quinn, not only was he disoriented and bleeding, but Quinn was already badly injured. At that point Morgan had tried, with the help of Mariano Dallo Gonzalez and another prisoner, to get Quinn onto a mattress and to safety. 60 Not only had Morgan made no mention of who had hit Quinn in his original statement to state investigators, but when investigators expressly asked him at any time during this incident, the entire incident, did you overhear any inmate or any person state who had assaulted Officer Quinn, he had answered with a categorical no, I didn't. All I heard is that there was an officer that was real bad off and for me to help him, and this was when I noticed Quinn on the floor. 61 Yet when this same CO was interviewed again by Simonetti's office later in preparation for the trial, this time he picked Hill's picture from a series of 3 identification books. 62 Kunstler also directed the jury's attention to the testimony of Gordon Kelsey, a correction officer who had been in Times Square with William Quinn when the rebellion began. He too had not identified Quinn's assailants when asked by an investigator right after the retaking. He had answered the question, "Did you observe anyone assaulting Mr. Quinn?" with a reply that he did see him go down, but as to who it was, "I couldn't tell you. Like I said, there was many of them." 63 He had elaborated, they all had their hands in on everything and a lot of hollering and yelling, but as far as who it was, I couldn't say 64 then. Months later, however, Kelsey changed his tune, telling investigators that he thought it was a white guy who hit Quinn with a 2x4. Still later, he agreed with prosecutors that the assailant was John Hill, a young man with a noticeably light brown complexion, that had struck Quinn. And that wasn't the end of the waffling. Indeed, according to the state's own records, Kelsey later retracted the identification of John Hill, because inmate Hill did not have a brush cut and he felt the inmate striking Quinn had a brush cut 65 by trial, though, Kelsey was once again willing to say he had seen Hill deal Quinn a fatal blow. As Kunstler said to the jury, "Of course he is sure, because that's the state's story." 66. To further cast doubt on the credibility of the prosecution's case against Hill and Pernisalis, the defense called its own CO witness to the stand, a man named Alton Tolbert. Tolbert's testimony was important because although he had claimed to have seen Quinn's killing back in 1971 when interviewed by the BCI, when pushed by the defense, he now admitted that he had lied to state troopers in 1971 when he volunteered his account because he wanted to be transferred to a closer prison. 67 He confessed he had made up the story, to ingratiate himself with his superiors and possibly obtain a transfer from Attica. 68 2 months after the Attica uprising, Mr. Tolbert had indeed been transferred to Elmira, his hometown. 69 According to reporters covering the trial, when coming clean on the stand, Alton Tolbert appeared embarrassed and meek, particularly when he admitted that, in fact, he had not seen Mr. Quinn at all on the morning of September 9, 1971. 70 Even though he had claimed to have seen Quinn being hit with a shovel, this was a complete fabrication. 71. The defense's own prisoner witnesses dealt even more blows to the state's case. One prisoner by the name of Everett Burkett, whom Kunstler pointed out had come forward to tell his story without inducement or promises, was positioned as quite a heroic figure because this short, stocky 27-year-old with a Van Dyke beard might well experience some form of retaliation from the state for cooperating with the defense, perhaps having his parole revoked, and yet still agreed to testify for one reason and one reason only: he knew that John Hill could not possibly have killed William Quinn because Hill had been with Burkett the entire morning that first day of the rebellion. Burkett stated firmly, in that time he had never seen the defendant hit anyone. 72. Not only did the defense argue, via Burkett, that Hill couldn't have killed William Quinn, it also wanted to show the jury that there were in fact legitimate witnesses to Quinn's beating and none of them had identified either Hill or Pernisalis as the perpetrators. Defense witness Charles Raymond Kratzley testified that he had been right there when Quinn was hit, and he described in graphic detail how one man had landed a blow on the forehead. Even though he wasn't sure who that man had been, he said without equivocation that it was neither one of the defendants in this case. This man, a white witness the press noted, struck most observers as a more believable figure than the state's various witnesses had been. As one reporter put it, this witness contrasted sharply with the prosecution's former inmate witnesses. 73 Unlike them, this man had received no deals to come and testify, even though he now had a very menial job working as a dishwasher in a restaurant in Rochester. 74 Kunstler made sure the jury knew that Kratzley had been given nothing but a hotel room and $40 to get himself to the court to testify. As important, he was risking humiliation on the stand because of his low IQ and because he had been originally imprisoned on a rape charge, and yet he still came. 75. In addition to Kratzley, the defense called two other witnesses who had also identified completely different men, neither Hill nor Pernisalis, as the ones who had fatally beaten Quinn. Kunstler pointed out to jurors that Simonetti's office had been well aware that these men existed, and that they would have told the grand jury this very different version of events had they been called. That they were not called, Kunstler suggested, was deeply unethical. The eyewitness testimony of prisoner Melvin Marshall would have been a problem for the state's case, so the prosecution did not allow him to testify. He saw Mr. Quinn. He saw him hit on the head by what he thought was a 2x4 or a baseball bat, but the person he saw was a black person. 76 How certain was Marshall about whom he saw? Well, Kunstler pointed out, he was close enough to see Quinn suffer tremendous bleeding after that hit, but also close enough to yell at the assailant, "For Christ's sake, don't kill him," which did in fact make him stop. 77 The second witness, Joseph Nance, was even more specific that it couldn't have been Hill or Pernisalis who killed Quinn. This prisoner not only insisted that he saw who beat Quinn, but he had been denied early parole despite his stellar record because he hadn't been willing to say it was Hill. As Kunstler noted, he saw the wrong people, he didn't see the people they wanted to be seen, so Mr. Nance never got any of these nice benefits. Pushing the point harder, Kunstler went on, why would he lie? He doesn't know John Hill, what is the motivation for this man? 78. Both Kunstler and Clark felt that they had put forward a strong defense of their clients. Clark had, like Kunstler, systematically questioned witnesses in such a way that the light shining through the holes in their testimony was bright indeed. It was challenging to defend two different people in the same trial, but it had been surprisingly easy to show just how weak the state's witnesses were. Both attorneys were so confident that the prosecution had been unethical in its efforts to build a case against their clients that they were eager to file motions to dismiss the case before it was time for closing arguments. Arguing his motion with great passion, at times almost yelling, Kunstler said that what has taken place in this court since the case began on a regular daily basis has been nothing short of rank perjury. 79 Not just correction officers had perjured themselves, he suggested, but shaking his head he said bluntly, I think, Your Honor, what you have in this case throughout, is the fine details planted in witnesses by the state, in what I consider, a totally fraudulent prosecution in order to have somebody answer for Mr. Quinn's death. 80. Clark's motion to dismiss charges delivered less dramatically also argued that the state had no credible evidence and that this lack of evidence suggested Charlie Joe Pernisalis should go free immediately. 81 Clark declared in wonder, I have to say that I have never in 24 years now at the bar, seen any office of prosecution submit on a charge of murder such inconsequential, insubstantial, and insupportable evidence. And I implore you to end this anxiety now and dismiss charges as to Mr. Pernisalis. 82 Clark reminded the jury that only one man claimed to have witnessed Pernisalis commit a violent act against William Quinn and only one other claimed to have even seen him in the area, but neither of these witnesses were at all credible. Two witnesses contradicted each other. Edward Zimmer's testimony that he had seen Pernisalis strike Quinn over the shoulders with a stick didn't fit with Dr. John Edland's statements that Quinn had had no injuries to his shoulders and, even if he had taken such a blow, it would have had nothing to do with Quinn's death. 83 Clark called Zimmer's by far the vaguest, most contradictory, and the most inherently impossible or incredible testimony in the entire trial. Tom Collins, another prisoner witness who placed Pernisalis on the scene, not only then admitted that he hadn't met Pernisalis until the 10th or 11th of September, but also acknowledged that he hadn't even been in Times Square when the fatal beating took place. 84 Summing up, Clark concluded his argument, there is no believable evidence to find Charlie Joe Pernisalis guilty of any offense other than being an inmate of Attica on September 9, 1971. 85 What is more, he went on to say to the judge, I am personally so distressed that this young man would be kept living in this staggering anxiety for 3 years, by the state of New York, on evidence so clearly inadequate. 86. Judge Gilbert King declined to grant either of the defense's motions. 87 King did not explain his ruling, but did chastise Kunstler for using this trial to try to focus attention on the wrongdoings of the state. As I have repeatedly held, he said, we are not here to try prison life in Attica. 88 When dismissing Clark's motion he was a bit less caustic. While he would not dismiss the charges against Pernisalis, he conceded that he would reserve the right to revisit this motion, and perhaps consider a lesser charge in the future. 89 And indeed, right before the jury left to deliberate, Judge King did dismiss the murder charge against Pernisalis and asked the jury instead to rule on whether he was guilty of second-degree assault and attempted murder. This didn't appease Clark, however. In his view the lesser charge totally missed the point that there was no evidence that Pernisalis had caused Quinn any injury whatsoever. 90. Clark would try to make this same point again in his closing remarks. He used his last opportunity to speak to the jury to highlight the same weaknesses in the state's case that he had laid out in his motion to dismiss. 91 On March 31, 1975, Ramsey Clark walked the jury through the little testimony that the state had presented against his client and then systematically noted the specific flaws in that testimony. Only 2 witnesses placed his client at the scene and only one of these claimed to have seen him commit an act of violence. Neither witness could possibly have seen what he said he did. 92 The jury must now, Clark implored, set his client free. In contrast to Ramsey Clark's subdued and relatively short summation, William Kunstler's dramatic closing remarks lasted 7 hours and unfolded over the course of 2 days. 93 Deeply frustrated, Kunstler felt that he had tried time and again in this trial to bring in testimony that would have directly helped his client that the judge simply refused to allow. He believed to his core that the state's actions at Attica, and the testimony of the governor himself, were not only relevant in this trial, but would have persuaded the jury that there was more than a reasonable doubt that John Hill caused William Quinn to die. Trying to contain that frustration, he, like Clark, painstakingly walked the jury through the testimony that it had heard, pointing out the myriad places when the witnesses' stories did not add up and the various reasons why jurors should consider a given witness's testimony to be unreliable because they had been incentivized to give the specific details. He noted with some bitterness that every witness the prosecution brought forward had shown a better memory now at this trial than they had 3.5 months earlier at the Wade hearing. 94 Kunstler conceded that one of the correction officer witnesses had himself been traumatized by all that he experienced during the Attica Uprising and he confided, "I thought he was troubled." 95 But that alone should have been reason to doubt his testimony. Kunstler also reiterated his argument that the entire court proceeding had been set up to suggest to jurors that his client was a scary person who needed convicting. As he pointed out, the jury was escorted by armed guards and, worse, the judge had made what Kunstler regarded as openly prejudicial remarks to that jury, that, if they were threatened or in any way impeded, they were to report it to the judge, to give the jury the idea that they might be imperiled or jeopardized or intimidated by these people. 96 This was absurd, Kunstler insisted. John Hill and Charlie Joe Pernisalis had been among the weakest and most vulnerable possible suspects and that, he suggested, was why the prosecution settled on them as the perpetrators. 97 You are sitting in a moment of history, he impressed upon the jurors, imploring them to do the right thing by acquitting his client. 98 In the state of New York, the prosecution gets the last word in a criminal case. So Louis Attica, his voice frequently rising to a shout, had the chance to speak to the jury after both Clark and Kunstler. 99 It was incredible, he insisted, that the defense was trying to discredit witnesses who had, under oath, clearly identified both John Hill and Charles Pernisalis as the killers of Billy Quinn. Regarding the fact that one of his witnesses gave vague testimony regarding the physical characteristics of Quinn's assailant, the best described feature was that he had slanty eyes, a point Kunstler had made much of. Attica scoffed. The prosecutor asked jurors to consider whether this description was in fact vague at all. 100 Ask yourself, he went on, how many of those prisoners may have had slanty eyes? That will tell you just how many inmates could have committed this crime. 101 He stressed also that he had brought 5 men to court who claimed they had seen Quinn hit by the defendants. Despite evidence that at least 4 of them had been offered a sweeter deal if they gave the specific evidence that they did, Attica continued to maintain that there were no promises made to the witnesses. 102 Regardless of the controversy surrounding the testimony of those witnesses, Attica ultimately chose to spend little time defending their credibility in his closing remarks. Instead, he sought to win the case emotionally, focusing the jury's attention primarily, and often graphically, on all William Quinn had endured on the morning of September 9, 1971. As the media noted, often in the course of his remarks, Mr. Attica showed the jury photographs of Mr. Quinn taken after his death, and of Mr. Quinn's brain, to remind everyone why they were there in court and of the magnitude of the crime for which he now sought justice. 103 At one point in his summation, Attica's finger shot out, pointing at John Hill, while the prosecutor shouted that this prisoner had literally tore away his human brain. 104 Looking over at the defense table with disgust, he said, I wonder if Mr. Kunstler ever once shed a tear for the wife of Mr. Quinn. 105. Once the arguments for Hill's and Pernazalist's innocence and guilt concluded, the jury shuffled out of the courtroom for lengthy deliberations, 25 hours in total. As they left, the defendants and defense attorneys felt optimistic, especially when the 4 alternate jurors exchanged power handshakes with the defendants before leaving the courtroom, and one of them, a 25-year-old postal worker, was actually heard saying, "I would acquit both." 106. As the hours dragged on, the defense felt even more hardened. Usually lengthy deliberations were an indication of a close vote favoring acquittal. 107. Surely, the jury would see this whole sordid picture and do the right thing. As John Hill remembered it years later, "I really thought that there was a good chance of acquittal, they had no evidence. Even Newsweek said that." 108. The crowds outside the prison still rallying and protesting on behalf of the defendants weren't quite so confident of the trial's outcome, but, for that matter, neither were the scores of police also flanking the courthouse. The result was much tension in the air. Earlier that morning the police had ordered one rally outside the courthouse to disperse, which had resulted in a confrontation and some arrests. 109. During the closing arguments about 400 more people came to demonstrate outside the courtroom and 5 were arrested. John Hill, who remained free on bond during the trial, had grabbed a bullhorn during a recess and implored the demonstrators to heed the directions of the police. 110. Feeling that his chances for acquittal were looking pretty good, it made him nervous to think that clashes between his supporters and the police might now turn jurors against him. On April 6, 1975, the jury finally reached its verdict. 111-1. The spectators had grown deathly quiet. The jury, 4 women, one of 2 blacks on the panel, announced solemnly that John Hill had been found guilty of murder and Charles Joe Pernisalis had been found guilty of second-degree attempted assault. 112. As the defendants stared numbly at the jury, John Hill's pregnant wife sobbed and the crowded courtroom briefly erupted into pandemonium. 113. When Justice King then ordered sheriff's deputies to handcuff the defendants, and jail them, the crowd exploded. 114. As utter chaos enveloped the courtroom, William Kunstler jumped to his feet demanding to know why they were being remanded before sentencing when real criminals like Watergate's John Mitchell hadn't been, and the crowd roared its agreement. Meanwhile Judge King was shouting for order in his court. It took several hours to clear the courtroom, and long after that ABLD supporters still filled the lawn outside, some in tears, all with a deep sense of foreboding about the many cases still left to go to trial. Charles Pernisalis, with hand at mouth, left, and John Hill, right foreground with feathers in hair, and supporters on April 5, 1975, the day before the verdicts were delivered in their trial for the death of guard William Quinn, courtesy of the Associated Press. This verdict had stunned, and it seemed a very bad omen for the scores of men who still awaited trial. 115. If the state's case had been this week against John Hill so full of contradictions, bribes, and lack of concrete evidence, and yet prosecutors could still manage to send this man to prison, possibly for life, then how little evidence would they need to make the rest of the Attica defendants languish in prison for the rest of their lives as well? This jury had, in fact, been divided as to whether John Hill and Charlie Joe Pernisalis had caused the death of William Quinn. As the first juror who spoke to a reporter explained it, in the first poll the 8 men and 4 women divided roughly in half on the question of whether the defendants had struck William E. Quinn. 116. This particular juror was himself conflicted. "I felt sorry for the family of Mr. Hill," he explained, "but I also felt sorry for the family of Mr. Quinn. It's not something I'll forget for a long time." 117. Undoubtedly it had mattered to this jury that its members had never felt any real connection to the defendants. The media also had not taken particularly well to them, although they liked Pernisalis far more than Hill. One paper published typical descriptions. Charles Pernisalis was someone who smiles a lot and wears a bell on his belt that tinkles when he gets up, as he frequently does, to whisper a suggestion to a defense lawyer, while John Hill was characterized as a man who seldom moves from his seat facing the jury, and often slumps forward on his elbows over the defense table in a posture of boredom. His face is almost invariably set in an expression of discontent. 118. It wasn't that the media or jury particularly liked Charlie Joe either, though. Indeed, Pernisalis often tried the patience of the court, coming into court late. 119 When he was late for yet another appearance one morning, Judge King angrily threatened to revoke his bail. Former ABLD coordinator Don Jelinek also felt that these defendants were not respectful enough in the court and, in his view, did not pay proper homage to the victim. 120 Jelinek feared their hippie-like style alone may have turned off working-class jurors from small towns across Erie County. 121. Others speculated that some of the jurors were put off by Kunstler's litigation style. Of course, Attica was a yeller too, and whenever there was a conflict he and Kunstler would both be shouting at each other simultaneously. 122 But somehow Kunstler didn't get the same pass for his bombastic style that Attica did, undoubtedly because he, unlike Attica, was known as a Marxist lawyer, and because Kunstler wasn't at all shy about challenging Judge King if he felt that Hill wasn't getting a fair shake. At one point in the trial, when Kunstler was trying to make a case that his client had been selectively prosecuted, for example, this discussion got derailed into a debate between him and Judge King over whether the United States was a great country or totalitarian in nature. 123 As one reporter put it, showman Kunstler could not resist the temptation to flay witnesses and have a go at State Supreme Court Justice Gilbert H. King. King was clearly hostile to Kunstler as well every time he tried to present a motion or mount a defense of his client that the judge disapproved of. Ultimately, however, it can be argued that the jury had not voted to convict on the evidence before them, and thus, probably no lawyer, even one meeker and less of a radical than Kunstler, could have won acquittals. Someone needed to pay for William Quinn's death. The defense team hoped that they still had a chance to do right by their clients at sentencing. First, they tried to vacate the jury verdicts altogether by arguing that there had been selective prosecution of their clients and, as important, because the defense had just learned that a sheriff's deputy, on duty in the courtroom, had told a radio news reporter early in the trial that 4 or 5 jurors had indicated to him that they were ready to convict even before they were empaneled. 124 Although this motion was not successful, it did delay sentencing and it gave time for the defendants to prepare arguments so that King might show some mercy in this phase of their case. John Hill spoke before the judge on May 8, 1975. But when he began his speech, the frustration and anger that he felt for having been reimprisoned overwhelmed him. First, he accused the jury of racism and of never thinking about the scores of people murdered by the state or the 14 million Indian peoples who have been killed in the 19th century. 125 The real criminals, Hill continued, were in Vietnam and they killed students at Kent State. Then he read a prayer for the Lakota Sioux. 126 Before finishing his speech, Hill said passionately, "I just want to tell my people that we will win, we will overcome everything," and then he embraced Kunstler. 127. Judge King was clearly displeased with John Hill and sentenced him to 20 years to life. As King levied Hill's sentence, he looked at him coldly and said that William Quinn had a right to continue his life to whatever end it came to. He had a right to continue his life as a husband and a father, and, the judge continued, Hill had taken it upon himself to make certain he would live no more. 128 Thereafter Hill was removed from the courtroom and taken directly to prison to begin his time. Since he would now be forever branded as Quinn's killer, Judge King decided that he shouldn't go back to Attica and sent him instead to Green Haven. 129. The afternoon's sentencing hearing for Charlie Joe Pernisalis went much better than Hill's, but not as well as Clark had hoped. For some time Clark argued hard before King that his client should be given probation since there was no evidence whatsoever that he had assaulted Quinn. 130 As important, he argued, this was a young man with a future if the judge could just see his way to being lenient. As he put it to King, "I love this young man, I believe in him. I believe he has enormous worth and potential, and I see in him a world of chance, necessity, and free will being cruel to him." 131 Further, he went on, "I believe he can attend Syracuse University in the fall." 132 While the judge was not willing to forego sentencing Pernisalis entirely, he did give him a relatively light indeterminate sentence not to exceed 2 years. 133 He then realized that, because of the wording of the Penal Code, an indeterminate sentence had to be for 3 years. 134 After the sentencing, the full weight of this trial loss hit the ABLD. Even though Herman Schwartz was often at odds with the ABLD and its lawyers, he recalled that the night the verdict came in was one of the bleakest nights I can remember. It was snowing and we went to have supper. The only time I ever saw Ramsey snap at me. We were very tense. We came back to the dimly lit courtroom. It was awful. Guilty of murder. Wails of grief at the courtroom. Michael Deutsch also remembers that moment as a terrible blow to the Attica brothers and the seeming good fortune they had had thus far defending themselves from state prosecutors. 135. Simonetti's office was as elated as the ABLD was distressed. It had, until now, had a rough go of it in the courtroom with 2 major losses and then, recently behind the scenes, having had to drop charges against another 13 prisoners for insufficient evidence. 136. As one reporter noted, with this victory, Attica and other prosecutors made no attempt to hide their satisfaction. 137. Now that they had succeeded in sending John Hill and Charlie Joe Pernisalis away for the murder of William Quinn, they were ready to turn their attention to the case of Attica brother Bernard Strobel, aka Shango. They were prepared to argue that he had brutally murdered fellow prisoner Barry Schwartz in cold blood and, as with Hill and Pernisalis, their goal was to make him pay. 40. Evening the score. Simonetti's office was delighted to learn that Shango's trial for the murder of fellow prisoner Barry Schwartz would be right after the Hill and Pernisalis win. They had been preparing for this case for several years now, relying heavily on the witness accounts netted by BCI investigators in the immediate aftermath of the Attica rebellion. They were now ready to get to it. It had been state troopers who had come across the bodies of Barry Schwartz, Kenneth Hess, and Michael Privitera up on a deserted tier of D Block back in 1971. At the time, they were disgusted, but they were also deeply relieved that these 3 ugly killings could not be tied to any state police or correction officers. Therefore, they worked hard to assist Simonetti's office in figuring out who had committed these heinous acts. These were by no means easy murders to solve, however. The problem the Attica investigators faced in these cases was, in key respects, the opposite of the one they had faced investigating Quinn's death. Quinn had been attacked in the midst of complete chaos, with hundreds of men on the scene and fists flying. However, on the day or days that Schwartz, Hess, and Privitera had been fatally attacked, it was unclear who had been there. As was also true in the Quinn case, however, prosecutors nevertheless forged ahead. By December of 1972 they had decided that several specific men had committed these murders and they were particularly interested in going after one of them, Bernard Strobel, aka Shango Bahati Kakawana. As one of the heads of rebellion security, along with Big Black, Shango was especially hated by the state troopers who had watched D-Yard for days. What is more, Shango was not likely to garner much juror sympathy. Unlike Hill or Pernisalis, Shango was neither really young, nor had he landed in prison on some juvenile charge or mere parole violation. This was a man who had been arrested in both 1957 and 1958 on felonious assault charges and then, years later, been accused of shooting 2 police officers in Detroit. 1 The officers had stopped Shango for a traffic violation that he had already paid, and he readily admitted that he had an altercation with them. According to Shango, though, the officers had overreacted when he went into his pocket to get his license and registration and they drew their guns. Acting in self-defense, he said, Shango in turn took out his own gun and began shooting them. 2. Shango wasn't apprehended at that time because he fled to Chicago in a cab and, from there, went on to New York. No sooner did he get to New York, though, than he got into another altercation with yet another man with a gun, shooting him in the head during a quarrel in a Bronx pool hall. 3 After this shooting, Shango was finally arrested, but not before setting fire to his own apartment to distract the police in the hope that he would get away once more. Eventually Shango was sentenced to 20 to 30 years in prison for manslaughter in New York after first being sent back to Detroit to stand trial there. The deal was that he would serve his New York time at Attica, and then do his time in Michigan. 4. Shango had lived life as a tough guy by his own admission. He hadn't always been a good man, but by the time he stood trial for Schwartz's murder, he was both demoralized and chastened. The sheer brutality he had seen in D-Yard had affected him profoundly, making him both more cynical and in some ways more humble than he had been before. He had been singled out for particularly brutal treatment during the retaking. As he remembered, he had unsuccessfully tried to dodge a fuselage sick of bullets pouring down from every direction, and was struck 3 times. 5 The first bullet entered his buttocks and travelled 12 inches up his back to within a hairbreadth of his spine. 2 more bullets ripped open his hands. With blood pouring from his wounds he lay still, while all around him he heard screams, infinite screams. 6. He could barely fathom the pain, so unreasonably excruciating. 7 Through the raindrops falling into his eyes he could see the countless number of blood-drenched bodies being carried away. 8 Suddenly a trooper screamed at Shango, "Get up, nigger," but he could only move his arms and the upper part of his body. The trooper demanded that he move towards the block crawl. Shango couldn't do that either. He tried to drag his own body toward a block, getting hundreds of tiny cuts as he inched along through blood, glass, dirt, and spit until they told me to stop. 9. In time Shango was thrown into a cell, the floor already slick with blood from the men who had been beaten and forced into cells before him. 10 Then began the torture. One of them set a small piece of paper on fire and threw it at me. I brushed it off, to which another trooper responded, "Don't burn the nigger. Here, let me put out the fire," and thereupon threw a cup of liquid mixed with filth on me. It smelled like piss and spit. 11 Later another officer flipped a cigarette butt at him saying, "Wake up, nigger, we've come to kill you, you ready to die black cocksucker," and then lifted his gun, cocked the trigger, and aimed it at Shango. 12 With sadistic enjoyment he said, after clicking the gun once, "I got 1 bullet in here, nigger, now beg. Beg like a nigger. Beg." 13. Eventually Shango began to heal, although he was kept in segregation in HBZ along with every other man the state had singled out as leaders of the rebellion. Ultimately, the grand jury named him in 5 separate indictments. By 1975, Shango was facing a life sentence plus 59 years for first-degree kidnapping, 34 counts, 1 for each of the hostages, first-degree coercion, for Hess and Schwartz, unlawful imprisonment, for Hess and Schwartz, felony murder for Hess, felony murder for Schwartz, and first-degree murder for Schwartz. Because of the way that the state had grouped together the kidnapping indictments, Shango's first trial would focus solely on the kidnapping of Barry Schwartz and charge him as well with felony murder and outright murder for his death in D Block. In 1973, when he was indicted, Shango was transported to Buffalo to stand trial. 14. Shango couldn't believe he was being charged with this murder. He had indeed been patrolling D Block when the brutal killings of Barry Schwartz, Kenneth Hess, and Michael Privitera had taken place. He also thought he knew who had killed them, who had snapped and taken his frustration and paranoia out on helpless fellow prisoners whose worst offense had been talking to a reporter, Hess and Schwartz, and on the unstable Privitera. 15 But he, Shango vehemently maintained, hadn't killed anyone during the rebellion. He had little faith, however, that any jury would believe him. Although Shango originally had decided to represent himself, as the months wore on he began to grow nervous and decided to contact the ABLD. 16 Attorney Barbara Handshaw was assigned to handle his case. Meanwhile, then ABLD Director Don Jelinek took a trip to Detroit, Shango's hometown, that would secure him better counsel than he ever could have dreamed of. 17. Jelinek had taken this 1973 trip eager to persuade lawyers from the Motor City to come to upstate New York to help the ABLD. He particularly hoped to convince Bill Goodman, the son of the famous civil rights lawyer Ernie Goodman, to lend a hand. 18 Jelinek initially had another client in mind for Bill Goodman, but when that man's case was dismissed, he asked him to represent Shango instead. 19 Both Goodman and Jelinek recognized that, given the brutality of the crime he was accused of, Shango would need excellent representation. Accordingly, Bill Goodman decided to ask his father to be lead counsel on the case. 20. Ernie Goodman felt some trepidation. As an out-of-state lawyer, he was unlikely to receive any state funding for his investigation or litigation. Additionally, Goodman was unwilling to stay in a communal home with the decades younger ABLD workers, therefore he also would have the expense of a hotel room in Buffalo as well as that of the commute back to Detroit on weekends. 21 But after some deliberation, Ernie Goodman agreed to take the case. His firm, Goodman, Eden, Millender, Goodman and Bedrosian, decided to subsidize his efforts. Even better, Haywood Burns, the new director of the ABLD, agreed to help him as CO counsel. As important, when he finally met Shango, he was really taken with him. As Goodman described him, Shango was a tall, well-built, handsome man, who at the time wore a beard and a mustache which gave him an additional dignified appearance, and he had a certain dignity of both his personality and his posture. 22 Shango was also a forceful presence. On the first day they met, Shango informed Goodman that his name was no longer Bernard Strobel and insisted that all pleadings be changed accordingly. Shango also made clear to Goodman that he would play a central role in his own defense. He too would decide strategy. As Goodman later remarked, with Shango he had one of the most unusual relationships I've ever had with any client I have ever represented. 23 Ernie Goodman didn't know when he took the case that Shango had grown up in his hometown, but this fact would eventually prove helpful as they developed considerable community support in Detroit for his defense. 24. As a defense attorney, Goodman made it a practice never to ask a client whether they committed the crime for which they stood trial. This rule held true with Shango. 25 This was strategic. The less he knew, Goodman reasoned, the easier it would be to develop the defense more from outside sources, from objective evidence, from physical evidence. 26 However, Shango wasn't willing to let the question of his innocence linger between them. It was vitally important to him that Goodman know that he had not killed anyone during the rebellion. He wrote to Goodman vehemently asserting his innocence. I can only ask that you believe my innocence. Not as a matter of legal presumption, but as a matter of fact. I am in no way guilty of any murder at Attica. 27 In another letter he reiterated, I am not guilty of any murder, please believe me. 28 In yet another letter he explained why Goodman's faith in him mattered so much. I am a very good person, Ernie, this I know deep within. I want to prove myself badly, to all of those especially who think I am such a bad person. I have made some bad mistakes in my life, as we all have. But most of my mistakes have been recorded, which makes me look like such a terrible person. I want to deal with this image honestly and correctly and prove it to be wrong. I want to prove many things, but most of all I want to prove that I am a decent and good person. 29. Bernard Shango Strobel, second from right, returns to D-Yard with attorneys Ernie Goodman, Haywood Burns, and investigator Linda Burris. Photograph by Michael Lehman. Courtesy of William Goodman. In time it would become important to Shango not only that Ernie Goodman believed in his innocence, but also that they were friends as well as colleagues in this long battle that they faced together. After one of the many tense meetings they had debating trial strategy, Shango felt compelled to apologize to Goodman as well as to express his fondness for him. I do hope you understand that there was nothing personal or feelings of dissatisfaction with the work you're doing, he wrote. On the contrary, you have been a source of great inspiration, hope and strength to me. Please understand this. Without you, I'm sure this matter would be almost impossible to deal with. 30. Although there was certainly tension between Goodman and Shango regarding defense strategy, who should testify, which witnesses should be called, how much should be revealed and held in reserve on the most important matters, they agreed. They had spent some time early on discussing various possibilities for how to defend Shango, but after the terrible loss in the Hill and Pernis Alice trial, both men concurred that this defense would center on the legal particulars, not on the case's political implication. Still, Goodman's trial team devoted considerable energy to managing its public relations both inside the courtroom and out. The team wanted to avoid any perception of defense spectators as loud and disorderly, which the press portrayed as a lack of concern about the judicial proceedings. 31 So, for Shango's trial, the ABLD made a deliberate effort to work with various established community groups to bring black middle-class spectators into the courtroom. 32 Outside the courthouse, one young woman, Devon Hodges, was specifically tasked with sending out press releases and both monitoring as well as massaging the media. Hodges had been chair of the English department at George Mason University and so knew about communications. 33 She had expressed concern that she had neither the contacts nor the budget to forge a good relationship with the media, but was determined to make it happen on $12 a week and much mimeographing. She managed to send out a press release to 50 newspapers each week. 34 Perhaps the team's best public spokeswoman was Shango's own mother, known affectionately by all as Ma Strobel. She was a Baptist minister in Detroit, where she had developed a community center in the heart of the city that provided many social services, particularly for children. Both in Detroit and around Buffalo, she became a tireless advocate for her son and a regular presence at all court hearings, perhaps the single person who was respected and trusted by all the different factions. 35 She acknowledged that her son was no angel, as she phrased it, but she believed him when he said that he hadn't killed anyone at Attica, and was determined that he get a fair trial no matter his past. To that end, Shango's trial team, and specifically 5 law students from the University of Buffalo, devoted countless hours to researching the ins and outs of every charge he faced and how these charges might most effectively be countered. 36 For this team there were thousands of pages of witness statements and testimony to wade through in the hope that there were obvious contradictions or competing eyewitness accounts. The good news, one of the student researchers explained about these witnesses, was that we had the person's original criminal record, we had his grand jury testimony, and we had his Wade hearing testimony. We also had, for some of them, their original interviews with the state police. 37. It was also vital to make sure that the state's witnesses had not been in any way coerced, so the defense relied heavily on a lead investigator named Linda Burris. A member of the New York City branch of the National Lawyers Guild, Burris had come to Attica right after the retaking. She had seen the hate in troopers' eyes firsthand and had suspected that the state was determined to see the prisoners pay even more than they already had for their rebellion. Burris had been paying attention when Shango had initially contacted the ABLD for help, and she was one of the first to meet with him about the indictments he faced. At their first meeting, Burris was taken aback in equal measure by how handsome he was and how suspicious of everyone he seemed. Over the next several months, Burris eventually earned his trust and they fell in love with each other. When Ernie Goodman took on Shango's case, Burris offered to help in any way she could to prove his innocence. 38. The more investigative work that Linda did, the more Goodman became convinced of its value. As he saw it, one had to understand the whole uprising to put on a good defense. 39 There was no way to do this on any narrow basis of just ascertaining who had done what, but doing it more fully was clearly netting the defense dividends. 40 For starters, there seemed to be substantial evidence in this case, as there had been in Hills and Pernazelists, that the state's witnesses had been terrorized and coerced. As one state witness described his experience, the most persistent investigators had included Mild and Simonetti, and their initial approach was with how much time I had left to finish up my time, that both inmates and officers alike had praised my actions in helping everyone, how I deserved to be rewarded, how they could ensure me my upcoming parole, etc. They believed I could help them, it would be beneficial to me, etc. 41 This particular prisoner admitted that he was tempted by this offer. Especially after he was locked up in HBZ because I wasn't helping them. 42 He was even more tempted to tell them what they wanted to hear when he was sent to another facility, Wenda Correctional Facility, and when officers there told him that he was already on an execution list because prisoners there thought he had already cooperated with investigators. The prosecutors, he was told, could protect him if he helped them. So this man agreed to talk. But when he told them that he knew who had killed Schwartz, but that it wasn't Shango, an investigator told him bluntly that they were only interested in convicting Strobel, Champin, Dalu, Yomo, Frank Smith, and Blyden, precisely the men who were indicted for the murders of Schwartz, Hess, and Privitera. 43. Trying to nail down as much evidence of state bullying as possible, Goodman's team also wanted a Wade hearing, hoping it would clearly show that the witnesses' unlawful out-of-court identification of Shango was so unnecessarily suggestive as to amount to a denial of due process. 44 For 12 weeks, beginning January 6, 1975, and while the trials of Pernisalis and Hill were in progress, Wade hearings commenced for Shango and 4 other Attica brothers, Big Black, Herb Blyden, Roger Champin, and Yomo. 45 With so many defendants and so many defense attorneys as well as prosecutors jammed into his courtroom in Erie County, Judge Joseph Madina had a lot to contend with. By the time the Wade hearing ended, the transcript numbered 8,412 pages. The hearing itself took place in a nearly 100-year-old courtroom with no air conditioning. It was unseasonably hot in the room, and hostilities between the court employees and the defendants who arrived each day were palpable. Judge Madina was bombarded with stories of investigative impropriety. 46 State witness John Flowers told the court how Ernest Mild had questioned him sometimes for 8 hours a day, 5 days a week for months. 47 Each time they met, Flowers said, Mild pushed and pushed at him to name Shango and the other indictees as killers and made abundantly clear to him, as Flowers now testified, that if I had any information which was helpful to them, it possibly would be helpful to me. 48 Flowers told the court that Mild told me that they knew that Strobel and BB Big Black and Champ and brother Herb and Yomo had committed these murders. And that if I could give the information verifying this that it would be helpful when I went to the parole board, to show I was interested in helping the state. 49 These words were seductive for a man who wasn't due to get out of prison until at least 1988.50. Nonetheless, Flowers did not implicate any others, and he was kept locked indefinitely. 51 Flowers's terror was made worse by being unable to distinguish between state police investigators and Simonetti's staff investigators. To him they were all the same, and given all he had endured on the day of Attica's retaking back in 1971, he feared anyone connected to the New York State Police could really hurt him. 52 When he eventually did agree to testify for the state, Flowers was paroled. Many of the state's witnesses shared Flowers's experience. Time and again prisoners admitted that they had said what the state wanted to hear out of fear of prison authorities. 53 The defense lawyers were equally alarmed when they learned that the prosecution had also been exceedingly sloppy, if not outright negligent, in the way that it handled its photo identification process, and yet it was being allowed. As Ernie Goodman recalled, a well-drilled witness unhesitatingly identified the photo that a prosecutor handed to him as that of the accused Shango as he had looked on September 9 with no beard and a shaved head. 54 The problem for the prosecution was that when that lawyer perfunctorily handed that same photo to the defense so that it might be entered in as evidence, Goodman noted immediately that it wasn't Shango at all. The man in the photograph was actually Yomo. To the state, Goodman mused, all blacks apparently looked alike. 55 Further evidence presented at the Wade hearing indicated that the state had heard witness testimony that clearly pointed to someone other than whom they wanted to indict, but they never called these witnesses before the grand jury. At least 4 prisoner witnesses who testified at the Wade hearing indicated their belief that the death in question had not been caused by those who now stood accused of the crime, but rather had been at the hands of another prisoner altogether, Thomas Hicks. Hicks was the prisoner whose deep intellect had so impressed Attica's teachers back in 1971, and he was also the prisoner who Lieutenant Joe Christian claimed had attacked him as he was trying to rescue the hostages. The attack, he insisted, that prompted his fellow troopers to protect him by spraying that area with pellets and bullets. 56 In fact, one witness who was now willing to testify that Shango had killed Schwartz not only had initially told state investigator Ernest Mild that he had never seen Shango with any blood on him, but he had then testified at the Wade hearing that he had seen Tommy Hicks with a great deal of blood on him. 57 Similarly, another prisoner who was now going to testify against Shango admitted that, originally, he had told state investigators that he had seen Hicks with a knife in his right hand and 2 white hands grasping Hicks' hand, coming from the direction of the bed, and then he saw Hicks come to the doorway of the cell and wipe a knife or sharp instrument on his shirt or his pants. 58 A third prisoner agreed that he had seen Hicks, not Shango, with shears and blood on him, but he too was now going to be a state witness against Shango. 59 By the close of the Wade hearing, the defense attorneys were disgusted by all that they had heard. In their opinion, Francis Cryan, one of the 2 prosecutors from Simonetti's office in charge of this case, was simply dirty. 60 Goodman felt sure he had proved that the prosecution knew that other person or persons were responsible for that particular crime, and it was obvious Cryan was implicated in this since he was the main person deciding which witnesses would be brought before the grand jury. 61. From his point of view, it could not have been any clearer that state witnesses had been coached, manipulated, and bribed to finger his client. Even Cryan himself had, in Goodman's view, admitted as much when he testified on December 18, 1974, that he did write letters about inmates that had testified. When explicitly asked if the purpose of those letters was to make the parole board look favorably on a given prisoner witness, prosecutor Cryan replied, "Well, I think that speaks for itself." 62 Goodman hoped that Judge Madina had been paying close attention and that he would, in turn, rule at the close of the Wade hearing that the identification of Shango had not been made properly. However, Judge Madina seemed not to hear all that had been testified, or, perhaps, did not believe the prisoners who told tales of fear and coercion. He concluded there was no tainting of the identification made during the investigation of the deaths of inmates Hess and Schwartz. The identification procedure used by state officials was proper. 63. The trial now was unavoidable. Goodman's team would have to put Shango's fate in the hands of a jury and hope that it could see how this case had been rigged from the start. Even though Goodman couldn't put Cryan himself on trial as a principal sick villain in the case, he nevertheless hoped that the jury would have a critical view of the prosecutor's reliance upon, and sanctioning of, shoddy tactics simply to win a case. 64 He would repeatedly remind jurors of the nature of the investigation, the pressure the state exerted upon people over whom it had absolute control. 65. That argument would only have an effect if the jury was not already prejudiced against prisoners in general, or Shango in particular. Goodman was worried since it seemed that Judge Madina was growing harder toward the defense after the Wade hearing. Beth Bonnera, from the ABLD's jury project, recalled that the change in the judge's behavior caused grave apprehension in the defense team. Only a week earlier we had cheerfully discussed whether waiving a jury and going to trial before Madina alone might be the best strategy, because at least at first the judge had shown respect and sympathy for both Ernie and Shango. Now, he was putting on a cold, hard mask and seemed irritated at the smallest request. 66 As Shango's defense team saw it, the judge's demeanor was crucial. The tone of a trial is determined in many subtle ways by the judge. His treatment of the parties gives the jury clues to his thoughts, which they incorporate into their evaluation of the evidence. 67. Beth Bonnera and her colleague Eric Swanson were determined to get a jury for Shango that would not be prejudiced or easily swayed by an unsympathetic judge. Ernie Goodman was eager to work with the ABLD jury project, which, he could see, had undertaken the Herculean tasks of data collection and community network building. The week before Shango's jury selection began was particularly hectic. While defense lawyers busily argued their motion to dismiss indictments, the jury project was trying to amass enough information to make sure the defense could pick the best jurors. As Bonnera remembered it, we sent letters to members of the community network alerting them to the start of the case. A meeting was held to decide which of the psychologists used on an earlier Attica murder trial, the Hill and Pernisalis trial, were reliable. Then a meeting was scheduled with those we wanted to use. Data on the current composition of the Erie County jury pool was collected. 68 What they found led Bonnera to recommend that Ernie Goodman immediately file a motion to challenge the entire pool as unrepresentative of young people and women. 69. He did, and to his surprise Judge Madina granted the motion. But there was still much work to do. 70 Because Ernie Goodman was the most seasoned lawyer on Shango's team, the plan was that he would begin the voir dire, the questioning of potential jurors, then either Haywood Burns or Shango could step in. The key to a successful voir dire was having solid research from the jury project. Any answers a potential juror gave could be analyzed in light of the jury project's data on juror attitudes. Whatever rating a given juror netted from that analysis would help the defense identify whether he or she should be questioned more closely and carefully. 71 The job of collecting information for the jury project seemed never-ending. In addition, as soon as anyone on the defense team questioned a juror, the jury project team immediately contacted its community network to find out any additional information that might be helpful in gauging whether that individual would or would not be a good pick for the defense. Even with a relatively good jury pool, picking a sympathetic jury would be no easy task. As Goodman recalled, seeing the first 50-person panel made the defense terribly pessimistic. They were middle class, middle age, elderly, white, mainly men, very few young people, and one black person, possibly two. 72 They also found that a significant number of the prospective jurors had close relationships with law enforcement agencies. One was a neighbor of an Attica prosecutor and had even asked him for a ride to court. 73 Some potential jurors didn't even attempt to hide their contempt and racist views of black people and, yet, in Goodman's view, the judge was trying to shut down the defense's ability to probe their racial prejudices in the voir dire questioning. Goodman finally lost his patience and addressed the judge. "This has been a difficult day for all of us," he began. "I have felt almost a sickness come over me as I have listened to this jury. The defense has a right, and an obligation, to find out how the race of this defendant will affect the jurors. But you have virtually instructed every juror on that panel how to answer our questions, and you have made it impossible for us to get at their true feelings on this volatile matter." 74 The second jury panel seemed just as bad to Goodman's team, but, thankfully, the third panel was better. 75 The people on this panel appeared to be less prejudiced, even though the lawyers hadn't really been allowed to probe jurors based on their racial views. By then the defense team was well versed in how to most effectively use the voluminous data given it by the jury project, and this had helped them pick a better jury despite the limitations placed on the voir dire process. 76 By taking seriously the information provided by the jury project, Shango's team felt fairly good as the jury selection process drew to a close. To Goodman, the jury project had been a godsend. He was surprised at how efficiently the ABLD lawyers had been able to utilize its community network to receive feedback. He knew very quickly whether a juror was one we would obviously want or one we would obviously reject. 77 Simonetti's office was upset that the ABLD had been conducting a telephone interview program with all the prospective Attica jurors to attempt to determine their prejudices in this matter, particularly since they had to concede that such interviews were essentially legal. 78 Just before the final jurors were chosen, however, the prosecution and defense alike were hit with a lightning bolt. One of the ABLD's legal volunteers, Mary Jo Cook, revealed that she was, in fact, an informant for the Federal Bureau of Investigation. The 26-year-old white woman had first come clean to a lawyer on Barbara Hanska's staff, who, in turn, persuaded Cook to go to the press. Her admission, they knew, would have major implications for the myriad cases they were trying to defend, including Shango's, as well as the one they had just lost. 79 John Hill's lawyer, William Kunstler, immediately called his own press conference to insist that, in light of this revelation, the verdict in both his clients and Charlie Joe Pernazalist's cases should be overturned. 80 This request was denied. Judge Madina agreed to halt Shango's trial in the midst of final jury selection to hold a week-long hearing on the matter of the informant. 81 Testimony revealed that Mary Jo Cook had been an employee of the FBI from June of 1973 until November of 1974. Her boyfriend was already informing for the Bureau, while also reporting to someone named Jack Steinmetz at the New York State Police. Since Cook very much needed money, she was excited when asked if she too might want to become an informant. 82 The FBI, it turned out, had a very specific group that they wanted her to infiltrate: Vietnam Veterans Against the War/Winter Soldier Organization. 83 She was given the code name Joe Leroy and she made between $50 and $80 each month for her reports. 84 According to Cook, she delivered these reports to her control agent, a Mr. Gary Lash, in a park or a cemetery that was a really peaceful place. 85 Gary Lash, she insisted, was not just any FBI agent. He had already, in the course of the FBI's official investigation called for by the Justice Department back in 1971, talked to every witness, hundreds of witnesses, state troopers, guards, and other people. 86 Although Mary Jo Cook had been asked, officially, to spy on the VVAW, by September of 1973 she had also become a regular around the offices of the ABLD. Cook remembered her first Attica defense meeting well. At a storefront on Connecticut Street, they showed a recent documentary by Cinda Firestone about the Attica brothers, and Big Black as well as John Hill and Charlie Joe Pernisalis had all been there. 87 From that moment forward she began volunteering for the jury project. She gave Lash everything she could, she testified, even down to telephone numbers, any little piece of information. I supplied him with details about people that I considered important, whether or not I understood what their importance was. 88 Wondering where that information went, Cook actually asked Lash. Most of it stayed in Buffalo, he told her, but a summary of it also went to Washington, which she already knew because, as she testified, I got a specific telephone call from Washington twice as to the information that I know. 89. According to Cook, she had, in fact, learned a great deal that the FBI wanted badly to know. For example, during one of the first Attica trials, the one in which Willie Smith was charged with raping John Schleich, she had heard from fellow volunteers that he had a problem with his lawyer, that his lawyer was not working well with the ABLD, among other matters. 90 Additionally, Mary Jo said, she had received information about Mr. Strobel's defense last summer, whereupon she was called into Judge Madina's chambers to describe in more detail what she had learned. 91 Perhaps her arrangement with the FBI would have continued indefinitely, but the longer Cook worked for the ABLD, the more sympathetic to the defendants she became and her conscience began to plague her. What really bothered her, Cook said, were the tactics used by state investigators to build their cases against the Attica defendants. For example, she said, the only reason that they had started their cases against Willie Smith was that they wanted the public to be swayed against all future Attica defendants, get it, thinking of them all as deviants. 92 The fact that the brothers had suffered so much physical abuse also really got to Cook. In fact, she soon became so obsessed with the question of whether there had been atrocities during and after the retaking at Attica that she went to her FBI handlers to ask them what really had happened. On the stand she recalled one meeting with Lash and another agent, an old Irish Catholic named Ed, who kept trying to reassure her that there had been no atrocities. I kept telling them that I knew there had been atrocities at Attica. Their response was a categorical denial. 93. No denials, though, were able to combat what she had learned from the Attica defendants themselves and, in time, their accounts of torture kept her up at night. By the time Cook was helping the jury project, she was already torn. Although she had not admitted it to her FBI handlers, she had actually volunteered there because deep down she actually thought what it was doing was a good thing. 94 And then her guilt pushed her to admit that she was an informant. 95 According to Cook, she was by no means the only FBI informant in the ABLD, and indeed asserted that there was one still there named Kevin Ryan, so she wanted to do the right thing and tell the ABLD what had been going on. 96. Even though it was clear from the hearing that Mary Jo Cook had been privy to the defense strategy, and she insisted that she had shared what she knew, she had a hard time proving this, and proof is what Judge Madina wanted. Cook insisted that she did in fact pass on the information that she had obtained from the defense people, including vital information regarding the jury project, legal defense strategy, courtroom strategy, communications between lawyers and clients, specific information on defendants' positions and personal problems, and the internal structure of the ABLD as a defense effort and how it was coordinated. 97 Madina, however, wanted corroboration. Although she came to his courtroom with a large leather briefcase filled with various reports, that wasn't enough. 98 She would have had even more documents, she explained to the judge, but suspicious fires had broken out both at her residence and at ABLD lawyer Barbara Hansku's office, and everything not with her now had been destroyed. 99. Although Cook had, in Madina's view, insufficient corroboration that she had passed defense secrets to the FBI, notably, no one in the Bureau denied that Cook was an informant. Cook's control agent, Gary Lash, confirmed that he had been specifically assigned to security matters in 1971 and to the VVAW, that Cook reported to him, and that he also knew state policeman Jack Steinmetz. But Lash insisted that he had never requested Miss Cook to spy on the Attica Defense Camp 100, even when another FBI agent admitted that he too had been placed in charge of monitoring the Attica defense effort, had also received information on the ABLD, and had even been in contact with prosecutors from Simonetti's office. It seemed to satisfy the judge when he then insisted that he did nothing with the information. 101 Simonetti's prosecutors James Grable and Charles Bradley confirmed that they had talked with the FBI about the ABLD, but both denied that they used information on the ABLD provided to them by the FBI. That too seemed to satisfy Judge Madden. 102. To the stunned reaction of the entire ABLD, Judge Madden's 12-page decision concluded that there was no evidence of governmental interference with the Attica legal defense team and that Miss Cook's allegations were not supported by her testimony, which I must characterize as general and extremely vague. 103 When New York Times columnist and former Attica observer Tom Wicker learned that the FBI had planted a paid informer among the defense workers, to him it had seemed obvious that the trials, such as Hills and Pernazalists, that had just taken place were not fairly conducted. 104 Not to Judge Madden, however. The trial against Shango would proceed. And so jury selection resumed. Jury project captain Beth Bonner now worried that even the research the defense team was relying on might be tainted. There was the possibility, she noted, that Cook had messed with the statistical studies and the resulting info they were getting to pick a jury was faulty. They had no choice, however, but to go forward. 105 Jury selection finally ended on May 15. Opening statements commenced 5 days later. 106 Prosecutors Frank Cryan and Daniel Moynihan approached the jury with great confidence. Bernard Strobel, they insisted, had caused the death of Barry Schwartz by stabbing him with a sharp instrument. In addition, he was charged with kidnapping Schwartz, which allowed the perpetration of the murder. 107 The state's first witness, prisoner George Kirk, was not that convincing. Kirk's story kept changing on the stand, and at one point he simply broke down and said, "I've had my days mixed up for years, praying I'd forget the entire matter." 108 Watching the prosecution struggle to get Kirk to finger Shango filled defense attorney Goodman with relief. In his view, the jury realized that this witness was a person that they just couldn't believe. 109 The state, though, regrouped and called prisoner John Flowers to the stand. Although Flowers also had a hard time telling a coherent story of what he had seen and heard, he did tell the jury something crucial to the prosecution's case. He said that Shango had told him Barry Schwartz was going to be executed for treason. Flowers had been the medic called to Schwartz's cell to sew up the wounds he had suffered when glass was thrown at him after he had been moved to D Block. This was, he claimed, when Shango told him that Schwartz was to be executed. Prisoner witness Jack Florence also helped to implicate Shango in the murder of Schwartz by placing him at the scene and giving him the same motive he had killed Schwartz for being a traitor. Florence had testified before the grand jury earlier that he had seen both Schwartz and Hess being led, naked, to D Block by Bernard Strobel and others, and that they were accusing these men, most specifically, of treason. The prosecution had him recount this same story for the jury. 110 Ultimately, prosecutors needed an eyewitness to Schwartz's murder. Before introducing witnesses willing to testify to this, though, the state first decided to set the scene to make clear to the jury just how brutal this murder had been. To do this they put a prisoner by the name of Willie Locke on the stand. Locke claimed to have seen the aftermath of Schwartz's alleged execution and told the jury in graphic detail how he had seen two guys laying on the bed with blood all over them. 111 This was but a prelude, though, for calling prisoner Jimmy Holt. Holt was one of only two witnesses who would tell jurors that he had actually seen Shango stab Schwartz, whereupon he screamed and fell to the floor. 112 But Holt's testimony wasn't as strong as the state hoped it would be. In fact, even the prosecution had found it hard to buy this man's testimony. According to an internal memo in 1975 that was addressing the myriad interviews state investigators had done over the years with Jimmy Holt, lead prosecutor Cryan admitted that even he doubted Holt's credibility. As he noted to his colleagues, Holt related an account of a stabbing which allegedly he witnessed in 42 Company on Saturday night. Holt now informs us that his previous statements concerning these events were based upon what he had heard and not from observations he personally made from the slop sink room in 42 Company. 113. Even Holt's testimony about the events leading to those murders, about what had happened in the yard on Friday night, was, in Cryan's opinion, sketchy. His recollection now of the details of some of these events is somewhat different as to some particulars. 114. Worse, the prosecutors in Shango's case knew that Jimmy Holt was by no means their only flawed witness. They were also aware, for example, that John Flowers had also told them completely different stories at different times. For example, when he was interviewed by an organized crime task force investigator in early 1972, Flowers claimed that he had seen Strobel with several knives down his pants. 115. 2 months later, however, when interviewed a second time, he made no mention of having seen Shango at all. 116. By the time he testified before the grand jury in June of 1972, he had yet another account to share in this case, stating that Shango had what looked like an arsenal of what knives or screwdrivers, you could see handles sticking out of his belt. 117. But the prosecution's star witness, it turned out, was to be neither Holt nor Flowers. Cryan and Monuhan instead were counting on a prisoner named Jimmy Ross to make their case. Ross testified that he had seen Strobel in a black raincoat with a pirate's sword, along with 4 or 5 men, put his hand on the man's head, then he cut his throat. 118. It appeared to jurors that this witness was very credible. He had obviously been traumatized from having seen this horrific murder. At one point the judge offered Mr. Ross a handful of tissues, and while he told this story, the jury of 5 men and 7 women listened to his testimony with looks of intense discomfort on their faces, their eyes fixed on this slight and frequently inaudible witness. 119. But whatever ground the prosecution thought it had gained with its alleged eyewitnesses to the murder of Barry Schwartz, such as Jimmy Ross, was lost almost as soon as Ernie Goodman, at times with his son Bill stepping in to help, as well as Haywood Burns and Shango himself, began their cross-examinations and eventually called their own witnesses to the stand. Ernie Goodman's first blow to prosecutors Cryan and Moynihan's case came during the cross-examination of the state's first witness, George Kirk. Not only was it already obvious that his testimony made little sense since it had changed even as he testified, but, as Goodman pointed out, the state knew this was a totally unreliable witness. For starters, prosecutors knew that this man suffered from mental illness and had been so unstable that even the state couldn't rely on him despite granting him parole for agreeing to testify against Shango. No sooner did he get let out than he skipped town and went to California. When he ran out of money, he was so desperate that he called the state troopers for funds with which to return. 120. Goodman then took time to dismantle the credibility of the state's second witness, John Flowers. Unbeknownst to anyone in Simonetti's office, before he had taken the stand for the state, Flowers had already given Shango's defense investigator, Linda Burris, a statement that became extremely important at his trial, one of the highlights. 121. Written in longhand on yellow legal paper by Flowers himself, his own statement in his own writing, in his own language, made it clear that he had told the state investigators something completely different from what had happened in order to secure his own parole. 122. So, after Flowers had just testified against Shango as Frank Cryan hoped he would, Goodman then presented him with his own handwritten refutation of that same testimony. According to that statement, Shango had not, in fact, told Flowers that Schwartz was there to be executed. What he had actually said was that it was good Flowers was patching Schwartz up and he was trying to keep things calm. Look, Shango had really said, we don't want anybody to get at these people, those who want to hurt them, and we are trying to safeguard them, and we can't let anybody in here who might do something to them. So we don't want anybody coming in without a pass, and that's why it is important that everybody coming in do have a pass. 123. The jury just gaped at this completely different portrayal of what had gone down in D Block on the day in question. Even if they weren't sure which of the accounts to believe, one thing was certain: Flowers had proven to be a liar, and, as Goodman saw it, that in itself was really a devastating blow to the prosecution's case. 124. Things didn't bode well for the rest of the state's witnesses under Goodman's cross-examination either. Willie Locke, for example, had told the gory tale of throat-cutting and seeing the bloody victims on their cots and had, very clearly, put jurors in a mood to make sure that, if Shango had done this horrific crime, he should pay for it. Goodman, however, meticulously walked Locke through the other statements he made to investigators and, most importantly, the testimony he himself had given to the grand jury previously on July 19, 1973. He then asked him directly, "Did you ever see Shango with blood on him at any time?" To which Locke, hanging his head, simply said, "No." 125 Goodman then did the same thing with Jimmy Holt. 126 Very quickly he had Holt admitting in front of the jury not only that it was difficult for him to remember what he saw and what he heard later, he gets mixed up, but that, in fact, he had actually told the state that someone altogether different than Shango had murdered Schwartz. According to Holt, he had explicitly told state investigators that Tommy Hicks had gone crazy and kept stabbing Schwartz until he was dead. 127. Ernie Goodman, however, most needed to discredit Jimmy Ross, since he had such graphic testimony of Shango actually killing Schwartz. Goodman had to think hard about how he would tackle this particular man on the stand because Ross was already such a pathetic figure. Whatever happened, he, Goodman, didn't want to appear to be bullying or belittling this very thin, small, white, gaunt-looking, sallow-faced, pock-marked man, this pitiful object. 128 So rather than push Ross around on the stand, Goodman decided instead to make clear to the jury just how easy it had been for the state's investigator, Ernest Mild, to get Ross to say anything he wanted him to. As Goodman pointed out, Ross had tried to stay away from him, try not to answer his questions, try not to say what he wanted to say, but Mild had put things in his mouth, had suggested to him certain answers to certain questions. Pushing again and again to get in something more and more and more, and at the same time suggesting what that more and more ought to be. 129 Ultimately Goodman's cross was very successful. As the jury could now see, Mild had suggested so much to Ross that, ultimately, he was willing to make the statement the state wanted him to, under oath, about the killing. 130. For jurors, however, the question remained, if Shango hadn't killed Schwartz, then who had? Goodman felt fairly certain that the jury would want to have some sense of this before it would be willing to render a not guilty verdict for his client. So he went for the state's jugular, calling for witnesses whose other statements and testimony supported the defense's claim that the Attorney General deliberately and not by mistake or neglect deliberately withheld from the grand jury testimony that would show that it was not Shango who killed Schwartz. 131 More specifically, Goodman referred back to what the defense had learned during the Wade hearing. These witnesses had named another man, Tommy Hicks, as the killer, but and this point was key. The state didn't want Hicks to be the murderer because he had already been killed in the retaking. 132. As proof of these assertions, Goodman noted that Frank Cryan had not brought any witness who identified Hicks as the killer before the grand jury or to this jury. Why? Because at least one of them would have, according to Goodman, directly contradicted Ross's testimony that Strobel was inside of the cell when this murder took place. It completely eliminates him, and on that testimony Cryan actually had 3 supporting corroborative witnesses, all of which tend to prove that it was Hicks, not Strobel. 133 Goodman noted that another prisoner reported he had heard Thomas Hicks say, "I have cut 2 dudes' throats," and seen Hicks covered with blood everywhere, hands, clothing, chest, face, and carrying a straight razor, beige-colored, burned handle in his right hand. 134 A third witness who was also known to the state had not only looked in the cell and observed Tommy Hicks cutting a white dude's throat, but had also pointed out that the state's main witness against Shango, Jimmy Ross, hadn't even been there when this murder took place. He had already left the gallery. 135. Even after decimating the state's witnesses, and showing the ways in which they had, in his view, engaged in prosecutorial misconduct, Goodman couldn't be entirely confident of Shango's chances of acquittal. He had seen what had happened in the Hill and Pernisalis trial, where neither defendant had benefited a whit from the jury's knowing of the state's unsavory deeds, pressuring and bribing of witnesses. Goodman hit upon the only way he might eliminate any doubt that remained in the jurors' minds regarding Shango's innocence, compelling the jury to look carefully at exactly when Schwartz had been killed. 136. Goodman had spent a lot of time poring over the autopsy that John Edland had done on Barry Schwartz. He was no pathologist, but he was struck by the presence of rigor mortis in Schwartz's body on Tuesday at 5 a.m., which certainly suggested that he had been killed probably not more than 30 hours before the autopsy. 137. This was important. If that were true, that meant that Schwartz had died after Saturday, the day that prosecutors said Shango had killed him. 138. Goodman began to wonder, if medical evidence indicated that Schwartz didn't die until after Saturday, that meant not only that his client was in the clear, but that troopers might have actually killed Schwartz and Hess during the retaking. 139. Not a single state witness placed Shango anywhere near the murder scene after Saturday. Goodman was worried about getting Shango to agree that Edland should be their parting shot to the jury, neither was he sure that he could persuade Edland to testify. Goodman decided that he, Shango, and Linda Burris all needed to sit down and decide, together, what the final strategy should be. So he went to the jail. It was a miserable, horrible day, he recalled. The depressiveness, the heat, just being within the bars on a beautiful day outside, not being able to smell the air except through those bars, was enough to destroy the morale of everybody. 140. They persevered, however, arguing, bantering, and reviewing everything that was available and the witnesses that were possible. 141. Whatever strategy they decided upon, Shango asked, would it be enough to convince the jury of his innocence? 142. Goodman couldn't promise that. All he could say was that he felt his approach to the defense was better, more effective, and less fraught with dangers than, for example, allowing Shango to testify on his own behalf as he still wanted to do. 143. Shango wanted to speak to clear his own name, but he more desperately wanted an acquittal on all counts. He wanted no compromise verdict. He wanted and believed he was entitled to a complete acquittal. 144. Maybe Drive Edland could be the surprise witness that would make all the difference. At first, John Edland had no interest in testifying in Shango's case. He had over the last 4 years suffered so much abuse, so much hate mail, so much hostile press that he wasn't eager again to re-enter the fray. He wrote to Goodman, I would prefer to remain intellectually detached from the prosecution or defense of any of the Attica tragedies. 145. Eventually, however, Goodman persuaded him to explain his autopsy to the jury. The morning that he was to testify, Edland and his wife, a very concerned and interesting person, who was terribly supportive of what he was doing, met with Goodman over breakfast to go over what would happen. 146. When Edland walked into the courtroom that day, the state's surprise was palpable. To Goodman's relief, Edland was a great witness. He didn't come off as coldly intellectual and detached, but as a straightforward kind of guy, talking in a straightforward type of language that jurors could understand rather than testifying like a professional or an expert witness. 147. This was good because Goodman needed him to explain some rather complicated science having to do with the time of Barry Schwartz's death and the way that rigor mortis manifests in the body. Speaking clearly and without hesitation, Dr. Edland stated that, based on rigor mortis at the time that he had autopsied the victim, Schwartz had died on Sunday. 148. Frank Cryan went ballistic. He hopped to his feet and began peppering Edland with questions, all of which seemed somehow sarcastic and disrespectful. At one point Cryan approached Edland with a heavy medical book in hand and tried to suggest that there were many medical experts who would totally disagree with his analysis of rigor mortis vis-a-vis time of Schwartz's death. The more Cryan questioned Edland, the more aggressive he became. However, the prosecutor's bombastic style seemed to backfire. After enduring one particularly aggressive question from Cryan, Dr. Edland finally lost his patience, responding in such a dramatic, powerful, emotional way, Goodman recalled, that it knocked all of us back on our feet, including the members of the jury. 149. It was as if a long-blocked dam in Edland finally burst. He spoke of how he had been isolated, tortured, and put under extreme pressure even though his findings had been independently verified and he had autopsied over 5,000 bodies in his career. 150. And before he stepped down from the witness box, Jurors had seen this man's pain. Earnestly, he said, his voice breaking, he had done the best job he could, and though others were welcome to disagree with his findings, he was confident of his conclusions. 151. As Edland left the stand, the courtroom was hushed. Ernie Goodman was struck by the tone of his voice, his expression, the intensity of his voice, the way he looked directly into Cryan's eyes. His whole appearance showed the jury the amount of pressure under which this man had been living simply because he had told what he had seen, with no motivation other than to state the truth. 152. Perhaps Goodman could have rested his case at that point. He would later concede, it was the highlight and the most dramatic moment in the whole case for me. 153. However, he had two more defense witnesses to follow Edland on the stand. The first, a former prisoner named Albert Victory, who was to testify to the positive role Shango had played throughout the rebellion, particularly in trying to ease any tensions in the yard that might erupt between white and black inmates. Then former Attica observer James Ingram testified about Shango's reasoned character in the yard as well as to the broader fears that had led prisoners to detain Schwartz in the first place. 154. It was time for the closing arguments. On June 25, 1975, the defense made its summation. Goodman walked the jury through the myriad inconsistencies in the state's witnesses' testimony as well as reminded the jury of the many witnesses who had seen something utterly different from what the state claimed had happened. Goodman had hoped that this case would have been dismissed long ago. As far back as the Wade hearing, it was obvious to him how much evidence had been suppressed, so much that it should, in his mind, now force an acquittal. 155. It seemed incredible to him that the state's entire stable of witnesses in the Attica cases had all paroled after cooperating. 156. Even more unbelievably, he argued, the state's entire case against Shango rested on the testimony of only one man, Jimmy Ross, who the jury could see had been used by the prosecution because he was a weak, pitiful figure to establish a case they couldn't get through any other witness. 157. As Goodman made his way to sit down after his long review for the jury, it was clear he was satisfied that he had done all he could. Even the judge, in Goodman's view, despite not having dismissed this case, had been pretty fair to Shango. He had, for example, made sure that Cryan couldn't make any reference to Shango's previous record before the jury, and, when Shango came into the courtroom each day, the judge had ensured that he was brought in by the deputy in a way that people wouldn't see the handcuffs and through the judge's own office and into the courtroom without handcuffs. 158. After Goodman walked the jury through his defense against the murder charge that morning, Haywood Burns summed up the defense's arguments against the charges of kidnapping and felony murder that afternoon. It was then the prosecution's turn. Cryan's summary took over 2 hours. 159. He seemed undaunted as he got up to make his own closing arguments. He focused the jury's attention on the sheer depravity of the murder of Barry Schwartz and argued not only that Shango had been there when that murder took place, but that several witnesses believed he had done the crime. Jimmy Ross, he stressed, might be troubled, but he knew what he saw. When Frank Cryan sat down, even Goodman had to concede that, overall, the prosecutor had done a good job in his summation. His witnesses had been so weak and yet he tried valiantly to make their testimony make sense for the jurors. As he put it, Cryan had dealt with many of the questions that had been raised in our arguments and he dealt with them generally in a fair way. 160. The fact remained that Cryan himself wasn't particularly likable. 161. As Goodman put it, what was lacking about Cryan, and it had been lacking throughout the whole trial, is that he is not a concerned human being. You never felt humanity coming out of the man, and that was evident in his final argument. 162. The next morning, June 26, 1975, from 10:10 until 11:28 a.m., Judge Madina gave his detailed charges to the jury, whereupon it left to deliberate. As it turned out, they would be voting only on whether Shango had committed first-degree murder. At the 11th hour, the judge responded affirmatively to a motion Goodman had filed earlier to get the kidnapping charge against his client removed, so the felony murder charges were also dropped. 163. Since many of the men awaiting trial were charged under the same indictment, this decision would have serious implications for future cases, because if there hadn't been a kidnapping in this case, there couldn't have been kidnappings in the rest of the cases that the state hoped to try. In fact, with this decision, the judge had kicked the legal moorings that underpinned the state's most dramatic cases yet to be tried right out from under them. Still, Shango was hardly off the hook. The state was charging him with the murder of Barry Schwartz, a charge that could net him a life sentence. The jury, though, was not going to decide anything quickly. Hours after leaving to deliberate, they asked for some trial testimony to be read to them and, then, an hour after that, they adjourned for dinner. After their meal the jurors were back at it but still had much they felt needed to be discussed. At 8:15 p.m. someone came out to ask for some clarification on the judge's charges. By 8:30 p.m. they were again deliberating, and at 8:55 p.m. the jury took its vote. 164. When the jury emerged from the deliberation room on the evening of June 26, it was utterly silent in the large courtroom. So drained were Goodman and the rest of the defense team that all he could manage was to bury his head in his arms as he waited for whatever the jury had to say. The jury foreperson slowly rose and, in a somber, dispassionate tone stated that the jury had found Bernard Strobel not guilty of murder. When the words sank in, suddenly it was pandemonium. On hearing the verdict, Ma Strobel fainted in her seat, right behind her son, whereupon Shango jumped up and tried to attend to her. 165 Goodman wept. 166. When Ernie Goodman, Haywood Burns, and the rest of Shango's defense team walked out of the courtroom into the dark summer night, they were met by scores of ABLD supporters who applauded them as they walked down the stairs. Again, Goodman was overcome. It was a remarkable feeling, he remembered. It was a defense that had been able to jointly overpower the state, without money and without expertise in many cases, and yet it had been able to bring some kind of justice to that courtroom. 167 Everyone assembled felt an integral part of that victory. A chant began to grow louder all around the courthouse: Attica means, fight back, and then Attica means from in the street, and a slightly muffled, but still powerful, fight back from inside the Erie County Jail, where many Attica brothers still sat, awaiting their trials. 168. 41. A long journey ahead. In the wake of their embarrassing defeat in the trial of Bernard Shango Strobel, Attica Special Prosecutor Anthony Simonetti and his stable of prosecutors lost some faith that the state would necessarily win the cases still slated to go to trial. In every case that had already gone to trial, including in the single one that they had managed to secure convictions, that of Hill and Pernisalis, the ABLD had relentlessly done its homework, and had managed to drum up substantial support in the court of public opinion. The ABLD had, for example, blanketed the recent Erie County Fair with colorful, friendly leaflets questioning whether this was indeed a fair county and asking residents to be their best selves when sitting on Attica juries. Thanks to the ABLD, it was unlikely that a single potential juror in Buffalo had not at least heard of, if not actually seen, one of these flyers. Nevertheless, Simonetti and the judge overseeing all of the Attica cases, Carmen Ball, were determined that all remaining cases proceed as quickly as possible. Both men were in fact facing some media criticism that, although 62 prisoners had been charged with committing crimes at Attica back in December of 1972, and some of them, like Shango, had been named in numerous indictments at the same time, by 1975 prosecutors had only managed to bring 5 cases to trial. A key challenge that Simonetti's team of prosecutors had faced from the beginning was the considerable amount of time it had been forced to expend on responding to the ABLD's strategically deployed blizzard of motions. What is more, the ABLD's myriad motions had at times been granted, which also set back prosecutors, particularly when they were required to dismiss charges against a given defendant altogether. As the New York Times noted in November of 1975, charges against 27 defendants had eventually been dismissed for lack of evidence or other legal reasons. 16 defendants had passed away while waiting for their trials. 2. The state still had plenty of Attica defendants left to try, however, and Judge Ball was committed to getting these scheduled as soon as possible. 3. One of the cases still to be tried was that charging several Attica brothers, including Donald Noble, with the attempted murder of Attica Correction Officer Michael Smith by cutting him with a sharp instrument up on the catwalk on September 13, 1971.4 The fact that Michael Smith himself had told prosecutors that Donald Noble had actually tried to save him from being gunned down on the catwalk on that day, or the truth that Smith's most catastrophic injuries had come not from any homemade prisoner weapon but rather from having been shot numerous times on the day of the retaking, had not stood in the way of their desire to pursue this case against these indictees. The case they were most eager to get to trial, however, was the so-called leadership indictment, Indictment No. 5, which had charged 16 Attica brothers, the ones who had been in segregation after having had XS chalked onto their backs on the day of the retaking, with multiple offenses. Among these men were Big Black Smith, Herb Blyden, Roger Champion, and Shango. Once again Frank Cryan and Daniel Moynihan would represent the state. Judge Ball expected this trial of Attica's most high-profile rebels would last close to a year, and it would be the political trial, and it will take the longest time to try and will probably be the most explosive. 5. As much as prosecutors would have liked to get on with the leadership indictment since it was the most involved and would take so much of their energies, first up on the docket was to be the trial for Attica prisoner Yomo Joka Omowell, born Cleveland McKinley Davis, who stood accused of murdering fellow prisoner Kenneth Hess. 6. Yomo was the son of a North Carolina sharecropper whose family moved to Virginia when he was 12. His father became one of first African Americans to run a service station in Virginia, but Yomo had little interest in that business. After a few years of hanging around his dad's shop, he went looking for work in Virginia Beach, where he and a friend were arrested for unknowingly transporting moonshine. Their boss had paid them to drive a car across state lines to bring a delivery to a customer, but had failed to tell them they were running liquor across state lines. Whereas Yomo's white friend was allowed to enlist rather than do time, Yomo was sentenced to 5 years in Virginia's hellhole of a state penitentiary. When he finally got out on parole, he was a different person, jaded, cynical, and deeply disillusioned about life. Sensing this change in her son's outlook, Yomo's mother tried to give him a fresh start by sending him to live with one of his uncles up north in the Bronx. By then, though, Yomo felt a whole lot more comfortable hanging around with folks who had experienced the same things he had, and, in time, he was spending all of his time with those who skirted the law and was himself committing petty crimes just to get by. Hoping to avoid getting locked up again, he changed his name to Eric Thompson. Before long, he was busted for robbing an auto parts store, and he found himself locked up again, this time in Sing Sing. At this prison he underwent another transformation. He devoured every book he could get his hands on in the library and met many other intelligent people on the inside. Thanks to this education, he not only began to rethink his personal direction, but he also began to think about the nation itself in more critical ways. A pivotal moment for him was seeing the electric chair that had executed accused spy Ethel Rosenberg. He swore that he could still see where her urine had stained the concrete. The image haunted him as he tried to make sense of a country that prided itself on free speech and acceptance and yet was all right with electrocuting that mother. Yomo, now living as Eric Thompson, increasingly questioned the world around him. He also found himself gravitating toward the teachings of Islam. He converted, and it was then that he became Yomo Joka Omowell. He liked the name Yomo because it was a powerful moniker that meant burning spear, snake, or dragon. After becoming a Muslim, Yomo also joined the Black Panther Party for self-defense because he found its ideology empowering. Every political group had a following at Sing Sing: the Panthers, the Republic of New Africa, the Five Percenters, and others, and their growing appeal greatly alarmed correction officials. Trying to neutralize the perceived threat, Sing Sing administrators decided to round up the apparent militants and send them, as a group, to Auburn Prison. As a defense minister in the Panthers, Yomo was one of those transferred to this new facility. Yomo was also one of those transferred to Attica after his activism during the Auburn Uprising of 1970. When Yomo arrived at Attica, he couldn't get over how miserable the conditions were there. He couldn't believe that the men there were so desperate for time outside their cells that they would literally stand outside in the sleet and rain just to catch some fresh air. Yomo was also taken aback by how cold the guards were at Attica. Attica's correction officers barely spoke to the prisoners, preferring instead to convey their wishes with the butt of their batons. In his view, Attica's officers treated the men in their charge like animals that needed neither shelter from the elements nor the camaraderie of conversation. He realized, however, that there was an upside to the COS attitude toward prisoners. Since they didn't see them as feeling and thinking human beings, they paid no attention whatsoever when prisoners like him wanted to hold political meetings in the yard. When the Attica Rebellion of 1971 began, Yomo was working in the barbershop. Although guards knew him as a militant, in the initial chaotic hours of the riot he protected a correction officer named Heller and civilian staff from harm. When the retaking of Attica commenced, however, Yomo was shot multiple times. He was struck on his upper left arm with shotgun pellets, which, he later explained, ripped open the inside of my left arm. Yomo was shot 6 more times in his neck and back. Then he was one of the dozens forced to run through a gauntlet of troopers and COS raining blows down on them. Yomo was suffering from gaping wounds and a collapsed lung. That night, he begged prison officials to take him to a real hospital. They refused. There he remained, in 4 to 5 inches of standing water, without sufficiently warm clothes, real food, or even a mattress. He had attempted to keep his wounds clean to avoid infection and to rehabilitate his own lungs by doing intensive breathing exercises in his cell. It was so cold in that cell that Yomo shivered and his wounds continued to bleed. After eventually losing so much blood that he looked near death, and with investigators from the Jones and Pepper commissions now poking around, prison officials finally took Yomo to a hospital in Buffalo for a transfusion. The doctors there were shocked by how severely injured he was. But in the hospital, the ugly threats and serious harassment from law enforcement continued. During the night, Yomo insisted, a guy came in and he was acting strange. He had trouble putting the blood unit on the pole and suddenly Yomo felt a cold liquid entering his arm. He started to hyperventilate, having a terrible reaction to whatever the stranger had given him. Hospital staff had to give him something else to stabilize him. 7 Yomo and his roommate worried over who it might have been in his room that night. No one knew who he was. He wasn't an employee, he later explained. 8 On another occasion, Yomo cowered in his bed as a state trooper walked into his room, looked at him coldly, and then said to the nurse, "This bastard ain't dead yet." On another occasion a different trooper planted himself next to Yomo's bed and passed the time playing Russian roulette. He would play with me putting bullets in and taking them out and threatening to shoot me, Yomo recalled, shuddering. He would click it pointed at my head and then it wouldn't go off. 9 Once Yomo finally left the hospital, he was placed in HBZ. There his harassment continued, albeit in a different vein. As Attica's narrow halls filled with investigators from the Bureau of Criminal Investigation of the New York State Police and Simonetti's office, Yomo understood that he was going to pay still another price for having rebelled beyond that of having been shot so many times. And, sure enough, when prosecutors presented cases against him before the Attica grand jury, Yomo ended up with more indictments than any other prisoner. Ultimately, Yomo found himself facing 34 counts of kidnapping as well as 4 counts of coercion and unlawful imprisonment for taking hostages. He also was charged with kidnapping and murdering Kenneth Hess. 10 The latter case was the more sensational one, and it would be tried first. At least Yomo's murder trial came after Shango's, and this turned out to advantage him quite significantly. Because Judge Madina had decided in Shango's trial that no kidnapping in the traditional, legal, or actual sense of the word had taken place in D-Yard during the Uprising, Judge Ball was forced to bar the prosecution from relitigating the same issue in Yomo's case. 11 In fact, not only did prosecutors have to dismiss felony murder charges against Yomo in his upcoming trial, charges that could only be brought had there been a kidnapping, but they were forced to drop them against Herb Blyden, Frank Smith, and Roger Champin in their pending trials as well. 12. Yomo, however, still stood charged with the first-degree murder of Kenneth Hess. Even though his trial was commencing years after the retaking at Attica, Yomo was still struggling physically and mentally from all he had endured on that day and those following, and he worried about his ability to marshal an effective defense. In addition to having flashbacks and nightmares, he was also in a great deal of pain. As important, he had grown unusually fearful and suspicious of people, including those who were trying to help him in the ABLD. This deep wariness of others is what had led him to create his own defense committee, the Attica Bond, to free Yomo. His defense efforts weren't totally isolated from the ABLD. Over the previous years, while awaiting his trials, he had come to trust at least one of the ABLD lawyers, Elizabeth Gaines, a great deal. Liz had heard of Yomo during the course of her work with other Attica brothers who were members of the Black Panthers. Whenever she would ask the other Panther prisoners questions, invariably they would tell her that she needed to speak with Yomo first. While it at times annoyed her, Liz was impressed with how tight this group was in the New York prison system, and how much they revered Yomo. When the ABLD asked her to interview him, she was intrigued. The day that Liz first met Yomo, he was on a list of 6 prisoners that she was supposed to talk to, but when she walked into his room she was transfixed and stayed longer than she should have. From the moment they began talking, she was taken by his political knowledge and analytical mind, and he was also, in her view, an incredibly beautiful man. She could see right away that he was a brilliant strategist and, indeed, out of the many brothers she had already spoken with, she didn't know any who had Yomo's level of perspective on the politics not only of the Attica struggle but also of the struggle against racism in America more generally. 13 In fact, so moved was she by this man that walking out of his room she realized that she had just met her first real love, and later that night she actually called her mother and said that this was the guy I was going to marry. 14. Yomo, it turned out, was equally struck by Liz. She was not only smart, opinionated, and passionate, but was also determined to speak her mind, which Yomo found captivating. Over the coming months, they met again and again to discuss his case, and their love affair intensified. The closer they grew, though, the more eyebrows were raised in the larger ABLD community. Over time, tensions began to develop between Yomo and Liz on the one hand, and some of the other Attica defendants who felt that the two of them had isolated themselves. Just as the relationship between Dallo and Barbara Handschuh had caused rifts between some of the men awaiting trial, so did the relationship between Yomo and Liz. Anytime you have a couple and a team it is tricky, recalled Liz Gaines, but in Yomo's opinion what was really at issue was the fact that Liz was white. 15 He felt compelled to pen a defense of his relationship with Liz and the fact that she was white. He wrote, "A white woman don't ever make a black man any less black by standing at his side in trying times, it's just that that woman has committed herself to stand and realizes that their struggle in life is one and the same, so don't think I have copped out on my people or rounded on them for a white woman to hide my face from black struggle." 16. The other source of tension between Yomo and the rest of the Attica brothers and the ABLD was his belief in a different approach to his defense. Liz Gaines agreed with his sense that many of the white lawyers in the ABLD felt that the brothers were too stupid to weigh in on their own defenses. 17 Neither she nor Yomo felt that these lawyers would take seriously Yomo's desire to make his case political, and to make it part of the larger political struggle of the Panthers. In Yomo's opinion, Attica brothers such as Shango had foregone politics and let the lawyers do the job like a mafia model. 18 Big Black had also said he wanted a more political defense, but Yomo didn't particularly like Big Black and thought he actually was not political at all, describing Big Black's Attica Now collective as having no platform. They would always back down. I never felt they were strong. 19. What irritated Yomo most was his sense that the other brothers, including Black, were trying to aggrandize themselves at the expense of the less public brothers and those still locked up. In one letter from the Erie County Jail, written in July of 1974, he had called out what he referred to as the reactionary niggers of Attica, chiding them for speaking beautifully about things on the outside, while he and the rest of the brothers had been left behind within these walls of pure living hell. 20 In his view, those brothers on the outside were the darlings of the ABLD, which was reason enough for him to want nothing to do with that organization. Ultimately he did accept some legal help, agreeing to let an attorney by the name of Vincent Doyle represent him as long as Liz Gaines would be there as well, but he remained suspicious of the ABLD and insisted on his right to tell his own lawyers how to inject politics into my defense. 21. Although Yomo had formed his own defense group to raise funds and drum up public awareness of his individual case mainly for political reasons, he was nevertheless a pragmatist. 22 He knew that the ABLD had resources and the ear of the press and the public. He didn't want to alienate this group totally and insisted that he, in fact, wanted a basic working alliance with ABLD, other defense committees, prison groups, political organizations, etc. 23 To other ABLD lawyers such as Big Black's Michael Deutsch, Yomo's position, while perhaps understandable, was ironic. In his view, when it came time to gear up for Yomo's trial, all-out legal wrangling and maneuvering, not political messaging, soon took center stage. Vinnie Doyle's primary defense strategy would indeed be more legal than political. In his view, it was clear that Yomo was being selectively prosecuted by the state. Despite the preponderance of evidence suggesting that the bulk of the crimes at Attica in September of 1971 had been committed by law enforcement officers responsible for all of the deaths there save the 3 prisoners in D Block and CO William Quinn, the state of New York had exclusively, and thus selectively, prosecuted only prisoners. It seemed clear to Doyle that Yomo was one of those being selectively prosecuted. Even the press was now writing pieces about the state's seeming single-minded focus on trying prisoners. Before Yomo's case came to trial, Doyle successfully filed what is known as a Clayton motion, a motion to determine whether the state had singled him out. It would be heard before Judge Ann T. McCall. 24. This hearing was a real turning point for Yomo. He was finally able to get the full story of the abuse he had suffered at trooper hands, and his myriad gunshot injuries from those same members of law enforcement, onto the record, and he was able to show the judge the physical scars that he still bore as a result of that trauma. Prosecutor Charles Bradley recalled one shocking moment in the hearing when suddenly Yomo, handsome and a very big and powerfully built guy, began to describe his scars and then asked the judge for permission just to show her. 25 When she agreed, he looked to Liz Gaines and asked that she help him, whereupon Gaines came forward and lifted up Yomo's shirt for the court. 26. As the hearing came to a close, it was clear that Judge McCall had been moved by Yomo's story, and the prosecution didn't like it. Even Yomo felt that she might be leaning more toward his side than theirs. Sometimes when he was particularly animated, even swearing and talking like a panther, as he put it, the DA tried to silence him, but the judge essentially declared that Yomo could speak as he wanted. Yomo's attorney, Vincent Doyle, and the ABLD for that matter, read a deeper significance than a particular fondness into the judge's willingness to let Yomo talk. For years, the state had been bullying the Attica defendants and had, perhaps, finally overplayed its hand with this jurist in Buffalo. At Judge McCall's urging, Vinnie Doyle began settlement discussions with Simonetti's office. Over the past 3 years, state prosecutors had tried to get various Attica brothers to plead out, including several of the men indicted under one major indictment, number 10, who, it would later turn out, would have their cases dismissed completely because the state lacked enough evidence to proceed. Although Doyle was eager for Yomo to consider a settlement, he knew that it would not be easy to persuade his client to take it. Yomo had from the beginning been hostile to any mention of a plea deal. If he hadn't committed the crime, he reasoned, then he should not say he did just to avoid a longer sentence. Also, Yomo had been very hard on every other brother who had taken deals, and he was no longer speaking to them. 27. Simonetti's offer was significant. He would drop the murder charges if Yomo would plead merely to coercion. His sentence would, thus, be 4 years including time served. 28 Even better, he could take something called an Alford plea, which allowed one to plead guilty while still, officially, proclaiming innocence. In short, Yomo could walk away from this legal nightmare and still not have to concede any wrongdoing. 29 Deep down, both Yomo and Doyle felt that the state's willingness to offer this plea had less to do with Judge McCall's desires than the fact that Yomo insisted he knew exactly who had shot him on September 13, 1971, while he lay on the ground, injured and bleeding. He had made clear to the prosecution that he was both willing and determined to testify to that effect. The fact that, during the hearing for Yomo's Clayton motion, much of the testimony had corroborated his account meant that state prosecutors had great incentive to settle. 30 Even before Judge McCall pressed for a deal, and prior to any ruling by the court, Simonetti's office made an offer to drop the charges, in return for a plea to a minor offense. 31. After careful consideration, on October 9, 1975, Yomo pled guilty to coercion, a Class D felony that could carry a maximum sentence of 7 years but for which he would serve no additional time. 32 Importantly, both to Yomo and to the rest of the ABLD defense effort, he did not allocate to a specific or named event, date, or victim, but rather stated in open court that although innocent, he was taking his plea solely to enable him to end a prosecution that had been initiated 3 years before. 33 Yet another case against the Attica brothers had ended with mud in the state's eye. And yet, just as in Shango's case, thwarting the state's efforts to prosecute did not lead to Yomo's immediate freedom. Despite the plea deal in this case, Yomo still had to return to Attica to finish serving his original time. Something profound had shifted in his relationship with the authorities there, however. It seemed to Yomo that they were far less capricious, and less eager to push him around. When his mother died, for example, Yomo asked to be allowed to attend the funeral in North Carolina. To his surprise, they allowed him to go. As he recalled, "They paid for 2 officers to come with me, so many people were at the funeral home and the guard took my handcuffs off, I could have run and I did not." 34. Without question, the authorities in the Attica Correctional Facility, the New York State Police, and in the state prosecutor's office were in a far different position by the close of 1975 than when they had first announced prisoner indictments in December of 1972. The state's cases were falling apart, and prisoners who had been vilified in the press were now being written about as the victims of state bullying. Most significantly, on April 8, 1975, the New York Times broke a story that rocked the entire New York State Attorney General's office to its core. Someone inside the Attica investigation had become a whistleblower. Malcolm Bell, one of the main prosecutors in Simonetti's office, was now claiming that his colleagues and bosses had worked deliberately and systematically to prevent the prosecution of the troopers and correction officers who had committed crimes at Attica. In fact, he alleged, Simonetti, Frank Cryan, and others had actually tried to cover up these crimes entirely. Bell had originally raised these shocking accusations against his fellow prosecutors in 1974 as Shango's trial was beginning. But neither judges nor state officials were willing to move on his allegations and, thus, the state proceeded with their cases. 35 By the time Yomo presented his evidence of selective prosecution, these revelations that could support his claims had finally gotten some attention. When Yomo entered his Alford plea, everyone in Simonetti's office felt that they would all suddenly be subject to much more scrutiny. They were correct. Part 8. Blowing the Whistle. Malcolm Bell. Malcolm Bell had entered the practice of law with conventional ambitions. When he left Harvard Law in the 1950s, he felt fairly agnostic about politics but was optimistic about the way that the nation was progressing. Indeed, it tended to annoy him when, in the 1960s, he saw an increasing number of protests critical of the United States erupting on campuses and city streets. Bell had served 2 years in the Army, first at Fort McClellan in Alabama and then in Wiesbaden, Germany, and he was a patriot. In 1968, Bell cast his vote for Richard Nixon and unapologetically supported an American presence in Vietnam. By 1971, Bell was divorced and living in Darien, Connecticut. He had worked on corporate litigation at one of Wall Street's most prestigious firms, and was currently doing similar work for another firm uptown. He was, however, restless. He liked the law because it had integrity. But corporate work was not always honorable, and, frankly, he found it tedious. Bell was no radical, but one of the reasons he had been attracted to the law in the first place was to do some good. He was coming to believe, however, that the civil cases he was working on made very little difference in the grand scheme of things. In 1973, Bell found himself wondering if he might try his hand at criminal law. At least it would be more exciting. That August, he saw an intriguing ad in a law journal that would change his life. The Attica investigation had placed a rather cryptic call for prosecutors. He applied and soon found himself sitting across a desk from Anthony Simonetti in the Attica investigation offices in Lower Manhattan. To his astonishment, he learned that this was an opportunity to work on one of New York State's largest criminal prosecutions ever. He was offered a modest $28,500 a year job, and he accepted it with enthusiasm. Bell was to be Anthony Simonetti's chief assistant, tasked with collecting and presenting evidence to Attica's grand jury of any crimes committed by law enforcement during the retaking and rehousing at Attica. A year into his stint at the Attica investigation, however, he had begun to wonder whether his superiors were in fact as interested in pursuing cases against members of law enforcement as they had been against prisoners. By 1975, Bell would find himself reluctantly at the heart of one of New York's most newsworthy whistleblowing scandals. 42. Joining the team. From Malcolm Bell's first days on the job at the state of New York's Attica investigation, it struck him as odd that so much effort was going into prosecuting prisoners from Attica when the officers had killed 10 times as many people as the inmates had won. However, the decision to investigate prisoner crimes before police crimes had been made well before Bell was hired. 2. In 1972, Deputy Attorney General Robert Fisher wrote to his boss, Louis Lefkowitz, that the prisoners' killings of C.O. Quinn and that of fellow prisoners Schwartz and Hess were more obviously homicides than the killings of correction officers John Montelian or John D. Arcangelo. 3. And, as he put it to an attorney from the Justice Department in these early years, any crimes members of law enforcement may have committed against the prisoners while rehousing them after the uprising were of a lower priority. 4. There had been pushback on this perspective. In October 1971, the Goldman panel had noted uneasily that the Attica investigation was concerning itself solely with the prisoners and not with members of law enforcement. 5. Even some of the individuals who had witnessed trooper abuse firsthand, such as National Guard Surgeon Dr. John Cudmore, began publicly airing the view that the state's disinterest in trooper crimes was outrageous and unacceptable. 6. State investigators had not even asked Cudmore about the horrific acts he had seen troopers commit until a full 2.5 years after Attica's retaking, and, as Cudmore pointed out to the press in disgust, it would be hard even to identify one's own children if this much time had passed since you had seen them. 7. As Malcolm Bell saw it, there wasn't anything wrong, per se, with his bosses investigating and indicting prisoners so zealously. If prisoners had committed crimes at Attica, Bell reasoned, then they should be held accountable. He too began to find it troubling, though, when it seemed that his colleagues were pursuing prisoner cases even when the scantness of evidence against the defendants was quite glaring. It specifically bothered him that the witnesses whom the state relied on to make its cases against prisoners, for example, had clearly changed their stories over time. It also seemed to him that these witnesses' memory of past events was vague at best. He had noticed with some serious discomfort that his colleagues were not above leading and coercing these witnesses to make their cases. 9. Bell's boss, Simonetti, and his fellow prosecutors were also uncomfortable with the ways in which at least the early evidence in their investigation had been collected, that is, by the investigators from the NYSB's own Bureau of Criminal Investigation, but they felt that they had gotten it back on track. They had not, in their view, done anything inappropriate to make their cases. And, in the early days, Bell was happy to see it this way as well. In fact, it was a good sign, he thought, that Simonetti had hired him to work on the so-called shooter cases, the incidents during the Attica retaking in which a member of law enforcement had fired his weapon at a prisoner or hostage without legal justification. Simonetti might have started with the indictment of Attica's prisoners, but he was clearly gearing up to indict troopers and Cos too. Simonetti had, even before Bell's hire, brought a case against a New York State trooper before the Attica grand jury in 1972. He had assigned the case to the only African-American prosecutor on the team, Ed Hammock, a former New York County Assistant District Attorney and head of a respected Manhattan narcotics rehab program, but no indictment followed. 10. Even though Hammock no longer worked in the office and Bell couldn't ask him what had gone wrong with his cases, Bell could see why he might have failed. 11. For starters, Precious little groundwork had been done on any case involving a trooper or a CO even by the time Bell had joined the team. No one had pieced together the evidence secured against members of law enforcement in such a way that an airtight case might be made. Bell had little more than inconclusive memos about the fatal shooting of 2 hostages on the catwalks and fragmentary memos about the deaths in the hostage circle, but there was no coherent story waiting for him when he was assigned to the shooter cases. Point 12. This, however, had advantages. Bell could approach the shooter cases with his mind as open as possible, vowing to work as hard to find evidence of officers' innocence as of their guilt. 13. And yet, the closer Bell looked at this evidence, and the more he compared the statements that troopers and COS had given to explain their actions with other evidence such as photographs from D-Yard, the more apparent it was to Bell that the statements didn't add up. For instance, the troopers who had fired from A and C blocks insisted that they had aimed only at prisoners who were trying to attack hostages, yet even a novice investigator could see from the photographs that there were no hostages or anyone else in the direction to which the inmates were running. 14. Countless prisoner witnesses had also made clear that if they had been able to move at all, they had actively fled away from the troopers' fire, certainly not run toward it. And it wasn't just the evidence that didn't support the troopers' statements, neither did common sense. 15. One NYSP sergeant who officially admitted to firing at prisoners offered 3 completely different versions of why he did so. At one point he said the prisoner was about to throw an object at him, but didn't state what it was. In another statement he said that he had been unable to make out exactly what that prisoner had in his hands because there was so much gas in the air and he had been wearing a gas mask. Yet this officer had also claimed on yet another occasion he knew for certain that the inmate had been wielding a Molotov cocktail. 16. Statements intending to explain how a trooper got shot in the leg in D-Yard during the retaking, the only trooper hit by a bullet, also troubled Bell. According to this trooper, State Police Lieutenant Joseph Christian, he had been shot when trying to get to the circle of hostages in D-Yard to rescue them. Armed with 2 pistols and a shotgun, Christian stated that he had been running toward the hostage circle when a prisoner ran at him with some sort of club and proceeded to hit his helmeted head with that object. Then, in order to save Christian's life, troopers on B catwalk claimed to have fired their shotguns at this prisoner, in the process not only wounding Christian himself in the leg, but also killing several of the state's own men, the hostages in the circle. According to this scenario, the hostages' deaths, while tragic and terrible, were wholly accidental and unavoidable and legally justifiable. Given that so many hostages in that circle had been hit by trooper fire, it was vitally important to Bell that the troopers' accounts be truthful. Yet he was troubled. Joe Christian's own statement, which was supported by a photo taken during the assault, made clear that he was right in front of the hostages when he got shot and not well off to the side as the troopers had maintained. This could mean that the troopers had been reckless to have fired at that time, and with that much power. 17. As troublingly, at least 3 of the 8 hostages had not been killed by shotgun pellets from B catwalk, they had been hit by rifle fire, and yet not a single rifle shooter admitted shooting at that area of the yard. In virtually all of the shooter cases, Bell was not investigating whether the shootings had resulted in death per se, he was trying to determine whether the shots themselves had been justified. Take, for example, the shooting of Sam Melville, the white prisoner who, having been incarcerated for bombing various buildings to protest the Vietnam War, had written the expose of Attica's profits from its laundry facilities, and had been a leader at the negotiating table. Members of law enforcement were openly thrilled that Melville had perished in D-Yard during the retaking, and Bell found the details of this shooting disconcerting. Firstly, according to several witness accounts, Melville had been shot to death while trying to surrender. And then, the trooper who took credit for shooting Melville was a BCI investigator and claimed that he had shot only in self-defense. Melville, he said, had been trying to throw a Molotov cocktail at him. Yet Bell could see from the evidence that no such weapon was located anywhere near Melville. Time and again, Bell found that trooper claims of having shot prisoners in self-defense had been completely fabricated. This was particularly evident when he closely examined the killing of a prisoner named James Robinson. Robinson had initially been shot by a .270 bullet, which did not kill him outright. Another trooper came upon Robinson lying on the ground, bleeding profusely, and proceeded to riddle the wounded man with shotgun pellets. Because this trooper was shooting at such close range, those pellets went into one side of Robinson's neck and out the other in a spray. To justify this shooting, this trooper took great pains to claim that Robinson had come at him wielding a knife. A gory photograph of the dead man showed a curved sword beside him as proof. Yet Bell quickly recognized two damning facts. First, photos taken seconds before and seconds after Robinson was shot showed him lying in exactly the same position on the pavement, and there was simply no way he could have sprung to his feet after being wounded from the .270 shot, lunged at the trooper, and then lain down in the exact same position between the time the two photos were taken. 18 As troublingly, in the first photo taken of Robinson by troopers there was no sword anywhere near him. But in the second photo again an image indicating that this man had not moved there was. 19 Someone else had clearly placed it next to him for that second photograph. The body of inmate James Robinson lies where he was killed. In the second shot, a weapon has been placed under his hand. From the Elizabeth Fink papers. Bell was particularly haunted by two prisoners' deaths, Kenny Malloy and Raymond Ramon Rivera. Malloy had been shot 12 times in the head and body, at close range. Rivera, who had been cowering in a hole prisoners had dug under the sidewalk, was similarly pulverized with 10 pellets. 20 Piecing together various accounts, Bell learned that at the first sounds of helicopters and gunfire, Rivera had squeezed himself down into this hole to shield himself from the gunfire. Rivera had no firearm, nor any other weapon that could have been construed as a threat to law enforcement. Nevertheless, a state trooper lowered his shotgun into the edge of that hole and fired off a round of buckshot into Rivera's leg, whereupon he quickly bled to death. 21 Trying to justify the shooting, this trooper had also claimed that he was acting in self-defense. His own embellishments in his statement, however, soon undid the veracity of this claim. He said that he hadn't used his own weapon, it was a shotgun that he had, fortuitously, taken from a prisoner. He was in fact, he wanted to show, a hero for preventing that prisoner from killing a hostage with the same gun. But it was common knowledge in Simonetti's office that the prisoners in D Yard had had no firearms. More than the discrepancies and outright lies in the troopers' accounts of their own actions, Bell was alarmed to find as he went deeper into the investigation that higher UPS in the New York State Police seemed to be deliberately hindering his investigation by either not cooperating or, quite literally, concealing evidence. Simonetti had actually warned Bell that the state police had refused to cooperate, withheld evidence, and generally obstructed our efforts to learn and prove what had happened, and now he was seeing this firsthand. 22 Back in October of 1971, when the U.S. Department of Justice had opened its own brief inquiry into possible civil rights violations at Attica during the course of the retaking and rehousing, one that ultimately went nowhere, its investigators had also been frustrated by the lack of candor from the state police and their unwillingness even to provide the statements that troopers had given right after the retaking. 23 For example, when FBI officials asked Henry Williams, the NYSP captain who had helped Major John Monahan orchestrate the assault and the head of Troop A's BCI team who had headed up the initial evidence gathering there, to turn over the trooper statements he had taken, Williams stalled. Their request, he said, would necessitate some checking on his part, and he never did turn them all over to the Department of Justice. 24. The truth was, since BCI investigators had tainted the collection of evidence after the retaking, neither Simonetti's office nor the FBI could be certain what evidence even existed. These state police investigators hadn't, for example, even asked any of the surviving prisoners what they witnessed, while all around them the police were shooting people and their processing of the crime scenes in D Yard and the catwalks seemed shoddy at best. 25 Captain Hank Williams had requested that the Niagara County Sheriff send men in right away to remove dead and wounded inmates and hostages, and as early as 10:30 a.m. on the 13th, he had those men start a cleanup operation that removed potentially vital evidence from the yards, from storage rooms, from the tunnels and from other unoccupied buildings. 26 This cleanup detail had completed its assignment long before any independent investigator arrived on the scene. 27. Yet Bell and his fellow attorneys at the Attica investigation suspected that there might be a great deal of evidence that the state police had collected and simply refused to turn over. Unfortunately, every piece of evidence they managed to force the NYSP to give them seemed compromised in some way. For instance, one batch of statements that BCI investigators had taken from the NYSP troopers who had participated in the retaking read not like objective shooter reports, but more justifications for killing, complete with tales of prisoners rushing at them and trying to kill them. Bell soon realized that these might not even have been the first statements taken on September 13. There were rumors of a first generation of handwritten statements that had been written on yellow paper. Perhaps the NYSP had instead turned over a second set of comparatively empty and innocuous statements that they took on September 15.28. In Bell's mind, this could mean only one thing: someone had decided that those troopers had needed to revise the statements with clearer justification of why they had fired so many rounds and wounded or killed so many people. No one had ever accounted for the actions of NYSP troopers on September 14, which caused Bell to wonder if higher UPS in the state police had spent that day debriefing their troopers and getting them to write new statements. This didn't mean that the more fantastical statements were useless to Bell, however. The one thing that they did provide, in a few instances, was evidence of which specific prisoners were shot by which specific troopers and, as important, evidence of which troopers had fired their weapons without justification and thus, in all likelihood, criminally. This would be a valuable start. If Bell could comb through these statements carefully enough, he might find some real leads to follow. If a trooper admitted to shooting a prisoner, for example, and Bell could show that his justification was bogus, then he might have some solid cases to bring to the grand jury. Other important paperwork was still lacking, however. Each troop that had sent men to Attica had made blotter entries of personnel and equipment dispatched to Attica, but had made absolutely no record as to serial numbers of weapons and to whom they were issued. 29 Then, between October and December of 1971, as the BCI had interviewed over 100 state police shooters from all over the state, 15 National Guardsmen, and a group of Wyoming County deputy sheriffs, there was zero effort to link individual weapons to individual shooters in the statements they gave. 30 Worse, one BCI investigator stated that he was told specifically not to conduct a weapons accountability investigation of those shooters he interviewed. 31 Another stated that he was assigned by Captain Williams only to conduct general interviews of state police shooters. He was not instructed by Captain Williams or anybody else to conduct a weapons accountability investigation during the interrogation. He was not instructed to obtain serial numbers or otherwise identify the weapon discharged by those shooters he interrogated. 32 Still another trooper had actually started a list of which weapons he was passing out to which troopers on the night of September 9, but then destroyed that list after he found out the next morning that some of the weapons he had listed had then been given to other troopers altogether. 33 Furthermore, none of the troopers who had fired weapons during the retaking had been asked to fill out a discharge of firearms form, which heretofore had been standard procedure, nor had they done any ammunitions accountability paperwork. 34 Bell well knew that weapons and ammunitions accountability were basic to police procedure, as were things like picking up expended shells and marking their location, and leaving bodies where they had fallen so that key measurements could be taken. 35 None of this had been done. Adding to Bell's investigative headache was the fact he needed to rely heavily on the NYSP's own photographic and film records of the retaking, but that evidence had been tampered with. 36 A camera had been filming throughout the rebellion and all through the day of the 13th, recording the sounds of hundreds of shots, but there was absolutely no footage of anyone actually shooting. Even more damningly, Bell could see that the state police shortened the tape from approximately 6 minutes of assault to approximately 4 minutes of assault before turning it over to the investigation. 37 One of the men who'd been filming for the state police blamed the problems with the visual evidence on technical difficulties. During the first few seconds of the assault, I had the Norelco machine recording, but because of the noise and activity, I turned it off. 38 Then, as soon as the rehousing began, and during the exact time the prisoners reported so much torture and abuse taking place, the tape allegedly ran out. 39 Either any visual evidence that might have incriminated a trooper had been excised, or it was never recorded in the first place. 40. Bell found similar problems with the NYSB's collection of still photographs. He discovered an amazing series of claimed malfunctions by state police personnel assigned to photograph the assault in operating their cameras or in having the photographs properly developed. 41. One NYSP photographer on the roof of C Block had taken an entire series of 35mm slides, which were turned over to Bell. However, when Bell's investigator Lenny Brown reviewed them carefully, he could see clearly that the film as numbered by Kodak showed two gaps in the sequence of photographs taken. Significantly, the first gap was about the time when a trooper would have been firing his shotgun through the neck of James Robinson in the vicinity of Times Square, and the next was when troopers would have emptied their pistols into prisoner Kenny Malloy. 42. The convoluted explanation offered for the missing photographs was that all the film packs were first sent from Attica to the New York State Police Photo Lab at Troop A headquarters. The color film packs were thereafter sent to the Color Processing Laboratory of the New York State Police at Troop E headquarters, and Troop E did not number their photographs in the same manner as did Batavia. 43. The more Bell probed, though, the more apparent it was that a simple difference in numbering or errors on the part of the photo lab techs could not explain what he had before him. Key photos had to have been removed before the state police turned them over to the Attica investigation. For example, Attica observer and highly respected State Senator John Dunn had told prison officials that he had seen prisoner Frank Big Black Smith suffering trooper and CO reprisals while laid out naked on a table in a yard, yet no such pictures were among those the NYSP had given his office. When Bell's investigator, Lenny Brown, finally obtained a photo of this moment not from the state police but from the individual Monroe County Sheriff's Office employee who had taken the photo, every detail of the story was clearly captured on film. Big Black lay on a table on his back in a yard balancing a football on his chest, while troopers in the frame shouted at him. 44. As upsetting as the missing photographs were on their own, the fact that troopers had actively tampered with the photographic evidence seemed worse to Bell. Had he not just happened to see the photo of slain prisoner James Robinson without a sword in his hand, he would never have known that a weapon had been planted in the later photo that the NYSP gave him. 45. Infuriated but undaunted, Bell pushed on with his investigation. His first order of business was to ask Anthony Simonetti how he might get the state police to turn over more evidence, and how prosecutors might address the tampering of the evidence they had discovered thus far. Bell recalled that Simonetti had asked him early on, in the fall of 1973, to explore whether they might go after police officials for conspiring to impede their investigation. It seemed like this might now be prudent. 46. As he considered his options, Bell devised another plan for holding troopers accountable for their shooting spree. The only way a trooper could be legally justified in firing his weapon was if it were demonstrably necessary to save himself or someone else from grievous bodily harm. If a trooper stated that he had fired in the direction of another person when there was no imminent danger, and if Bell could show that the justifying act had not happened, then he could perhaps indict that trooper on a charge of reckless endangerment in the first-degree charge, a Class D felony. 47. To determine whether threats to troopers or hostages had really existed, Bell could examine photographs, video, and numerous verbal accounts from non-Hooter troopers. Although not officially witnesses to the shooting in the assault, other very credible and totally disinterested people such as Dr. Warren Hansen, who had been brought into D Yard during the rebellion to tend to the sick, shared the view that troopers had exaggerated any threat to their lives or even the lives of the hostages on the morning of September 13, 1971. In Hansen's view, one based both on having come to understand the dynamic between the prisoners and hostages in the yard and then seeing footage of the assault, for most of the hostages no attempt was made to kill them and, when the shooting started, the executioners just dropped down to protect themselves. 48. While Bell remained committed to going after those who had killed prisoners and hostages, he was equally eager to pursue lesser indictments. As he put it, even if the highest crime for which most of the admitted shooters could be prosecuted was reckless endangerment, at least that was something. 49. Even going after reckless endangerment indictments, Bell suspected, was going to be difficult given the grand jury currently sitting in Wyoming County. After all, Hammock had tried to secure trooper indictments, and from what he knew of at least one of those cases, the jury's decision to let them slide was ludicrous. 50 Bell marveled, how could the jury consider the evidence and not indict this trooper? 51 All he could figure was that this particular grand jury had just been too close to law enforcement to consider indicting any officers. For this reason Bell was delighted in early 1974 to learn that Simonetti was going to ask Judge Ball to empanel a second grand jury. 52 There was still no guarantee of trooper indictments, but at least they'd get to select new jurors in this supplemental grand jury, and this just might make the difference. 53 The news that the state of New York was going to convene a second grand jury to assess crimes committed at Attica terrified the Attica defendants, who saw this as yet another attempt to frame them. The ABLD was filled with serious concern as well. The indictments rendered by the original grand jury had taken so much work, and so many resources, and the idea that there would now be a second one to contend with was alarming. The only group more unnerved by this news was the New York State Police. They knew well that this meant they were soon to be in the Attica investigation sights, and they felt blindsided and not a bit betrayed. From the moment the gas cleared from the air in D Yard, the highest-ranking officials in the state of New York had praised the troopers for their actions at Attica. Governor Rockefeller himself lauded their professionalism and hard work, as had Commissioner Russell Oswald, who had been subjected to much criticism from those same troopers. In an open letter Oswald had written for the January 1972 issue of Trooper, the magazine of the New York State Police, he appealed to them, "I am sure that you are as painfully aware of the criticism of both our agencies resulting from the events at Attica as I am. However, I am convinced that when all of the facts are known, both of us can be even prouder of the work of our respective staffs." 54. And even when Oswald had left the position of Commissioner of Correctional Services in April of 1973, the NYSP still had supporters in high places. Senator Ronald B. Stafford from the 43rd Senatorial District of New York, where Clinton Prison was located, responded with shock and outrage to the news of a second grand jury convened, possibly, to indict law enforcement officers. 55 He was disgusted that after years of intense pressure from radical groups and individuals, a decision was made to capitulate and use our law enforcement personnel as scapegoats for this tragedy. 56 The Police Benevolent Association of the New York State Police also came out swinging and demanded that the state provide troopers a legal fund to defend against possible indictments, claiming that it had already spent $200,000 of union funds to provide legal assistance to its members. 57 It also hinted that more monies might be due to address the mental anguish endured by the troopers and their families, which was considerable, the PBA president, Patrick J. Carroll, said. 58. Undaunted by this backlash, Malcolm Bell began building his cases for reckless endangerment and even for murder. Throughout February and March of 1974 he had met with Simonetti and others for shooter conferences, in which the main task was to sort out how many of the 128 shooting deaths and woundings at Attica had not been justified. Bell estimated that there were a minimum of 55 shots fired which could be considered criminal. 59 Simonetti agreed that there was enough evidence to bring at least 32 cases against troopers and cost to the grand jury for a range of crimes including a few attempted murders, a few perjuries, and mostly reckless endangerments. 60 By April of 1974, Bell had managed to identify about 70 state police and correction officers whom the grand jury might well indict, and, in his view, there were still more cases that could be pursued. 61. Malcolm Bell began presenting before the new Attica grand jury on May 8, 1974, along with fellow prosecutor Charlie Bradley. 62 Although Bell felt that he had a chance at indicting law enforcement with this grand jury, this new jury had some very close connections to that group. Two of the chosen jurors were aunts of one of the former hostages, Don Almeter. Another former hostage, Pappy Wald, had actually been considered as a possible juror, although he was dismissed. In addition, the Maine State Police lawyer, Bernard Bud Malone, had decided that any trooper witness called to the state would help the prosecution as little as they civilly could, and he allowed them, at times, to be outright obstructionist. Still, the jurors seemed interested in hearing why Bell thought that troopers and Koss had committed many provable crimes at Attica. Not a few of them eventually wore looks of dismay as they heard about all that the prisoners had suffered on the day of the retaking. 63 jurors seemed particularly to pale when they heard that one trooper had shot 4 pellets into a prisoner's thigh, and then, as that man writhed on the ground, another trooper became so irritated by his screaming from the pain of the pellets, he fired a shotgun slug through his ankle. 64. Jurors also seemed taken aback by former Attica hostage Michael Smith's appearance on the stand. Smith exemplified the costs of so much shooting on the day of the retaking. He had been a young CO when he was taken up on the catwalk as the retaking began, and then found himself shot multiple times. For years officials had maintained that Michael's severe wounds, including bullets that had exploded in his abdomen, were accidental, that he had been hit by the fragments of a single bullet intended for one of the prisoners on the catwalk. Prosecutor Bell was able to show the jury that something far more diabolical had taken place. Michael Smith's wound pattern, 4 bullet holes shot in quick succession and in a straight line, indicated that he had been shot by an automatic weapon and that he may well have been deliberately shot. 65 Only correction officers had wielded weapons that day that could have inflicted this wound pattern, and no correction officer could have mistaken Mike for a prisoner on that catwalk. 66 There was no doubt in Bell's mind that the CO who had shot Michael Smith had committed a crime. Still, he had to proceed carefully with all of his cases, particularly if the victim had been a prisoner whom jurors had seemed to care little about. He knew there was much inherent sympathy for members of law enforcement on this jury, and, if he overplayed his hand, they might balk when it came to voting to indict. A key problem was that the troopers' and Koss accounts of self-defense made for some persuasive testimony. One trooper, for instance, testified on June 13, 1974, that any prisoner who had been struck was absolutely resisting, and, indeed, he personally had witnessed prisoners who refused to cooperate. 67 And so Bell had to show jurors just how unable to resist Attica's prisoners actually were once the shooting began. Most effectively he pressed troopers who claimed to be acting in self-defense to describe the condition of the prisoners they saw all around them that day. Under oath, one trooper made clear that there had in fact been a lot of people screaming as a result of so much shooting, and that one man, a prisoner who had been shot multiple times in the thigh, was screaming quite a bit. 68 Bell could see the impact of this testimony on the jury. After 3 intense months of presenting evidence to the grand jury, Simonetti called Bell into his office to inform him that he had asked Judge Ball for a 3-week recess. This was fine with Bell until he realized that this wouldn't be just a short break. Simonetti was suspending only the cases he had been presenting and had, in fact, cancelled the 15 or so shooter case witnesses that Bell was planning to call before the jury. 69 Stunned, Bell pleaded with him to be allowed to continue, to no avail. Although Simonetti had appeared to be fine permitting him to take shooter cases before the grand jury, now Bell's efforts were being halted, in his view, counterproductively delayed, even though there was still much evidence to present. 70. And yet, once he thought about it, Bell realized that he had seen his superiors growing more uncomfortable with his efforts to go after law enforcement in recent weeks. To the extent that this had crossed his mind, he had just chalked this uneasiness up to the fact that prosecutors and police were natural allies and, therefore, it was understandably awkward. 71 But being unsettled by the prospect of indicting troopers for crimes was a whole lot different than actively preventing him from doing so, which, Bell realized, was what was happening. Although Simonetti gave no real explanation for this abrupt turn, Bell suspected the chain of command led all the way to former Governor Rockefeller. On August 20, 1974, newly sworn-in President Gerald Ford had nominated Nelson Rockefeller to be the Vice President of the United States. Rockefeller had tried to reach the White House many times. He had made a bid for the presidency in 1960, 1964, and 1968, and some thought that he had only resigned as governor of New York to do it again in 1976. 72 Rockefeller would certainly be unhappy if Attica got in the way of his chance to be the vice president, which well could happen if the troopers he had ordered into action were suddenly indicted for murder and other felonies. Confirmation hearings were about to begin, and the Attica investigation, should it be effective, might well make it hard for him to be confirmed. The subject of Attica would indeed come up many times in these proceedings. Countless witnesses testified about the role the former governor of New York had played at Attica: Representative Bella Abzug, New York Assemblyman and observer Arthur O'Eve, Lyndon LaRouche of the U.S. Labor Party, and Curtis Dahl of the Liberty Lobby. 73 Even some of the Attica prisoners came to speak. 74 None of this testimony was kind. Attica Brothers legal defense coordinator Haywood Burns and Angela Davis, the former Black Panther leader and now CO chairperson of the National Alliance Against Racist and Political Oppression, both came to the hearings and argued forcefully against confirmation. Among other things, they called attention to the former governor's moral duplicity in supporting Nixon's pardon while rejecting all consideration of amnesty for the Attica brothers. Burns argued, "The case for full and unconditional amnesty for the Attica brothers is as strong in every detail as the reasons advanced for pardoning Richard Nixon." 75 Rockefeller had indeed recently commended President Ford for forgiving the impeached former President Richard Nixon his sins, even called his pardon an act of conscience, compassion, and courage. 76 Davis pointed out that somehow, though, he didn't see the lives of more than 1,000 people at Attica, most of whom were black and Puerto Rican, as valuable. 77 She argued that Rockefeller's support of Richard Nixon's pardon while at the same time being responsible for the Attica massacre showed his contempt for equal justice under the law, his callousness and complete willingness to adopt the most lethal and brutal solutions to desperate social crisis born of human misery. 78 Perhaps Bell's suspicion that his cases were now being sidelined because of Rockefeller's political ambitions was overblown. The former governor in fact had a number of hurdles to overcome in these hearings, including having given major gifts to administration officials such as Henry Kissinger, using his fortune to undermine political opponents, and taking questionable deductions on his federal income taxes. Nonetheless, by waylaying Bell's hearings, there would no indictments of his troopers to cause any media uproar. On December 19, 1974, the former New York governor was confirmed. Bell very much suspected that Rockefeller supporters, including the Republican who succeeded him as governor, Malcolm Wilson, had wanted no chance of Attica making new headlines now, and Bell suspected that someone had made this very clear to his boss. 43. Protecting the police. The state officials would later contest Bell's characterization of the decisions made by the Attica investigative team. Something major had changed. In August 1974, when Bell's attempt to seek felony indictments against troopers was suspended, Simonetti explained his decision in a way that gave Bell some hope that his cases were being deferred for an even deeper investigation. According to Simonetti, they would now be trying to make cases against higher-ranking officials in the NYSP for hindering the investigation itself. 1. The plan had always been to go after the big shooting crimes first, and then to go after those high-ranking members of the NYSP who had made the job of investigating those shooting crimes so difficult by tampering with, or withholding, vital evidence. The fact that key slides had been removed from slide trays, that bullets had gone missing, and that entire swaths of film as well as radio transcriptions no longer existed, suggested that trooper shooters were being orchestrated from on high. This would also explain why state troopers had descended upon funeral homes after the retaking. A superior would have had to have dispatched these troopers, whom prosecutors had dubbed night riders, to lean on morticians to contradict Ed Land's account of how the men had died. At least one undertaker had been pressured to sign a written statement to the effect that there were no bullet holes in John Montelian even though he had obviously died from a gunshot. 2. Initially, it appeared to Bell that Simonetti was serious about going after the big fish in the NYSP. Bell estimated that out of the possible 30 or more cases of murder or manslaughter they might have been able to make against law enforcement shooters, only 5 to 7 cases were possible thanks to the state police's destruction of evidence, e.g., photos, death scenes, and their failure to collect evidence. 3. As Bell understood it, Simonetti was planning to present evidence to the grand jury against several ranking officers who had authority over the collection of evidence and who, Simonetti's office felt, had deliberately hindered the case. For Simonetti's main targets in this case included Lieutenant Colonel George Infante, the senior BCI man who had been at Attica right after the retaking as the police were collecting evidence in the yard, Major John Monahan, the Troop A commander who had been in charge of the retaking itself, and Henry Williams, the Troop A BCI captain who had also been instrumental in carrying out the retaking as well as taking trooper statements and collecting evidence when it was over. 5 Their intention was to show that Captain Williams had failed to order the recording of rifle serial numbers or the collection of expended shells, and he had ordered his men to bury evidence behind the prison, and instructed his BCI interviewers to stop short of asking about assault and brutality that followed the retaking. 6 Malcolm Bell, for one, believed that Williams should be implicated as well in preventing the Attica investigation from seeing incriminating photographs or troubling information in the state police's radio log, in sending the night riders to local funeral homes, and in making it so difficult to identify which trooper or troopers had been responsible for the death of prisoner Kenny Malloy. 7 NYSP Captain Henry Williams outside the prison, courtesy of the Democrat and Chronicle. The state felt it had a lot of damning evidence against Lieutenant Colonel George Infante, as well. If, according to Simonetti's office, Williams was the man who had carried out the cover-up at Attica, then Infante, the highest-ranking BCI officer at Attica on September 13, was its architect. 8 As they saw it, George Infante had not only been aware of what men like Williams had done to hinder a sound inquiry into trooper actions at Attica, but he also had played his own role in the cover-up. Bell, for example, suspected that Infante, who had supervised the BCI investigation to determine who fired what weapon, had gone to great lengths to protect at least one of the troopers suspected of killing Kenny Malloy. 9 That trooper claimed that he had acquired the gun used to shoot Malloy from a prisoner in D Yard, but his story later changed. According to Simonetti's office, Infante not only knew this, but he was personally involved in spinning the case. 10 In Bell's view, Infante certainly was aware of all the discrepancies, and as the commanding officer he should have made sure that all deaths were investigated thoroughly. The Attica investigation felt that it had the evidence to prove that Infante had instead tried to make the problem of this prisoner's death go away. When it was clear that the shooter's initial story wouldn't hold up, that trooper claimed that a nearby trooper handed him a shotgun, the one he admittedly used to shoot Malloy and fire several shots into the hole where prisoner Ramon Rivera lay cowering. 11 According to an internal report dated September 27, 1971, this trooper gave 6 different versions of the incident in Times Square on the 13th, and yet Infante, his main superior, never shared with Simonetti's office any of this evidence. That one of his troopers may have committed a crime in D Yard. 12 Later, whenever any prosecutor directly asked Infante about these deaths, all of his answers seemed evasive, argumentative, and gave little if any information. 13 The deeper Simonetti's team dug, the more Infante's impeding of the investigation looked to them like an outright cover-up of his trooper's crime. First, he had encouraged the trooper, a man he knew to have killed a prisoner, to resign and make himself scarce, which he had difficulty making the trooper do. 14 The man did submit his resignation letter on September 15, 1971, and the head of the NYSP himself, Superintendent William Kerwin, acknowledged this in a September 20, 1971, internal memo. But according to another memo sent on September 28, 1971, the trooper then balked and new pressure had to be exerted on him to go away. What was clear to Simonetti's office was that well before this, and certainly at any time thereafter, Infante, and indeed Kerwin himself, should have turned this trooper's name over to investigators. 15 It was possible that Infante had at least committed perjury and, if so, he should be held accountable. 16 Simonetti's office managed to get its hands on a number of internal memos that indicated quite a few high-ranking officials had vital information about the killing of Kenny Malloy but had concealed that knowledge. An NYSP inspector named A.L. Bardassi, for example, sent Infante a report regarding the Malloy killing way back on October 6, 1971. 2 days later, Infante had written another report to Kerwin, the head of the entire state police force, who had been noticeably absent when the Attica retaking went down. 17 Both documents indicated that real work had been done to ensure that the Malloy matter would just disappear. Even with these memos, as well as other evidence against high-ranking members of the NYSP, it seemed to Bell that Simonetti was now dragging his feet in these hindering cases too. Worse, Bell suspected that Simonetti was using the grand jury process to let the people in charge off the hook by granting them immunity. Under New York law, grand jury witnesses are automatically granted immunity from prosecution for their testimony. Therefore, it had been standard procedure for the Attica prosecutors to ask any member of law enforcement who had shot weapons, or had knowledge of such shooting, to sign a waiver of immunity prior to testifying before an Attica grand jury. Very few troopers willingly signed one for obvious reasons, yet putting someone on the stand without a waiver was always risky for prosecutors. The witness could, of course, reveal nothing of use and still be immunized from prosecution himself. And so prosecutors tried to bargain with such witnesses: if you give us something good, we are willing to put you on the stand without a waiver. 18 Some high-ranking members of the NYSP did willingly sign waivers, including Captain Anthony Malovich, the officer who had led the assault down Sea Catwalk, Captain John McCarthy, the trooper who led the team into D-Yard to rescue the hostages, and Superintendent Kerwin, the head of the NYSP. 19. Others, such as Major John Monahan from Troop A, who had helped plan and launch the retaking, did not. This could have been a setback to Simonetti's team, since what he knew might well be crucial to any case they hoped to build against a member of law enforcement for the actions they engaged in on September 13, 1971. But Malcolm Bell had figured out a way around this. To avoid immunizing Monahan from future prosecution, instead of calling him to the stand, Bell would enter as evidence his earlier testimony before the McKay Commission, in which he had said quite a lot that prosecutors felt could now be helpful in making the hindering cases. 20 To Bell's dismay, however, Simonetti unexpectedly put Monahan on the stand, granting him immunity by default, even though he had no agreement whatsoever that once he was immunized he would tell anything of value. 21. John Monahan, the man who, in Bell's estimation, was, at least physically, at the heart of the SP cover-up, was now fully off the hook for anything he may have done to prevent troopers from facing criminal charges. 22 He wrote immediately to Simonetti, reminding him that evidence exists which tends to establish that it was Monahan's decision not to obtain rifle and shotgun serial numbers from individuals who shot circa 100 people, and that at one point he shared with Lt. Col. Infante the questioning of one of the troopers who had killed inmate Kenny Malloy. 23 Simonetti was unsympathetic to this argument. And while Bell was still reeling from Simonetti's decision to immunize Monahan, his boss then decided to immunize Captain Hank Williams as well, even though Simonetti had seemed confident earlier that Williams would agree to sign a waiver of immunity. 24 This particularly distressed Bell, since he believed they had already presented ample evidence to the grand jury that directly implicated Williams in the majority of instances where the state's investigation had been actively impeded by the NYSP. 25. In the course of processing how it was that vital hindering cases had been allowed to implode, Bell eventually came to believe that a serious prosecution of members of law enforcement had in fact been set up to fail from the moment Simonetti had told him to switch his efforts from the shooter cases to cases of hindering the investigation back in August of 1974. Simonetti would have vehemently disagreed with this assessment of his strategic choices, but as Bell carefully deconstructed his work on the hindering cases, he was increasingly persuaded that his boss had sent him before the grand jury with cases that needed much more time and care to develop. In one instance he could remember clearly, he was sent in so unprepared that he didn't even know how to pronounce the name of the first witness. 26. Bell also began to feel that Simonetti's demeanor with various politicians whom he had previously held at arm's length was suddenly much more chummy. When asked, Simonetti denied that he was behaving any differently. For instance, although he had been asked to cooperate with the FBI background check on Rockefeller during the confirmation process, Simonetti insisted that this had not made him any less eager to prosecute crimes committed at Attica. Still, Bell thought it significant that he was suddenly no longer invited to meetings, say, with the FBI, surmising that his boss had begun to see him as a fly in the ointment. According to his fellow prosecutor Charles Bradley, it was true that Simonetti no longer trusted Bell. He had even asked Bradley to keep an eye on Bell in court. 27. Nevertheless, even with his boss now immunizing key officials in the NYSP from prosecution, Bell tried hard to push him to move against others in the NYSP where there remained compelling evidence of wrongdoing. Even before Simonetti put Captain Williams on the stand, Bell had written him a formal letter expressing his concern about the direction in which the investigation seemed now to be going. As Bell put it, "My basic fear, as you know, is that our investigation of a possible cover-up by the state police may itself become a de facto cover-up." 28 When Simonetti chose not to respond to Bell's letter and continued his plan to immunize Williams with no guarantee of getting anything useful for the prosecution's case in return, Bell's suspicions that the investigation was being sabotaged from within only intensified. 29. In time it began to worry Bell that Simonetti himself might actually be part of the cover-up. In addition to Simonetti's halting of Bell's shooter presentations to the grand jury, and then his immunizing of Monahan and Williams, Bell suspected that his boss had also protected a trooper who had watched the whole retaking from the roof of C Block and swore he saw none of the scores of shots which were fired where he was looking. 30 Bell had worked hard to prepare a perjury case against this man, spelling out on paper the powerful evidence that he planned to present to the jury, a paper that he then gave to Simonetti to look over. But after he read it, Simonetti did not allow Bell to take it to the jury. 31 Simonetti was, in Bell's view, actively thwarting equal justice under the law. And yet, Bell still had a hard time wrapping his head around this. He had, after all, managed to bring before the grand jury over 9,000 transcript pages of testimony before things began to deteriorate after August of 1974. And, of course, Simonetti himself had been the one to suggest going after the men with supervisory power in the NYSP. Bell was uncertain what to make of everything that had just happened. But then it soon became clear to him that he was not going to go before the grand jury, which was going to be disbanded. On November 7, 1974, and notably with Rockefeller still not confirmed in Washington, jurors had been told that when they did reconvene, they would have only 2 weeks of work before them tops. 32 Bell was thunderstruck. Not only did this grand jury still need to consider indictments in the shooter cases, but it also needed to hear cases relating to law enforcement brutality against prisoners when rehousing them after the retaking. Trying to impress upon Simonetti what a terrible idea it would be for him to disband the grand jury before its work was done, Bell sent his boss another letter, this one 10 pages long, on November 13, 1975.33. Simonetti had decided to deal with Malcolm Bell by ignoring him. When he failed to respond to Bell's latest letter, Bell finally realized just how isolated he had become and how unlikely it was that members of law enforcement would be prosecuted now, even though many others, not just him, had believed the evidence was there to do so. 34. 44. Smoking guns. A close look nearly 45 years later at the Attica investigation's own records, its internal memos, reports, and analyses of everything from ballistics to the locations of where individual prisoners, as well as hostages and troopers, were when the retaking of Attica began, reveals that Simonetti's office did in fact have a remarkable amount of evidence against specific members of law enforcement that did not result in the indictment of those men. With regard to the possible hindering of prosecution cases, men in Simonetti's office didn't just suspect that the top brass of the NYSP was involved in hiding evidence, they felt they had proof of such acts. The Attica investigation believed, for example, from the interviews it had done, and from the trooper statements that were taken right after the retaking, there was ample evidence that Captain Williams had actively assisted in setting up the BCI interviews of state police shooters on 9/13/71, and that, when he did so, the men taking the statements were not instructed by Captain Williams or anyone else to conduct a weapons accountability investigation during the interrogations, and were not instructed to obtain the serial number or otherwise identify the weapon discharged by those shooters they interrogated. One Attica investigators also had evidence from the internal memos and other NYSP documents they had seen that Williams's superior, Lieutenant Colonel Infante, among others supervising the BCI investigation, had decided that no one was to determine who fired what weapon. Further evidence indicated that Major Monahan was also complicit in this. Indeed, he had expressly said to one of his underlings that discharge of firearms reports wouldn't be necessary. 3 Even NYSP Chief Inspector John Miller, the senior NYSP officer at Attica who was ultimately responsible for this individual accounting, had decided not to follow that protocol. For Simonetti's office even felt confident it had identified the lower-level troopers who had also covered up evidence at Attica. 5 The BCI investigator from the NYSP who had been in charge of the Identification Bureau and Photographic Library, for example, had admitted that the film had been cut and attempted to be put back together chronologically but not numerically. 6 They also knew exactly who had deleted state police slides, by removing them from the slide trays before the police turned them over to the investigation. 7. As important, Simonetti's prosecutors were also quite certain they knew which troopers had shot their weapons without justification, and thus employed reckless endangerment under the law. Troopers had themselves admitted to the extraordinary amount of times they had shot their weapons, and time and again it was obvious that they had no legal justifications for the discharging of even one bullet or pellet. One trooper, J.R. Middlestead, had discharged at least 9 shots from his 12-gauge shotgun and admitted to hitting at least 3 people on B catwalk. 8 Another trooper, S.D. Sharkey, had hit another 3 people at least by shooting into D Yard and near Times Square. 9 In fact, Simonetti's team knew that a total of 364 trooper rounds had been fired, and the troopers' justification for these shootings had not been corroborated. The actions of Koss as well were identified as likely or possibly criminal. One CO, Nicholas DeSantis, for example, had shot more than 12 rounds from his .45 caliber Thompson. Even if it were true, as he claimed, that all of these shots 6 into D Tunnel and 6 into D Yard were misses, his firing, in the state's view, might still be deemed reckless. 10 As might the 18-round CO Howard Holt had fired with his .351 rifle, all onto D catwalk where prisoners stood. 11 On the day of the retaking, correction officers had fired more than 70 rounds into Attica's yards and onto its catwalks, and state prosecutors were able to determine who had fired the vast majority of the shots, even when they seldom knew whom the shots had hit. 12. Most damningly, Simonetti's office believed it knew exactly which trooper or CO had killed specific prisoners on the day of the retaking. Internal memos suggest that investigators had evidence that Trooper James Middlestead shot prisoner James Robinson through the neck at a range of 2 to 5 feet, breaking his neck and killing him instantly. 13 Simonetti's office also indicated that it knew who had killed prisoner Bernard Davis. Davis had died from more than 23 gunshot wounds, and one internal memo identified that officer as P.F. Stringham. 14 According to other documents, C.O. Stringham had also likely killed another prisoner Milton Manyweather. 15 One Attica investigator testified that Paul F. Stringham, armed with his own personal Brownie SIG 12-gauge shotgun loaded with 5 deer slugs, had identified a photo of P5, Milton Manyweather SIG lying on the catwalk to the right of Times Square, as the one he shot. 16. State investigators in fact had a long list of troopers and Koss whom they had evidence had killed or severely wounded prisoners. A trooper named Malcolm Heegman had himself identified photo 1C5, of inmate Melvin Ware, as the inmate he shot. 17 They also seemed to know the trooper whose shots had hit prisoner Milton Jones, and that trooper Gregory Wildridge had been reckless with his shooting, as well as hitting several specific prisoners who then perished. 18. Prosecutors also knew a great deal about the killing of prisoner Tommy Hicks. According to his autopsy and internal investigative memos, Hicks had been riddled by 5 bullet wounds from both a .270 rifle and .00 buckshot, and investigators believed they had sufficient evidence to show that the .270 had been wielded by Trooper Milford Clayson, and that Trooper M. Michael Grogan was also a likely shooter in this case. 19 Notably, investigators had also linked Trooper Clayson to the shooting of prisoners Lorenzo McNeil and William Taxi Cab Allen. 20. New York's Attica prosecutors had far more evidence to work with than the lack of law enforcement indictments implied, even for some of the most high-profile prisoner killings. For instance, although no one was indicted for the killing of L.D. Barkley, the 21-year-old prisoner with the granny glasses whose passionate speech in D Yard had been nationally televised, Prosecutor memos suggest that they had some serious leads. For starters, there was the testimony and statement of CO Ronald Hollander, who reported that he had fired one solid round at an inmate in D-Yard wearing granny glasses and a sweatshirt, and investigators noted his subject was inmate Elliot Barkley, 21. Whether it was Hollander's bullet that actually killed Barkley, or that of another CO who had also bragged of his killing and claimed to have kept the glasses on his mantle as a trophy, is not clear in the state's records. Point 22. What is clear, however, is that a number of COS knew who had killed this high-profile prisoner, and the state also had a number of promising leads to ascertain who that was. Simonetti's office also failed to take to the grand jury another member of law enforcement, BCI investigator Vincent Tobia, who had actually signed 2 statements admitting that he had shot a man whom he described as threatening him with a basket of Molotov cocktails. Simonetti's investigators believed that the man who was shot was Sam Melville, Attica's famous white radical prisoner, also known as the Mad Bomber 23. The McKay Commission's report from 1972 indicated that the man who shot Melville had indeed admitted to doing so. As that report put it, he was shot by a law enforcement officer who admitted aiming at him and stated his belief that he was justified in shooting him. 24. The photographic evidence did not support Tobia's claim. Only a jury could actually have determined whether or not this was murder, but lawyers for the prisoners had always felt strongly that Melville had been murdered in cold blood with his hands in the air in surrender. According to them, in a later civil trial, Tobia testified proudly that he had indeed killed this famous prisoner. 25. One of the ugliest prisoner deaths was that of Kenny Malloy, who had been viciously shot at close range. His skull had been riddled with so many bullets that his eye sockets were shredded by the shards of his own bones. Indeed, so gruesome was this shooting that one of the 2 troopers whom investigators knew to be responsible for shooting at this prisoner later spoke of having nightmares about seeing brains. 26. This trooper, according to an internal investigative report, was a man named Aldo Barbolini. He had shot Malloy with his .357 Magnum Smith & Wesson. 27. The Attica investigation was persuaded that Barbolini also had killed Ramon Rivera, shooting directly into this tunnel where Rivera fearfully lay. 28. From the earliest days of the investigation, Simonetti's office had looked closely at Barbolini, but all NYSP brass had been making sure that the investigators were told nothing. Significantly, the highest-ranking officials in the NYSP, including Lieutenant Colonel Infante, knew of Barbolini's actions that day and, as Bell saw it, they conspired to cover them up. According to an internal NYSP memo, Trooper Barbolini had been asked to resign on September 17, 1971, and, according to a New York State senator who later contacted the Attica investigation about the matter, Barbolini had specifically been told by his superiors that if he resigned he would not be prosecuted. 29. Through the rest of 1971, there was much internal discussion of how to deal with Barbolini. The NYSP brass was clearly still worried that his actions might come back to haunt them. 30. In October, Captain Hank Williams had called a fellow NYSP captain to advise him that 2 members of Fisher's staff traveled to the residence of former trooper Barbolini to interview him in regard to the investigation. 31. But, because Barbolini refused to speak to the 2 investigators, and the brass played dumb regarding what it knew, the Attica investigation limped along with regard to a case against this trooper. 32. Meanwhile, Barbolini, who had only worked as a trooper since May 6, 1968, liked his job and he kept trying to get it back. This clearly wasn't what his bosses had in mind, however, and they shut him down in January 1972. 33. Barbolini wrote again to ask not only to get his job back, but also to have his .357 Magnum Smith & Wesson revolver returned. At that point NYSP Chief Inspector John Miller personally replied with a curt no. 34. The gun, which wasn't even legally registered, was potential evidence against the NYSP. 35. Ironically, had the NYSP brass not expended so much energy on Barbolini in those early days, and had Lieutenant Colonel George Infante not involved himself personally with the internal investigation into this trooper's actions in D-Yard, prosecutors might never have known about him. Instead, they wondered what was so interesting about this particular trooper's actions. 36. Whenever anyone from Simonetti's office asked this question, though, the NYSP responded that this task of investigating Barbolini was merely an administrative issue. 37 No one bought this, particularly since this very trooper, and his actions in D Yard, had been the topic of discussion on September 24, 1971, in the private meeting that was held at Governor Rockefeller's pool house. This was the first of the 3 meetings in which state officials worked to get the Attica chronology straight. 38. Another trooper's shots, Simonetti's office suspected, had also contributed to Kenny Malloy's terrible and untimely death. According to an internal memo from state prosecutors, that officer was Gary Van Allen. 39. Simonetti's office not only believed that it had important evidence regarding who had killed prisoners, it also believed it had evidence relating to whose firing on September 13 had caused hostages to die. Take the case of those COS and civilians who had been shot to death in the hostage circle in D Yard. The story state investigators had been told regarding why troopers had shot so many pellets and bullets into that area was that they had been trying to save fellow trooper Joseph Christian from a prisoner who was attacking him. 40 From the beginning, Attica investigators like Malcolm Bell had seen some real problems in this story, specifically with regard to where exactly Lieutenant Christian was, versus where he claimed to be, when the shooting spree commenced. But even if there were some discrepancies, the real issue was whether the extraordinary number of shots that had been fired into that area were reckless. Had this shooting, which had led to hostage deaths and could have killed Christian, been justified? Simonetti's men painstakingly pieced together exactly where every hostage was in the circle, as well as where gunfire was coming from on the catwalks and in the yard near the circle, and which troopers were specifically assigned to those positions. Christian's rescue detail had included 25 regular troopers as well as 2 correction officers, and investigators discovered to a great degree which of these men were shooting what and where. 41 Lieutenant Kenneth Crowns had shot a round of .00 buckshot while in or near that circle, as had Milford Clayson, Thomas Griffith, and Michael Grogan. 42 So intense was their firepower, at least 14 different shots or 126 pellets had been fired in the direction of the hostage circle that the investigators marveled that any of the hostages had managed to survive the onslaught. 43. Quite a few of those shots were totally unaccounted for in the trooper statements, but with the information they had about other shots coming toward the hostage circle from elsewhere in the yard, there were strong indications of who else besides Crowns, Clayson, Griffith, and Grogan might have been responsible for hostage deaths. 44 One trooper, identified in the records as A. Krug, had admitted to firing 2 rounds of .00 at a prisoner just behind the hostage circle. 45 Another trooper, Jerry O'Hearn, had acknowledged that he too had shot a round of .00 at a prisoner who he alleged was attempting to stab a hostage. 46 Yet another trooper, William Staples, stated that he had shot a round of .00 at inmates coming at him with a knife. 47. Every detail mattered. Prison employees the state's own had died in that barrage. Hostages Edward Cunningham, Elmer Hardy, Richard Lewis, and Elon Werner had died on the scene from the .00 pellets that troopers had sprayed into the circle. Hostage Harrison Whalen eventually died at Strong Memorial Hospital. Simonetti's team would have had a difficult time connecting each of these deaths to one specific trooper's shots, especially since, unlike bullets, pellets can't be linked back to a specific weapon. Still, they had evidence that jurors might well have deemed the shootings unjustified and, therefore, a felony reckless endangerment if not manslaughter or murder. There could be no doubt that such shooting had put the hostages in serious jeopardy. 48 As one memo stated clearly, troopers Crowns, Griffith, and Clayson fired a total of 54 pellets at their targets in the area of the hostage circle, and, as important, it indicated that the location and direction of fire of the 3 are consistent with causing the wounding of the deceased and injured in and immediately near the hostage circle. 49 Trooper Clayson had admitted that he had fired his shotgun from B catwalk 4 times at a platoon of armed blacks who were rushing the hostage circle, but not only did Attica's prosecutors conclude that no such rush occurred, they also determined that Clayson's 4 shots, 36-48 pellets, had likely killed and/or injured a number of hostages and inmates. 50. Even when investigators were dealing with bullets instead of pellets, it was difficult to tie the deaths of specific men in D-Yard to specific troopers. Though investigators knew for certain that hostage Carl Vallone had been killed by a .30 caliber slug, and they knew that this came from someone's personal weapon and that these were mostly carried by Koss on the day of the retaking, they had no idea whose gun the bullet came from. .51 Several of the hostages had died from troopers shooting rifles, some in the hostage circle, such as civilian Herbert Jones and CO Ronald Werner, and also hostages up on the catwalks, such as John D'Arcangelo. It was remarkable how much Simonetti's office managed to figure out despite the lack of cooperation and the attempts to block them. With regard to the killing of hostage John D'Arcangelo, for example, they knew the approximate location of the rifle that had killed him, and therefore it became a matter of narrowing down who was shooting rifles from that area. 52 In time, Attica prosecutors zeroed in on several likely .270 shooters: Trooper Frank Panza, Trooper Richard Janera, and Trooper Stephen Sharkey. One internal memo noted that Panza's shots could have hit D'Arcangelo, while another memo speculated that Janera was a more likely candidate. 53 The latter memo noted that Janera had possibly hit two prisoners in addition to D'Arcangelo, and included a statement that ballistics consistent with D'Arcangelo. 54 Still another memo suggested that prosecutors also should strongly consider possibility that Sharkey's shot may have caused the D'Arcangelo fatal injury. 55 Ironically, it was Sharkey's own convoluted statements that had persuaded prosecutors that his actions may have led to D'Arcangelo's death. In one early interview, Sharkey described looking down at the catwalk at the exact spot where D'Arcangelo stood. Then he admitted firing on the inmates both to the right and to the left of D'Arcangelo. 56 Asked whether this hostage was still on his feet at all after he fired his rounds at these inmates, he answered that he was not. 57 In another statement, Sharkey said that he had looked through the scope and saw the hostage D'Arcangelo, and fired his 6 rounds in about 3 minutes. 58 The state even knew which trooper gun fired from C Block had killed D'Arcangelo, but they had no way of proving who had wielded that weapon. 59 The state prosecutors had quite a bit to go on regarding who had severely wounded hostage Michael Smith. They knew that the bullets that hit Smith came from correction officers' guns. The trajectory of those bullets indicated 2 likely suspects, including correction officer Daniel Clear. 60 Prosecutors also knew there were only 2 Koss firing from the roof of A Block down onto a catwalk. 61 They zeroed in on Daniel Clear, who had fired 4 shots, 3 on a catwalk, as the one who likely shot his fellow officer Michael Smith. 62 Significantly, C.O. Clear's statement was missing from the pile the NYSP eventually turned over to the investigation, but from the many others that the Attica prosecutors did have to pore over, they seemed to believe that Clear had shot Smith, and that Clear had in fact been armed with 2 guns on the day of the retaking: a .351 automatic rifle and an AR-15 automatic rifle. 63 Although questions appeared to remain in the minds of Attica's prosecutors about CO Daniel Clear's role in wounding hostage Michael Smith, they had no doubts whatsoever about who had killed hostage John Montelian. 64 An internal memo explained, Montelian had been killed by a .44 Magnum rifle, and this weapon, serial number 10004, was eventually recovered from a correction officer, J.P. Vergamini, who had, according to the coroner, gone home, got his deer rifle, and came back and shot one of his colleagues from his position on the 3rd floor of one of the cell block galleries. 65 Numerous documents from the Attica investigation indicated that everyone knew exactly who had killed John Montelian, everyone but John Montelian's family. 66 Malcolm Bell wasn't sure what he thought about a possible case against Vergamini because he felt that this killing may actually have been accidental. After all, Vergamini himself had never denied that his bullet had hit John Montelian, but he claimed that he was trying to fire at a prisoner-made barricade. Still, Bell knew that this killing required prosecutorial attention. Even a cursory probe of this shooting had revealed to Bell some troubling details in Vergamini's story. He had insisted that he had been trying to fire at prisoners standing by their handmade barricade, but John Montelian was 70 feet beyond the barricade and somehow he was still felled by the bullet he took in the chest. 67 As Bell pointedly put it, 70 feet was not a small margin of error and the effect was to kill him. 68 Either way, there was a case here. Even if Simonetti's office didn't want to indict Vergamini for murder, or even manslaughter, there seemed little question that his shooting had been reckless. In order to forestall the possibility of any charge, Vergamini's attorney proposed letting his client testify to the supplemental grand jury under a waiver of immunity that there had been much reckless shooting on the day of the retaking so that the state could build other cases with information he would provide. 69 Even this was not to be. As Bell explained, at the end of the day Tony Simonetti did not let me call him to the jury. 70. By the fall of 1974 it was clear to Malcolm Bell that no matter what evidence his office had against members of law enforcement at Attica, he would not be allowed to present it. 45. Going public. Malcolm Bell was well aware that his predecessor Ed Hammock had tried and failed to indict troopers before the first grand jury. After he had been there a while, he had watched as fellow prosecutor Frank Cryan also tried unsuccessfully to indict another trooper. As it turns out, however, there were other attempts to indict troopers and costs that Bell did not know about both before he joined the Attica investigation and after he had been sidelined in it. The Attica investigation had, at some point, tried to indict CO Daniel Clear for murder, manslaughter in the first degree, and manslaughter in the second degree, CO John Vergamini for manslaughter in the second degree and criminally negligent homicide, and Trooper Frank Panza for assault in the first degree. 1 They also would try to indict Major John Monahan on the charge of perjury, even though they had immunized him from other possible criminal charges. In each case, however, the first Attica grand juries had voted to no bill these troopers and costs, which meant that they had declined to indict. However, even if Bell had known about these attempts to indict members of law enforcement, attempts that Simonetti could certainly point to as proof that he was not ignoring or avoiding cases against law enforcement, his own suspicions of a cover-up at the Attica investigation would likely have persisted. For some time after he arrived in Simonetti's office, Bell had been told by his boss that the first grand jury was simply too sympathetic to law enforcement to indict no matter what the evidence. This might well have explained Ed Hammock's earlier disappointment before the grand jury, and this is certainly how Bell understood his colleague Frank Cryan's more recently failed attempt to indict Trooper Gary Van Allen for murder, manslaughter in the first degree, and assault in the first degree. 2 Indeed, this is a key reason why Simonetti had pushed so hard to get a second Attica grand jury impaneled, and why Bell had been so relieved to learn that he would get to present his cases to a totally new body. 3. But while Bell certainly had begun to see Simonetti's actions vis-a-vis his cases as his attempt to protect law enforcement, he now began to think that his colleagues who presented before the first Attica grand jury might also have been thwarted from on high. The more he considered his own situation, the more he felt that even before he was told to stop presenting his cases, his boss had made it unnecessarily difficult for him to call the best witnesses, or to utilize the best strategies in front of the jury. Yes, some of his colleagues had been allowed to take law enforcement cases to the grand jury, but Bell wondered if they had really been allowed to make the strongest case they could have. Was it the case that the first grand jury was unwilling to indict troopers and costs because they were biased toward them, or were the cases presented by the prosecution too weak to support? Bell couldn't know for sure, but his suspicions that the prosecutors really didn't want indictments might well have been confirmed by the fact that, according to Newsday reporter Edward Hershey, the Attica grand jury had actually voted to indict a trooper whom prosecutors said had killed John D. Arcangelo, but then someone in the Attica prosecution chose not to proceed. 4. By the close of fall 1974, Bell had begun to worry that he had stumbled upon an outright conspiracy to protect Attica's shooters, one that reached to the highest level of his own Attica investigation as well as to the office of the former governor, Nelson Rockefeller. On December 4, 1974, Bell received a phone call that he believed would allow him to test Anthony Simonetti's commitment to equal justice in the Attica investigation. The caller was a man with high state police connections who was reaching out to Bell because he said he had vital information for the investigation. 5 This evidence, Bell learned, might significantly bolster the hindering cases, those against the highest officers in the NYSP, for preventing the Attica investigation from doing its job, as well as the original shooter cases. 2 days later Bell met this informant at the Tarrytown Hilton and confirmed the value of his information. This man indicated that key NYSP tapes from the retaking did still exist, though the police had sworn under oath that they did not, because all tapes were routinely recorded over. Bell typed this good news into a memo for Simonetti. To Bell, however, Simonetti seemed unsettled by this lead, and was not at all eager to use this information. After barely discussing it, Simonetti demanded to know the name of Bell's source. Bell explained that he couldn't reveal that, at least not yet. Simonetti responded that Bell was hereby suspended. 6 To Bell, it seemed clear that Simonetti feared such new evidence could make the fire that he had been trying to put out under cases against top NYSP officials suddenly flame out of control, and he wasn't about to let that happen. 7 While suspended, Bell contemplated all that had happened in his shop over the previous year, and tried to figure out how to turn things around if that were still at all possible. If he had any hope at all of getting the state of New York to prosecute anyone who wore a badge, Bell finally decided, he would have to go above Simonetti's head, maybe to Attica Judge Carmen Ball, maybe to the Attorney General of New York, Louis Lefkowitz, or maybe even to New York's incoming governor, Hugh Carey. And yet, as Bell mulled over this possibility, it dawned on him that it could well put him in harm's way. A great many people had gone to great lengths to make sure that what he knew wouldn't become public. Wouldn't he now be seen as a threat by a whole lot of troopers who had shown themselves to be trigger-happy? Bell decided he would have to both lay low and to resign from the Attica investigation so that he could shine needed light on it. While at a friend's house, Bell penned his resignation letter to Attorney General Lefkowitz. Then he began going through the many Attica investigation documents he had in his possession. In the meantime, just to be safe, Bell also carefully instructed another friend to send all of these many documents to either Tom Wicker at the New York Times or to Jack Anderson, a journalist in D.C., should he end up in, say, a perfectly plausible accident with a truck. 8. On Tuesday, December 10, Bell sent his letter of resignation to Lefkowitz and laid out precisely what he hoped would happen next. My objectives have been to see that all the facts which are necessary for the grand jury's votes and report are placed before it, and that equal justice applies to inmates and officers. I would like nothing better than to complete the full investigation before the supplemental grand jury, and participate in any trials thereafter. It is clear to me, however, that the investigation is being aborted, beyond my power to help. 9 After sending off his letter of resignation to Lefkowitz, Bell also decided to phone Judge Carmen Ball. It was important to Bell that Ball not disband the grand jury, as he knew Simonetti was going to ask him to do. Judge Ball seemed wholly uninterested in hearing Bell's concerns, and rather than being moved to act, New York's highest-ranking legal official, Lefkowitz, simply accepted Bell's resignation on December 23. Lefkowitz then delivered a copy of Bell's 4-page letter to Mr. Justice Carmen Ball and also sent one on to Governor-elect Carey. 10. Bell's resignation letter set off a firestorm of worry and finger-pointing within the Attica investigation. Prosecutor Charlie Bradley was surprised that Simonetti did not have a nervous breakdown in the wake of Bell's surreal suggestion that he was overseeing a cover-up. 11 The only saving grace Bradley could see was that Bell had been an outsider from the very beginning, and therefore maybe no one would pay his allegations much mind. 12 Bell had heard nothing from his former boss, so he just assumed that no one had even given one thought to his claim that crimes were being covered up. A full 10 days after submitting his letter to Lefkowitz, the same day that the Attorney General sent a copy to the Governor-elect, Bell finally received a letter from the Attorney General which merely accepted his resignation and wished him success in the future. If Lefkowitz or Simonetti hoped that their highly disgruntled employee would eventually just go away, they were bound for disappointment. As Malcolm Bell waited for some sign that the Attica investigation might re-energize itself, or formally respond to his charges, he thought about ways to take his information to someone who might act. In January of 1975, Bell wrote up a systematic account of what evidence he and his fellow state prosecutors thought they had regarding crimes committed by members of law enforcement at Attica, and exactly what his bosses had done, in his view, to make sure no one was held accountable for those crimes. Underscoring his certainty that troopers and cops were being protected, Bell noted that there were 8,000 pages of testimony in the grand jury proceedings on possible crimes by law officers, pages that the highest-ranking politician in New York should carefully consider. Point 13 On January 30 he sent his report, 89 typed pages with an additional 71 pages of supporting documents, off to now Governor Carey. Point 14. Once again, Bell heard nothing. His report had pulled no punches. It was crystal clear that he wanted his charges reviewed right away in the interest of salvaging the investigation and completing a proper presentation to the jury. Insofar as these objectives are still obtainable. 15 Bell promised the governor that unless files of the investigation have been destroyed, everything he claimed was fully provable and that the myriad documents that Simonetti alone had in his possession were evidence of the investigation's lack of integrity. 16. And Bell's report had offered Governor Carey specific examples of specific crimes that had been committed by specific troopers. He named names and clearly indicated that his office had plenty of evidence with which to possibly indict many troopers and cause for crimes against prisoners and even their own fellow state employees, the hostages ranging from reckless endangerment and assault to manslaughter and murder. Lest the governor feel uncertainty as to why none of the trooper or CO crimes at Attica had been prosecuted, Bell emphasized that higher UPS in the NYSP had actively sabotaged any attempt to do so. He pointed out, for instance, that although reporters from the Los Angeles Times and the New York Times had managed to listen to the NYSP's radio scanner during and after the assault and had transcribed in rich detail what troopers were saying and doing on the ground during the most crucial hours of the retaking, there was much not included in the NYSP's official log of these tapes, which had been transcribed later back at the Batavia Post by the police themselves. Point 17 That official log indicated that there were no messages received between 9:53 and 10:30, it reflects no messages sent between 10:12 and 11:30, and, according to the NYSP officer who had been asked to make that transcript, it was Major Monahan, the man who had led the Attica retaking himself, who ordered him to compile that log sometime after 9/13/18. Similarly, deliberate sabotage had taken place with the NYSP photographs. Bell's report explained how Lieutenant Thomas Constantine of the NYSP had admitted that an NYSP sergeant, perhaps on the orders of another lieutenant, had moved certain slides from the slide trays to the academy safe before the slide trays were turned over to our investigation. 19 Between this sort of obstruction of justice, and the fact that the state police had buried the tents, tables, etc. that had been in the yard behind the prison before they could be examined for bullet holes, Bell was hopeful that Governor Carey too would see that a cover-up had been attempted and that he would make sure that Attorney General Lefkowitz stepped in so that the Attica investigation could get back on track and operate with integrity. 20 Meanwhile, however, it was clear that Simonetti's office was continuing to handle the NYSP with kid gloves. Even though Lieutenant Constantine had likely seen the murder of prisoner Kenny Malloy, for example, since he went down C catwalk behind or with Capt. Malovich's assault force and reached Times Square about the time Malloy was being shot, according to Bell, Simonetti didn't even push him on whether he had. Point 21. Bell's document claimed, in no uncertain terms, that there had been a cover-up, straight and simple. So many men had tried to prevent a true accounting of crimes committed at Attica, from the highest offices of the government to the troopers and COS at the local level. Bell pointed out that Rockefeller's office, from the very beginning, had sought to discredit Coroner John Edland and his finding that law enforcement bullets had killed hostages. Point 22 He noted as well that from the earliest days of the investigation until as late as the fall of 1974, Rockefeller attorney Michael Whiteman was not responding to certain requests for information that Attorney General Simonetti had made of him regarding information about the killings in D-Yard. Point 23. Despite the detailed and dramatic evidence presented in his lengthy report to Governor Carey, again he heard nothing. As 1 week became 2, Bell grew increasingly anxious because he desperately wanted someone to do something before the second grand jury was discharged. 24 On February 11, 1975, Bell called Carey's office. A secretary confirmed that his report had indeed arrived, but that it was sitting on the governor's desk unread. 25 Bell was incredulous and, less than a week later, he followed the phone call with a letter asking the governor to respond with all possible speed. 26. The governor did eventually read Bell's detailed and explosive document, which he immediately shared with both Lefkowitz and Simonetti. The trio needed to figure out if there was any good way to address Bell's charges without opening Pandora's box, without antagonizing NYSP brass as well as many other important political figures in the state. Carey was savvy enough to realize that this document could place his brand new gubernatorial administration at the epicenter of a public relations nightmare. Bell, ignorant of Carey's internal deliberations and still hearing no response to his letter, decided that he needed to get a lawyer to figure out his next steps. He secured the services of Robert Patterson, the high-profile attorney who had also been a member of the Goldman panel, one of the groups that had entered Attica to check on the prisoners after the retaking. Governor Carey's counsel asked Patterson and Bell to sit down with Lefkowitz and Simonetti to see if they might come to some sort of meeting of the minds. 27 That meeting, however, never took place, and Bell's conviction grew that his only remaining recourse was to go public regarding this cover-up. When, by March 25, nearly 2 months after submitting his report, he still had heard nothing from Carey, Bell decided to go to the New York Times with his story. He first approached Tom Wicker, who he remembered had been one of the original observers at Attica. Wicker said that he would speak with the Metropolitan editor about sending an investigative reporter to talk to him. The next evening, reporter Myron Farber showed up at his door to hear Bell's account of what had been happening at the Attica investigation. 28. Farber knew that he had a powder keg of a story on his hands from the instant Bell revealed it to him. He remained frustrated that Bell was so principled that he would not share any grand jury evidence and wouldn't publicly name names, but he knew he had enough even without these specifics to make national and even world headlines. 29 At that very moment, Attica was already very much in the news because the jury was deliberating in the John Hill and Charles Pernisalis case. 30. Myron Farber's story, published in the Times on April 8, 1975, pulled no punches, and unsurprisingly created quite a firestorm, especially thanks to the attention that ABLD lawyers brought to it. To them, Bell's allegations were powerful confirmation of what they had always suspected was happening within the Attica investigation. Ultimately, it fell to Governor Carey, not Attorney General Lefkowitz, to deal with the most immediate fallout from the revelations in the Times. Realizing that he had sat on Bell's lengthy and well-documented report that indicated major and outrageous failings on the part of New York State's own, very expensive, Attica investigation, Governor Carey moved into high gear. Behind the scenes, the governor began a feverish attempt to protect his office from a potential public relations disaster. For starters, he requested that Lefkowitz publicly respond to the allegations immediately. 31 As a new governor, he simply could not have the citizens of his state, who had been paying the cost of the Attica investigation for almost 4 years, think that he had ignored evidence that this investigative body was corrupt. 10 days after the story appeared in the New York Times, the Attorney General appointed former State Supreme Court Justice Bernard S. Meyer as a Special Assistant Attorney General to evaluate the conduct of New York's official investigation into the retaking of the Attica Correctional Facility in the days and weeks thereafter. 32. This decision, however, did not exactly keep the press at bay. The media had a field day once it heard who had been appointed to investigate the Attica investigation. The Boston Globe incredulously noted Meyer's lack of criminal experience. 33 Not only was this man not familiar with criminal law, but, as the Boston Phoenix pointed out, the time limit given Meyer to complete his investigation was preposterous. 34. The time frame that Meyer had been given to complete his investigation was indeed very compressed. He was expected to be done by September 30, 1975. A mere 5 months later, even though the Attica investigation itself had gone on for nearly 4 years, presented cases to 2 grand juries, and indicted 62 prisoners whose trials were still in progress. For Malcolm Bell, though, there was once again a modicum of hope. Maybe now all of the state's skeletons would finally be brought out of the closets, and maybe Attica's victims could get some justice. Bell firmly believed that it still wasn't too late. 46. Investigating the investigation. Democratic Governor Carey's selection of Bernard S. Meyer to head up the official inquiry into Bell's charges was highly political. Although Meyer was also a Democrat, notably he was one of the few in New York whom former Governor Nelson Rockefeller liked. At the end of Meyer's term as a justice of the New York Supreme Court, then Governor Rockefeller had taken the unusual step of issuing a statement praising Meyer, publicly recognizing Meyer's distinguished services to the judicial process, and remarking that it was most important that the judicial system does not lose a man of outstanding ability, who has rendered great service to the people. One seemingly unconcerned about his connections to Rockefeller, Governor Carey's office assured Meyer that throughout his investigation he would have the power to examine grand jury minutes, to subpoena witnesses and documents, and to examine under oath any persons with relevant information too. Knowing that he had a tight timeline of only 5 months, Meyer got right down to business. On the very same day he was appointed to his new post, he received a copy of Bell's so-called preliminary report from Carey's office and from Bell's lawyer, Robert Patterson, as well. 3 Within a week, Meyer also received the first preliminary submissions in response to the Bell report and charges from Anthony Simonetti, and by June 2 he determined that his investigation would require a budget of at least $330,000.40. Without this full funding, he insisted, it would be nearly impossible to hold the September 30 target date. 5. From Meyer's point of view, his job was not simply to determine whether there was a cover-up but also whether there was venality. 6. He also wanted to determine, if he were to discover deficiencies in the Fisher-Simonetti investigation, why such deficiencies occurred. 7. This was a tall order. It was hard to imagine plowing through the entire paper trail related to the Attica investigation in detail. Although Meyer would later concede that the time allotted had not permitted him to retrace every step the investigation had during the now 4 years of its existence, nevertheless, he dutifully tried to do so, not only making sure he had access to all relevant documents, but also asking the public to come forward if they had anything to share that might have important bearing on this case. 8. Meyer and his staff ultimately reviewed over 33,000 pages of this testimony heard by the 2 Attica grand juries and then compiled 500 exhibit folders with 1,000 documents with tens of thousands of pages for further review. Eventually, 37 members of the public, whose identities would be kept confidential in Meyer's report to the governor, offered information that, in turn, generated another 10,000 transcript pages. 9. Meyer also had numerous meetings with Malcolm Bell. When Bell saw how much pressure this man was under to finish his investigation quickly, he worried that this boded ill for getting at the truth, as did the fact that he had added 8 lawyers to his commission but only 1 investigator. 10. As troublingly to Bell, the questions asked of him seemed to suggest they were questioning Simonetti's mental balance and even asserting negative conclusions about it, rather than looking at the broader systemic problems with the investigation. 11. In August, 6 weeks before the deadline, Meyer's commission questioned Vice President Nelson Rockefeller for 5 hours under oath. 12. And yet, Meyer was at least willing to question Simonetti's boss. The former governor who had ordered the Attica retaking tried his best to offer little useful information. Asked whether he felt, in hindsight, that Robert Fisher should have used the state police to investigate its own troopers, Rockefeller responded that Fisher was a man of tremendous integrity and great experience, and in any case where he felt there could be a conflict of interest, he would use somebody else. 13. What is more, the former governor did not consider the investigation was being conducted by the state police, he said. I considered the state police simply investigators. 14. Rockefeller was similarly unhelpful on the subject of why the head of the NYSP, William Kirwan, wasn't on the scene during the riot at Attica, nor during the retaking, and why such an important operation had been handed off to the much lower-ranked Major John Monahan. He couldn't explain why Kirwan wasn't there, and he maintained that this absence hadn't bothered him at all. 15. Still, something important did come out of Rockefeller's deposition, the admission that he had been regularly in touch with the Attorney General about the Attica investigation and, what is more, that he got informal confidential reports from him as to the progress. 16. Rockefeller's testimony, in fact, shattered any illusions that he had not had influence over Lefkowitz, and thus over Fisher, Simonetti, and their men charged with investigating crimes committed by his state troopers and correction officers. He admitted on the record that the Attorney General stayed at the mansion always with me there, and we traveled up and down together, and I saw him down here a great deal. So I was with him a great deal and we would discuss many points. 17. This admission was exactly what Bell had been alleging, that the higher UPS in the Attica investigation were far too close to the very people who had ordered the retaking of Attica to properly investigate it. Rockefeller's right-hand man at Attica, Robert Douglas, also tried to say little of value, but his deposition was also revealing. Like Rockefeller, Douglas largely avoided the discussion of why Kirwan had not been in charge of the Attica retaking. When pushed to say whether it seemed strange that the governor would be represented by 4 very high officials, and yet the assault force would not have in command a superintendent of state police, Douglas merely responded that he didn't form that opinion. 18. However, as in Rockefeller's interview, Douglas admitted that Rockefeller's people had been deeply embedded in the Attica investigation from the very beginning. Although Douglas said he did not recall hearing anything on the day of the retaking about Kenny Malloy's alleged shooter, Aldo Barbolini, who was allowed to resign quietly rather than face potential prosecution, he had heard much subsequent. 19. Notably, though, no one in the state police had bothered to tell the investigation prosecutors about this man or what he had done. Douglas was also quite open about the fact that from the earliest days, the top officials in charge of the investigation had kept the governor generally informed regarding the progress of the investigation into the governor's own troopers. Douglas even acknowledged that Robert Fisher had participated in the debriefing at Rockefeller's pool house on September 24, 1971, the same debriefing attended by top men from the NYSP where the Barbolini matter had been discussed. 20. The Meyer Commission lawyer deposing Douglas seemed taken aback by this revelation, asking Douglas what would have been the point of Fisher sitting in on a conference of the persons responsible for that excessive force if there had been any, if he is supposed to be the independent prosecutor? For example, you certainly would not expect him to sit in on a defense counsel conference. Douglas responded that I didn't ask him to the meeting. I assume the governor did. 21. Either way, he saw no conflict of interest in this situation, nor with the fact that the BCI was investigating its own people. 22. Bell's allegations of inappropriate relationships among the governor's administration and the investigators were further supported by the testimony of Lieutenant Colonel George Infante. Infante revealed that his own lawyer had served as an assistant to Governor Rockefeller and the various persons in the executive chamber in their dealings with various investigative agencies concerned with Attica. 23. What is more, Infante admitted that this same lawyer had been contacted by Anthony Simonetti when the state prosecutor was considering giving immunity of some sort to Lt. Colonel Infante. 24. Of course, granting immunity to a member of the NYSP whom Simonetti had once dubbed the architect of the cover-up at Attica was tantamount to throwing in the towel on any case it might make against law enforcement for its actions there. More than a month after his deadline, on October 27, 1975, Bernard Meyer finally turned in his final 570-page report to the governor in 3 volumes. 25. Only the first volume would be released to the public. 26. Governor Carey and Attorney General Lefkowitz made clear that they wished the other volumes to remain undisclosed, citing law which permits the governor and the Attorney General to disclose, at their discretion, reports on investigations which they have ordered. 27. The so-called Meyer report was detailed and critical, but also a very carefully worded document. Ultimately, Meyer came down quite harshly on the Attica investigation. Not only did the report comment regularly on the Attica investigation's various and often glaring shortcomings, but it specifically called out decisions made by men such as Anthony Simonetti. And yet, to men like Malcolm Bell, as well to Attica's surviving prisoners and hostages, Meyer should have been far harsher on what they saw as the Attica investigation's kid-glove treatment of those who had committed so much harm in D-Yard back on September 13, 1971, and for weeks thereafter. Anthony Simonetti's granting immunity to top figures in the potential hindering cases, for example, had been deemed by Meyer merely a lack of good judgment, and the NYSP's being placed in charge of investigating its own people from the outset suggested a possible conflict of interest. 28. The report explained that more police had not been indicted only because of deficiencies in evidence gathering immediately following the retaking, which then left so little available to the investigation. to determine whether members of law enforcement were criminally liable or not. 29. As to Bell's charges of a cover-up at the highest levels of the Attica investigation, Meyer was unequivocal that there had not been any cover-up. The report conceded that there had been some serious errors of judgment, when it came to how troopers were dealt with by decision-makers in the Attica investigation, but there had not, he had decided, been any conspiracy to protect them. 30. The Meyer report actually went even further than stating that Malcolm Bell's charge of a cover-up was not well-founded, despite Douglas's and Rockefeller's testimony in their depositions for this commission. It also stated that his claims of such a cover-up were in some parts, based more on emotion than on fact. 31. Anthony Simonetti might have been a poor prosecutor, or perhaps just in over his head, the report concluded, but he nevertheless had conducted a detailed and logical investigation of the possibility that his investigation of possible law enforcement crimes may have been deliberately hindered by the state police. 32. To be sure, many steps should have been taken sooner, but that was the extent of his wrongdoing. 33. The Meyer report left Malcolm Bell, and Attica's many victims and survivors, appalled and deeply disheartened. He compared reading its findings to being at a hold-up and then being told by the investigator, "The money's gone and the bodies are here," but there wasn't any hold-up. 34. Bell penned a response in the New York Times arguing that Meyer wanted it both ways. Although he had to acknowledge that much covering up had happened, he chose to see those acts as unintentional. Therefore, he did not have to decide who directed it. 35. Notwithstanding the Meyer report's unwillingness to support Bell's contention that troopers and costs had been protected, it nevertheless offered some concrete recommendations that set in motion some positive developments for the prisoners who were still awaiting trial. The most important was a call for Governor Carey to appoint a special deputy attorney general whose sole purpose would be to review all convictions, all pending indictments and the evidence relating to possible future indictments with a view to taking, or recommending to the governor, whatever action he deems appropriate in this wholly unique situation. 36. The report also endorsed trying to correct the lack of even-handedness in the state's actions by continuing to seek indictments against law enforcement personnel in those cases, if any, involving serious offenses in which there is a reasonable probability of conviction, and possibly giving the NYSP evidence that might allow it to discipline its own employees whether or not such was sufficient for criminal conviction. 37. With regard to justice for Attica's many prisoners who had sustained serious injuries on September 13, 1971, the Commission suggested that they file a crime victims' compensation claim within, say, 1 year after passage of the amendment. 38. No mention was made, however, of dismissing the many riot-related criminal charges that Attica's prisoners still faced. In Meyer's view, amnesty is not the proper solution to Attica-related problems. 39. Although Bell was disappointed with the report's conclusions, many other New Yorkers who had long thought the Attica investigation a disaster felt it was wonderful news. One of these was Arthur Lyman, who had served as the general counsel for the McKay Commission during its extensive investigation into Attica, a longtime critic of the grim cycle of accusation and investigation. 40. In his view, it did not have to happen this way. 41. Lyman wrote a personal letter to Hugh Carey after the Meyer report was released, pointing out that although his commission had warned state officials that the fair administration of justice required even-handed prosecution, the state's investigation had still proceeded most uneven-handedly. 42. Lyman found it incredible that, despite the findings of the McKay Commission and other Attica investigations, there had indeed been widespread physical reprisals against prisoners as well as inadequate medical care. In the state's investigation, not a single indictment had been returned against a state official, a correction officer, or a police officer. 43. In light of the Meyer report, Lyman proposed a brand new investigation, one that must clearly focus on identifying those who established and condoned the order of priority that treated offenses by inmates as more serious than the transgressions by the lawmen. Even at this late date, that should not be beyond the faculties or the experiences of lawyers and investigators with a will to do justice. 44. Other New Yorkers argued against further investigations. The chairman of the McKay Commission, Dean Robert McKay, wrote to the governor that the time has come to stop the never-ending investigations, closing out this unhappy chapter of our history as quickly and justly as possible. 45 McKay recommended that all further indictments and investigations should be dismissed, except possibly the one remaining murder indictment, which had charged Mariano Dallo Gonzalez with killing fellow prisoner Mickey Privitera in D Block where Hess and Schwartz were also killed. 46. The public offered still other solutions for proceeding in the wake of the Meyer report. A group of clergy in Rochester recommended clemency for all who have been sentenced and dismissal of the remaining indictment. 47. This was exactly what various folks working to defend the Attica brothers thought as well. As Big Blacksmith's Attica Now group stated, the brothers' demand for amnesty in 1971 is more compelling for 1976. 48. Governor Carey committed himself to reviewing all existing cases before deciding how to proceed with the investigation. On the same day that Carey and Lefkowitz released the first volume of the Meyer report, they announced that Alfred J. Scotti, former Chief Assistant District Attorney of New York County, would be appointed Special Deputy Attorney General as the Meyer report recommended. Scotti's appointment was big news. Not only did it effectively remove Simonetti from any position of influence at the Attica investigation, but it opened up the possibility for a more balanced prosecutorial inquiry in the future. When Scotti began his probe, the prisoner indictments stood as follows: 8 of the 62 inmates who had been indicted had pled guilty to get their ordeals over. Some had pled right away, others later as their cases wore on. Only 2 men had been convicted after standing trial, John Hill and Charles Pernisalis, and 3 others had been acquitted after standing trial, Willie Smith, accused of raping James Schleich, Vernon Lafranc, accused of subduing hostages with a gas gun, and Shango, accused of murdering Barry Schwartz. Meanwhile, charges against 39 prisoner defendants had been dismissed entirely, either because Simonetti's office conceded there was insufficient evidence to go to trial, or because the defendants had not been granted a speedy trial. When Scotti began his investigation, cases were still pending against 27 prisoners and 1 state trooper, Gregory Wildridge, who had been indicted by the second grand jury quite suddenly during the Meyer Commission's investigation. As far as the New York State Police were concerned, Trooper Wildridge's indictment stank of politics. Simonetti's office had clearly scrambled to show that it could indeed indict a trooper once all eyes were upon it. Simonetti asked a prosecutor from his office to persuade the grand jury, just before it was to be dismissed, that Wildridge's actions at Attica evinced a depraved indifference to human life. 49. Wildridge was charged with reckless endangerment for having fired 10 rounds from his shotgun into D Yard, including some into a tent where prisoners were huddled. According to the indictment, Wildridge callously said he had fired so much to keep up the noise. 50. Wildridge, a 38-year-old, 14-year veteran of the force, was visibly supported by his NYSP fellows. At his arraignment, he was flanked by Captain Hank Williams, and Patrick Carroll of the Police Benevolent Association of the New York State Police told every media outlet he could reach that it was a travesty of justice to indict a trooper who was risking his life to quell a prison riot. 51. High-powered lawyers from the firm of Hinman, Straub, Piggers and Manning of Albany were ready to defend Wildridge from prosecution. They would argue that Wildridge had been under enormous stress at Attica, constantly and continuously exposed to tension-filled hours, given little effective sleep or rest, and subjected to days of rumors of inmate atrocities. Now the state of New York was prosecuting him for following orders in the line of duty. 52. Worse, these lawyers argued, their client had been ordered by his superiors to give statements of what he had done during the retaking without any constitutional warnings, and was repeatedly forced to give evidence against himself in the form of his own coerced written statement. 53. Simonetti's office must have been pretty shaken up by Bell's letter of resignation and his subsequent detailed and condemning report to the governor, because not only was Wildridge indicted in the wake of Bell's departure, but the Attica investigation also chose then to present cases against several other low-level members of law enforcement. According to Scotti's office, Simonetti's office ultimately scurried to present evidence against 4 troopers and 3 correction officers before the second grand jury. 54. In that mix was, for example, Trooper James Middlestead, whom prosecutors insisted had killed prisoner James Robinson and severely wounded others on the day of the retaking. He faced the possible charges of murder in the second degree, manslaughter in the first degree, attempted murder in the second degree, and attempted manslaughter in the first degree. 55 Similarly, prosecutors had brought evidence to this grand jury against correction officer Nicholas DeSantis for reckless endangerment in the first degree. Even though by his own admission he had fired more than 12 rounds from his .45 caliber Thompson into the heavily populated D Tunnel and D Yard on the day of the retaking, he was not indicted. 56 Neither was Middlestead. When Alfred Scotty stepped into the Attica investigation, he could see clearly that getting indictments against troopers and correction officers would be near impossible at this late date, in front of a grand jury that was feeling rushed, and with this team of prosecutors. Having looked closely at the evidence, it frustrated him because he could see cases where the evidence presented to the grand jury warranted an indictment, but in one of them, for example, since that state trooper had already received immunity from the prosecution, prior to my appointment, he cannot now be legally prosecuted. 57 Still, he promised that he would continue to seek indictments against law enforcement personnel and others in those cases, if any, involving serious offenses, in which there is a reasonable probability of conviction. 58 There were at least 2 cases against law enforcement that he wanted to pursue, including one matter that involves a possible intentional killing by a state trooper and another that involves a possible serious obstruction of the Attica investigation by a member of the state police. 59 However, Scotty did not pursue these cases. Instead, he recommended on February 26, 1976, that the only pending law enforcement indictment, against Gregory Wildridge, be dismissed, and that no reattempts to indict troopers or costs should be undertaken. Although Scotty claimed that the action we recommend today should not be misconstrued as condoning the brutal acts of some law enforcement, it effectively did just that. 60 The truth was that there was no will to make these cases against law enforcement officers in the wake of the Meyer report if ever there had been. 61 Once it was clear there would be no more trooper or CO indictments, Scotty felt more pressure than ever to take a close look at the remaining cases against prisoners, which everyone now agreed were sloppy at best and, at worst, downright unwinnable. Even when the state had managed to find evidence against the prisoner defendants, its highly questionable provenance made the cases weak if not tainted. In this context, less than 3 months after having been appointed to assess the existing and potential Attica cases, Scotty recommended dismissing all pending indictments with the exception of one Mariano Dalu Gonzalez. 62 Scotty even recommended that the one prisoner defendant who had already pled in a still active indictment be allowed to retract his plea and be cleared. 63 On April 22, 1976, Governor Carey proudly announced, on Mr. Scotty's recommendation, State Supreme Court Justices Frank R. Baker, January 26, February 26, and Carmen F. Ball, February 26, dismissed 11 indictments, naming 24 inmates and the only state trooper indicted. 64. The Attica brothers and all of their lawyers and supporters were relieved to hear this news, yet it was hard for them not to feel deep bitterness as well. Ernie Goodman wrote a heartfelt letter to his Attica client Shango on February 27, 1976, after having attended one of the hearings in which indictments were vacated. I went to Buffalo in the expectation of dismissal. I had anticipated it would be a happy event. I was mistaken. It was bittersweet. Bitter, because Scotty's assumption that belated justice proved the essential fairness of the system, was hypocritical. The reason there was any belated justice was only because of the struggle of those who had to fight or die. And the struggle was long and heartbreaking. During its course many wavered, weakened, and gave up. Some capitulated. Others, like yourself, stood fast, gained strength and fought back, gaining understanding and support as we revealed the cruel and unconscionable efforts of the state to prove that the leaders of the rebellion were barbarous sadists. 65. The prisoners and their advocates were angry that they had been put through so much for so long, and sickened that Governor Carey was, in their view, still trying to protect the troopers. Carey insisted that any law enforcement officers the state had been looking to indict would remain unnamed and that their names should only be revealed if and when disciplinary hearings are undertaken within their various state agencies. Even Scotty, who originally had recommended the release of all volumes of the Meyer Report, ultimately endorsed Judge Meyer's suggestion that the second and third volumes should not be made public, undoubtedly because these volumes had grand jury testimony in them that might specifically name troopers and cops who had committed crimes at Attica. 66 Meanwhile, though, the prisoner who the state thought had killed fellow prisoner Mickey Privitera in the midst of the uprising, Dalu Gonzalez, was not going to be afforded any such consideration. 67. With the dismissal of all but one Attica indictment and with the promise that no indictments would now be sought against troopers, there was no longer any need for the Attica grand juries. And so, Judge Carmen Ball dismissed both panels on March 30, 1976. 68. 47. Closing the book. Dismissing the remaining indictments as well as the grand juries, however, had not quite ended the Attica headache for Governor Hugh Carey. In fact, in the wake of his April 1976 press conference, which announced that the indictments were being vacated and, thus, the Attica investigation was effectively being dismantled, much of the public, however, thought still more should be done. He received hundreds of letters calling for him to grant executive clemency to all prisoners who had pled or been convicted of an Attica-related offense since they had been so selectively prosecuted and, also, to prevent a later governor from deciding, for whatever reason, to reopen the Attica investigation. 1. After much deliberation and consultation with Scotty and others, Carey tried once and for all to end any more talk of Attica. On New Year's Eve 1976, Carey called a press conference to make the stunning announcement that he was going to pardon every prisoner who had pled out in an Attica case, grant clemency to every prisoner who had been found guilty in an Attica case, and drop all inquiries into the potentially illegal actions of any state officers and employees at Attica back in September 1971. Even disciplinary actions against them would now be off the table. Attica has been a tragedy of immeasurable proportions, the governor stated, unalterably affecting countless lives. Too many families have grieved, too many have suffered deprivations, and too many have lived their lives in uncertainty waiting for the long nightmare to end. The time has come to firmly and finally close the book on this unhappy chapter in our history as a just and humane state. 2. Carey explained why he was taking this bold step. In short, all of the inquiries into the recent years of the Attica investigation had persuaded him that the state, through its highest officials, failed abysmally by being wholly insensitive to its constitutional responsibilities, and now, equal justice by way of further prosecutions is no longer possible. 3. In his view, state officials had bungled the investigation so badly that they had effectively precluded the possibility of now bringing anyone to justice for crimes that may have been committed at Attica. 4. But instead of settling the Attica question for good, the governor's announcement brought it back into the public eye once again. Surprisingly, the most hostile responses came from the people who had dodged the biggest prosecutorial bullet as a result of it, the New York State Police and New York State Correction officers. Patrick Carroll of the Police Benevolent Association made major waves in the press, sharing how appalled he was to hear that the governor had pardoned Attica's prisoners, and both the PBA and the Correction Officers Union were critical of Carey's statement that he would not pursue disciplinary action against officers who had been on duty at Attica. On behalf of the PBA, Carroll called the governor's statement a slap in the face because it suggests that the guards and troopers had in fact committed disciplinary infractions. 5. According to a CO union official, it leaves a cloud of suspicion over our heads. 6. The Attica brothers had a more complicated response. Everyone was relieved that the indictment ordeal was over and that, better still, anyone who had received time as a result of having been indicted would have their records cleared. But there was still much anger over the many years of so many lives that had been spent living in fear of prosecution. They were also angry that even though John Dakajwia Hill was included in the governor's clemency decree, his sentence was commuted. Hill had not immediately been released from prison. Hill wasn't slated to get out until October 23, 1994, the commutation only ensured that he would be eligible for parole in January 1977. Governor Carey would do nothing sooner. 7. Hill, for one, was relieved that his parole was much nearer. He felt certain that, Armed with the Carey decree, he would be released by the parole board within the month. Yet when he appeared before the parole board in January 1977, it did not go as he expected. As the board deliberated, John Hill sat in the prison's visitors' room with his wife, Alicia, and their 17-month-old son, John Jr. The board decided that releasing him could possibly lead to a widespread negative community reaction, and they refused to consider his parole again for 2 more years, the longest interval the board was permitted to wait before having to reconsider his bid for release. 8 When he heard this decision, Hill just shook his head in dismay. 9 In his statement to the press, he was despondent, telling reporters, "If they leave it to the discretion of the parole board, I'll never get out of these penitentiaries. The guards still want revenge for what happened." 10. The board's reluctance to release Hill only increased the pressure on Carey. To everyone's surprise, one of Hill's most vocal supporters became former Attica prosecutor Malcolm Bell. Bell filed a lengthy affidavit supporting Hill, and also made a public statement on his behalf that he was aware of no circumstances which make the lack of fairness and even-handedness of the Attica prosecution any less applicable to John Hill than it was to these other inmates charged with serious felonies. 11 Multiple grassroots organizations expressed support for Hill with flyers such as "Immediate Amnesty for Dacajwe," which reminded the public that Carey may claim he closed the book, but in reality he closed the door on Dacajwe. "We must make the pressure on him to grant amnesty greater than the pressure to continue the cover-up." 12 A faith-based organization, Charter Group for a Pledge of Conscience, urged people to please write or wire the governor today demanding that he grant unconditional pardon to John Hill. 13. In the face of this pressure, Carey's office maintained that it could do nothing. 14 It would be up to Hill's attorneys, now William Kunstler, Margaret Ratner, and Elizabeth Fink, finally to obtain Mr. Hill's freedom via the courts. 15 Notwithstanding the flack Carey received from Hill's supporters and that which he endured from the heads of the organizations representing the state police and the correction officers, he and the state of New York had done their best to bury the bodies. 16 Bernard Meyer certainly thought he had settled the question of cover-up. Alfred Scotty had ended the Attica investigation, and by offering pardons and clemency, Governor Carey had at least officially closed the book on Attica. The state hadn't considered one factor, however: the many hundreds of men who had been wounded and tortured at Attica, and the families of the scores of men who had been murdered, who had not yet had their day in court. They were not going to let the book on Attica be closed until their story was completely and truthfully told. Though it would take almost 20 years from the time that Carey tried to end all matters related to Attica for them to take state defendants to court, take them the prisoners would. Part 9. David and Goliath. Elizabeth Fink. When Governor Hugh Carey closed the book on Attica, and the criminal trials faded from the headlines, attorney Elizabeth Fink had been living and breathing the fallout from the Attica prison uprising for almost 5 years. Fink was what activists in America lovingly referred to as a red diaper baby. She had grown up in the heart of New York City's most intellectual and politically left milieu, and then attended Reed College. An impromptu road trip to Chicago after graduation in the summer of 1968 ignited her own passion for social justice. That August, during the Democratic National Convention, Fink found herself exposed to a most intoxicating experiment in participatory democracy. This moment was transformative for Fink, not only because the demonstrations that rocked that city inspired her deeply and made her feel passionate about the fight against the Vietnam War, but also because she was shaken to her core by the law enforcement violence she saw directed at protesters young and old. When Liz Fink came back to New York, she joined the offices of a prominent radical newspaper, but soon thereafter her father died and she left to run his business. Feeling some pressure from her mother, who had always wanted her to be an attorney, Fink then enrolled in law school. Armed with a JD degree, Fink suspected that she could do some very important political work, fighting the government officials and politicians who were using the courts to squelch dissent. Attica would give her that opportunity. Liz Fink arrived in Buffalo on July 4, 1974, less than 2 months after she was admitted to the practice of law, and she hit the ground running as a key person in the Attica Brothers Legal Defense, ABLD. On July 5 she first went into Auburn Prison to meet with the men there awaiting trials. Soon Fink was one of the main liaisons between the indicted Attica brothers and the many people working on their behalf. She had become particularly close with fellow Attica lawyers Dennis Cunningham, Michael Deutsch, and Joe Heath. These four worked closely with Big Blacksmith and, like him, believed that politics must be central to any defense strategy. Fink was very much aware of the gender politics of the ABLD as well. As much as she liked and admired her male colleagues, she often felt sidelined by them. That is, until the 1980s. In that decade and into the next, Liz Fink would find herself in charge of the highest-profile Attica case to date. Big Black was not about to let the state of New York close the book on Attica and was counting on her to ensure that he and the rest of the prisoners finally had their day in federal court. 48. It ain't over till it's over. Ad hoc Governor Carey had authority to pardon those who had already been convicted of an Attica crime. He did not in fact have the legal power to pardon anyone in advance of a possible conviction. In other words, while it might have been politically expedient to claim that there now would be no legal actions taken against members of law enforcement for what they had done at Attica, his pronouncement held virtually no weight as a judicial decision or a legal decision one. Many of Attica's surviving prisoners had actually been trying to make the state of New York accountable for the horror of the retaking via civil actions since 1971. In fact, 508 of them had filed notices of intent to file suit in New York's Court of Claims by December of that year. 2 Undoubtedly there would have been many more, but by law, prisoners who were still incarcerated were not allowed to file these suits, and even those who were released only had a window of 3 years in which to do so. Then, in 1974, the Court of Claims decided that it would hear no Attica civil case until all of the criminal cases had been dispensed with, which meant that in 1977, in the wake of the Carey pardons, numerous lawsuits related to Attica were finally ready to proceed. 3. These cases already comprised one of the largest and most complicated set of claims ever brought against the state, according to one newspaper report. 4. Of course, more suits were now likely to follow, particularly since the Meyer report had made clear that the state had made many mistakes in its handling of Attica. As the press pointed out, it would now be very difficult for the state to deny culpability in the civil arena. 5. Attorney General Louis Lefkowitz noted tiredly, with motions and appeals, this could go on for years. 6. It did go on for years, in part because it was so hard for the prisoners to get their cases heard. The Court of Claims eventually ruled in 14 prisoner suits that had been filed in the early days after the rebellion, but only 9 of these were resolved in favor of claimant, and 5 were dismissed. 7. As important, even the cases that eventually did win prisoners a damage award took so long to wend their way through the system that some plaintiffs did not live long enough to see the money. This process was in fact so drawn out that one of the Attica plaintiffs wrote to the clerk of the court in March 1983 to remind everyone that his life has been shortened by the Attica incident, and that if his claim was not tried soon, neither my witnesses nor myself will be alive for the trial. 8. That plaintiff died the following year, but his estate was finally awarded $164,000 in damages in 1989. 1989 would be a good year for a number of Attica prisoners thanks to the decisions of one judge, who was willing to rule that the state was in fact liable for damages and injuries resulting from the intentional use of excessive force. 10. And yet, while it was true that 9 prisoners, or their estates, eventually were awarded a total of $1.5 million in damages, as one legal scholar noted, for so many others of Attica's surviving prisoners there was little or no redress. 11. Still, this wasn't the end of Attica legally. Indeed, as far as New York was concerned, the case most threatening to it had, even at the close of the 1980s, still not been resolved. This case, Inmates of Attica v. Rockefeller, had originally been filed in Federal District Court in Manhattan on September 13, 1974, at the very last minute before the 3-year statute of limitations ran out. This class action civil rights suit on behalf of the Attica brothers, one that had originated in that first injunction against violations of prisoners' rights that lawyers had sought before Judge John T. Curtin back on the night of the Attica retaking, argued that the main officials in charge at Attica, from Governor Rockefeller to John Monahan of the NYSP to various officials at the prison, should be liable for $100 million in damages. They had violated the rights of prisoners by using excessive force and unrestricted firepower calculated to cause unnecessary and inexcusable death, serious injury, terror, and suffering. 12. While the energies of the Attica brothers and their lawyers were consumed with the defense of the 62 men indicted in the criminal courts, this civil case had bounced among various judges in Manhattan. The first judge recused himself for being too connected with various litigants in the case. The next worked in the same firm that now represented Nelson Rockefeller. Rather than recuse himself and give it to another jurist in New York City, however, the second judge suggested moving the case upstate. Bad news for the Attica brothers. The deck seemed stacked against the plaintiffs in several ways. First, any legal help they might secure was likely to be in New York City, and they had few resources to manage traveling back and forth to Buffalo. Furthermore, in their desperation to get the case filed by the deadline, the prisoners had originally filed a very general complaint. It listed many John Does as defendants because there had not been enough time to figure out who all of the potential defendants might be. Fortunately, an attorney from the National Lawyers Guild in Manhattan decided to take the time to read the McKay Commission's detailed 1972 report and amend the complaint to name specific defendants: shooters, officers, state officials, prison administrators. But then the ball was dropped again. Back in 1974, when inmates of Attica v. Rockefeller was filed, anyone who was named in a civil case like this one had to be served by a representative from the Federal Marshal's Service. The key here was that someone from the plaintiff group would have to arrange for a U.S. Marshal to serve every potential defendant, not as simple a task as it might seem. In the chaotic years of the criminal defense, this procedure simply did not happen for many of the individuals. By 1979, the only 5 defendants who had been successfully served and remained in the suit were former Governor Nelson Rockefeller, former Commissioner of Corrections Russell Oswald, NYSP Major John Monahan, former Attica Superintendent Vincent Mancusi, and former Attica Assistant Deputy Superintendent Carl Fiel. Many key figures, from NYSP Lieutenant Colonel George Infante to Attica Deputy Superintendent Leon Vincent, could breathe a sigh of relief that they had dodged a potentially deadly legal bullet. When the case was moved to Buffalo, into the Court of the Western District of New York, the prisoners' class action suit was assigned to Judge John T. Elfvin. From that day forward, the state's lawyers tried to get Elfvin to dismiss the case, but Elfvin denied their motions and made clear that the case would proceed. He insisted on knowing, however, who would be representing the plaintiffs. That was a good question. Officially, the Attica brothers' civil case was being handled by a New York City lawyer named Bob Cantor, but the fact was that it had been hanging around for so long that no one was really in charge anymore. If someone had been on top of things, Elfvin might not have been able to dismiss the defendants who hadn't been served by a U.S. Marshal. An attorney could have argued for more time to serve them. Attica brother Frank Big Black Smith was well aware that if there were no lawyers who had the time to commit themselves to this civil case, it would soon be over without any satisfactory results. By this time, Big Black was working in Bob Cantor's office, and he could see that this man, alone, would have a hard time taking on a case of this magnitude, especially one that would be argued so far away from Manhattan. Big Black very much hoped that someone specific would agree to take on this case: Elizabeth Fink. Fink was a criminal lawyer, not a civil lawyer, but Big Black had seen her in action during the Attica brothers' legal defense efforts and had always thought she was just the sort of fighter they all had needed then and still did. Black and his fellow Attica brother Akil Alyundi approached Fink about taking on the Attica civil case. She was flattered, but initially refused. She was recovering from a recent illness, and also working around the clock trying to get another client, Black Panther Doroba al-Mujahid bin Wahad, aka Richard Earl Moore, released from prison. The brothers grew alarmed when Judge Elfvin announced that if the plaintiffs did not commence discovery in this case by February 21, 1981, he would pull the plug. Fortunately, a pro-SE clerk in Judge Elfvin's office, Ellen Yaknin, had worried about this possibility for months, as she had watched Big Black check in with her again and again to make sure that this case was alive and well. It seemed to her that he needed some help. When Judge Elfvin gave a firm deadline for the plaintiffs to identify their counsel, Yaknin asked the judge if she could try to find some attorneys for the case. Yaknin and Elfvin had a heated debate as he argued for the case to be dismissed and she begged him to give her just a bit more time to find some lawyers. Ultimately, he did allow her to try. 13. Yaknin's first call was to a local attorney she knew, who declined. She then turned to prisoner legal services, who also said no. Feeling a bit desperate, Yaknin then decided to call every lawyer that she had seen named on the original complaint. Each of them also declined to take on the case. Any lawyer worth their salt could see that this was a classic David and Goliath case which would require enormous resources and energy, as well as spending a tremendous amount of time in upstate New York. Every time Ellen Yaknin called another attorney for help she was told the same thing: call Liz Fink. So she did. Fink, though, also said no. She explained to Yaknin that she was unusually busy with other cases and, what is more, she was a criminal not a civil litigator. 2 days later, however, Yaknin's phone rang. It was Liz Fink, who had talked at length with Big Black Smith. They had decided that they, together, would try this case. Yaknin called it a very brave thing to do, which was putting it mildly. 14 The state's defendants had hired the best connected and best funded lawyers in New York, and the only way that the prisoners might be able to prove their case would be to get the state to turn over evidence in discovery. Given that this case was, at bottom, about murder, torture, and abuse, Fink and Big Black had little doubt that the defense would continue to make every effort to block their access and to continue the now time-honored strategy of insisting that the prisoners, not the state, bore all of the blame for what had happened at Attica. Nevertheless, Fink and Big Black came into Judge Elfvin's court prepared to argue their first discovery motion. As Yaknin recalled, the other lawyers were blown away. 15 Still, Fink had to fight hard for every single thing the plaintiffs would need to proceed in this case. Not only did defense lawyers persist in trying to have the case dismissed, but they also insisted that the class suing them was invalid. Judge Elfvin seemed to enjoy what he viewed as a game of cat and mouse between the defense and the plaintiffs, and he played right along. 16 In an order he issued on October 30, 1979, Elfvin agreed the plaintiffs were, legally, a classic group who had shared a similar enough experience to stand together as one to seek damages from the state. Then, almost a year later to the day, he changed his mind on this point and revoked the plaintiffs' class certification. It would be another 5 years before he once again granted the plaintiffs' motion to recertify as a class. 17 To Liz Fink's frustration, this sort of waffling on the judge's part would continue for years, in her view capricious and childish power-tripping. 18. Frank Big Black Smith and Elizabeth Fink, 1981, courtesy of the Democrat and Chronicle. Fink's biggest fight with Elfvin and the state lawyers alike was trying to get meaningful access to state documents via the discovery process. Unwilling to leave any stone unturned, Fink filed 14 subpoenas as well as numerous requests for admissions paperwork that asked specific questions of the defendants that, once answered, could then be accepted as fact as the trial proceeded. For example, she asked, "Do you admit that 39 people were killed on September 13th?" In lieu of a response, the defendants' lawyers from the elite firm of Milbank, Tweed, Hadley and McCloy stalled on her requests and filed their own motions to have her case dismissed. Some of those motions backfired. For instance, the argument that the plaintiffs did not have the resources to litigate the case opened the door for Fink to argue that the entire case was clearly about an imbalance of power and, therefore, that this was all the more reason why it should proceed. She maintained to the judge that she could handle this case even while, behind the scenes, she worried mightily about their limited resources. Fink was almost single-handedly footing the ever-growing cost of the case, dipping into family savings and borrowing money when she could to cover phone bills that averaged $1,500 a month, exorbitant commuting costs, and the staggering amount of money needed to get documents typed, copied, and filed. No matter how tenacious Fink and Big Black were with their discovery subpoenas, though, the state's lawyers repeatedly denied that they had anything worth seeing. In March 1982, Fink finally got permission to meet with state attorneys at the office of the Attorney General in the World Trade Center, where all of the Attica files from the years of criminal litigation were kept. There she and two other lawyers she had known since the ABLD days, Joe Heath, who had worked on the Hill and Pernisalis case, and Michael Deutsch, who also had been central to Big Black's defense team, returned day after day as officials allowed them to see only one box. And so they would argue to see another box. One more container would be brought out the next day, and then the whole tedious process would repeat itself. So the plaintiff lawyers went back to court. On June 7, 1982, they returned to the World Trade Center armed with a court order and the right to see everything the state had on Attica. Lawyers from Milbank, Tweed joined them to review the documents together. After 3 days, the defense lawyers, according to Fink, grew bored of the process and left. To their relief, with no defense lawyers on site, and with only one records clerk remaining in that office who was willing to give them fairly free rein, Fink was able to see virtually any document she needed to see despite the state's instructions to allow her access to only selected items. 19 Once she had seen documents that no one outside the Attica investigation had ever seen, including all 3 volumes of the Meyer Report and countless documents from the state's years-long investigations of prisoners and troopers, Fink felt well prepared to litigate the case. 49. Shining the light on evil. And now armed with vital documents to prove their case against prison and police officials as well as against New York's former Governor Nelson Rockefeller, Liz Fink and her team were most eager to go to trial. To their dismay, however, Judge Elfvin suddenly allowed the state's lawyers to realize their long-time efforts to remove Rockefeller from the list of named defendants. It was common knowledge that Judge Elfvin was good friends with Rockefeller's attorney in this trial, so close, in fact, that they used to go horseback riding together. 1 Still, the plaintiff lawyers thought that the judge might not protect him this overtly. Fink appealed, but even the appeals court panel slated to consider the motion had to recuse itself since all 3 judges on it also had close relationships with Rockefeller. Indeed, it took 3 separate panels of judges to get a ruling on the appeal and, even then, at the end of 1989, the plaintiffs lost their bid to keep Rockefeller in the case. And so Fink and her team had to move on. They had been requesting trial dates since 1987, but time and again the defendants had found reasons the dates should be moved. In December 1989, Fink again filed papers seeking an immediate trial date. The trial was set to commence on June 5, 1990. But in March of that year the remaining defendants named in the case followed Rockefeller's lead and filed their own motions to be removed from the case, arguing that they too had immunity and thus couldn't be named defendants. Judge Elfvin denied these efforts and confirmed that the plaintiffs' 8th Amendment claims would be permitted against former Commissioner Russell Oswald, for failure to plan for medical needs in connection with the plan of retaking, NYSP Major John Monahan, for his role in supervising the state police officers who participated in the retaking, and former Attica officials Superintendent Vincent Mancusi, Assistant Deputy Superintendent Carl Feel, and Commissioner Russell Oswald, all for failure to prevent the acts of retaliation that took place subsequent to the prison retaking. 2. Word that the civil suit was about to go to trial once again thrust Attica into the national spotlight. It did not escape people's notice that, with this federal trial about to begin in Buffalo, for the first time the full extent of the killing, brutality and denial of medical care inflicted on the men at Attica would be publicly exposed. 3. To make sure this case stayed in the public eye, a newly formed Attica Justice Committee got to work. The fact that 1991 marked 20 years since the Attica Rebellion greatly helped this committee bring attention to the case. Soon, events marking the anniversary and fundraising for the committee sprang up around the country, including the Attica Prison Rebellion and U.S. prisons 20 years later in Ann Arbor, Michigan, that showcased speakers Frank Big Black Smith and others. 4 Similarly, a Can't Jail the Spirit event was held at the Bethlehem Lutheran Church in Oakland, California, on September 13 to commemorate 20 years after the Attica Rebellion, the murder of George Jackson, and the imprisonment of Geronimo Pratt. 5 An Attica Rebellion and U.S. prisons. 20 years after Attica event was also held on the campus of Eastern Michigan University, as was an evening to commemorate the 20th anniversary of the Attica Uprising and support the brothers and their families in their federal lawsuit at the Canaan Baptist Church in New York City. 6 In addition, lawyers from the New York area sent out their own fundraising letter asking that each of us contribute $1,000 to this cause, either by loaning the money for reimbursement in the event that a favorable verdict or settlement is reached, or by contributing the money. 7. On the eve of the Attica civil trial's opening, the Attica brothers plaintiffs had an impressive team of lawyers on their side, made up of Liz Fink, Michael Deutsch, and Joe Heath, as well as 2 other attorneys from the earlier days of the Attica criminal trials, Danny Myers and Dennis Cunningham. On the defense team were Richard Moot, a third-generation trial lawyer who had been trained at Harvard and now represented Moncusi, Irving C. Macron represented Phil, and John H. Stenger represented Russell Oswald, and, following Oswald's death in March of 1991, his estate. 8 This trio was supported by 5 more defense attorneys and numerous paralegals. Though the defense team was far better funded, they were routinely startled by how well the plaintiffs' lawyers argued their case. To the defense's annoyance, it was obvious that attorneys such as Liz Fink were at a great advantage, having already spent so many years working on the criminal cases. Her team already knew exactly who had seen abuses taking place at Attica, and thus whom to subpoena. As important, the plaintiff lawyers also had at their disposal the myriad interviews that the ABLD had conducted back in 1971 with the National Guardsmen and doctors who had been at Attica on the day of the retaking. From these older interviews they knew that there were many they could call to testify. Indeed, the attorneys' deep familiarity with Attica meant that they had quite a few disinterested witnesses, such as doctors who had tried to assist the wounded in the immediate aftermath of the shooting, National Guardsmen who had witnessed prisoners being tortured following the retaking, and even high-profile former Attica observers. Some of these witnesses, such as observer John Dunn, had reported the horrors he witnessed at the time, and yet they had continued exactly the sort of evidence that could prove the plaintiffs' arguments. 9. And the plaintiffs also had many former Attica prisoners who themselves could testify as to the trauma they had endured while state officials like Moncusi or Oswald had looked on. Although there were literally hundreds of these men who could have testified, ultimately the plaintiff's case relied upon just a handful, but their harrowing tales of abuse certainly were sufficient to show just how cruel and callous the state of New York had been at Attica back in September of 1971. The witness list of men from D-Yard included Richard Clark, Herbert Blyden, Akil Al-Yundi, Carlos Roche, Jerry Rosenberg, and, of course, Frank Big Black Smith. 10. Unusually, the testimony of these witnesses was recorded in detail because of an earlier indiscretion in Judge Elfvin's personal life. Following an affair between Elfvin and the court reporter, she was no longer allowed to transcribe trials, so they now had to be taped. There was much drama to record throughout this trial. What Elfvin's clerk, who had kept this case alive, Ellen Yaknin, called pure theater in the courtroom. 11 Captured on the tapes were Liz Fink's impassioned statements that, according to Yaknin, mesmerized the jury, as well as much heated bickering between Judge Elfvin and the various attorneys, which he, at least, seemed to greatly enjoy. 12. The jury hearing all of this was a virtually all-white, all-working-class group of men and women from upstate New York. This was in no small part because in federal cases the judge questions prospective jurors, and Judge Elfvin, over the strong protests of the plaintiff lawyers, had refused to consider race or a juror's potential racial biases when conducting his voir dire. Nevertheless, the evidence brought to bear in this case left every man and woman in the jury box visibly stunned. One witness, a medical specialist and a sergeant major in the New York National Guard named David Burke, had been assigned to deal with the many wounded men who covered the yards at Attica. He testified that troopers and cops at Attica had prevented him from loading the ambulances, and that certain Attica staff physicians had treated the prisoners cruelly. 13 One doctor was speaking to the inmates and saying, "You say you're hurt? You're not hurt? We'll see if you're hurt." And he was kicking and hitting them, disregarding their visible wounds. 14 Sickened at the sight of more blood, more gunshot wounds, and more injuries that day, than most people see in a typical day of combat. Certainly in Vietnam, Burke as well as his fellow National Guardsman Dr. John Cudmore had tried to stop the abuse to no avail. 15. Other disinterested parties corroborated this witness's testimony. Dr. David Breen, who had been a third-year medical resident at the State University of New York at Buffalo in 1971, had headed for Attica in an ambulance with 7 or 8 people, including several surgical residents and blood bank technicians. As soon as Mancusi finally called for some doctors. 16 Breen confirmed that Attica's own doctors had been abusive toward the wounded men in the yard. He repeated a story he had originally told years earlier that no one had been interested in hearing at the time. He had seen Dr. Selden Williams near a Spanish-speaking prisoner with a serious gunshot wound to his leg who was hysterical and nearly delirious with pain. 17 While the prisoner kept trying to sit up, the doctor kept trying to force him back down. Finally this wounded prisoner had been struck on the head with a blunt object by a security guard, a very severe blow to the head, while Dr. Williams, according to this witness, just looked on impassively. 18 While on duty in the prison's poorly staffed hospital, Breen had watched as a number of inmates were struck by security personnel, whether they were guards or prison guards or National Guardsmen, I don't know, he said, but a number of prisoners were struck with clubs and other objects. In the process of forcing them to comply with the demands that were being made on them. 19 The witness had been so upset by the trauma that he made the contact with a newspaperman who put him in touch with the federal authorities who never did contact him. 20 When Breen first arrived, he had been stunned to see that absolutely no medical care was being given to the hundreds of wounded prisoners in the yard. 21 Many men needed surgery, but the medical facilities at the prison were Spartan at best, and disturbingly, there was no post-operative monitoring or care being provided at all to those who had to undergo primitive emergency surgery. 22 Without such care, the prisoners had suffered horribly. They faced respiratory obstruction, urinary tract obstruction, pain, bleeding, and a variety of complications which may occur following surgery, not the least of which is pain. 23 Yet despite the obvious agony of Attica's many wounded, this then young medical resident noted, he saw no meds being administered at all. 24. A third witness, National Guardsman Dan Callahan, added further detail to the stories of abuse. Callahan testified that he had seen a gravely injured light-skinned black man being seriously hurt by a high-ranking CO. They forced him to his knees, and at that point, the correction sergeant backed up a short distance and then ran forward and kicked the man in the face. He immediately went limp and his head was hanging down. He was bleeding. 25 That same day, Callahan had also seen a larger group of inmates who had been undressed. They were lying on their backs with their legs drawn up and shotgun shells had been placed on their knees. 26 Among that group, Callahan had been particularly disturbed to see an inmate who was lying on his back on what looked like a ping-pong table, his feet touching the ground. He had been stripped, and a football had been placed either on his chest or on his neck, and he was crying and begging for mercy. 27 This man on the table, the jury could clearly see, was none other than Frank Big Black Smith, sitting near them in the courtroom flinching as Callahan recounted his nightmare. Jurors also heard the gruesome account that former guardsman James O'Day had originally recounted in 1972 to both state officials and federal employees of the Justice Department. 28 O'Day had witnessed a correction officer dump a wounded inmate from his stretcher onto the floor and then demand that the man move and go down the walkway from Times Square towards C Block 29. When he was unable to do so, the CO had taken a Phillips head screwdriver and, with this prisoner, lying on his back with his knees up in the air and the guard reached down in the genital area of the rectum and poked this man 4 or 5 times and told him to get moving. 30 Even though O'Day's eyewitness account had not, back in 1972, persuaded the U.S. Justice Department that civil rights violations had taken place on the day of the retaking, Liz Fink very much hoped that O'Day's account would now persuade the jury. Prison officials on the catwalk looking down into the yard in the immediate aftermath of the retaking, from the Elizabeth Fink papers. Even if jurors might have doubted O'Day's testimony, the testimony of another state trooper who had participated in the retaking, Gerard Smith, made them suspect that O'Day hadn't seen the worst offenses. Trooper Smith pointed out that the NYSP men had deliberately removed every bit of identifying information, badges, name tags, and so on, so that authorities couldn't identify what troop or pinpoint the individual in case something happened. Ed. 31 Captain William Dillon of the New York State Police testified that he personally had told troopers to take off their identification, and he, of course, was reporting to his superior, Defendant John Monahan. 32 Gerard Smith also had terrible stories of prisoner abuse. One prisoner had lain motionless on the pavement, while a trooper had his gun up to his head and was shooting. This gentleman 33. Some troopers were going through Tent City and different foxholes the prisoners had built, and one that I saw explicitly just stuck the rifle into the hole and pulled the trigger and then checked the area out. 34 Smith saw another trooper drop a prisoner off of C catwalk into the yard, 15 feet down, and he was already hurt. Meanwhile, other prisoners were being hit in the head. 35. As horrible as the stories from these disinterested witnesses were, the testimony from the men who had experienced the abuses firsthand had the greatest impact on the jury. One Attica prisoner had been cowering near the hostage circle, and when he didn't lie down to the liking of a state trooper, he was shot above the knee. 36 Another prisoner, who had been shot twice, testified to finding himself in the midst of countless bodies on the ground, like they had those slave ships. There was people packed on top of people. I was pushed, I fell down and I couldn't breathe, and somebody was on top of me, I was on top of somebody else, and there was like stacks and stacks of people. 37 He had panicked because he couldn't breathe, but they was telling us, keep your head down, so I'm trying, I can't breathe, I'm trying to crawl and I'm trying to get the person up off of me. 38 Later that night, he had found himself in a cell, naked. There was a lot of hollering and a lot of cells open and they were trying to take people out. I did hear a lot of noise. I heard gunshots. At one point when it was very quiet, then the lights went on, then there was hollering, and then they were shining lights in your face, and you know, they shined the light at my face and everybody's face in the cell. They was going from cell to cell doing it. 39 The guards were looking for so-called leaders to bring to HBZ. The prisoner went into shock from his 2 gunshot wounds, and from the cold air pouring in through the shattered windows. 40. For the Attica brothers and their lawyers, it was imperative in this case that the jury should not only be persuaded that reckless torture, abuse, and medical neglect had taken place, but also that the defendants had known about it, had overseen it, and may even have ordered it. Although many of the defendants from the original list had been absolved, either because they hadn't been properly served, or because the judge had allowed them out, Liz Fink believed that key officials could still be linked to the abuse. After all, Commissioner Russell Oswald was in charge of the entire Department of Corrections, Superintendent Vincent Moncusi and his assistant Carl Fiel had been in charge of the prison from the moment the retaking shooting ceased, and Major John Monahan had been the leader of the NYSP's assault on the prison. The plaintiffs had to show the jury that these individuals had been instrumental in creating the situation that had led to so much suffering and trauma during the retaking, or been liable for not stopping the horrific abuses that continued later. Numerous witnesses, even when they didn't necessarily intend to help the plaintiffs, provided strong support for the plaintiffs' case. Former Attica observer and New York State Senator John Dunn's time on the stand left no doubt that Attica's own prison officials had been all too aware of the abuses taking place on their watch. By 1991 Dunn was serving as the U.S. Assistant Attorney General for Civil Rights, appointed by George H. W. Bush, and thus he made a highly credible witness. As Dunn told the jury, on the morning of the retaking he had been touring the facility on a catwalk looking down into the yard, and he had seen naked men running in a direction toward me through a row of correction officers who were striking them with their batons on buttocks. 41 Dunn and his guide, DOC's Deputy Commissioner Walter Dunbar, both saw 2 long lines of correction officers hitting men. 42 Dunn was shocked, horrified, embarrassed on the part of the establishment, and he told the jury that he had actually told Dunbar, Walter, I am seeing something I shouldn't be seeing and it better stop. 43. Testimony about the negligence of medical care came from pathologist Michael Bodden, who had been tasked with reviewing the findings of John Edland's prisoners' autopsies. Based on those autopsies, Baden was able to assess whether better medical care might have saved lives at Attica. 44 The case of prisoner Sam Melville was indicative. Melville had died of a shotgun slug that entered the left upper chest and caused his lung to collapse. 45 However, Baden made clear, if he had been found and identified and diagnosed and treated in a rapid manner, this is the type of wound that could be recovered from. 46. Equally damning in terms of specific defendants causing, via their orders, specific harm that came to prisoners, the jury heard from troopers whose testimony clearly supported the claim that Monaghan was indeed the main man making the retaking decisions on the 13th. 47 Drawing from those accounts, Liz Fink argued to the jury that Monaghan had the biggest responsibility, not only because he was the head of Troop A, the main state police unit from Batavia there to retake the prison from the first day of the uprising, but also because other members of the NYSP had also testified that he was the operational commander, that he was the person in charge. 48 Even though it was a man much higher up the chain of command than Monaghan, Lieutenant Colonel George Infante, who had, for example, allowed retaking troopers such as Mr. Barbolini to resign, rather than to prosecute him with the 3 counts of first-degree, or second-degree murder, that would have put him in jail for 25 to life, Liz explained to the jury that even he was reporting to Monaghan then. 49. According to Fink, Deutsch, and Heath, however, Monaghan was not the only official at fault. Plaintiff attorneys established from witness testimony that some of the most egregious incidents of abuse took place in the yard during the rehousing, and during the night of the assault, when Carl Feel was the highest correctional officer present. 50 Feel admitted that he had seen correction officers in his command using too much power to put someone down, or that they were cursing or shouting, insisting that he had told several, "Be professional, please, keep it down. Do your job more professionally." 51 When pressed, he had to admit that he had left the COS and troopers without supervision, and had not followed up on whether they heeded his warning. Feel tried to shift the blame for their actions to his deputy, telling the jury that "I know that Leon Vincent was down there and I assumed he was in charge," but his own testimony that Vincent had been with him in the administration building, not in the yard, undermined that defense. 52 The plaintiffs argued that Feel hadn't reined in his own people and, worse, he had decided to go home in the period immediately following the retaking, when the risk of violence was high. 53 This was a crucial argument. The claim against Feel depended not upon his personally and directly participating in any acts of abuse, but on what he did or did not do as the supervisor of the men who did commit these acts. Throughout the trial, the defense team's strategy had largely focused on trying to discredit witnesses, rather than defending their clients' actions. This strategy tended to backfire, for example when Oswald's attorney, John Stenger, tried to discredit a National Guardsman by drawing attention to his avoiding service in Vietnam. As the New York Times reported their exchange, Mr. Stenger noted that Mr. Burke had told the jury he had been trained as a combat medic. "But you've never seen any combat, right?" Mr. Stenger asked. "I beg your pardon," answered the witness. "Have you ever seen any combat?" the lawyer persisted. "I think," Mr. Burke said, "I saw combat that day, sir." 54. By January 9, 1992, all testimony had been heard, closing remarks from both sides had been delivered, and Judge Elfvin was ready to give the jury its instructions to begin deliberation. The judge's jury instructions, however, were confusing and included inaccurate standards for judging the case. Elfvin told the jury that the standard was wantonness but then indicated that context is important. Jurors, he suggested, had to decide if the situation in the yard was riotous, not riotous, or somewhere in between, then apply either a sadistic and malicious standard, a deliberate indifference standard, or some hybrid of the two. 55 The plaintiff's attorney Michael Deutsch expressed his dissatisfaction to the judge. "We are very troubled by these jury instructions because you have created a situation where you juxtapose what you consider normal versus emergency. Now, obviously, it was not normal what was going on here at Attica, but what we are talking about didn't occur where there was still an emergency either, nothing that would have justified excessive anything." 56 Deutsch elaborated, we would ask that it be made specifically clear as to the medical care that it falls within the non-quelling, after the riot was quelled or within a non-emergency situation, and there's thus no need to apply any kind of gradated standard on that question of liability. Point 57 They had proven under the law, Deutsch insisted, that state officials were negligent in this case, and he was not going to sit by while the judge tried to muddy the matter with flawed instructions to the jury. As Liz Fink saw it, Elfvin's instructions implied to the jury that in order to rule for the plaintiffs everyone had to be a sadist when that wasn't the standard. 58 She objected as well to the fact that Elfvin characterized Attica to the jury as a facility filled with dangerous prisoners when days of testimony had shown clearly that this wasn't even most of the time the case. 59 Despite the fact that she and her fellow lawyers argued these points through most of the long day, Elfvin was unmoved, and Fink had to be content with noting on the record that we believe you committed a reversible error. 60. As the jury began its deliberations, a new drama erupted. Judge Elfvin decided to take a vacation to Barbados, explaining that he would read their sealed verdict a month later when he returned. Point 61 The press was incredulous, and the plaintiff attorneys were furious, that the judge would take a holiday in the midst of a trial as important as this one. Everyone knew that Elfvin usually took this vacation at this time of year but had tried to dissuade him from doing so. Upon hearing that Elfvin had actually departed for Barbados, Liz Fink and her fellow lawyers tracked him down by phone, pleading once more to get him to come back to Buffalo. All Elfvin said in reply was, "They tell me there's a lot of bloviating in the paper this morning. I haven't read it myself, about the fact that the judge is leaving and the jury is continuing deliberations, so I guess you better put it on the record whatever you feel." 62 Michael Deutsch replied, "Judge, I guess what we're concerned about is what happens if you're gone and the jury has a substantive issue that needs to be addressed." 63 They cannot be addressed, Elfvin stated bluntly. "Now, if they get stuck in that situation on all four defendants," he went on, "the best I can come up with right now is they'd have to wait for me to come back." 64 Joe Heath then erupted. "The fact that substantive issues could not be resolved and the jury deliberations would have to be truncated and they would have to move on, is certainly a problem to us. As you know, this is a very serious matter." 65 The judge remained unmoved. To Elfvin's surprise, his own boss, the chief judge of the Western District, Michael Telesksa, then got involved. Point 66 As Telesksa recalled, he immediately ordered Elfvin home because over that weekend the jury had a really tough time. The phone system wasn't working, so they couldn't contact Elfvin with their questions, and, meanwhile, the New York Times was asking Telesksa for his reaction to Elfvin's having abandoned the case for the beach. So he called Elfvin himself, and they had a spirited discussion. 67 Elfvin came back to New York the next day. But Elfvin returned to the courtroom furious and spiteful. He punished the jury for its role in cutting his vacation short by instructing them that they would now work around the clock to come to a decision. 68 Outraged, the jurors wrote to the judge on January 22, 1992, "We, the Attica jury, feel an urgent need to register a response." 69 These men and women acknowledged the historic significance of the Attica case and the honor they felt to be considering it, but they took their duty as jurors conscientiously, seriously, diligently, and steadfastly. 70 For many of them, a good night's sleep had become but a vague and elusive memory of days gone by, and now they suddenly felt pressured and in a very real sense punished because they were unwilling to rush their verdict. Point 71 In closing, they wrote, "Our goal is justice, whether it takes 2 weeks or 2 months. The pressure and stress at times seems unbearable, but we continue to persevere." 72. Judge Elfvin's treatment of the jury, combined with the plaintiff's evidence against the state officials, did not seem to bode well for the defendants. If one were to lay bets, most would have said that the Attica brothers would finally be able to hold state officials accountable for all that had been done to them at Attica. And yet the judge's instructions had confused the jury, and had, additionally, caused major confusion with the jury sheets by offering jurors too many options. 73. Liz Fink and the victorious Attica brothers outside the courthouse in Buffalo, 1992, courtesy Mike Grawl / The New York Times. In the end, the jury found that the civil rights of Attica's prisoners had been violated during and after the retaking of the prison, but, when it came to deciding which of the 4 defendants on trial should be held responsible, it was split. Ultimately, jurors were only able to agree that one man, Attica's Assistant Deputy Superintendent Carl Fiel, had been responsible for the acts committed at Attica. They believed he had been part of the planning and then personally oversaw the brutality. 74 With regard to the responsibility of the other 3, Superintendent Mancusi, Commissioner Oswald, who had died in March of 1991, and Major Monahan of the State Police, who had died in 1987, the jury was hung. Although disappointed that so many defendants had escaped legal censure, Attica's surviving prisoners were still elated that their ordeal had been acknowledged in the verdict against Fiel and that they would finally be awarded some damages. Importantly, if any defendant was found liable, the state was liable, and this was no small thing. First Assistant Attorney General of New York Richard Rifkin was already telling reporters that he was willing to begin negotiations regarding the estate payment on behalf of Mr. Fiel. 75 However, when exactly they would receive the money, and how much they would get, was not yet clear. As one newspaper speculated, the issue of damages would be resolved either through a settlement or a final legal ruling years from now. 76 And yet, so much time had already passed, it was hard to imagine holding on through more delays. 50. Delay tactics. While the plaintiffs were satisfied, the defendant Carl Fiel felt the trial had been supremely unfair. In his view, he had been one of the least powerful men in the chain of command at Attica during the rebellion there. Somehow the governor of New York, the commissioner of corrections, his own boss, Vincent Mancusi, and even Major John Monahan, who had actually led the assault on the prison, had not been found liable, but he was. To be sure, both Oswald and Monahan had passed away, but that mattered not. If he was liable, then surely they, or more technically their estates, should have been as well. Though Fiel couldn't comprehend the reasons for the verdicts, Liz Fink and her team understood just what had led to such a strange outcome in this case, and she had every intention of using this knowledge to make sure the other defendants did not, in fact, get off scot-free. A key reason why so many of the defendants had skated was because of the way the case complaint had been written. In essence, the original complaint had named specific defendants in connection with specific violations, for example, naming Monahan for his role in the assault but not for the reprisals, Mancusi for his role in the reprisals, but not in the neglectful medical care. The jury was asked only to consider if Mancusi was liable for the ugly reprisals, therefore it could not even consider other ways in which each defendant may have been liable for other actions they had or had not taken in 1971. Determined to leave no stone unturned in this regard, Fink decided to file a key motion to amend the complaint so as to add causes of action against defendant Mancusi for failure to provide the plaintiffs with medical care in violation of their constitutional rights, and against the estate of Monahan for the reprisals that plaintiffs suffered after the retaking, and filed a similar motion to add in Oswald for the reprisals. 1 In the first motion she argued that the facts presented during the 1992 liability trial make it clear that there is more than sufficient evidence to support a verdict against defendant Mancusi for failure to provide medical care and a verdict against the defendant estate of Monahan for the reprisals suffered by the plaintiffs. 2 Ultimately Elfvin dodged these motions. Although he eventually ruled that the verdict against Fiel should be taken as ascribing responsibility to Fiel and Oswald and Mancusi for any and all reprisals for which any of them had the requisite involvement per the Civil Rights Act, it didn't alter the jury's decision and, thus, Fiel alone remained legally liable. 3. Fiel refused to accept the jury's decision in his case. 4 He would try to capitalize on Judge Elfvin's convoluted jury instructions and verdict sheets, arguing in his own appeal that the plaintiffs had failed to show liability because the special verdict questions were not properly submitted or correctly phrased in accordance with the facts of the case and the applicable law, and, thus, that jury and counsel misconduct deprived him of a fair trial. 5 What is more, the passage of over 20 years since the events deprived him of an opportunity to be heard at a meaningful time and in a meaningful manner as is required by due process. 6. Judge Elfvin was tired of being challenged. He responded firmly, "This court finds that there was sufficient evidence for reasonable jurors to return the verdicts which were rendered against Fiel. This court has considered all of Feel's other contentions and also finds them to be without merit. 7. While Judge Elfvin was not willing to let either the plaintiffs or defendant Feel revisit the jury's decision, or what had led to it, he also seemed unwilling to move the case forward to determine damages in the wake of that decision. Elfvin's clerk Ellen Yaknin put it bluntly, Judge Elfvin made decisions to deliberately delay the cases. 8. There were a number of ways to handle the damage awards in the case and Elfvin seemed loath to embark on any of them. There could be negotiations with the state that would result in a settlement of an agreed-upon amount, or there could be a jury trial, or several of them, to determine damages. At one point Judge Elfvin was so frustrated with the plaintiffs mounting pressure on him to settle the issue of compensation, he threatened to insist upon 1,200 separate damages trials, which would be impossible for their lawyers to handle. 9. From Liz Fink's point of view, the best thing that could happen for her clients, many of whom by now were very ill or had already died, was to settle this case. Yet even for this to happen, there was much work to be done. She and her team first had to go through incredible work to make sure that any potential class member in this class action suit was notified that they had a right to this settlement. As she recalled, Judge Elfvin made me pay notice to the class in the most expensive way possible. He, for example, ordered that I put a notice in USA Today. 10. Then, to facilitate the distribution of monetary awards, the plaintiffs' attorneys had to devise a questionnaire to determine who had suffered exactly which violations of their Eighth Amendment rights. Cruel and unusual punishment. 11. In 1994 a frustrated Liz Fink wrote to Judge Elfvin indicating that they had settled upon 6 clear categories of damages and that she had all of the information regarding which of the plaintiffs fell into which category. 1. Those who suffered physical reprisals before they were locked in their cells. 2. Those who suffered physical reprisals before they were locked into their cells and who were subjected to mental torture after they were locked in their cells. 3. Those who suffered physical and mental reprisals both before and after they were locked in their cells. 4. Those who were subjected to special and extraordinary physical reprisals before they were locked in and who were subjected to mental torture after they were locked in. 5. Those who were subjected to special and extraordinary physical and mental reprisals both before and after they were locked in. 6. Those who suffered injuries sustained in D-yard who were also subjected to reprisals. 12. Judge Elfvin's response made it abundantly clear that he still was in no hurry to move forward. In fact, he actively muddied the situation by suggesting, for example, that Feel should, now 3 years after the liability trial, appeal the verdict. 13. Incredulous, Fink penned a scathing letter to the judge reminding him of the extraordinary time and resources her team had put into preparing for the damages trials, which, she noted, had already been scheduled for that November. 14. Now, suddenly, on the brink of trial, she wrote, Your Honor unilaterally and without consent of counsel has cancelled the scheduled damage trials, and worse, he had invited Feel to appeal at this late date. 15. Pulling no punches, Fink declared, this suggestion is unconscionable and not consistent with fairness and justice. 16. Despite the fact that there had indeed already been 3 years of status conferences concerning the damages issues, and that defendant Feel was in the plaintiff's view now raising a specious argument that damages upon the reprisals verdict cannot be awarded until after there has been a determination of liability for the assault, the judge still refused to set a date for any damages trials. 17. The years continued to drag on. 18. Meanwhile, Liz Fink and the rest of her team worked to be sure they would be ready in case they could move Elfvin to begin the damages trials on schedule. They pored over scores of depositions that had been taken which indicated who had been tortured at Attica and in what manner. In one deposition, Akil Al-Yundi, aka Herbie Scott Dean, told how he had been forced to crawl from D-yard to A-yard, and run a brutal gauntlet, and then received an ugly beating from C.O. Donald Jennings. 19. Call on your Allah now. See, Allah can't save you, Al-Yundi said Jennings had shouted while landing blow after blow. 20. Al-Yundi endured all of this after suffering a gunshot in the hand during the retaking from an unjacketed bullet that literally blew out the back of his hand. The wound was so big that one could see daylight through it, and it would eventually require 16 major and 16 minor operations to heal. 21. Fink and her team spent untold resources getting many of the Attica brothers seen by doctors, including psychiatrists, so that there would be a clear and dispassionate assessment of just how much damage had been done to these plaintiffs by officers of the state. Every report that came back made clear that the physical and mental damages these men had suffered were extensive. As one doctor wrote of an Attica prisoner he examined, he describes being in a cell with 4 other men without water, food, or clothing for 2 days or more, and recorded this man's own words: "I know what a person can do to me now. I have become withdrawn and introverted. I want to be left totally alone." 22. Another physician diagnosed a prisoner with suffering severe post-traumatic stress syndrome in addition to physical trauma because this man had been stripped and, as he had described it to the doctor, been paraded around naked like a trophy by the state police, who were making all kinds of obscene statements, jokes about penis size, etc. 23. Liz Fink knew well that it could still be a long time before Elfvin would begin damages trials where she could actually use these depositions or psychiatric reports. She now had years of experience watching Elfvin drag his feet in the original case and thus had no reason to think he would act any differently in the damages phase. Perhaps, she thought, there was a way to settle this directly with the state of New York. After all, when the Field verdict was handed down, First Assistant Attorney General Richard Rifkin had seemed open to discussing this. So in 1992 Fink decided to contact Elfvin's boss, the man who had yanked him back from Barbados, Chief Judge Michael Telesksa, to see if he would be willing to help broker a settlement with the state. She assured Telesksa, the defendants have no objection to a settlement process and agree that a judicial intervention might be helpful. 24. Telesksa was well aware that this settlement was going to take political finesse. As he later put it, "I knew that all roads led to Albany. It was going to be a political decision before any money was had." 25. Telesksa was not sure that he was the right one to oversee such negotiations, so he punted the task to another judge. He explained to the plaintiffs that he would help them manage a settlement if one was brokered, but he felt that Magistrate Judge Edmund Maxwell, a jurist who years earlier had heard testimony from prisoners regarding abuses at Attica, should conduct the actual negotiations and report back to him. 26. Behind the scenes, even though Maxwell was officially in charge, Telesksa too made a number of discreet inquiries and let them know that all I wanted from them was the money. The cases would go away forever. In short, they would be buying a hell of a lot of absolution. 27. Telesksa was having a hard time making any headway with the state. 28. The biggest barrier to settling with these plaintiffs was the idea that it would be tantamount to an apology. The state was not about to apologize. 29. He even tried to address this issue head-on, assuring the state, "There will be no apologies, since I knew one wasn't forthcoming," and yet still he could see they weren't ready to budge. 30. Even the affable Magistrate Maxwell was getting nowhere with the state. So Fink decided that the Attorney General's office needed another firm push. It just so happened that Liz Fink and Michael Deutsch were at this time also working on another case currently being tried in front of Judge Jack Weinstein, the most impressive judge in the court, as far as Fink was concerned. Weinstein was one of the top 5 district judges in the country and, as important to Fink, he was Mr. Class Action. He had settled cases related, for example, to Agent Orange 31. When Fink found herself in front of Judge Weinstein, she broached the subject of the Attica case and asked for his help. Weinstein was reluctant to get involved, but she pushed, assuring him that Maxwell would appreciate his help. The next day, Weinstein had to be out of the court, so a different magistrate was in charge. Unexpectedly, Judge Weinstein arrived with Ken Feinberg, another attorney known for his mediation and settlement skills. Feinberg seemed eager to get involved and offered to take advantage of his regular communication with the Attorney General's office to suss out whether the state was really serious about settling. He said, "I will ask Cuomo." 32. This was big news since he was talking about approaching the then governor of New York, Mario Cuomo. A few days later, according to Liz Fink, Feinberg confirmed that the state had no intention of compromising, and also that First Assistant Attorney General Richard Rifkin, whom Fink had been counting on, had no authority to make any deal. When Fink called Rifkin to see if this was true, he was surprised to hear that he had no power to make a deal. He ended the call to look into the situation, and called Fink back almost right away to say, "You're right, I don't." 33. Demoralized, Fink again turned to Telesksa and, with the help of court clerk Ellen Yaknin, managed to get him more overtly and actively involved in trying to seek a settlement. But Telesksa also got nowhere with the state, and so he decided to lean on Elfvin again, to hold some damages trials. Under pressure from his boss, Judge Elfvin finally scheduled 2 damages trials, instead of one main trial to decide damages for each Attica prisoner in the class. There would be one trial that would set the highest level of damages a prisoner in the class could get, based on the case of the torture suffered by Frank Big Black Smith, and a second trial to set the lowest level of damages a prisoner in the class could receive, based on what an Attica prisoner by the name of David Brosig had suffered on the day of the retaking. Frank Smith's trial was set to begin on May 29, 1997.34. 51. The Price of Blood. Finally, more than 25 years after the smoke had cleared over Attica, a damages trial began on behalf of Attica survivor Frank Big Black Smith. But this Attica brother had not just been waiting for justice to be done. He had worked as Liz Fink's paralegal to bring the original civil rights case to trial in 1991 and had labored since to make sure that all surviving Attica prisoners were told of the class of which they were a part and were informed that damages trials would now begin. He would have to relive everything one more time, in order to make sure the jury knew how barbarically he and his fellow prisoners had been treated in 1971, but this time he would make sure he was really heard. The damages trials would be quite different from the 1991 trial that determined Carl Fehl's liability. Entirely new juries had to be constituted, and the issues they would hear were also very different from those in the previous trial. Since liability had already been established, each jury simply had to decide the amount of the monetary award the plaintiff would receive. The idea was that Big Black Smith's trial would set the high end of the damage award. No one in the class would receive more money than he did, and the only men to receive an equal amount would be the Attica brothers, who had already been placed in Category 1, those who had suffered the most severe violations of their Eighth Amendment rights. From the very first day of the trial, it was obvious to the press and jury why Big Black Smith's case had been selected as the benchmark for the high-end damage amount. Liz Fink refused to sugarcoat the brutality at the heart of this case. In her opening statement, she also emphasized just how long prisoners like Frank Smith had been fighting to get some justice from the state of New York. That first morning, she told the jurors how Smith had tirelessly led the fight for justice with the prisoners who are at Attica, even after he was released from prison in August 1973. She reminded the jury that what this case is about, ladies and gentlemen, is torture. This was torture that lasted for hours, that was physical, was race-based, and was psychological. This was torture that was witnessed by others, and these witnesses will come in and testify before you about what they saw happen to him and their reactions to what they saw. 2. Unsurprisingly, the lawyer now representing Carl Fehl, Mitch Banas, tried to paint a very different picture for the jury. He stated bluntly, "You will hear very little medical proof of what actually happened, injuries actually suffered by Mr. Smith. You won't be hearing about casts or stitches or surgery. What you will hear about are bumps and bruises and bandages." 3. Further, he argued that Smith's injuries have not prevented him from earning a living, have not diminished his earning capacity, have not significantly impacted the way he lives his day-to-day life, and have not otherwise stopped him from leading a productive life. 4. But Banas's words seemed absurd from the moment that Big Black took the stand. By now, Big Black was 64 years old. He had been fighting to be heard, and for the state of New York to be held accountable for its actions. For much of his adult life, he was going to make sure that the jury understood exactly what had happened to him. Black's testimony transported the jury back to the hazy, gas-choked prison yard where he and hundreds of other men had been forced to strip naked and crawl or stumble across the muddy, rutted yard while suffering repeated blows from troopers and cops. He testified quietly. "I kept hearing my name, I was crawling as everyone was made to do, and I kept hearing my name, 'Where's Big Black, "Where's Big Black?" And then eventually someone said, "There he is, there's the nigger, we got him now." He came over to me and said, "Get up, nigger," and kicked me and I got up. It was Mr. Howard Holt, officer I worked for in the laundry. He said, "Get up, nigger," and I got up and walked some, and he pushed me some and I fell back down, and then I got up and I walked across the yard with him pushing me. Other officers joined him and they led on the side up to a block tunnel and placed me on the table. 5. According to Black, the officers kept saying that I had castrated an officer, and they was gonna do it to me. He had pleaded with them, "I didn't do it, I didn't do anything like that, you all know I didn't do anything like that, why you doing this to me?" 6. These men, however, were unmoved. "They say you like to play football, we going to put this football into you, nigger, and then we gonna kill you." 7. On the stand, with tears streaming down his face and voice choked up, Black explained to the jurors how these men had shoved a football under his chin and told him that if he let it drop, they would shoot him. His voice choked up as he tried to convey to the jurors what it had felt like to lie on that table for more than 5 hours being tortured, trying to keep that football from falling, looking beseechingly up to the catwalks where state employees and officials were looking down, and to have known that none of them would intervene to stop his abuse. 8. As the men on the ground struck him repeatedly in the testicles and shouted threats, the men above were spitting on me, dropping cigarettes on me, and the shell casings from fired weapons was dropped on me and kicked from the catwalk down onto me. I was scared and they told me not to move, and I would flex my body to make the cigarette fall off me, hopefully, so it wouldn't burn too long. 9. His legs hung over the edge of table for 6 hours, until they started to go numb. I kept trying to move them to keep some kind of feeling in them, he explained, but he was terrified of moving too much lest the football fall. Ironically, he recalled, the football became a part of me. I felt that it was good that the football was there, it gave me something to concentrate on and to deal with how I was feeling. I was afraid that if it wasn't there, if it would fall, that they would do something to me. 10. Frank Big Black Smith, on table, and other prisoners were tortured for hours as their fellow prisoners were marched past them. From the Elizabeth Fink Papers. Looking at the jurors, Big Black wept more as he told them, "I was scared, you know I was afraid, and I kept thinking, how could a person say that and do these things to another person, regardless of the fact that I was an inmate." 11. He spoke of the pain he had been in. "My head was hurting and my side was hurting, my back was hurting, my leg was hurting, and the most excruciating pain I had was in my testicles. It was a very excruciating pain at that time that I was laying on the table in my genital area." 12. When he had at last been ordered off of the table, he had been there for over 6 hours. When he tried to shift his weight, he could hardly move. "I sat up and my legs were dead and, you know, I fell to the ground, to my knees, and I tried to get up again, trying to balance myself on the table, and I got pushed, I got hit then, and I finally got enough strength to get up and to go to the doorway. I was scared, I was beyond scared." 13. Somehow Black managed finally to get himself to the door of a block, but his heart almost stopped at the sight of 20 to 40, maybe 50 officers on two sides, and in the middle they had glass on the floor, and I was told to go through there. Still completely naked, he endured the blows of axe handles and the baton and pig handles. 14. As he ran this gauntlet, I was pushed, I was hit, I fell down, I was dragged, I went through a lots of licks to my arm, to my leg, to my back, to my head. 15. The pain, Black repeated, had been horrendous. "I mean pain, it's just pain, unbearable pain, my testicles, my fingers cut and arms and back is sore, I'm full of pain." 16. There was ugly emotional pain too, as he was forced to endure an endless barrage of vile racial attacks, slurs. 17. From a tunnel, Big Black was forced to run through another gauntlet on the way to HBZ, where he knew he would be in more danger. 18. When he arrived in housing block Z, Black was knocked to the floor and they was beating me on my arms and on my legs and on my back. They bust my head, I passed out, blacked out, because the next thing I remember, I was in a dark room by myself. 19. By this time he had blood running down his face, yet the ordeal was still far from over. 20. Once he had been placed in a Cell, troopers, and Cos made Black lie on the cold cement floor, still naked, legs spread eagle. "Open your legs for us, nigger, we gonna take it." At least 3 correction officers were shouting at him as they continued to hit his genitals and began playing Russian roulette at his head. 21. Finally, someone had put Black on a stretcher, ostensibly to take him out of HBZ to get some medical care for his injuries. "They put me on a stretcher," he recalled for the jury, "and I could remember that first someone came in and put like a little gauze or something on my wound and I was placed on a stretcher and I was taken in the pharmacy's part of the hospital where a bunch of other people was laying all over the floor." 22 Suddenly, though, Big Black was yanked back up to HBZ and, on the way, he was summarily dumped on the floor of the elevator and was made to scoot my buttock up flush against the wall with my feet up on the wall with me laying on my back while being threatened with more injury. 23 When the elevator doors opened he was told, amid jeers, shouts, and laughter, to run along the hallway to his cell, and was once again beaten along the way. 24 Indeed, Black said, some of the worst pain he had experienced that day was actually in his wrists, which were fractured because he had used them for so many hours to protect himself from the countless vicious blows to his body. His entire body by then was swollen. 25 More than 20 years later, he showed the jury how he still couldn't fully raise his right arm up over his head, his legs still swelled terribly from the damage he had suffered, and he still had burn marks everywhere. 26 Although he was now once again contained in a cell, Black remained terrified, especially when Correction Officer Howard Holt came by. As he began praying as hard as he could for some protection, Holt, he told the jury, had pointed a gun at his head to play Russian roulette. While all of this was taking place, Carl Fiel had passed by and looked into the cell. As Big Black recalled, Mr. Holt was saying to him, "This is the person that castrated the officer, and Fiel is looking at me that and we gonna castrate him? Oh, he's the one that castrated the officer, yet, we gonna castrate him too." 27 Seeing that even an Attica supervisor like Fiel was unmoved to protect him convinced Black that he had no one to help him in this isolated area of the prison and, should he die, no one would know or care. Still, even though Fiel had merely looked on as Holt played Russian roulette with him, Black remembered, "I'm still praying and hoping that the real truth would come out because he knew he was innocent." 28 I didn't do this, and I was hoping someone would understand." 29 As he prayed his urine ran red with blood and both of his fractured wrists dangled limply. 30 In the courtroom, Black felt good about having finally told his story on the record. But he was also embarrassed by his own tears and his inability to tell it more formally and perhaps clearly. "I think the crying is anger," he tried to explain to the jury. 31 His tears came unbidden, he went on, "due to the fact that I felt violated, helpless. I could be walking the street, I could be driving the car, I cried at night in my bed, it's just something that bothers me." 32 Multiple physical and psychological evaluations could have corroborated for the jury just how much this ordeal at Attica had scarred Black. He had received thorough evaluations, one well after the first trial had ended, and according to his physician it was obvious that this man still suffered from the horrific torture he had endured in 1971.33. The doctor's notes read, "He reported that every time he thinks about what actually happened to him at Attica he starts crying, he gets angry, and then he becomes afraid that he will somehow lose control." 34 Notably, to deal with this trauma Big Black had turned first to drugs and then to God, which helped somewhat, but he was by no means healed either psychologically or physically. According to the doctor's report, his injuries to his urogenital area were such that he urinated blood for about 2 years and he still had nightmares, being unable to trust anyone in his life. 35 In the doctor's view it was indisputable that Big Black suffered severe post-traumatic stress disorder and, without question, it was what Black experienced during the retaking of Attica and more importantly, the psychological and physical torture that he experienced after the prison was retaken that caused him to develop this disorder. 36 To the plaintiff team's fury, however, Judge Elfvin would not allow Big Black's physician to share his informed conclusions with the jury because if he were allowed to give his opinion I would have to have allowed Mr. Fiel to bring in his psychiatric expert to the courtroom to give his opinion. 37 Fortunately, Liz Fink didn't rely solely on medical testimony to persuade the jury that Big Black had been tortured while Carl Field looked on. She also made sure that the jury heard from several of the people who had testified at the liability trial in 1991, including National Guardsman Dan Callahan, who had witnessed some of the torture Black had suffered on the table in a yard. Other witnesses to the abuses he had suffered included another guardsman named Ronald Dill, who happened to open the door of the prison hospital and very clearly saw the brutality committed against him. 38 Black had been on the floor writhing and begging for mercy, saying over and over again, "I didn't do it, boss. I didn't do it, boss." 39. By the time the case came to a close on June 4, 1997, this jury was visibly shaken. In her closing remarks, an exhausted Liz Fink tried to stress how important it was for the men and women of the jury to really hear all Black had endured at Attica and every day since. "True," she said, "the only thing you can do is give him money. And it doesn't make up for it, but it justifies the fight and it heals and gives you closure. And what money is about, what the monetary award is that it compensates Mr. Smith for what was done to him, for the hours he spent being tortured, and it makes an attempt, ladies and gentlemen, an attempt to make him whole." 40. Judge Elfvin once again gave an Attica jury instructions as it headed into deliberations. With every word he uttered, Big Black and his lawyers felt the judge was trying to undermine them. Elfvin opened by telling the jury that this whole trial had been a very emotional situation for many of the parties involved and opined that some of the witnesses were very emotional, wrapped up in this whole matter. 41. He reminded the jurors that the first trial had already established that the prisoners' civil rights had been violated, so now they had to determine whether they were persuaded by the evidence presented to them in this trial as to the nature and extent of this violation of rights, and determine how those violations translated into a monetary sum. 42. However, he went on, although jurors accepted that reprisals had taken place at Attica against the prisoners, they still had to determine whether this plaintiff, Mr. Smith, suffered and/or suffers and/or will suffer the effects of such, and, should they determine that he would get money, any monetary award of damages must be reasonable. 43. Big Black and his legal team looked on, stunned. Just as in the first trial, Judge Elfvin was trying to shape the outcome of the jury's deliberations by distorting his instructions by inserting his personal views of the case. They also couldn't believe, given these instructions, that the jury must decide if Black suffered psychological effects, that Judge Elfvin had prevented the jury from hearing the conclusions drawn by a medical professional about the causes of Black's psychological trauma. As Michael Deutsch noted disgustedly on the record, "Just so the record is clear, we do have an exception to the way the court formulated the instructions as the psychological testimony because the defense psychiatrist never came here to testify at all." 44. Elfvin's instructions to the jury that their award must be reasonable was equally galling and potentially costly to the plaintiffs. As they pointed out, what is reasonable to one party might well be unreasonable to another. Notwithstanding Judge Elfvin's attempts to blunt the impact of the evidence and to limit their monetary award, jurors had listened carefully to the testimony and were moved by his ordeal. On June 5, 1997, they awarded Big Black $4 million in damages. It was Elfvin's turn to be stunned. Not only was this amount huge, but it was an amount that, given the structure of damage categories, many other former Attica prisoners would also be entitled to from the state of New York. 45. On June 23, 1997, soon after this first headline-making award was announced, the second damages trial began for former Attica prisoner David Brosig. Brosig was selected as an example of a prisoner who suffered the average level of harm common to all of the class members, not singled out for special vengeance after the assault. 46. But the average level of harm at Attica during the retaking or in subsequent weeks was no easier to hear about than the traumas suffered by Big Black Smith. Once again Liz Fink opened the trial by highlighting the importance of the jury's job in the case. This time she was flanked not only by Michael Deutsch and Joe Heath, but also by New York City lawyer Danny Myers, who, like her, had been working on Attica cases for decades now. 47. Here it was, nearly 30 years later, she pointed out, and they still hadn't managed to secure justice for the scores of prisoners who had been so wantonly and horrifically abused. These jurors could help to remedy this, she reminded them, by awarding Attica survivor David Brosig substantial compensation for damages. Fink explained that Brosig was only in Attica in the first place on a minor parole violation. He had gotten into trouble as a kid and then got out, but then failed to report to his parole office. 48 At Attica, she went on, this young man was not only beaten on several occasions unnecessarily, but was also subjected to psychological torture, which affected him for the rest of his life. 49 The juror's task, Fink made clear, was to determine two things: whether Mr. Brosig suffered reprisals, actions which are taken that are sadistic, which are malicious and are for the very purpose of causing harm. And after you determine whether he was subjected to those kind of reprisals, it is your responsibility to set a monetary value, compensatory value on what he should get for those damages. 50. The jury then heard Brosig's story firsthand. He was a shy man, unused to being in the spotlight, and he spoke quietly. You couldn't crawl fast enough, he tried to explain to the jurors, shaking his head. 51 You couldn't crawl too fast with your hands on your head, so the bodies, the people coming through the door started piling up on top of me. I began to feel like I was getting crushed, suffocated. It was like being on the bottom of a giant pile, and I know I had to get out of there. It is I felt that I would suffer, I would get hurt. 52 And so, Brosig went on, his impulse was to try to get up so that he might get some air. As he tried to stand, though, a state trooper came up and he pointed a shotgun at my head and said pretty much the effect of "nigger lover, you are going to die," and he hit me with the shotgun. It was enough to see stars. 53 We were called nigger lovers, Brosig, who was white, explained. We were told at times that we deserved to be killed. We were told that we didn't deserve to live, that we were nothing but garbage. Nobody would care. At this point, like Big Black before him, Brosig began to weep. And he too was embarrassed that he was so emotional. The jury heard a muffled "I'm sorry" as he tried to gather himself. 54 Eventually continuing, he told the story of his ordeal after the shooting stopped, being forced to get through the gauntlet of troopers and caught in a tunnel. You could hear the sounds of pain of the people being hit, and you could hear angry remarks, he said sadly. Pretty much racial epithets. Nigger, nigger lover. 55. As in the damages trial for Big Black, Fink made sure that the jurors heard plenty of corroboration of all that David Brosig had experienced from other witnesses. Just as Big Black's jury had, this jury also heard of retaking horrors from men such as Observer John Dunn and National Guardsman Daniel Callahan. They also heard medical testimony, and, most movingly, from Brosig's former wife, Gail, about how much this man suffered in the years after the trauma of Attica's retaking. When Liz Fink made her closing remarks on June 26, she felt that they had done all they could to make it clear in this courtroom that even those who had suffered the least torture at Attica would be permanently scarred. Through her witnesses she had proven that David Brosig had endured a sustained terror which continued unabated for days and which reappears to this day, 26 years later, when he's close to 50 years old. 56 She reminded jurors how Brosig had described the beatings, the screaming of the inmates, the sounds of sticks on flesh. Here he is, 21 years old, naked, vulnerable, terrorized. 57. Then, after the beatings, there was the period where Brosig had been ordered to stay standing for hours on end and threatened with death if he swayed or fell. What was the justification for this? Fink asked the jury. There wasn't one. They were made to stand because they wanted to terrorize and torture them. They were made to stand there for cruel and unusual punishment, for a malicious reason. 58. Imagine the terror, Fink said sadly. And really, you don't have to stretch your imaginations, because you saw the effects of what happened to him when he testified. You saw him break down. 59 Perhaps worse than anything, the torture that was inflicted upon Mr. Brosig, was not by the actions of law enforcement existing in places where barbarism is the law, but what happened here happened about 50 or so miles away, committed by people who are sworn to uphold the law and the Constitution. 60. In his closing remarks, defense attorney Mitch Banas focused on trying to make the jury question whether any of this horror was really Carl Fiel's responsibility, even though the original trial had already determined that it was. 61 Now I'm not here to tell you that nothing happened to Mr. Brosig at Attica on September 13, 1971, he stated in his closing remarks. Obviously things happened to him. What I am here to do is to try to help you place what he says happened to him in the proper context. 62 That context, Banas suggested, was the utter chaos of a riot in a moment when ordinary people were simply trying to restore some semblance of order. As Banas said in conclusion, one of the things that's certainly beyond dispute in this case, is that there were extraordinary conditions prevailing at Attica on September 13, 1971. It was hardly a picnic there. Portions of the prison had been destroyed, hostages were being held. Violent inmates had weapons that they could use against law enforcement officials. Yes, there was a need to conduct continuous head counts, even if it meant waking inmates up. Obviously, there was a need to strip the inmates and search them for weapons and make them lie down and move on the ground to make room for other inmates in D-yard. None of that was retaliatory, and none of it was, in any way, malicious. 63. You have to ask yourself, he said in closing to the jury, what injuries did Mr. Brosig really receive from that? Most of the nightmares Mr. Brosig testified about were abstract. How often does Mr. Brosig have those nightmares, regardless of what they are about? 64. Yet again, though, even with Banas's alternative narrative at their disposal and with equally problematic jury instructions from Judge Elfvin, the jurors hearing this case had been appalled by the treatment that David Brosig had endured as a young man during the retaking of Attica. On July 16, 1997, they awarded him $75,000 in damages. 65. Now the state was in real trouble. On the high end of the damages scale it was on the hook for $4 million, and on the low end it would have to pay out $75,000 to a class of 1,200 men. The state decided, immediately, to appeal the original liability case because, if that were to be overturned, the damage awards would go away. As this appeal went forward, Liz Fink and the rest of the plaintiffs' attorneys were worried because they feared that the Second Circuit Court of Appeals would rule in such a way that protected the state from liability for the tens of millions of dollars the two damage verdicts indicated that the prisoners were now owed. They were correct. A three-judge panel of the United States Court of Appeals for the Second Circuit heard this case on July 16, 1998, and decided on August 3, 1999, that jury verdict in the class liability phase failed to establish Fiel's class-wide liability and thus the court therefore reversed both the liability and damages verdict. 66. This decision was devastating and deeply ironic. The plaintiffs had argued vehemently that Judge Elfvin was committing reversible errors in the way that he had instructed the jury before its deliberation, but in their view these errors only benefited the defense. In this circuit court decision, however, the judges saw these same flawed instructions as working unfairly against Fiel. In fact, Judge Ralph K. Winter wrote, Elfvin's jury instructions had virtually ensured that the juries in the damages trial would be forced to consider issues of Mr. Fiel's liability a violation of the Seventh Amendment's bar on different, successive juries trying the same issue. 67. In another irony, the court confirmed that Judge Elfvin had also caused serious problems with the jury verdict sheets he had issued. Winter's decision explained that the verdict sheet that the original jury had been given was flawed because the wording did not require findings sufficient to support class-wide liability or even liability to particular, identifiable plaintiffs. 68 Rather than see this error as, again, benefiting the defense since, for example, these flawed sheets were, in part, what let many defendants off the hook in the court's opinion, this error had harmed Fiel and therefore the damage awards of Smith and Brosig must be reversed. 69 Fiel's rights had been additionally violated, the decision went on, because Elfvin had allowed the damages phase juries to revisit many of the same issues as were considered by the liability jury, and indeed Elfvin was directly chastised in this ruling for causing confusion in the damages trials when he equivocated as to what had actually been established in the liability trial. 71 of the most alarming aspects of the appeals court's decision, however, was that it questioned the wisdom of Judge Elfvin in certifying a class action to begin with. 71 If the Attica brothers were not determined to be a class, then any future attempts to hold anyone liable for their pain would have to be done one by one. Potentially, and unimaginably to lawyers like Liz Fink, justice would have to come via litigating 1,200 separate cases against the state. Still, the Second Circuit made it clear that those 1,200 men had every right to have their concerns addressed, to come to some sort of resolution with the state of New York, now and not a minute later. Indeed, the decision made clear that the defendants in this case had done all they could, frequently not without the court's acquiescence, to delay resolution, and that strategy can no longer be tolerated. 72 And, given the long history of this matter, it concluded, we direct the district court to give it expedited treatment. We stand ready to exercise our mandamus power to order a lower court to do this court's bidding should unreasonable delay occur. We respectfully suggest that the Chief Judge of the District Court consider assigning this matter to the judge that is best able to expedite its resolution. 73. No matter how much it chastised Judge Elfvin, this panel's decision was heartbreaking to every one of the Attica survivors who were still alive, as well as to the family members seeking justice for deceased relatives. Liz Fink too was bereft. She had known that Elfvin's jury instructions weakened the plaintiff's chances of victory, but when the defense had appealed on the grounds that it weakened Field's chances with the jury, she was forced to argue that these problematic instructions had, at worst, been harmless in light of the preponderance of the evidence they had presented of the state's liability. And, according to Ellen Yaknin, Fink was utterly brilliant in mounting her argument when she came before the Second Circuit. 74 Still, she was unable to stop that three-judge panel from undoing everything she had fought so hard to win in 1991 and 1997. Yet giving up was, in Fink's view, not an option, especially considering how much had gone into the trials. At least the Second Circuit had not disputed the facts that the plaintiff's lawyers had spent years establishing, and it also called for the state to stop dodging its responsibility to resolve this issue with the plaintiffs. It was time, Liz Fink decided, to reapproach Judge Michael Telesksa. This time, the state of New York would be brought to the table. 52. Deal with the devil. By the time the Second Circuit Court upended the Attica civil case victory, it had been nearly 3 decades since the state had retaken the Attica Correctional Facility with extraordinary force. There was, Liz Fink hoped, still a chance to make the state officials take some responsibility for the trauma caused back in 1971. There was still the possibility that they could force the state to reach a settlement. That would at least be something. And so she called Ellen Yaknin and asked her to ask Judge Michael Telesksa of the Western District if he was still willing to try to settle the case. He was. And, as Yaknin reassured the plaintiffs, he was a damned good settler one. Telesksa was a bit incredulous that here he was, this many years later, still trying to get the state of New York to do the right thing. Couldn't the Attorney General's office understand what was so obvious to him, which was that these prisoners just weren't going to give up? He knew well that the defendants had spent decades dragging their feet, undoubtedly hoping that because of sheer lack of momentum it would just go away, but how could they not grasp that this would never happen, to the damage awards which were, in his view, so high, and the state could probably have settled for a lot less. 3 Now, this number was out there. Everyone knew what an upstate jury had thought these men's pain and suffering was worth. Now what number would they have to agree to? Knowing that he had a tough task in front of him, Telesksa decided just to start knocking on doors and hope that someone would start talking settlement with him. In his mind, the state might agree to a figure of $15 million. He wasn't quite sure why this number stuck in his head, other than that it was still a lot of money for the state to pay out, but it was a lot less than the 2 juries had said they should pay. In his view, even $15 million was low when one considered the horrendous injuries here, horrendous treatment for, as he tried to make clear to his counterparts in the governor's office, the Attica case was the pure definition of what the court had in mind in Estelle v. Gamble, the famous ruling that applied Eighth Amendment protections against cruel and unusual punishment to prisoners. 5. Deep down, Telesxa wondered if getting this case back in his hands was exactly what state officials had been hoping for when they appealed the damage awards. "We'll reverse it, make sure Telesxa gets it, and he'll wrap this thing up." 6. In short, getting him involved could prove to be the cheapest way out of it for the state. 7. If the Attica plaintiffs were devastated by this decision, Judge Elfvin was made livid by it. "When they ripped the case away from me," the judge recalled, "I angrily took down the photo of Attica I had always had on my wall and threw it away." 8. True, Elfvin had been the judge on this case since January of 1975 and, for that reason, he had come to feel proprietary about it. He had never liked the idea of settling the case, and had always felt that he should oversee its legal journey. Indeed, he had, in his own words, very much enjoyed the Attica trials and all of the back-and-forths he had engaged in with the plaintiffs' team in particular. 9. Although he thought that Joe Heath was a jerk and that Deutsch was a very heated individual, he had actually liked Liz Fink and got a kick out of what he considered sparring with her. 10. That it was just so much sport to him was clear. As Elfvin noted, it disappointed him whenever he would erect some sort of obstacle to trying the case if Fink then didn't push back at him in the way he had hoped to get things moving. 11. Although the decision of the Second Circuit made him very angry because they had called him out and he thought that their reasoning was stupid, Elfvin hoped still to be part of the next phase of resolving the case, whatever that should be. 12. At least theoretically the cases could still be retried and he could still oversee them. But that didn't happen. As he recalled, "Nobody talked to me, I heard nothing, I got angry, and shipped everything off. I was done with it." 13. And, from then on, Attica left a sour taste in Elfvin's mouth. 14. Meanwhile, Judge Telesxa also felt that he was getting stonewalled in his case by Governor George Pataki's office. Indeed, the first offer he received from the higher UPS was a mere $50,000.15, but he pushed and pushed. Eventually, to his delight, he managed to get the state to agree to settle with the plaintiffs in the Attica class action suit for $12 million. He was elated. No, it wasn't the $15 million he was shooting for. But it was a great deal more than the $50,000 that the state had tried to get away with. He was not, for that reason, at all apologetic when he presented it to Fink and when reporters started calling him following the formal announcement of the settlement on January 4, 2000. The question now loomed: how would this money be distributed? Telesxa also had the power to determine this and, in a most unusual move, he decided that he would invite the many plaintiffs to come into his courtroom and, in their own words, tell him what exactly had happened to them. Not only would he be able to determine the damage awards for each of them, but, as importantly, he would be helping them get all that they had endured on the record. 16. If the state of the New York wasn't going to offer an apology, he remembered, I at least wanted them to know what trauma they paid their money for. 17. He wouldn't cross-examine these men, or permit others to badger them. He would just let them talk and, ultimately, Telesxa recalled, it was the most fulfilling thing I ever did. 18. And so, for the next few months in 2000, scores of former Attica prisoners took the stand in Judge Telesxa's chambers and, one by one, told the harrowing stories of what they each had experienced in the Attica Correctional Facility in September of 1971 and for nearly 30 years thereafter. Of all the men who spoke before Telesxa, Frank Big Black Smith struck the judge most profoundly. As he recalled it, Frank made a very powerful witness when he testified before me. The truth of it all just resonated with him. 19. But the more stories he heard, the more deeply Telesxa understood how much all of the men had truly suffered. They all remembered the same things. 20. Telesxa found himself haunted by the scope of the abuses that took place at Attica and what he heard from one former Attica prisoner in particular. This man had, prior to the retaking, been an exceptionally good basketball player, one good enough that it seemed he had the realistic aspiration of becoming a pro basketball player upon his release. Knowing this, troopers had dragged him from his cell after rehousing him, and with the butts of their guns they crushed the tops of his feet. 21 His mangled feet healed badly, never being properly treated, and now he hobbled like a duck. It sickened Telisksa that he would never be able to give him the money he deserved, but when he tried, apologetically, to explain, this man replied to the judge that it was all right. All he had wanted really to do was to tell my story. I wanted to help my brothers. 22. Once the stories were recorded, Telisksa decided the distribution of funds. He allocated $8 million for the former prisoners and $4 million for the Attica attorneys who had, he acknowledged, funded this case wholly out of their own pockets, particularly out of Liz Fink's pockets for decades. The specific details of the historic settlement with the state were announced on August 31, 2000. Ultimately Telisksa awarded 502 claimants settlement monies, and he divided this group into 5 clear-cut categories. 23 The first category awarded $6,500 to each of the 260 men who were beaten, ran the gauntlet, received physical injuries, suffered emotional distress, nightmares, etc., or experienced any combination of these occurrences. 24 The second category included 112 men who would receive $10,000 each for having received beatings which resulted in broken bones, including broken fingers, broken ribs, loss of teeth, and continue to suffer from emotional distress. 25 Category 3 The 95 men who had received gunshot wounds and or were singled out for special treatment, such as being subjected to more severe, repeated beatings which resulted in a permanent disability and continuing emotional distress, would get $31,000 each. In the fourth category, the 15 men who had received very severe, multiple beatings, were subjected to acts of torture, or were severely wounded by gunfire, and whose injuries were life-threatening and resulted in serious permanent disability, either physical or emotional, would be given payments of $125,000.26. And finally, in Category 5 were the 20 men named in the class who had died as a result of gunshot wounds received during the retaking. Each of their heirs would each receive $25,000, except those of one who would get $27,000.27. More important than how the state's $12 million would be distributed was Telisksa's narrative regarding how this settlement had come to be, and upon what traumas it was based. In the introduction to his lengthy settlement document, Judge Telisksa told the story of the Attica Rebellion and the long legal battles for justice and accountability that followed the deadly retaking. 28 is important, though, he explained the process by which he had come to know the horrific stories of the retaking. As he noted, approximately 200 plaintiffs chose to testify in support of their claims during the period of May through August, 2000. Approximately 160 appeared in person and gave their testimony at the federal courthouse in Rochester, New York. 29 These men had come, most at their own expense, from across the country, from New York, and from New Jersey, South Carolina, Ohio, Pennsylvania, Florida, and Minnesota. And Telisksa had not only believed what these men told him, but felt that some of the men may actually have understated the extent of their injuries and how those injuries affected their lives. 30. Ultimately, the most valuable part of Telisksa's order for monetary awards was his final summaries, the appendix to the order, within which he brought to life the horrors that the men at Attica had endured. As the New York Times explained it, the 200-page settlement served as a harrowing encyclopedia of the traumas suffered during the retaking of the prison, the horrific event just shy of 3 decades earlier that had left scores dead or wounded, and countless more psychologically scarred. 31. Within Category 1 claims, for example, Telisksa not only brought David Brosig's heartbreaking story into the public eye, but he had also done so for scores of other victims. On May 30, 2000, one man explained in excruciating and quiet detail how, on September 13, 1971, he had been beaten on his head, back, and legs while in D-yard, was beaten while walking down the A-yard steps, was beaten for not crawling fast enough while in A-yard, and was beaten on the head, back, and legs while running the gauntlet. He sustained cuts on his legs from crawling through the glass. 32. Not only had this man not received medical attention, but he testified that he was afraid to request medical treatment because he saw a prison doctor hitting inmates with a club. 33 and, still in 2000, he suffered terribly from severe post-traumatic stress disorder, nightmares, flashbacks, and an inability to keep a job. 34. Telisksa not only transcribed the testimony of each man who had come into his courtroom, but he made sure it would be readily available to the public. From that day forward, anyone could learn of men such as one who had been identified as a leader and marked with an X on his back by correction officers. 35. As this man explained what happened then to the judge, he was forced to strip and was placed against a wall with other leaders and was told, "Don't worry nigger, it'll be quick and fast," whereupon he was beaten so badly that his back was permanently injured. 36. They could also learn about the Attica prisoner who suffered first and second-degree chemical burns, as well as lasting emotional trauma from troopers gassing him directly in his face. 37. Another man, one who had only been in Attica one day before the rebellion, was cut by glass, kicked down a flight of stairs, and beaten so badly that his right shoulder was dislocated and some of the muscles in his right shoulder were torn, along with the ligaments in his upper right arm were ripped when he was forcibly lifted by his arms. 38. The very worst tales told, however, came from the men included in categories 3 to 5. There was the man who had both of his legs riddled with buckshot and then was beaten on his head, arms, back, and shoulders by correction officers in the A gauntlet. 39. Another was still haunted not only from the severe beatings he endured but also from witnessing his best friend being shot and killed. 3 decades later, he had told Telisksa, "I can still see his face every morning, I can't function, I've lost my family, my friends." 40. Still another who was permanently handicapped from the abuse he received had headaches and flashbacks whenever he saw helicopters or policemen. Indeed, virtually every claimant that Judge Telisksa heard from continued to suffer from flashbacks, nightmares, avoidance, and severe post-traumatic stress disorder. 41. And how could it have been otherwise? All of the men had been tortured, and the men deemed leaders were not only abused on the way through a yard but then tortured in the box. One man being beaten the whole way to HBZ was then forced to climb a stairway lined with guards holding rifles, plank boards, and nightsticks and was struck in the chest, back, legs, arms, feet and head. Once he made it to the top of the stairs, he was kicked so hard in the stomach that he fell down the stairs and was again forced to run the gauntlet up the stairs. He was then placed in a cell, with no mattress or water, and when he attempted to urinate, he discharged pure blood. 42. That particular man, Telisksa noted, had suffered permanent damage to his kidneys, was hospitalized for 56 days, and underwent 4 surgical procedures to correct his bladder function. 43. The death claims in Category 5 were equally poignant, since in these cases it was surviving family members who had come to tell their stories. Josh Melville, the son of the prisoner Samuel Melville, came into Telisksa's court on August 7, 2000, to speak eloquently on behalf of his father. 44. Josh Melville gave Telisksa a series of exhibits consisting of pictures, a forensic ballistic report, and photos of his deceased father in support of his position that his father was intentionally killed by a New York State trooper, and he firmly stated that his father had stood up for injustice, protected the hostages, and was targeted for assassination. 45. Nearly 30 years after troopers had stormed into Attica with guns blazing, Attica's prisoner victims were able to tell just how brutally and inhumanely they'd been treated by the state of New York and, as importantly, their stories were believed. They had not only been able to recount the severity and depth of the torture they endured, but they had managed to get some measure of restitution for it. The sums they received were, relative to their injuries and trauma, pitifully low. But the experiences these men shared with Telisksa indicated that there was no amount of money that could truly compensate for this level of emotional and physical trauma. As prisoner Howard Partridge mused quietly about his torture at Attica at the hands of a trooper, "I remember those blue eyes. I had never seen so much hatred in anyone's eyes." 46. And, even though they had settled with the state still would not admit to wrongdoing at Attica. And so what the men had gotten wasn't justice. It wasn't even close to justice. But it was the closest thing to justice that these men would ever get. 47. Part X. A Final Fight. Deanne Quinn Miller. By the year 2000, Dee Quinn, the daughter of slain Attica CO William Quinn, had become Dee Quinn Miller, the mother of 2 young girls and a resident of Batavia, New York. Dee Quinn Miller didn't talk about Attica often, but decades after her father's death, this event still very much shaped who she was. Back in 1971, 5-year-old Deanne Quinn had been taught that prison was a place for bad guys. Her dad had become a prison guard at nearby Attica when she was 3.5 years old. He had taken this position because it paid better than his job as a social worker. Since she had been told that dangerous men were in Attica, Dee wondered if her father was scared when he went to work. She could see how nervous her mother got anytime the prison's siren blew and how relieved she was when he finally pulled up to the house at the end of his shift. After September 9, 1971, Dee's father never came home again and her life was forever changed. When news broke in January 2000 that Attica's prisoners had just been awarded a multi-million-dollar settlement with the state, Dee Quinn Miller was outraged. She knew that many of those prisoners had been severely beaten during and after the retaking of the prison, but, as she saw it, they deserved what they got for having started a riot. They had created the chaos that killed her father. She burned inside wondering why these prisoners were getting restitution for what they had endured at Attica, and yet not one of the former hostages or the families of the slain hostages had received even so much as an apology from the state. Dee Quinn Miller was determined to remedy this. 53. Family Fury. On January 4, 2000, when Attica's former prisoners finally were awarded some restitution, they were elated. Many others across the country, though, could not fathom what had convinced the state of New York to agree to pay them any money. 1 Perhaps no one was more stunned to hear of this settlement than Attica's former hostages, who also had somehow survived the assault on the prison, and the family members of the hostages who had been killed in the retaking. The fact that they still had received nothing from the state, no money, no apology, nothing, and had been largely ignored for the last 30 years was almost too much to take. Although he was thrilled that the prisoners finally had been heard after 29 years of deceit, cover-up, and injustice, former Attica observer and still prominent New York Times columnist Tom Wicker summed up the surviving hostage and hostage families' dismay when they heard of the prisoners' settlement. As he put it in a piece he wrote, "But what about the widows and families of the inmates hostages who were slain that day by indiscriminate state police gunfire? So far, the state of New York has done nothing remotely adequate to compensate these forgotten victims of the bloodiest day in America since the Indian Wars." 2. For decades Attica's surviving guards and widows had all suffered in silence, barely speaking of Attica and hoping that they could get past their ordeals. But the settlement news was like opening a long festering wound. It was of little surprise that many correction and state police officials are upset by the $8 million settlement, saying it is wrong for former prisoners to receive financial benefit because of a riot that they started. 3 But the former hostages also shared this view. Although many of them had felt a kinship with the prisoner survivors, at least right after the retaking, that feeling had long since dissipated. "I don't think they should get anything," retired correction officer Gary Walker, who was one of the 31 hostages, told the Buffalo News. "It isn't fair. What happened to them is a lot less than what happened to us. It's a slap in the face to you and to me." For Donald Werner, whose brother and uncle were both killed by police gunfire at Attica during the retaking, felt just as Walker did. When he heard of the prisoners' award he was shocked and angrier than he had been for years. "I'm a very, very bitter man," he admitted to reporters. 5 It will never go away. I don't think I've got a good night's sleep since '71. 6. 2 girls hold a vigil at the memorial to the Attica staff, on the anniversary of the retaking. Collection of the author, undated photo. Many former hostages and surviving family members of hostages first learned of the prisoner settlement on a radio station, WBTA, broadcasting out of Batavia, just 12 miles from Attica where so many prison employees now lived. WBTA radio personality John Carberry announced the news as soon as it broke. On that particular Saturday morning's show, he had been planning to spend most of his 90-minute segment covering Martin Luther King Jr. since the King holiday was around the corner. But no sooner had he read the settlement details than his producer, Deb Horton, got a call from a man she strongly suspected to be an Attica hostage survivor. He was upset. He wanted her to know how badly he and his fellow men were screwed over by the state of New York. 7. When the caller hung up, Deb Horton thought about it, and then called him back to ask if he would consider discussing this issue on the air. 8 Then Horton made a decision that would change history. She would dedicate an entire live radio show to news of the prisoner settlement. She would broadcast it from the Signature Cafe in downtown Attica in the hope that many of the prison employee survivors and their families would attend to share their reactions and tell their stories. 9. The radio show happened 5 days after the prisoners' settlement was announced. Deb was nervous about having enough people there to carry the show. To her surprise, however, almost 200 crowded into the cafe and everyone wanted to talk. 10 The 1-hour broadcast that she had planned taped for more than 2 hours. 11 Her husband, local public defender Gary Horton, who had come along that day, was troubled by the stories he heard. Despite what he and the rest of America had assumed, Attica's hostage widows had been left to survive as best they could, alone, and all of them had suffered mightily as a result. Post-traumatic stress clearly plagued many of the hostages who had survived, and their family members had suffered right along with them all of these decades. As remarkable as it might seem, this was the first time any of these people had shared their stories, even with one another. 12 John Carberry was shocked by what was unfolding around him. As he told one fellow writer, "It's one of those rare opportunities as a journalist where you suddenly find something that needs light, and it takes off on its own." 13. That day at the Signature Cafe was life-altering for many there. When Christine Quinn Schrader, the middle daughter of slain CO William Quinn, had heard that the prisoners had been awarded money, she was so outraged and betrayed by our judicial system, that she had decided to come to the cafe just to vent. Once there, though, Christine was overwhelmed with emotion of a different sort. 14 For the first time in my life I got to meet some of these other families who had also suffered through this horrific event. It was like a support group, only 30 years too late. As the mayor, hostages, troopers, and family members spoke, I could not help but cry. 15 Christine's mother, Nancy, and her sister Dee Quinn Miller attended too, albeit reluctantly. Miller was also furious that prisoners had gotten money from the state and, frankly, was so mad she wasn't sure she wanted to hear any more about it. Ultimately she decided to go to the cafe only because, once there, she might learn more so that she could file an appeal to make them the prisoners give their money to us since they took our dad's lives. 16. Dee Miller was surprised by how many people had shown up, and her mother was seeing people that she hadn't laid eyes on in nearly 30 years. It was hard for her even to recognize the survivor families. Nancy Quinn thought she recognized the family of slain CO Edward Cunningham and some of the others, but it was all so overwhelming. For decades now no Attica survivor in her town had discussed anything related to the pain they had endured, and now here they all were in the same room. Suddenly Miller heard people whispering that former Attica hostage Mike Smith, the one who had been shot so badly across the abdomen during the retaking, was also there. She had no idea who Mike Smith was, but there was clearly a nasty vibe about him circulating in the cafe. Miller eventually gleaned that Mike Smith wasn't that popular with the other hostage survivors because they felt that he had been too friendly with the prisoners back when he worked at the prison and, recently, had also made public statements in support of the fact that they had finally gotten restitution from the state. He was also disliked because rumor had it that at some point in the preceding years he too had tried to sue the state for the gunshot wounds he had suffered. Turning against the state, biting the hand that fed so many residents of this area, was considered bad form. As Miller recalled, summing up the ugly gossip about him that filled the air around her that morning, he wasn't a state boy. They hated him for breaking rank. He was outspoken that the state had shot him. He was stepping outside the bounds of the good old boys club that was Attica. 17. Most of the folks assembled at the Signature Cafe knew precious little about what had really happened in D-Yard after the riot, and they had uncritically accepted the state's version of the retaking and rehousing. D. Miller was one of these. As she later mused, "I knew nothing about Attica 18, and so, when Mike Smith finally got up to speak, to much eye-rolling and sighing in the group, she found her head spinning. She realized that nothing was as she had thought it to be. 19. Mike Smith told the group that Attica had needed reforms back in 1971, and that the state had cared so little about the prisoners and about its own employees that it had gone in with guns blazing. The state had known that people would die, Smith said, and it had thereafter abandoned the surviving employees as well as the widows and kids of those who had been killed by state police gunfire." As D. Quinn Miller listened to Mike Smith recount his nightmare on the day of the retaking, and of all he had endured since due to his gunshot wounds, tears began rolling down her face. She suddenly saw that the prisoners and Koss had both been sacrificed by the state, and thus that they weren't each other's enemies. Hostage survivor Mike Smith, courtesy of the Democrat and Chronicle. As Mike Smith spoke about not begrudging the prisoners for standing up to the state and, instead, standing with them so that all could get the restitution that they deserved, D. Quinn Miller found her pre-existing views about the Attica Uprising and its aftermath crumbling. She also began to see why Mike was targeted in the Yard 20, as she put it. Michael was a real humanitarian, and that is why he was resented. 21. As the show wrapped up, Miller knew she had to meet Mike Smith. She walked over to him, introduced herself, and connected with him right away. As she remembered it, we hugged each other and we cried. 22. D. Quinn Miller drove home after the broadcast, overwhelmed by all she had learned. She now no longer resented the prisoners and no longer felt that they should not have received money. 23. But now, her anger burned even hotter than it had before on behalf of the other survivors. Dee's mother, Nancy, had had to take care of her, her little sister, and the new baby who was born soon after she buried her husband, when she had barely 2 nickels to rub together. It may have been just that the prisoners had been compensated, but to Dee Miller it was unjust that her mother still hadn't received even a token payment from the state. As she put it, "I still remain without a father, as do the families of the inmates who were killed." 24. Although not every hostage or hostage family survivor felt as magnanimously as D. Quinn Miller and Mike Smith did about the prisoners' right to a settlement, all agreed that the state had treated them abysmally and that it was time for them to come together as a group. A son of slain correction officer Edward Cunningham fumed when he thought about the fact that his mother had been abandoned by state officials despite promises that she would be cared for. Russell Oswald, then Commissioner of Correctional Services, came right to our house, the younger Cunningham told a reporter, and I remember him putting his arm around my mother and saying, "Helen, we're going to take care of you." But they never did. 25. Several months after the show on WBTA, the surviving hostages, widows of hostages, and hostage families decided to come together in an official new organization called the Forgotten Victims of Attica, FVOA, one that local public defender Gary Horton, radio producer Deb Horton's husband, would provide legal services for pro bono. 26. The very first meeting, called by former Attica hostage G.B. Smith, took place at the American Legion Hall. Notably, Mike Smith wasn't invited. 27. When Gary Horton showed up at this meeting, he really wasn't sure about the best way to proceed. Horton had grown up in Batavia and, although his father had been a state trooper, the family had little connection with the regional prison system. Gary Horton had graduated from Hobart College the year that Attica erupted. When he chose a career as a public defender, he did learn a little about Attica, but that was only because he was trying to prevent his clients from being sent there. 28. Horton believed to his core that the hostage survivors deserved their day of justice with the state, but it had been hard for him to listen to so much vitriol directed at the prisoners that morning. 29. And yet, Horton was heartened to see that, over time, many of the hostage survivors in Batavia and Attica were beginning to grapple with the hostility they felt toward the prisoners. Some like Don Almeter, G.B. Smith, and Dean Wright would never warm to the idea that the prisoners had received money. As Wright put it to a reporter, anyone who was a hostage for 1 day or 1 hour deserves at least what Frank Smith Big Black got. 30 others, however, like Karl Vallon's widow, Anne, had worked through their anger. As Anne explained it, first you get real angry at the inmates. Then you find out they acted more humane than the officials. We've never been able to heal. 31 As the FVOA grew, to between 50 and 70 members, 20 to 40 of whom were meeting every Monday night, the group learned to make decisions by consensus. D. Quinn Miller explained to one reporter, "These are all survivors, we each have our own beliefs." Some people said, the state troopers were right. They went in. They did their job. They didn't want to kill anybody. And you have people who say, the troopers sucked. They wanted to kill everybody. They didn't give a rat's ass for anybody's life. But, you know, we are respectful of everybody's opinion. 32 At the end of the day, Quinn Miller said, what the group wanted most was to be acknowledged for who we are, and for the truth to be told. 33 The FVOA's most challenging task was figuring out how the employee survivors were going to get their own restitution from the state. Some members clung to the idea that they must first find a way to stop the prisoners from getting their money. The vast majority of members, however, wanted to devote all energies toward getting their own justice. 34 A key step in this direction was to educate the public about what had happened to the hostage survivors after the retaking, or, as the daughter of slain hostage Elmer Hardy put it, to let the public know that everything that should have been done for them wasn't. 35 To that end, the FVOA sponsored a forum on the riot's consequences at the nearby Genesee Community College on September 26, 2000. Mounting a successful public relations campaign on their own behalf was the easy part. Figuring out how they could pressure the state to give them damages as well was much more difficult. Debating this question tended to generate serious tensions in the group. The FVOA began discussing this question as Judge Michael Telesksa was in his Rochester courtroom hearing prisoners' searing stories of torture in order to decide how he would divvy up their award. Michael Smith, as well as the entire family of slain hostage Karl Vallon, tried to suggest to the broader FVOA group that Telesksa's prisoner hearings presented a great opportunity for the organization. The FVOA could take a public stand in support of the prisoners and, in the process, levy enormous PR pressure on the state to offer them a settlement as well. Mike Smith had actually testified on behalf of the prisoners in Telesksa's chambers, and Jamie and Mary Ann Vallon, the children of Karl Vallon, regularly showed up in chambers to show their solidarity with the prisoners. Ellen Yaknin, who had become a senior attorney at the Greater Upstate Law Project in Rochester, was at an event held for the prisoners where she happened to see this trio from the FVOA, and she tried to talk them into joining forces. 36 Because the FVOA had already decided to make all of its decisions by consensus, however, the organization was clearly not going to work closely with prisoners. Although Mike Smith and the Vallons would continue to support Attica's former prisoners, and though D. Quinn Miller would, in time, come to have a profound relationship with Frank Big Black Smith and even to meet personally with Richard Clark and the other men who had carried her father out of Times Square to safety, the FVOA decided to go it alone. As Gary Horton put it, they decided to raise money, rent a bus, and walk the halls of Albany to call attention to us. We held small press conferences. We walked office to office. 37 To make the most of its trips to the state capitol, Horton asked Jonathan E. Grades, the head of the New York State Defenders Association, to assist the FVOA. He knew all the players in Albany. 38 54 Manipulated and outmaneuvered. Attica's surviving hostages and hostage families were left, by 2000, with few options for being heard was itself a product of how badly they had been treated by state officials way back in 1971. Right after the retaking, they too had hoped to get justice via the legal system and, like the prisoners, they too had filed many individual claims against the state of New York. State officials, however, worked hard behind the scenes and via the state insurance fund to make sure that their suits would go nowhere. As a state employee, any survivor of the Attica retaking, or any widow or dependent of someone killed in the assault, was likely entitled to some sort of state or federal compensation benefit. According to representatives from the state back in 1971, in the case of an employee who dies in service not as the result of an on-the-job accident, the state provides through the employee's retirement system a benefit of 3 times annual salary. There was also the Social Security death benefit for the families of the slain hostages as well as various disability benefits, including workmen's compensation, for those who managed to survive the assault. 2 Attica's victims were even able to seek benefits such as overtime pay for all the hours they were in captivity. 3 But while meager Social Security payments did come through for some of them, most had no clear sense of what was happening vis-a-vis the monies they might be owed by their employer, the state of New York. Right after the retaking, as the dead hostages were being buried and the wounded were healing, all any hostage survivor or family member really knew was that Oswald had promised to take care of them. The commissioner had actually visited some of the wounded cos to assure them that they could take up to 6 months off and would still get their salary. He said much the same to the CO widows. The state would also make sure they were taken care of. 4 And, sure enough, within a very short period of time state-issued checks began arriving at the houses of the surviving hostages and hostage widows alike. Eugene Smith was one of the surviving hostages who was thrilled to get his first check of $95 since he was still an emotional wreck and was hardly ready to go back into the prison to work. 5 D. Quinn Miller's mom was equally thankful when she began getting checks for $112 every 2 weeks. 6 Another Attica widow with a larger family than the Quinns began receiving $230 a month, and she too breathed a sigh of relief. 7 The checks that all of these survivors had been given, ostensibly so that they might buy groceries or pay bills, looked exactly like the checks they had always cashed each month from the prison. However, they were not. 8 Although Oswald had implied that the former hostages were on a period of authorized leave, and the widows had been told that this money was being given to them simply to ease their burden in a terrible time, all of these survivors were in fact being paid from workmen's compensation funds. 9 This would have huge implications for their future. Receiving payments from the Workers' Compensation Board was not, in itself, odd. When terrible on-the-job events happened, investigators from the Bureau were supposed to review the occurrences in question as quickly as possible so that they might get the facts necessary to fill out C-62 forms. 10 Then hearings would be held to determine compensation, at which injured workers or widows would be present. But none of the standard procedures were followed with these Attica survivors. After some of the survivors had personal assurances from Oswald that they would be taken care of, Representatives Robert Knight and Leonard Mann of the State Insurance Fund tried to do everything possible to expedite payment to them. 11 And so, without formally filing for workmen's compensation, the checks simply showed up soon after the retaking. Unbeknownst to the recipients, the instant that an Attica survivor or widow signed and cashed one of these checks, under New York state law they had elected a remedy, which meant that they could no longer sue the state for damages. This is exactly what Attica's survivors had hoped to do. Although they were grateful for the small checks they had been receiving, hostage survivors and surviving family members were barely making it and thus were also interested in filing damage suits against the state in the Court of Claims. Ultimately there were 28 such individual claims and each sought damages on grounds that the state used excessive force in the retaking, which had led to death and injury, and that the state had failed to protect its own employees on the job. 12 None of these plaintiffs were much aware of what the others were doing. Each was isolated, just trying to get some help for their particular family. Determined to help these individuals, 2 attorneys out of Buffalo, William Cunningham and Eugene Tenney, began a decade-long process of trying to get these cases to trial. Cunningham's cases, collectively, sought more than $15 million, and Gene Tenney worked as well to get substantial damages for 22 more hostage plaintiffs in his cases. 13 Clearly, however, state officials had known that they would likely be sued and thus had scrambled to protect themselves by getting checks into the hands of the survivors and widows as soon as possible. State Insurance Fund employee Morris Jacobs went on the record many years later that the state's investigators were well aware that Attica employees could sue and there was speculation about how many would take compensation versus how many would sue. 14 If anyone doubted that the state had tried to stack the odds in its favor, Jacobs noted, one only had to review the procedure that had been followed in all other cases. It seemed that someone must have filled out C-62 forms on behalf of the survivors and widows, and then submitted and approved them before any hearing, which was certainly not the protocol. 15 What is more, whoever filed C-62 forms on behalf of the widows and authorized payments prior to a hearing would have had no official authority to do so. 16 Even though scores of Attica survivors and widows living in upstate New York had dutifully filed the paperwork necessary to sue the state, it eventually became clear that they were going to have to fight like hell to even have the right to keep their lawsuits alive. The burden fell on their attorneys to show that elective remedy didn't apply. 17 On July 6, 1981, the New York Supreme Court Appellate Division, 3rd Department, issued a decision that devastated all of the hostage survivors and widows. In the case of Werner v. State, the court ruled that former hostages or widows who had accepted workmen's compensation checks for the period of the uprising and afterward were barred from seeking additional monetary damages from the state. 18 In practical terms, this meant that despite 13 judges having been involved in these hostage cases since 1971, suddenly all of the cases save one were dead in the water. 19 Back in the awful weeks following the retaking of Attica, Linda Jones, widow of slain hostage Herbert Jones, just happened to mention to a friend of hers that she had received a check from the state. It also happened that this friend worked for attorney William Cunningham. Since she knew that Linda Jones had little knowledge of finances, let alone dealing with state officials, the friend advised her to stop by Cunningham's office, just to see if there was anything she needed to know about this check before she cashed it. On October 21, 1971, Jones showed Cunningham the $21 check, which, she explained, officials had told her was for the 4 meals the state of New York thought it owed her dead husband for the period during which he had been held hostage by inmates at the Attica prison. 20-something about this seemed odd to Cunningham. Acting on what he later described as gut instinct, Cunningham recommended that Linda not cash the check. 21 What she might do instead, he suggested, was file a lawsuit against the state of New York. If they could show that it had used excessive force in retaking the prison, she might win a great deal of money. 22 To win, she would have to prove that her husband's death had resulted from an intentional tort perpetrated by the employer at the employer's discretion. 23 Although attorney William Cunningham felt that his client was on firm legal ground, Jones's case was dismissed on December 31, 1972, virtually at the same time that the state was handing down its scores of indictments of prisoners. 24 A judge had initially ruled at the state level that she could sue, but the state appealed and that decision was reversed. Since 1971, lawyers for the state, in both the civil and the criminal courts, had been expending a great deal of energy to make sure that neither the prisoner victims nor the hostage victims could be heard. Like the prisoners, however, Linda Jones was undeterred. Her lawyer appealed the appellate decision, and the next December her right to sue was reaffirmed in a highly unusual reversal. 25 In fact, the Court of Appeals ruling said that all of the other survivors of the Attica dead, as well as those wounded in the assault, may file suits now, and, what is more, that it expected that a good number of them will do so, and many may also seek to involve Mr. Rockefeller personally. 26 And so, William Cunningham and Jean Tenney proceeded with all of their hostage survivor and widow cases. Like the prisoners' many civil suits, all of these cases had to be kept on hold until all of the Attica criminal cases were resolved, but Cunningham and Tenney made good use of that time. For William Cunningham, the years between 1973 and 1976 were busy indeed. He was determined to take as many depositions of high-ranking state officials as possible, and one of the most important of these, he thought, would be that of Nelson Rockefeller. To Cunningham's frustration, however, now Vice President Nelson Rockefeller was not particularly forthcoming as he sat for his questions on April 22, 1977. Quite predictably, he answered the question of whether excessive force had been used with a categorical absolutely not. And yet, unwittingly, Rockefeller did help Cunningham's case. 27 Although the former governor laid all responsibility for the retaking at Commissioner Russell Oswald's door, he did acknowledge that he was the one who had insisted on using the state police for the retaking. On this issue, he said, I prescribed what should be done to make it possible for him to carry out his order. 28 Significantly, this meant that whatever the state police proceeded to do at Attica, the governor himself had authorized. What is more, Rockefeller admitted on the record that state officials, including those from his office, the state police, and the head of the Attica investigation, had in fact met in the wake of Attica to compile a coherent narrative regarding all that had happened at the prison. He also revealed that there was a physical copy of that narrative somewhere. At first, when Cunningham asked him about this, Rockefeller stated that he had made no writings, notes or any memorandum concerning the Attica Uprising from September 9 to the 13th and thereafter, and he insisted that the only account ever given to him was verbal. 29 Eventually, though, the former governor admitted that he had appointed a committee of 2 to prepare a written report. One was Harry Albright and the other was Elliot. 30 Rockefeller had both seen and reviewed this report. 31 So, as soon as Governor Hugh Carey ended the Attica investigation and all criminal trials related to the uprising, Cunningham felt pretty good about his chance of getting some restitution for his clients. Linda Jones's suit came before Judge Robert Quigley of Rochester in October of 1977, and Cunningham was eager to proceed. The trial was recessed almost as soon as it began, however, because lawyers for the New York State Police had decided to fight tooth and nail to prevent Cunningham from using the many trooper statements that had been taken in the immediate aftermath of the retaking. Whereas Cunningham argued forcefully that these statements were essential to his ability to show excessive force, the state brought out the big guns, Attorney General Robert Abrams and Assistant Attorney General John R. Stewart, to prevent their use. There was a great deal at stake here. The only reason Cunningham had gotten his hands on the many hundreds of correction officer and trooper statements in the first place, and knew that they would help his case, was because lawyers for the state had overplayed their hand with the judge in this case. 32 In short, Cunningham had gone to Judge Quigley seeking a subpoena dutes tecum, allowing him to ask the Attorney General for any Attica documents that might pertain to his case, much as Liz Fink would do almost a decade later. Predictably, the state stalled, and implied that it really had nothing relevant to share. Judge Quigley, however, was getting increasingly frustrated with the defense and, knowing this, Cunningham went to him and told him exactly where these documents were in One World Trade Center. The judge wanted to see for himself what was there before issuing a new order. And so the two of them went to the World Trade Center and spent 48 hours combing through file cabinets. They hit pay dirt. After first setting aside the hundreds of parking tickets stuck in those cabinets that state troopers were hoping the Attorney General would fix, they located the statements. Once he had these, Cunningham remembered, "I knew I had 133. Armed with these statements, Cunningham still had the challenge of figuring out how he was going to get them into the record. 34 There was really no way to enter them into evidence one at a time, so he made the bold decision to try to enter them all at once. This was a dramatic moment as lawyers for the state immediately jumped up and began their effort to block this move. 35 Cunningham had feared that this would happen, and so, the night before, he had asked his secretary to help him get these many statements to a copy shop in Rochester. Once there, they asked the shop to close down and he would write them a healthy check as soon as they were done copying the pile. He had already told the judge he would bring the statements back to court, which he then did, but he suspected that this would be the last he saw of them, so he made sure he had copies back in his Buffalo office. 36 The state's lawyers managed to halt the trial once again because a higher court now had to rule on the question of whether these statements were admissible. The statements were indeed removed from the plaintiffs, but Cunningham had ample time to study his copies carefully back in his office. This, in turn, gave him a clear trial strategy. All I had to do was subpoena the troopers who fired, he realized. Even if they had been given immunity in the criminal trials, their immunity did not hold in a civil case. 37 When the Jones trial finally resumed in November 1978, the state suffered a major blow. Cunningham was going to be able to use the debriefing statements the guards and troopers made shortly after the riot. 38 But even with statements that placed specific troopers in specific locations engaging in specific acts, these same troopers could still invoke their Fifth Amendment rights, thus not confirming anything that these statements said. As trooper after trooper refused to testify, Cunningham's patience thinned. They wouldn't answer any questions at all, not even basic ones such as whether they had worked at Attica. This was particularly frustrating to Cunningham because he knew from their own statements, just as Malcolm Bell had, exactly who was guilty of excessive use of force. And so he chose his witnesses carefully, including troopers such as Gregory Wildridge and cops like John Vergamini, and high-ranking troopers such as Lieutenant Colonel George Infante. He even tried to bring New York's longtime Attorney General Louis Lefkowitz to the stand. Every single one of these men, however, refused to answer his questions. As infuriated as Cunningham was by this refusal to cooperate, Judge Quigley was even more livid and, to everyone's surprise, the judge slapped these men with contempt of court charges. Of the 20 witnesses cited with contempt, 18 were sentenced to jail. 39 Most of the contempt charges were for refusing to answer questions, but Lefkowitz's charges were for refusing to produce certain documents and reports. 40 All jail terms ultimately were stayed pending a hearing before another judge. However, 41 Everyone would have to wait to see how the other judge would rule regarding the recalcitrant witnesses' liberal use of the Fifth Amendment. 42 By November 30, 1978, this question still hadn't been decided, but the standoff between the plaintiff and law enforcement continued. 43 In one remarkable instance, Judge Quigley had ordered a superintendent of the New York State Police to appear in court and state for the first time the names of 10-12 troopers recommended for disciplinary proceedings. 44 This man was actually supposed to bring into court the letter sent to him by Alfred Scotty, the man Governor Hugh Carey had appointed to resolve the remaining prisoner indictments in the wake of the Bell revelations and the Meyer report. However, when the NYSP superintendent arrived in court, he did not have the letter and claimed that he did not understand the instructions. 45 When pushed, he acknowledged that he wanted to keep those names in confidence. 46 Disgusted with the superintendent, Judge Quigley leaned back in the cushions of his courtroom chair, rolled his eyes, held his temper, and told him icily, "The court orders you to take yourself to the nearest telephone. You are to call your secretary and make sure she understands the document you have in mind, and whoever you wish to authorize from your office is to get in a motor vehicle and proceed, within the speed limits, to this court with the document today." 47 William Cunningham remained tenacious. Rather than relying on trooper admissions, he made sure that some surviving hostages gave their own first-hand accounts of the retaking. This was itself startling testimony for Quigley to hear, and to have on the record, since few in the nation had yet heard what these survivors had in fact endured. And, indeed, it wasn't always easy for Cunningham to get these people to come forward to relieve their trauma. Reporters like Tom Goldstein of the New York Times found the stories riveting. As he put it, some of the surviving hostages have told how they developed nervous conditions, must take medication, often drink heavily and sleep irregularly. The Attica riot brought on almost a reverse personality. Richard Fargo, a former guard, testified last week. "Now," he said, "he is jumpy, nervous, and can't stand to be in crowds." 48 Cunningham's other triumph in this trial was getting Russell Oswald, the former Commissioner of Corrections, to admit that troopers and cops had indeed used excessive force in the retaking. 49 Oswald began by noting that he couldn't understand why the cops, for example, had transcended our orders and shot their weapons during the retaking, but their use of firearms at Attica had, nevertheless, been reprehensible. 50 When Cunningham pressed, and asked pointedly whether Oswald thought that Co. John Vergamini had used excessive force when he shot John Montelian, Oswald said, "I would say yes." 51 Getting a state official to acknowledge under oath who had shot John Montelian, a hostage who had later died from that same shot, was huge. For the purposes of this lawsuit, it confirmed just how excessive and brutal the shooting during the retaking had been. Of course, it also confirmed that state officials were aware who had killed whom at Attica, the very point that Malcolm Bell had been trying to make when he went public back in 1975.52. Attorney William Cunningham also made major headway for Attica's hostage victims in general, not just Linda Jones, when, over the state's objection and after yet another hearing, he was allowed to use grand jury testimony to refresh the recollection of recalcitrant witnesses. 53 This was crucial since it meant that when Cunningham had one trooper from the NYSP on the stand who refused to talk, for example, he was able to put this witness's previous grand jury testimony into the record evidence. That confirmed he had hit 4 targets during the retaking, and there was no evidence that any of them had been resisting his authority. Armed with this testimony, Cunningham was able to state for the record, "Well then, we can further presume you killed 4 people." 54. Judge Quigley issued his decision in the case of Jones v. State on August 31, 1982. It was a scathing denunciation of the way the state of New York, as well as its troopers and COS, had handled the retaking. It had been a long trial, one that had been stalled repeatedly as Cunningham battled the defense for access to the post-retaking statements, volumes 2 and 3 of the Meyer Report, and grand jury minutes. No matter how hard they had tried to conceal evidence, though, lawyers for the state had not managed to prevent Quigley from hearing evidence in his decision. He noted, for example, that at trial, Major Monahan testified he once had most of the items described in the subpoena, but that he had burned them in the fireplace at his home, an act the judge found appalling. 55. He also made clear that he just didn't believe state witnesses, such as their repeated claim that evidence didn't exist or had been lost. As he put it, "It is incredulous to believe that all copies of the overall plan for the retaking of the Attica facility are, somehow, missing." 56. The judge was also infuriated that the highest officials of the NYSP simply would not take responsibility for the retaking, preferring instead to pass the buck regarding who was actually in charge of the retaking. Monahan had admitted to the court that he, with the assistance of Captain Malovich, had drawn up a plan for the retaking of the prison, but then he claimed to have placed Captain Henry Williams in charge of that post and ordered him to stay there, and had selected Captain McCarthy to be in charge of the rescue crew. 57. Quigley wasn't having it, though. As he wrote in his decision, despite Monahan's attempts to dodge responsibility, his planning, direction, choice of subordinate leaders and his commands to cease firing were actions that clearly indicate he was functioning in the command position. 58. Not only did it matter to Quigley that Monahan was responsible for the overly brutal retaking, he found it unconscionable that this man had clearly admitted hearing gunfire after he gave the ceasefire order, and that he knew the names of certain troopers who had shot either inmates or hostages, but that he refused to share that information with investigators at the time or the court now. 59. Quigley just couldn't get over how unnecessary the force used during the retaking of Attica had been. He took particular note, for example, of the fact that even General O'Hara of the National Guard had admitted that the gas used in D-Yard was so immobilizing, and thus so ineffective for riot control, that he personally had ordered it out of the inventory of the National Guard, and yet this was exactly what the NYSP had used and then had also used ammunition. 60. Perhaps worse, Quigley noted, O'Hara had testified that it was the general consensus of opinion by all the officials present that the hostages would be killed one way or another, and indeed that everybody had that impression. 61. Quigley was most shocked by the sheer magnitude of firepower that the state had authorized at Attica. The key here, as he saw it, was the nature of the weapons the state had allowed to be used, namely shotguns that dispersed sprays of pellets. Each of these pellets was approximately the size of a .32 caliber bullet and lethal, wrote Quigley, and the total number of pellets fired from shotguns accounted for would be between 2,349 and 3,132 lethal pellets raining down into D-Yard, which, incredibly, was in addition to 8 rounds from a .357 caliber, 27 rounds from a .38 caliber, and 68 rounds from a .270 caliber. 62. Of course, he noted, these counts did not even include the bullets showering into this group of inmates and hostages from correction officers and other members of law enforcement not fully accounted for. 63. It is the court's conclusion, Quigley wrote, that the force used was indeed excessive, and that such conclusion is amply demonstrated in the trial record. 64. Excessive firepower was used against people already immobilized by gas, according to high-ranking officials from the National Guard, such as John C. Baker and General Almarin C. O'Hara. 65. Quigley noted, the evidence excessive force presented is so overpowering in favor of claimant that the court does not need to resort to the rule that it may view the evidence in the light most favorable to the plaintiff. Claimant has met her burden of proof and has established a prima facie case. 66. The award? After a careful review of all the evidence, the court finds the claimant has been damaged in the sum of $550,000, which includes funeral expenses, with interest thereon from September 13, 1971 to the date of judgment herein. 67. Linda Jones would ultimately win $1,063,000 from the state. 68. Unsurprisingly, the state appealed this ruling, but the appellate division upheld Judge Quigley on November 4, 1983. The state appealed once again, but in June of 1984 the higher court declined to hear that appeal. 69. A sniper on the prison rooftop wears a makeshift gas mask, September 14, 1971. Courtesy of the New York Daily News/Getty Images. It was perhaps in the context of this huge settlement that Judge John Elfvin was trying to stall the prisoners who were eager to get their civil suit against the state to trial until 1991. It had to have been clear to any jurist following the Jones case that there was abundant evidence that members of law enforcement had used excessive force in D-Yard during their assault, and the way the assault force had treated prisoners that day was far worse. Tragically, though, the prisoners themselves knew little of the testimony heard in this case and thus found themselves having to prove many of the same facts all over again in their decades-long court battle. Also unfortunate was the fact that the Jones victory had done nothing to bring justice to the rest of the hostages who continued to suffer their post-Attica trauma individually and alone. That is, until the forgotten victims of Attica, in the year 2000, came together to fight as a group to politically shame the state of New York into doing the right thing by all of its victims. 55. Biting the hand. After the decision came down in Werner v. State that the hostage survivors and widows who had elected a remedy by cashing their checks from the state couldn't sue, they were left with few options but to pressure politicians in Albany. If they could just get some legislator to hear of the injustice they had suffered, and take up their cause, they might finally get some restitution. And so, the forgotten victims of Attica kept heading to the state capitol. Gary Horton explained their goal as forcing a settlement by making it too uncomfortable politically for them to ignore us when they had some reason to think that the strategy would be successful. Thanks to drumming up support from various state assemblymen, the FVOA received word on June 15, 2000, that the state had given final legislative approval today to a resolution calling for an annual day of mourning for the 11 prison employees, the hostages slain during the retaking, and William Quinn, but not the 32 inmates, the 29 prisoners killed during the retaking, and Hess, Schwartz, and Privitera killed in September 1971. More importantly, several other state legislators had responded to the prisoner settlement, and to the hostage families' dismay at said settlement, expressed in a meeting on April 14, 2000, by proposing some monetary compensation for the widows. By the close of 2000, State Representatives Dan Burling, Charles Nesbitt, and Dale Folker put together legislation that would give each of the 11 widows $50,000, a much lower figure than anyone hoped. Burling originally had proposed $90,000 each, but that figure had been whittled down in budget negotiating sessions. The FVOA rejected the state's first proposed settlement outright. As one newspaper put it, those payments have been scoffed at by some survivors as too little too late. Some relatives said they won't cash the checks. 3. Equally significant, the FVOA explained, the widows were by no means the only survivors of Attica. Not only were there others who needed restitution, such as the children of the slain hostages and those hostages who had survived the retaking but had been physically and emotionally damaged by it, but the FVOA had always wanted more than just money. They had rejected the state's offer as much because of the state's refusal to admit any wrongdoing. 4. The FVOA worked to build a consensus on a clear list of what it wished the state to do, and crafted a 5-point plan for justice. 5. The plan demanded the following. 1. An apology from the New York state government, officially acknowledging culpability for the deaths of hostages, physical injuries to Correction Department employees, and emotional trauma suffered by hostages and their families, as well as the state's duplicity regarding compensation. 2. Opening state records on the riot and its aftermath, to provide closure to the families, dispel misinformation given to the public, correct the denial of due process. So the state can learn from its mistakes and to expose the cover-up that the state perpetrated. 3. Counseling for survivors and families. 4. A guarantee that the group can conduct a memorial service outside the prison each September 13. 5. Reparations to group members. 6. Regarding the last demand, a newspaper noted that while group spokeswoman Deanne Quinn Miller said no exact figure has been set, some members use the award to Mrs. Jones as a benchmark for widows, with a lesser amount for survivors. 7. The FVOA took their demands to Albany in the summer of 2000 intending to meet with now Governor George Pataki. Instead they were met by the Governor's Council, Jim McGuire, the Commissioner of Corrections, Glenn Gourd, and a team of both senior and junior members of the Governor's Council. 8. Undaunted, D. Quinn Miller, Mike Smith, and Jamie Vallone, the son of slain hostage Carl Vallone, along with FVOA lawyers Gary Horton and Jonathan Grades, launched right into their pitch. First, the FVOA hoped that the governor would agree to come to an Attica anniversary event their group was holding the next month at the prison, and, second, they hoped that he would consider their list of demands in the meantime. The governor's representatives assured the FVOA members that someone would get back to them within 30 days. D. Quinn Miller recalled they all left the meeting feeling not only that these people would help them, but that Governor Pataki would actually come to their event. 9. Yet the 30-day deadline came and went and the FVOA heard nothing from Pataki's office. 10. And so they began writing follow-up letters, many of them. When they still heard nothing, they decided to switch strategies. After lengthy discussions with attorney Jonathan Grades, the FOVA decided to draft a document arguing for the need to hold truth and reconciliation hearings similar to what had been held in South Africa in the wake of apartheid regarding what they had endured at Attica in 1971 and in the decades since. After submitting their document and again hearing nothing for almost 6 months, they were surprised to finally get word that the governor would appoint a task force to look into the possibility of holding such hearings. This Attica task force, comprised of 3 members and a chair, was officially constituted on March 13, 2001. According to media sources, Pataki asked the task force to listen to the group's concerns and make recommendations about resolving those issues. 11. Notably, however, the governor had given the task force no timetable for doing so. 12. That this task force was formed at all came as a surprise to FVOA lawyer Gary Horton. When FVOA attorney Grades first proposed the idea of trying to get a meeting with the Governor's Council, and then to go all out for a South Africa-inspired Truth and Reconciliation Committee, it had been hard to imagine anyone in Albany actually agreeing to either of those things. 13. However, Grades had been correct to assume that Governor Pataki had no desire to get in the middle of another Attica-related public relations disaster. Too many governors before him had had to deal with the fallout from Attica and it had never been pretty. The FVOA had mixed feelings about the Attica task force. It was good that the governor's office was doing something to respond. But once the members saw who had been placed on this panel, they weren't at all confident that the state's effort was serious. As D. Miller put it, "We weren't sure if those on it were there for a stall tactic." 14. How could it bode well if the chair of the task force was none other than Glenn Gourd, the current head of the very Department of Correctional Services, DOCS, that had mistreated Attica's survivors and widows back in 1971? D. Miller personally was incensed that State Senator Dale Folker was also appointed to this task force, since, in her view, he had whined to the media that the Attica widows were ungrateful when they had rejected his proposal to get them each $50,000. Equally worrisome was the fact that Folker, as a Republican politician from Wyoming County, had actually been present at the Attica disturbance. It was anyone's guess whose side he was on. 15. The appointment of the second member, former Attica observer Arthur Eve, was not much more reassuring to some FVOA members since he had always been such an outspoken advocate for the Attica prisoners. The final member was cause for some hope. Assemblyman Jeff Ryan Aubrey, a Democrat from Queens, might be more independent as the chairman of the Assembly's Committee on Corrections. 16. Not only was the Attica Task Force announced to great fanfare, but this body almost immediately met with the FVOA. D. Quinn Miller, however, felt that this first meeting boded ill for the future of the surviving hostages and the hostage widows. Commissioner Gurd seemed openly hostile to them in the meeting, abruptly leaving the room on 2 or 3 occasions. In turn, D. Miller and the other FVOA leaders felt their own hostility grow because they couldn't agree on anything. The FVOA wanted open hearings. The state did not. We were specific and they were vague. 17. Whether the members had been more persuasive than they thought, or the commissioner was under more pressure than they knew, the group unexpectedly received notice just a few weeks later that there would be public hearings on Attica beginning on May 9, 2002, in Rochester and continuing in Albany. The FVOA had a great deal of work to do before the hearings began. If this was going to be an open hearing at which everyone would be able to get their stories onto the record, it was crucial that people from the group be willing to participate. D. Quinn Miller and Mike Smith, along with Gary Horton, worked to persuade virtually all of the Attica hostage families that they needed to speak up. This was their long-awaited chance, maybe their only chance, to tell the world what had really happened to the Attica employees during the retaking and after. The FVOA knew, however, if the state were to settle, they would also need non-interested witnesses who could back up their stories of trauma and neglect, and to corroborate the FVOA's claim that the state had manipulated their members into taking workmen's compensation so that they would never be able to sue the state. And for that matter, they would also need people who could really speak to the lengths that state officials had gone to keep them from getting any restitution for all that they had suffered as a result of the forcible retaking of Attica back in 1971. For the first point, the attorneys Gene Tenney and William Cunningham could provide ample evidence that excessive force had been used against hostages during the retaking, much of the same evidence that they had presented in Linda Jones's suit. For the second, Morris Jacobs, the man who had worked for the state insurance fund, was willing to testify as to the workmen's compensation manipulation. And finally, to the state's undoubted dismay, the FVOA elected to bring whistleblowing Attica prosecutor Malcolm Bell in to testify to state officials' efforts to cover up their wrongdoing at Attica. Getting Malcolm Bell involved was no easy decision, particularly for D. Quinn Miller, who thought of Bell as the lawyer who, in 1976, had sought to receive clemency from Governor Carey for John Hill, the man convicted of killing her father. Deep down, Miller wasn't sure what to think about whether Hill really had or hadn't killed her father, but she was nevertheless leery, at least initially, of turning to his lawyer for help. But Mike Smith had, through Frank Big Black Smith, made contact with Bell, and he persuaded the rest of the group that Bell's testimony would be vital for the FVOA's cause. Gary Horton, Mike, and Sharon Smith, and former hostage John Stockholm and his wife, Mary, all descended upon a quiet and rustic area of Vermont where Bell now lived. He greeted them warmly. He was ready to do anything he could to help the FVOA. 18 Come to Albany, they said. The public hearings would be the FVOA's one shot at making its case that the hostage survivors and widows also deserved restitution from the state of New York. 56. Getting heard. During the 6 days of public hearings that the Attica Task Force held between May and August of 2002, 85 people came to tell their story. Originally there were only going to be 2 days of hearings at the Rochester Institute of Technology in May and 2 days of hearings at the Empire State Plaza in Albany that July, but so many people wanted to be heard that a third set of hearing dates at the Rochester Institute of Technology was added in August as well. Department of Correctional Services Commissioner Glenn Gurd opened the first public hearing at Ritzchester Carlson Building on May 9, 2002, by recognizing the historic public hearings on the plight of correction officers and civilian employees won in these hearings. Gurd made clear, the roughly 22 people who testified would only be asked for statements, not for evidence. We will be willing to take each victim and survivor at their word. We will not interrogate the victims or their survivors. 2. The surviving hostages and family members who testified found their experience emotionally wrenching. They had been talking about Attica in FVOA meetings and had felt support doing so, but to speak formally, with so much at stake, and to the general public, was much harder. John and Mary Stockholm were the first to the microphone. John Stockholm said quietly, "We were repeatedly hurt and disappointed by the poor treatment we received. We were told to take time off after the riot. But no one told us by doing so, we would forfeit our rights to compensation, to sue for remedies. We did not know. 3. His wife, Mary, brought a more personal story to bear. I did not know how to deal with my husband's mood swings, the night sweats and, worst of all, the silence. At the age of 24, we were expected to get over it, to get on with our lives, which we did, although the events of Attica are just under the surface. 4. The family members of the late Richard Fargo also made sure that their pain was clearly expressed. Fargo, a hostage, had survived the retaking but had suffered greatly until his death in 1992. His wife, June, spoke of feeling swindled by the state, how they had been called with other hostages to a meeting at a Presbyterian church soon after the prison was retaken, at which Commissioner Russell Oswald had told the surviving hostages to relax, to take time off, and that all would be well. She also noted that they were all told not to talk about what had happened to them at Attica. 5. Most importantly, according to June Fargo, taking time off hadn't helped her husband. Richard had long-term physical and emotional effects from being held hostage. He took heart and diabetic medicine for 20 years. He had bouts of aggression and anger, and nightmares. He would wake up in the middle of the night with severe chest pains. He tried very hard to put the whole ordeal behind him, and he drank too much to do that. Our family lost a happy father and a husband. I never knew what I would find when I got home. I literally shook. Our quality of life was severely impaired. We couldn't go into crowds. He was always looking behind him. Panic attacks set in when helicopters flew over our house, which happened frequently. Our life was governed by Richard's moods. He died, still needing counseling, on May 29, 1992. He never got over the fact that his employer could treat him and fellow hostages and widows and survivors so badly. 6. Testimony from Fargo's daughter Susan echoed her mother's story. He could become very angry very quickly, or very emotional, crying, choked up, shaking, volatile. I never knew which father I would be coming home to. 7. Dean Wright, another hostage survivor, also testified that day. He declared that not only had he been lied to by the state officials who said they would take care of the hostages, but he also had been badly used by the state in helping Anthony Simonetti's office make criminal cases against prisoners. He explained how members of the Attica investigation had hounded him to identify prisoners, bombarding him with pictures and peppering him with leading questions. It got to the point, he said bitterly, where it didn't make any sense to me. They tried to put words in your mouth that he was where he wasn't or was doing something that you didn't see him do. 8. While the state tried to make Attica all about what the prisoners had done wrong, Wright himself was suffering post-traumatic trauma from his own experiences in D-Yard. Just out of the clear blue sky I'd get the shakes, I still get nervous, I get withdrawn, and it bothers me, because I don't know why I do these things. 9. Despite feeling terrible, Wright had no choice but to go back into the prison to work. When he went back to being a CO, though, we talked about a lot of things, but the riot was never one of them, and our feelings were never one of them, and our problems were never one of them, and thus his own problems just festered. 10. As the years wore on, Wright felt more and more bitter. He was still furious at the prisoners and he hated the state. We were wronged by the inmates. They are the ones that caused the riot, we didn't. We were wronged by the state. We were lied to by the state. 11. Wright's son Scott came to the microphone to testify, after seeing his father go through this for years. Scott Wright had one message for the task force: all of these people should be commended for what they have endured. I feel that the state of New York owes these people an apology. 12. Before the first day of hearings ended, the task force heard not only from surviving hostages, widows, and children of hostages, but also from the lawyers William Cunningham and Jean Tenney, who had spent decades trying to seek justice for them in court. Cunningham explained in detail his 13-year journey to get some restitution from the state for the widow of Herbert Jones. He made clear how much energy the state had expended on trying to stop this woman from getting any money, going so far as to comb through its many thousands of cancelled checks to see if they could prove that Jones had cashed hers. Indeed, Cunningham said disgustedly, the Attorney General asked for a recess, so that the controller could make a further search for the check. They knew Linda Jones didn't take any funeral expenses. They knew she didn't take a nickel. The judge, rightly so, granted a recess. They couldn't find it. To this day, they can't find it. It's because she didn't sign the check. 13. Smiling, he added, I happen to know where the check is. To this day, I have it. 14. Even though Jones hadn't taken workman's compensation, as she then testified, 5 appellate division judges had told her that she still couldn't sue. Indeed, it wasn't until the Court of Appeals stepped in that she had any chance of being heard in court. 15. And Linda Jones had been one of the lucky ones, as testimony from attorney Jean Tenney made clear. As Tenney explained, he had worked on hostage survivor and widow cases for 30 years, and he still found it shocking just how manipulative the state had been with his clients for the first 20 of those years. It was very difficult for me to, as a lawyer, to have judges, esteemed judges who I respected previously, find that these people elected a remedy, as their husbands lay in hospitals, as they lay in morgues, they, the surviving hostages and widows of the slain hostages, had elected a remedy, an intentional decision to take workers' compensation. 16. Seeing the look on their faces broke Tenney's heart, particularly since he could still remember so vividly when he first met with them down at Jim Hardy's insurance office in the town of Attica in December of 1971. He had promised them then, I will do everything in the world I can for you, not knowing how badly the state had already swindled them. Although they hadn't retained Tenney until December 1971, as he noted bitterly, you can bet your sweet life the state insurance fund had all of their lawyers working on this case. And they were working it from the first date. I'm not talking September 13th, I'm talking about September 9th, something he had found out in a series of hearings in which he later participated. 17. Tenney himself had spent over $100,000 on the survivor and widow cases, but, he made clear to the task force, he wasn't requesting compensation for himself. Whatever you give them is theirs. 18. Some of the most heart-wrenching testimony came in subsequent days from the widow of John D'Arcangelo and then from hostage Carl Vallone's widow and children. D'Arcangelo's widow, Ann Driscoll, recounted that her husband was only 23 when he died and their daughter was barely 3 months old. What is more, her husband had just graduated from college, majoring in psychology and history. He was my husband, a new father, the breadwinner of the family. And most importantly, he was my best friend. 19. And yet, on September 13, 1971, there she was in the basement of some church identifying his bloody body. My memory of this place, she said quietly, was that it smelled of blood and dirt. 20. Anne barely had time to grieve, though, because a few weeks after the funeral, a group of well-dressed men arrived at my mom's house in Auburn, New York. Commissioner Oswald was one of these men. He handed me John's final paycheck and told me that I had to sign these papers that he brought with him. He told me that these were documents that assured us that the state would take care of Julie and me for the rest of our lives. I didn't have a clue that by signing these papers, I would never be able to sue the state. We were awarded $36 a week. And those benefits ended when Julie was 16. 21. Widow Ann Vallone was so angry at Commissioner Gourd by the time she was called to the mic that she lashed out at him on the record. Having watched Gourd throughout the day, it had seemed to her that he looked bored as people bared their souls. 22. Looking over at him, Ann said, I think you people are just listening to us, trying to appease us, show that you are all good guys. 23. With her voice breaking, Ann Vallone told how her family was so traumatized and that her then 10-year-old son, Carl, her husband's namesake, was particularly scarred by his father's death. 24. Now if anybody needed counseling in this whole wide world, it was my son Carl, she said sadly, but they had no money for such a luxury. 25. Ultimately Carl, her child, had hanged himself. Carl's sister, Mary Ann Vallone, had also been irreparably harmed by the death of her father and, as important, by the state's abandonment of his family. She had been 15 back in September of 1971. The kids in my family got so messed up and so bitter and so hostile and so angry, so miserable. And we took it out on my mom, every single day of the rest of her life. We could not cope with it. We could not cope with what happened. 26 After her father's death, Mary Ann was so filled with rage and fear that she could barely function. She found herself hating the state troopers more than anything for wanting to kill as many black people as they could, but she was also terrified of these troopers, so she ended up leaving New York State as a young girl because I thought the New York State troopers were going to kill me and throw the gun next to my body. 27. By the time Mary Ann was an adult, she had taken turns hating everyone in her life. I hated the hostages that lived, I hated the civil rights movement, I hated blacks, I hated God, I hated correction officers. I hated my mother, and I hated my father because he went to work. 28 Mostly, though, Mary Ann hated herself. I tried to destroy myself for years because I turned all this anger inside too. I could not figure out who to blame, who is responsible for all this. She ultimately decided that the prisoners were actually not the ones to blame. As she explained, I forgave them first. I forgave them a long time ago. They were victims too. After I got a little bit of education, they were the first ones I forgave. But it took me a long time to forgive God. 29 It was especially hard to forgive God when she learned that her brother, Carl, had killed himself. My brother was in pain, she said in tears herself. My brother killed himself, hung himself off the deck of his $125,000 house when he was 33 years old. 30. The July and August hearings brought even more trauma to the stand. During the July hearings in Albany, 3 sons of slain hostage Edward Cunningham testified that their worlds had been turned inside out by his senseless death and the way that state officials handled it. Mark Cunningham spoke of a nagging uncertainty that his dad was even in the grave marked with his name because the state had messed things up so badly that it had to dig up his dad's body to autopsy it. 31 Mark also tried to express how hard this had been on Edward Cunningham's widow, a mother of many kids who never really recovered. She never stopped calling state officials and trying to be heard, he noted, and because she was never heard, every day of her life was pretty much anxiety, and depression just filled her life for the whole 28 years before her death. 32. Mark's brother John, who had only been 8 when his father was killed, chose to read a letter written by his mom before her death. The frustration I and the widows of Attica have felt since the death of our husbands, at Attica, has been extreme. It is difficult to accept the way things were handled, and the outcome for our men and families. The deception and treatment by the state, rumors and misinformation made many years of torture for us. I would like the records to be opened. We should at least be able to know the truth of what happened there at Attica. 33. Hostage G.B. Smith told the task force in July that he still couldn't believe that the state hadn't even paid them for the entire time they had sat in terror as hostages in D-Yard because, other than for 8 hours a day, they were, technically, off the clock. 34 And former hostage Gary Walker tried to explain to the task force just how much he and his fellow survivors had suffered. For the first couple of years, he said, I broke out in hives constantly because my nerves were shot. I took pills. I did not go back to work for 6 months because I just could not, and then when I got back I got scared more, but I said, well, I got to take care of my family, I got to take care of my kids. I have to have a job. 35. The cover-up concerning the deaths at Attica had also taken a real toll on many assembled, especially on Don Werner, the brother of slain hostage Ronald Werner. He told the task force about going to the funeral home to see his brother's body. When we were allowed in the funeral home, I asked Dick Marley, who was a family friend for years, if Ron's throat had been cut. He looked right at me, says Don. I am not permitted to answer that. This bothered me for a long time. I have never found out really what happened to my brother. I never found out how he was killed. 36 Lest the task force suspect men like Werner of hyperbole, the FVOA made sure that Malcolm Bell also testified, describing in calm and minute detail the state's effort to dodge responsibility for the deaths and injuries at Attica. A guard in a gas mask speaks to an unidentified hostage lying on a stretcher. From the Elizabeth Fink papers. Ultimately, the task force was left with no doubt that state officials had swindled the surviving hostages and hostage widows via the workmen's compensation system. Morris Jacobs, the former employee of the State Insurance Fund, minced no words when he declared that the state of New York, including top officials of the State Insurance Fund, as well as the Rockefeller administration, had induced the acceptance of workers' compensation in order to avoid liability for intentional tort. 37 These officials had callously manipulated the system to deny benefits to the widows, had targeted the Attica widows, by violating an inflexible rule, which is not to approach widows prior to a hearing without the approval of their attorneys, had intruded on the vulnerable widows within days after the fatalities knowing that the widows were unrepresented by attorneys, and had been guilty of blatant hypocrisy in initiating and accelerating compensation payments prior to hearing under the bogus pretense that they are befriending and favoring the Attica widows by expediting payments. 38 Ultimately, he insisted, insensitive bureaucrats had maneuvered to victimize the widows a second time by depriving them of seeking alternative, appropriate, legitimate and reasonable redress and indemnification. 39. By the time the hearings closed in August 2002, there could be no question that the hostage and hostage family survivors of Attica had endured a great deal. Sharon Smith, surviving hostage Mike Smith's wife, gave some of the most jarring testimony. If the state had not sent troopers and correction officers into Attica with guns blazing, Mike would never have received the horrific injuries he had. Worse, this same state then abandoned him in his moment of greatest need. Sharon explained in graphic detail how there were 4 wounds of entry. The bullets seemed to have burst into hundreds of small fragments which were found all over the peritoneal cavity, and quite a few of them were embedded in the pelvis and sacrum. The fragments of the bullets had played havoc in the abdomen. There were about 20 perforations of the ilium which were repaired. At 2 different places, the ilium was completely torn into small pieces. It was found there were 4 complete tears in the sigmoid colon. There was a large tear in the dome of the urinary bladder, measuring about 5 inches. The floor of the pelvis was badly injured. Some wounds were so big a fist could be introduced into them. 40 Then, as Mike was still in intensive care fighting for his life, a letter dated September 30, 1971, came to their house indicating that the state hadn't received records that it needed and that if the Smiths didn't file this paperwork immediately, the state would not pay his medical bills. I was in a panic, Sharon recalled, so I filled out the papers and sent them back without the benefit of legal representation. Little did she know that these documents too related to workmen's compensation, and thus she was electing a remedy that would prevent her from suing the state later on. Meanwhile, Mike's injuries were so bad that he didn't come home from the hospital for 91 days and, even then, he was transported by ambulance, as he could not walk or sit up. Michael weighed 124 pounds 41. Sharon, who was also taking care of their 6-month-old baby, was left in charge of Mike's rehabilitation at home, which was a monumental task. Yet, again, Mike's physical injuries almost paled in comparison to the added injuries he suffered from the state's self-interest and manipulation. As Sharon pointed out, there was no contact from the state as to his well-being until March 13, 1972, and they only called then because a sergeant wanted him to come by and ID inmates for the criminal prosecution. 42 Later, when Mike wanted to keep the bullets that had been removed from his body, he had to sign a statement that he would not hold the state responsible, he would not use the evidence against them. And that was in 1986. 43. When the hearings ended, everyone who had testified was exhausted and not at all sure what was supposed to happen next. Presumably their stories would move the Attica task force to address their list of demands, but as far as anyone could tell, there was no deadline placed upon this body to act. How long would they have to wait to hear from state officials whether their words had in fact mattered? A long time, it would turn out. 57. Waiting game. In the months following the Attica Task Force hearings, the forgotten victims of Attica had very little sense of what was supposed to happen next. D. Quinn Miller reached out to Task Force member Arthur Eve and, as they became close, learned some disturbing information about the entity that she and other FVOA members were hoping would help them. According to Arthur Eve, the Attica task force wasn't particularly cohesive or democratic. In his view, only Dale Folker and Glenn Gould were making the decisions, and even the governor seemed out of the loop. Eve shared with D. Quinn Miller his concern that Commissioner Gould was trying to wrap up this whole inquiry as expeditiously as possible and, since he was maintaining such personal control over the process, it wasn't certain how much justice would be had. Of course, this greatly bothered the FVOA members, especially since they knew that the task force was not facing a deadline and, therefore, no real pressure to make any sort of recommendation to the governor. So D. Quinn Miller took it upon herself to keep the pressure on by writing regularly to the governor and trying to lean on Gould himself. Every time she spoke with the commissioner, though, she found herself frustrated. In short, she recalled, they wanted to do it all their way. They were nasty. One growing increasingly concerned that momentum might soon be lost, the FVOA decided on a new tactic. It would try to go public, in hopes that state officials would, in turn, feel embarrassed not to settle with the FVOA. 2. However, reaching out to the public was expensive and required building powerful networks. Knowing this, the FVOA decided to begin with correction officers' unions around the country, asking them to spread word of the fight and, if possible, help the FVOA financially. Within a few months, the FVOA had powerful unions such as the New York State Correctional Officers Association and Police Benevolent Association, NYSCPA, the California Correctional Peace Officers Association, CPO, and other unions from Massachusetts, Pennsylvania, Ohio, and Florida as important allies. From these organizations they received a great deal of publicity as well as monetary support. Bringing in CO unions, particularly NYSCPA, had a real cost too. Glenn Gould hated the union and especially disliked its militant president, Rick Harcrow. 3 With the union on the FVOA's side, the organization succeeded in drumming up much public attention and sympathy, but it also served to make negotiations with the task force much more tense. 4. The FVOA heard nothing from the Attica task force for so long that, on February 13, 2003, it decided to issue a report entitled A Time for Truth, which it hoped would shame Commissioner Gould into offering something. This document began by noting that the task force had not made headway on its study since the hearings had ended 6 months earlier, and chronicled the sporadic, and dismissive, correspondence that the FVOA had received from state officials. 5 In a letter of November 18, 2002, the docs had assured the FVOA that it planned to present carefully considered and well-reasoned recommendations on each of the 5 points that are as fair as possible to all involved, and yet had also made clear that it wanted no further input from the FVOA. 6 This was unacceptable, the FVOA made clear. Via this report the group was reiterating its evidence and grievances in the hope it will be of assistance in finally producing just results. 7 The report provided the public record with a clear summary of the riot events, as well as a careful exposition of the riot's immediate aftermath, and made it clear that the FVOA wasn't going to just fade away. Attica is the ghost that has never stopped haunting its survivors, including both the inmates and the families of the deceased guards and prison personnel, the report noted, and therefore the FVOA was going to insist on some remedy from the state. 8. To make sure that the task force members would not simply bury this report under a pile of papers, with great fanfare the FVOA also called a press conference. At this event were representatives of NYSCPA, the Correction Officers Union, former correction officials, prison reform advocates, and historians, all loudly stating the importance of the Attica task forces doing its job. 9 The FVOA had come to see that bringing the public into its battle with the state was a good strategy. The group even got former New York State Senator and Attica observer John Dunn to write an open letter to families and friends of the forgotten heroes of Attica, which won some attention. As Dunn put it bluntly, the state, which was instrumental in the violence which resulted in the deaths of dedicated prison guards, has steadfastly denied just compensation to the victims of that violent retaking. 10 And so, Simple justice demands that the state do right by the families and survivors of those loyal and courageous state employees who faithfully held the line and were prepared to make the ultimate sacrifice. 11. Malcolm Bell had also remained an outspoken supporter of the FVOA in the public sphere. He too wrote an open letter, in this case to Governor Pataki, on July 16, 2003.12. It was time, he argued, for Pataki to do the right thing. To Bell, the Forgotten Victims' 5-point plan for justice was reasonable, responsible, and, under the grim circumstances, modest. 13. By 2003 the FVOA had amassed many supporters, but one of the most surprising was a group of New York State Police. Since the FVOA had formed in 2000, the Blue Knights, a motorcycle club of New York State troopers, had been holding annual fundraising rides for the group. Heading up this effort was Trooper Tony Strollo, whose brother Frank had been a hostage and who himself had participated in the retaking. Strollo was personally conflicted on how that retaking had gone down. In his heart he knew it had been a disaster and that terrible things had happened as a result of it. 14. But he also felt strongly that the state had placed troopers in a terrible situation by sending them into this prison tired, upset, and untrained for what they were expected to do. 15. And so his way of coping was to offer his support to the hostage victims of Attica with this annual ride. In 2003, they stood with NSCAPA, the CPO, and other unions in support of the FVOA at a rally held in front of the Capitol. 16. DOC's Commissioner Glenn Gould noticed that public pressure was mounting and that he would soon have to issue some sort of response to the FVOA's demands. In September of 2003, he sent the group a draft report that outlined what the task force would be recommending to the Pataki administration, including a monetary settlement of $8 million. 17. The $8 million settlement figure was based on what the prisoners had received, with the idea that this amount would be shared by many fewer people in the FVOA, which meant more money for the hostages than what the prisoners had been awarded. Interestingly, the task force explained the difference by reasoning that most, if not all, of the state workers killed would have remained employed in some capacity. Therefore we believe they are entitled to higher per-person awards than inmates received. 18. As for the other four demands of the FVOA's 5-point plan, the draft report attempted to dismiss them as unnecessary or problematic. Regarding the release of Attica records, the report explained that there are no Attica records sealed by order of any governor. 19. Therefore, with the exception of the 2 volumes of the Meyer report that a justice of the Wyoming County Supreme Court had confirmed sealed in a decision of May 22, 1979, like Carmen Ball before him, he had believed the grand jury material they contained to be privileged. There was nothing stopping FVOA members from going to the New York State Archives and looking at any Attica document they liked. 20. The task force did not feel that special provisions for counseling needed to be stipulated, recommending that FVOA members pay the costs of counseling from any reparations they might receive. 21. Finally, the task force stated that an apology would not be forthcoming from the state because it was its opinion that government descends a slippery slope if subsequent administrations believe they have the authority to take their view of today's standards and apply them retroactively to apologize for the decisions of their predecessors whose actions were based upon the prevailing contemporary social standards of an earlier era. 22. By taking the position that state officials in 1971 had acted in accordance with policies and procedures that were the law and were acceptable at that time, the Attica Task Force was clear that despite what the FVOA had hoped, the state did not see the hearings it had held to be in any way like the Truth and Reconciliation proceedings that had recently taken place in South Africa, where state officials were asked to apologize for actions that may have been legal but were nevertheless immoral. 23. If Glenn Gould thought that his draft report would be received with relief by the FVOA, he couldn't have been more mistaken. The FVOA rejected the $8 million payout as an insult, and noted that not a few years earlier the state had mentioned paying widows a total sum of $50 million and the group considered that amount the starting point in the negotiations. 24. D. Quinn Miller, Mike Smith, and the rest of the men and women who had been working to keep the FVOA a major priority of the Pataki administration were furious that they had waited for more than a year for a proposal from the state that ignored most of their demands and offered monies that were not at all what the group had in mind. As D. Miller recalled, "I wanted 50 million and I wanted the same amount to be given to everyone 25 since there ultimately were 52 families in the FVOA, totaling 152 claimants, $8 million would be inadequate." 26. The FVOA responded to the task force's draft report by going public with a detailed 40-page response. D and others had heard that the full task force had not been consulted when this draft report was written, which felt even more insulting as a response to their heartfelt and agonizing testimony. Task Force member Arthur Eve apparently knew nothing about the report until the FVOA leaked it to a local newspaper. 27. The FVOA's response to the task force's draft report was nothing short of scathing. It was published in the form of an open letter to the New York State Legislature on January 13, 2004, and stated clearly that the task force's draft report to the governor was offensive to the FVOA. 28. The FVOA responded point by point, beginning with how outrageous it was for the task force to claim an apology was out of order on the grounds that the state had acted within acceptable bounds. There are not now nor were there in 1971 any prevailing contemporary social standards that would condone the death, injury, pain, anguish, and neglect inflicted upon the FVOA by the state of New York. 29. As for the task force's claim that anyone could access state-held records related to the Attica Uprising, the FVOA pointed out that not 6 months earlier a member of the FVOA, through FOIL, New York State's Freedom of Information Law, application, requested access to specific McKay Commission records held by the state archives. That request was denied. 30. The task force's suggestion that they pay for their own counseling was also offensive and out of touch, the FVOA declared, since it ignores the differing costs of counseling that each member might have based either on the level of treatment needed or on existing insurance benefits. And further fails to recognize that the children of the hostages, some of whom suffer the most substantial psychological damage traceable to this event, may receive no immediate monetary reparations from the state should their parents still be alive. 31. Not to mention that if counseling monies were going to have to come out of each FVOA member's settlement monies from the state, this was all the more reason to revisit the sum that the state had recommended be awarded to these same members. Finally, on the issue of state compensation, the FVOA response was equally acidic, accusing the task force of ignoring the most logical benchmark of fairness, the Jones judgment, and uses instead as a benchmark the settlement of inmate litigation against the state. 32. That settlement had come not from a court ruling but rather from prisoners being forced to settle. Arguably, the FVOA noted, their compensation was insufficient and only a fraction of what might have been awarded had the litigation continued, since, it also pointed out, juries previously had awarded only 2 of those plaintiffs over $4 million, and had this been the benchmark, the state's payout would have been staggering. 33. As important, the FVOA went on, why should the hostages get less than the prisoners had gotten in their settlement just because they weren't asking for attorney fees, since their attorney, Gary Horton, hadn't charged for the work he did for the FVOA? Even though they weren't paying him, the costs of approaching the state for remedy had been high for the FVOA. 2.34. There was one more point about compensation that the FVOA felt crucial. In its draft report, the Attica Task Force had recommended taking whatever compensation funds were agreed upon from the budgets of the Executive, the Senate, and the Assembly in equal shares. This was a terrible idea, the FVOA maintained. The FVOA believes that they are owed compensation from the state of New York and that compensation should be funded by the state budget. Otherwise, this would merely serve to take funding away from various health, education, and social welfare programs currently supported by the legislature. The FVOA does not believe that their suffering should be ameliorated through escalating the suffering of others. 35. Needless to say, when reporters got wind of the Attica Task Force's draft report, and then heard how hostile the FVOA was to the proposal, they began calling Commissioner Gourd and pressured him to explain what the task force might do next to address the FVOA's concerns. To the public he did little more than offer platitudes, repeating his mantra that the state has a moral obligation to resolve the Attica dispute. 36. To the FVOA, however, Gerd wrote a far more vitriolic reply entitled simply Commissioner's Commentary. It was clear from the opener to the reply that he was angry. I want to update you on the work of the Attica Task Force which I chair, now that my discussion draft report on our work has been made public by an anonymous source. 37 He asked members of the FVOA to consider what their answers might be to several complex questions that, in his view, had to be resolved before any settlement could be reached between them and the state. If, for example, they now were to receive the same amount of money that Linda Jones had been awarded, were FVOA members willing as well to pay back the workmen's compensation monies they had already received? Or, if they insisted on taking the same sort of settlement as the prisoners had secured, were they prepared to accept that as a final settlement, meaning that the state would not pay their counseling as some separate obligation? 38. The FVOA refused to get into a back-and-forth argument with Gerd. Instead, the group made a fateful decision to go to the powerful California Guards Union, the CPO, and ask for its help to fund a lobbyist who could provide a direct connection to sympathetic state legislators. The California Correctional Peace Officers Association indeed helped them to secure a lobbyist and, in addition, to fund construction of an FVOA office in D. Quinn Miller's home so that she could work full-time with Mike Smith and Gary Horton on landing a settlement. With this new financial backing, this trio was soon speaking around the country as well as traveling regularly to Albany to meet personally with lawmakers. This travel and PR work was costing the FVOA more money than even the CPO was able to offer, so it then turned to other correction officer groups around the country for help. Although NSCPA and the CPO had offered the lion's share of the needed funding, many other organizations stepped in to help as well, including the Correctional Peace Officers Foundation, CPOF, and Corrections U.S.A.39. From selling Attica anniversary coins to conducting fundraising drives among their own members, these many organizations, along with law enforcement unions in Massachusetts, Pennsylvania, Ohio, and Florida, all worked with the FVOA to pressure Pataki's office into settling. 40. In the fall of 2004, the FVOA had collected sufficient money to finally pay for a lobbyist. The man they hired, Artie Malkin, normally commanded anywhere from $4,000 to $12,000 a month for his services, but agreed to work for much less as long as the FVOA would do much of the scut work, making the calls, writing the press releases, and such, so that all he had to do was gladhand and negotiate in Albany. 41. And the FVOA lobbyist was good at doing just that. His credentials were impressive, and he had a client list ranging from the New York State Defenders Association to the Drug Policy Alliance to the American Lung Association, the Police Benevolent Association of the New York State Police, and even Teach for America. This meant that he had major connections in Albany, and indeed he had a close relationship with Governor Pataki's counsel, Jerry Connolly, as well as with New York Attorney General Elliot Spitzer and even First Assistant Attorney General Richard Rifkin. 42. As Thanksgiving 2004 neared, the FVOA had the sense that something was finally happening in the governor's office. The lobbyist was calling D. Miller more frequently to let her know where the governor's office was in terms of a monetary amount for the settlement, and, at these junctures, she would run the news by the FVOA members and then, in turn, go back to him with a counter-proposal. Then in December 2004, the FVOA told its lobbyist that a settlement couldn't wait any longer. Frances Whalen, the widow of slain hostage Harrison Whalen, had just died, and she was the fourth widow to die since the FVOA had begun its work in Albany. Only 7 widows remained who might hope to see restitution from the state, and D. Quinn Miller feared that time was running out. 43. By the end of December 2004, discussions between the FVOA lobbyist and Pataki's counsel were taking place virtually around the clock and, finally, as D. Quinn Miller put it, they hammered this out. 44. On January 14, 2005, the state of New York formally agreed to a $12 million settlement with the hostages who had survived Attica and the family members of the hostages who had not. As a show of good faith, Pataki's office agreed to disperse $2 million to the 52 families right away, with the remainder to be worked out at a later date. The FVOA had earned its victory. Or so it seemed. 58. A hollow victory. Even though the surviving hostages and hostage widows had finally settled with the state, it was still not clear how the money awarded to them would be distributed. The eventual decision would once again, now 35 years later, link their history with that of Attica's surviving prisoners and prisoner widows in powerful and poignant ways. As a key leader of the forgotten victims of Attica, D. Quinn Miller had learned early on to reach out to anyone who might help her get some sort of justice for families such as hers, and, in turn, she had come to learn much more about what had happened at Attica than she had known before coming to that radio show with such anger in 2000. She had, for example, reached out to Frank Big Black Smith and talked for hours on end, so that she might better grasp what had really happened to him. D. Quinn Miller came to love Big Black and to trust him completely. After talking to him, she decided that she should reach out to Judge Michael Telesksa to decide how the FVOA settlement should be distributed, just as he had done with that of the prisoners. The more she thought about this, it felt right. After all, Judge Telesksa had expressly written in his August 31, 2000, document awarding the prisoner survivors their money that he very much regretted that this settlement still did not help the families of the hostages. 1 And so D. Miller had actually reached out to Telesksa quite early on in the FVOA's battle with the state. Indeed, she had hoped Telesksa would help make state officials recognize that the FVOA was serious, and not going to go away, so she had kept in close communication with him throughout 2004 as negotiations intensified. Those negotiations definitely took some heated twists and turns, and Miller came to know, and to trust, Telesksa quite well as they had unfolded. Back on December 18, 2004, for example, the FVOA lobbyist had gotten the state to agree to $10.5 million, but Miller rejected this offer because she had faith that Judge Telesksa could lean on First Assistant Attorney General Richard Rifkin on their behalf and get more. As she had waited for a response to the FVOA's rejection of the $10.5 million, however, Dee's faith was tested, and indeed the pressures of trying to get a settlement worked out before any more Attica widows died shattered her nerves and landed her in the hospital. From her hospital bed she called the lobbyist, Artie Malkin, in utter anguish. I can't do this anymore, too. And in this crucial hour, Dee watched as Telesksa worked to help the hostages with as much energy as he had the prisoners. Thanks to the behind-the-scenes pressure levied by Telesksa, when the lobbyist went back to the governor's council and mentioned that Dee was ill, that another widow had just died, and that this had to end now, the state finally agreed to $12 million, the figure that it had also granted the prisoners. 3 At a jubilant Christmas Eve party at a local church, D. Quinn Miller and Gary Horton gave everyone the news, and the FVOA decided unanimously to accept this offer. 4 As Miller remembered it, we had the best Christmas we had had in quite a long time. 5. A guard looks on while one inmate carries another, badly injured, inmate. Courtesy of Judge Telesksa. Although Dee was fairly certain that she wanted Judge Telesksa to oversee the way in which the newly awarded $12 million would be dispersed to the FVOA families, she still had some reservations that would have to be addressed. As she explained it, I had to go see him, even though Frank Smith thinks he is great. I wanted to make sure I thought so too. I wanted to make sure he wasn't biased. 6 When she saw that he had on his desk a heart-wrenching picture of one prisoner helping another, as a trooper looked coldly on, she believed that she had found the right man. As she explained, his pics in his office spoke volumes. That pic did it for me. 7. Still, D. Miller wanted to let the judge know how the FVOA's situation, while similar to that of the prisoners, was not the same. In her view, the dispersal of funds in the hostages case shouldn't give more to those who had suffered the most physically or even psychologically, as in the prisoner settlement, but in her opinion those families whose men had been killed should receive the highest awards. By 2004 there were so few widows left, she argued, that they should get the most. Needless to say, this was a controversial position to take in the eyes of some of the FVOA members, since some, such as Michael Smith, had endured a lifetime of suffering from the wounds received during the retaking. But D. Quinn Miller was pleased that Judge Telesksa at least listened to her point of view, and she left her meeting with him feeling that he would be fair and objective. 8. Miller had to persuade her fellow members of the FVOA that Judge Telesksa should be the one to decide who got what in their settlement with the state. The subject of giving Telesksa this task had come up on several occasions at various FVOA meetings already, and it had been clear that there was some dissent. At one such meeting held 5 months before the settlement was announced, Gary Horton broached this subject and had gotten a hostile reception. 929 members had come to this particular meeting, and many were uncomfortable when Horton prefaced his remarks that evening by stating that the FVOA members and former Attica prisoner Frank Smith had been on a common quest for justice. 10 Judge Telesksa, who had so clearly helped Frank Smith in his cause, Horton went on, might be a good ally to the FVOA as well. The gathering grew quiet. Some were on board, but others, including former hostages G.B. Smith and Gary Walker, were not. So when this issue was on the table for real in 2005, Miller knew that she had a lot of work to do to build consensus in the group for working with Telesksa. Over the next weeks, and over many cups of coffee and lengthy phone calls, she was able to get everyone on board. When the FVOA announced that it wanted Judge Telesksa to apportion their settlement, one of the most conservative members of the Attica Task Force, State Senator Dale Folker, refused to allow him to do so. In Volker's view, the FVOA should have no say whatsoever in who would get to apportion the state funds. Undaunted, the FVOA asked its lobbyist, Artie Malkin, to get involved. From him, though, they learned of another roadblock: the governor intended to appoint someone to do this job. Still, though, the FVOA members persisted. For days they met with the governor's lawyer and argued passionately for Telesksa to distribute the funds. He was the best choice, they argued, because he had no learning curve. He understood the ins and outs of the Attica retaking and its fallout better than anyone else the governor might appoint. Ultimately, the state agreed to establish the Attica State Employee Victims Fund, and the governor accepted the FVOA's request to have Telesksa handle the settlement. On May 2, 2005, Pataki made that appointment official. Judge Telesksa was grateful to be given this opportunity. In 2003, Big Black had been diagnosed with cancer and had grown increasingly ill, and since then the judge had spent a great deal of time talking with him on the phone. In those conversations, Black had expressed his hope that the former hostages and hostage families would also get some justice from the state, and he felt that Judge Telesksa should be the one to help them get it. He had told the judge, "Take care of the families of Attica prison employees, they are good people, they have had their pain too." 11 And so, if the FVOA was willing to agree to binding arbitration, Telesksa decided, then he would do the apportionment. 12. Notably, there were certain matters over which Telesksa had no control that had been decided in the governor's office. To ease the burden on the state budget, the settlement would be paid out over 6 years. What is more, the deferred payments would not accumulate interest. Also, although it was stipulated that the settlement would be paid out at some point between September and March of each year, no promises of exactly when were made. 13 In a bit of good news, the settlement funds would not be taxed. 14. Before getting down to business, Judge Telesksa first held several meetings with D. Quinn Miller, Gary Horton, and Mike Smith, as representatives of the FVOA, to make sure he understood what sort of apportionment they had all been imagining. As they spoke, he took notes, and he couldn't help but notice that there were still some real differences regarding which FOVA members deserved the highest awards. As D. recalled, the judge picked up on it. The tensions between me and Mike. 15 Telesksa already knew that D believed the widows deserved the most money, but Mike Smith argued that they, while profoundly scarred, had not necessarily suffered the most trauma. There was also the thorny question of where the death of William Quinn, Miller's father, fit into all of this. After all, he had not been killed by the state, although, in Miller's view, there was no question that, ultimately, he too had died because of state negligence, ironically the same point that attorney William Kunstler had tried to make in front of the jury deciding his client John Hill's fate back in 1975.16. To help work through these differences of opinion between FVOA members, Telesksa decided to meet with the entire FVOA group on June 13, 2005, in order to get a sense of what everyone else thought should happen. As he had with the former prisoners, he invited them to tell their stories on the record. He made clear that he would also read the Attica Task Force testimony and, if members wanted to, they could tell their stories to him privately and such testimony could be sealed. 17 He instructed every family member to get all of their relevant documentation to him by June 15 so he could begin holding anywhere from 4 to 6 days of testimony. His goal was to have the entire matter settled by August 1 to meet the state controller's deadline for processing payments. There were now a total of 150 people claiming a piece of this settlement, including, ironically, Lieutenant Joseph Christian, whose rescue mission near the hostage circle on September 13, 1971, had, according to both the McKay Commission report and Malcolm Bell's whistleblower report, led so tragically to many of the hostages being shot to death by troopers firing from up on the catwalk. 18. On July 3 Judge Michael Telesksa issued his long-awaited order, amended and finalized on July 12, 2005.19. As this order explained clearly, there were 3 groups of eligible claimants. There were the families of those correction officers or state civilian employees who died in the course of the Attica retaking, and this was important wording because, by not specifying how they died, it meant that William Quinn could be included in this group. 20 Then there were current or former correction officers or state civilian employees who were physically attacked, held hostage, or detained by inmates during the riot, even if released prior to the retaking of the prison by state forces. Or their heirs if they had since died. 21 Finally, there were current or former correction officers or state civilian employees who had been employed at Attica during the retaking, or any current or former New York State Police employees, who were shot during the retaking of Attica Correctional Facility by state forces on September 13, 1971, or their heirs if they had since died. 22. Once Telesksa had determined these 3 groups, he then divided them into 6 subclasses. 23 There was Category 1, $550,000. Which included William Quinn and Harrison William Whalen, also described as those persons who died as a result of injuries inflicted by inmates, as well as those persons who were mortally wounded during the retaking on September 13, 1971, and who suffered conscious pain and suffering for a period of 20 or more days. 24 There was Category 2, $500,000, which included hostages Edward Cunningham, John D. Arcangelo, Elmer Hardy, Richard Lewis, John Montelian, Carl Vallone, Elon Werner, and Ronald Werner, also described as all persons who were either killed instantly during the retaking on September 13, 1971 or died no more than 19 days thereafter from those injuries. 25 Category 3, $380,000, covered former hostages like Michael Smith, those persons who were severely, but not fatally wounded, as a result of injuries sustained during the retaking on September 13, 1971. For purposes of this subclass, a severe injury is one that required hospitalization for 20 or more consecutive days during the period between September 13 and December 13, 1971, or which resulted in brain damage. 26 Category 4, $225,000, was designated for those persons who were taken hostage for at least some period during September 9 through September 13, 1971, or persons who participated in the retaking of Attica prison and who, as a result of beatings received from inmates or injuries sustained from gunfire, received permanent physical injuries that resulted in a complete or partial physical disability. Category 5, $150,000, included those persons who were taken hostage for at least some period during September 9 through September 13, 1971 and who received significant injuries as a result of gunfire or beatings received from inmates. 27 Finally, Category 6, $100,000, covered all remaining persons who were held hostage for any period of time during the riot. 28. In this order, as he had done in the prisoner's order, Telesksa also included extensive narrative evidence of the Attica victims as well as that of disinterested parties who could corroborate their testimony, everyone from prisoners to members of law enforcement who had participated in the assault. Telesksa had been particularly moved by what he had heard from a former sheriff's deputy from Niagara County who was there on the morning of the retaking. He was very emotional in describing the shooting that took place and how unnecessary it was. He had trained officers in riot control as a deputy and was a former Marine MP and felt that there was no need to use bullets. Tear gas would have been sufficient to subdue the inmates. 29 Indeed, quite a few men had taken the time to offer corroborating testimony even though they personally could not share in the settlement fund. 30 And Telesksa was glad that so many had, finally, spoken up. As he said in the concluding paragraph of his order, hopefully, the survivors and their families of the Attica riots of 1971 will no longer feel forgotten, and that those who suffered and continue to suffer will feel some measure of comfort, at least from the fact that the matter is concluded and some measure of justice was served. 31. Some measure of justice was the best, perhaps, that anyone could have hoped for after almost 35 years. As former hostage Ron Kozlowski explained it to reporter Gary Craig, "It doesn't really fulfill what you went through," he said. "But," he added, "it's better than nothing." 32 others, such as FVOA attorney Gary Horton, were also pragmatic about where the FVOA had finally ended up. "I'm not sure what true justice could be in this situation. We're happy we reached this point. Personally, it's further than I thought we'd be able to reach." 33 And, as Mike Smith put it, "I don't know if this is justice, but this is as close as we're going to get." 34. The inscription on the memorial reads, "In memory of the employees who gave their lives in the riot of September 9-13, 1971, February 2015. Courtesy of the New York Times." To D. Quinn Miller and to Michael Smith in particular, however, this victory ultimately felt hollow. The fact was that, despite now agreeing to pay $20 million to the scores of people it had so badly and unnecessarily traumatized, and millions more to the lawyers who had represented them, the state of New York still had not admitted wrongdoing. There was no admission of responsibility, let alone an apology to any prisoner or hostage who had suffered the retaking. The state had managed to keep the survivors of its horrific retaking from knowing the details of that plan and of that day by refusing to bring all of its documents into the public eye as the FVOA had demanded. So many people continued to be protected by keeping these files closed to the public. As D. Quinn Miller knew after meeting so many Attica survivors since the FVOA first began its journey, opening the records would not, in itself, bring peace to the victims. Actually, what they learned could well shatter lives in altogether new ways. She wondered if this was particularly true of some of the children of slain hostages she had gotten to know. She worried that some of them might not react at all well, say, to learning who had actually killed their dads. 35 This shouldn't have been the state's call, however. It was wrong that state officials had decided to protect those who had committed crimes at its behest. It was immoral that it was still covering up what actually had happened on its request. Until the full truth about what had happened at Attica was told, thought Miller, this moment in history would still haunt all of its victims. Epilogue. Prisons and Power. BY 2011, when I found myself staring down at the collected materials that littered the warehouse floor of the New York State Museum, many former Attica prisoners and former Attica hostages, as well as Attica's observers, lawyers, and state officials, had already passed away. Former Attica prisoner Frank Big Black Smith lost a grueling battle with cancer in 2004. Former head of the Attica investigation Judge Robert Fisher died in 2005. In 2009, Judge John Elfvin passed away, and by 2012 former Attica observer Tom Wicker, former Attica superintendent Vincent Mancusi, and former Attica hostage Gary Walker had died. In 2016, as this book was going to press, former Attica prisoner Richard X Clark and lawyer Elizabeth Fink passed away. But even though so many of Attica's participants and witnesses are no longer here, this historic moment has not faded into obscurity. In these pages, their history lives on. They made Attica matter. However, Attica's legacy, what this moment meant for the history of the United States, remains deeply contested. Given the brutal way in which the Rockefeller administration ended the Attica Rebellion, and in light of the support they received from the President of the United States, readers might be surprised that Attica's immediate impact was to spark some serious reforms of the American criminal justice system. Less than a week after the retaking, the 340 members of New York's Democratic State Committee, including top party politicians such as New York Mayor John Lindsay, met on September 19, 1971, at the Hotel Syracuse and called for the immediate implementation of the central demands that had been made during the Attica Uprising, including greater religious and political freedom, banning censorship of mail and newspapers, and providing more counseling and additional rehabilitation services. Point 1. Similar rumblings could be heard in the halls of the New York State Legislature, even before the Jones Committee, the special state panel that had been convened right after Attica to study penal institutions, released its January 1973 report on how to improve prisons. Point 2. During the 1972 legislative session, the Rockefeller administration, supported by legislators from both parties, was actually proposing various prison reforms, including that prisoners should be allowed to leave prison for a week of educational or vocational training, that they should be permitted temporary leaves from prison for events such as family funerals, and that they be allowed to secure medical care for themselves if the treatment they needed was unavailable at their facility. Point 3. All also seemed to agree that year that prisoners who had been imprisoned for comparable crimes should all be eligible for parole in roughly the same amount of time. 4. The upshot of these various proposals and recommendations, which stemmed in no small part from community groups across the state levying enormous pressure on their legislators, was that over 150 prison reform bills were introduced in the legislature during the 1972 legislative session and 8 were passed. The most important of these included the governor's $12 million package of new funds. 5. Not only did prison reform have some real support in the New York State Legislature's 1972 session, but when Governor Rockefeller proposed his budget for 1973, he exempted the Department of Correctional Services from expenditure restrictions placed on all other state agencies so that the prison reforms could be funded. Attica even seemed to positively impact discussions taking place at the federal level. On the floors of Congress, the Pepper Commission, headed by Democrat Claude Pepper, suggested that serious prison reform bills needed to be considered in the wake of what Attica had revealed about the state of America's penal facilities, and Republican senators from New York such as Jacob Javits were also being pressured to bring about real changes in the way that the state's prisons were run. As one constituent wrote to one of Javits's right-hand men, one positive step might be to tie all future LEAA Law Enforcement Assistance Administration grants to state and local authorities to an acceptance and implementation by the latter of the reforms contained in the 28 Attica Demands. 6. While many scholars and pundits have considered the 1960s the heyday of prisoner rights, and the 1970s the decade of unmitigated backlash, the decade immediately after the Attica Rebellion saw vital victories for prisoners across the country in general and at Attica in particular. 7. In the years that followed the uprising, most of the practical proposals the Attica brothers had fought for were in fact implemented across their state. Right after the rebellion, the Department of Correctional Services requested nearly $2.7 million for the inauguration of department-wide inmate food service and clothing programs that would permit the department, for the first time, to provide a nutritious diet to all offenders confined in correctional facilities. 8. The department also asked for nearly $400,000 for the purpose of recruiting and assisting minority group candidates in joining the Department of Correctional Services, and received a grant to expand day and evening academic/vocational training in selected New York facilities. 9. These requests were important, as was the continuous pressure that the Attica prisoners themselves put on their own administrators to make good on the various promises that had been made. Within a year of the uprising, the New York Times reported that reforms had been implemented regarding clothing, food, visiting privileges, mail censorship, and the number of showers permitted. 10. In addition to paving the way for the prisoners eventually to get better food and medical care, the Attica Uprising also led to their visiting hours and other privileges being substantially increased and improved, as well as to their employment opportunities being expanded. 11. Following the rebellion, inmate liaison committees also were established. These were bodies elected by a vote of the prisoners, intended to help channel grievances, communications, and suggestions from the inmate population to the correctional authorities. 12. The state of New York seemed to take CO training more seriously as well. The Department of Correctional Services, for example, decided to hold a comprehensive orientation training for correction officers at the New York State Police Academy in Albany on December 6, 1971, which covered subjects as varied as types of inmates, attitudes and supervision, interpersonal dynamics, prejudice, and minority cultures. 13 Thanks to the Attica Rebellion, numerous existing grassroots efforts to push for prison reform were newly energized in New York. In November 1971 a large conference was held in Binghamton called After Attica What, and, as important, entirely new prisoner rights organizations were founded, such as Prisoners' Legal Services. 14 Numerous other, older organizations that had long been advocating to humanize New York's prisons, such as the Osborne Association and the Fortune Society, were also galvanized by Attica. Thanks to their efforts, New York's criminal justice system as a whole became less repressive in the wake of the Uprising. But though Attica reflected the extraordinary power and possibility of prisoner rights activism, at the same time, Janus-like, it also reflected, and helped to fuel, a historically unprecedented backlash against all efforts to humanize prison conditions in America. One cannot overestimate how much it had mattered not just to New Yorkers' views of civil and prisoner rights activism, but also to the views of countless other Americans when state officials stood outside Attica in the immediate aftermath of their assault on the prison and told outrageous tales of prisoner barbarism. The rebellion had been front page in television news for an entire week, and when state officials told the nation that the prisoners, those who had claimed to be clamoring only for better treatment, had slaughtered innocent hostages, many were naturally horrified and disgusted. Activists and protesters, many concluded, had simply gone too far. Indeed, to countless white Americans in particular, Attica suggested that it was now time to rein in those black and brown people who had been so vocally challenging authority and pushing the civil rights envelope. It appeared, now, that they weren't legitimate freedom fighters, they were instead just dangerous thugs. 15 As one Time magazine reader put it in his October 1971 letter to the editor, Governor Rockefeller did exactly the right thing. And now let's not have the courts get lenient with these murderous convicts. 16. Importantly, it wasn't just disenchanted citizens that took this message from the events of 1971. So too did policymakers. The Attica Uprising prompted the American Correctional Association, ACA, to conduct a major study of prisons, one that was disseminated widely, which concluded that there was in America by 1971 a new type of prisoner. 17 This new type of prisoner was not only to blame for the ugliness that had happened at Attica, reported the ACA, but he was a regular presence in, and a major threat to, a majority of prisons and jails in the nation. 18 And, lest there be any doubt about why the nation now faced the threat of this more militant convict, it was because these men had spent the 1960s acquiring a knowledge superficially and otherwise of history, race problems, street fighting and the vocabulary of radicalism, and they now believed they were a victim of racist society. 19 Most alarming, according to the ACA, this new breed of politically radical young prisoners believed that they were in a holy war against racist oppressors, which, the organization emphasized, did not bode at all well for the law-abiding citizens of this nation. 20. This particular understanding of Attica and what it suggested about prisoners would inform how officials across the country dealt with the incarcerated from that year forward. While some enacted reforms in the immediate aftermath of the Uprising, other prison wardens and commissioners of correction in California, Connecticut, Vermont, and West Virginia all loudly spoke out against ever again negotiating with prisoners. Force, they insisted, was now a must. 21 In fact, some intimated, simply asserting more authority might be insufficient when it came to dealing with this new breed of militant black prisoner. Perhaps there now needed to be an entirely new sort of penal facility for these men. No sooner had the smoke cleared over Attica than New York's Commissioner of Correctional Services, Russell Oswald, was pitching exactly this idea to Governor Nelson Rockefeller. According to media reports, Oswald proposed isolating up to 500 of the state's 16,000 inmates to forestall rebellions in so-called maxi-maxi facilities. He argued that there were certain individuals who couldn't be allowed to move about in an open institution. 22 They needed segregation and intensive help. 23 As Fred Ferretti of the New York Times summed it up, the more militant people, the aggressive people, would be concentrated so they won't spread their poison to other inmates. 24 Other departments of correctional services across the country agreed with Oswald's assessment that there was a crisis brewing thanks to black militants in the prisons, and at least one prison administrator was confident that in the atmosphere that existed in the wake of Attica, we will be able to do it. 25 That Attica had directly, albeit unwittingly, helped to fuel an anti-civil rights and anti-rehabilitative ethos in the United States was soon clear to people paying attention to electoral politics across the nation. Any politician who wanted money for his or her district had learned that the way to get it was by expanding the local criminal justice apparatus and by making it far more punitive. The tougher on law and order a district was, the more dollars would come its way. 26 As Republican State Senator John Dunn put it bluntly, as a result of Attica, the public attitude is that we've got to get tougher. That means we've got to put more people in prison. We have not reached the point where as many people as should be in prison, are there. 27 Dunn had no idea how right he was about the public's expectations. Notably, for all of the Rockefeller administration's nods to prison reform funding in 1972, the following year Governor Rockefeller added to his reputation of being tough on criminals by passing a set of drug laws that were more draconian than anything that had ever before been on the books. 28 Legislation was enacted that, for example, created mandatory minimum sentences of 15 years to life for possession of 4 ounces of narcotics, about the same as a sentence for second-degree murder. 29 These 1973 drug laws were subsequently duplicated across the country, in ever more punitive iterations, over the next 2 decades. By 1978, for instance, Michigan had passed a so-called 650 lifer, a law that automatically gave life sentences to anyone caught with 650 grams of cocaine. And seemingly overnight, any crime, not just drug crimes, could net someone extraordinary penalties. Indeed, in the 1980s and the 1990s, politicians passed scores of laws at both the state and federal level that criminalized acts that had previously been legal, as well as passing countless mandatory minimums and so-called truth in sentencing laws that ensured substantially more prison time for any act that was now, or had always been, considered illegal. 30 And by 1990, Republicans were trying to pass a tough-on-crime federal bill that, among other things, would reduce the number of aggravating factors that are needed for the courts to impose a death penalty. 31 Tellingly, when a less draconian bill was also proposed, the president of the National District Attorneys Association tried to undercut any support for it by saying that the bill looked like it was drafted by the death row pack at Leavenworth or Attica. 32 This district attorney need not have worried that anything less harsh would pass. Not only did the Republicans triumph that year, but plenty of Democrats also wanted to get even tougher on crime. In 1994, Democrats and Republicans again banded together to pass an even more devastatingly punitive piece of legislation, the Violent Crime Control and Law Enforcement Act. This act was the most comprehensive tough-on-crime bill in American history. Among other things, it earmarked $9.7 billion to fund the building of more prisons. By 1995, the U.S. prison population had topped 1 million, and was still growing at an unprecedented rate. 33 The fact that so many of these people now in prison had been arrested because they were drug addicts, mentally ill, poor, and racially profiled concerned few if any politicians, whether in a state house or in Washington, D.C. Then, to make sure that this now enormous group of the incarcerated did not resist their deteriorating conditions of confinement via the nation's legal system as they had done so effectively both before and after the Attica Uprising, in 1996 legislators passed the Prison Litigation Reform Act, PLRA. The PLRA was a deadly blow to American prisoners. So many prisoner rights victories of the 20th century had been made possible by the ability of the incarcerated to access federal courts to protect their Eighth Amendment right not to endure cruel and unusual punishment. This new law made it much harder for prisoners to protect themselves legally. For example, it required proof of an actual violation before any decree or injunction could be issued, and it also severely curbed the discretion of the federal courts to render decisions with implications for the system as a whole, and the law actually required them to take the public's safety into consideration when rendering any decision. The Act additionally placed a cap on attorney fees and required that a panel of 3 judges agree before any prisoner could be released from confinement as a result of a lawsuit. 34. By the time the 21st century began, America's war on crime and war on drugs had criminalized the nation's poorest neighborhoods, its already most marginalized black and brown communities, to such a degree that the nation descended into an internationally unparalleled crisis known as mass incarceration. While the lies told at Attica how it had been spun did not, in some linear way, cause mass incarceration, they had certainly fueled it. 35. Importantly, although the war on crime had begun 6 years before Attica, America's dramatic spike in incarceration rates began directly after that rebellion had been quashed. And, notably, in the age of mass incarceration, the word Attica no longer connoted struggle and resistance in the popular imagination as it had years earlier in the lyrics of John Lennon's Attica State or in Sidney Lumet's blockbuster film Dog Day Afternoon. Rather, by the 1990s, Attica, when it showed up in the lyrics of rappers like KRS-One and Zach De La Rocha, or in an episode of The Sopranos, or even in the kids' cartoon SpongeBob, had come to mean the worst of the worst criminal. 36. America by the early 21st century had, in disturbing ways, come to resemble America in the late 19th century. In 1800, the 3/5 clause gave white voters political power from a black population that was itself barred from voting, and after 2000, prison gerrymandering was doing exactly the same thing in numerous states across the country. 37. After 1865, African American desires for equality and civil rights in the South following the American Civil War led whites to criminalize African American communities in new ways and then sent record numbers of blacks to prison in that region. 38. Similarly, a dramatic spike in black incarceration followed the civil rights movement, a movement that epitomized Attica. From 1965 onward, black communities were increasingly criminalized, and by 2005, African Americans constituted 40% of the U.S. prison population while remaining less than 13% of its overall population. 39. And just as businesses had profited from the increased number of Americans in penal facilities after 1870, so did they seek the labor of a growing captive prison population after 1970. In both centuries, white Americans had responded to black claims for freedom by beefing up, and making more punitive, the nation's criminal justice system. In both centuries, in turn, the American criminal justice system disproportionately criminalized, policed, and forced the labor of incarcerated, disenfranchised African Americans in ways that wrought incalculable damage both in and outside of America's penal institutions. 40. Attica's prisoners knew this long history well. This was their history. And this is why they refused to give up until they had effected truly meaningful prison reform. These prisoners felt, just as the state did, that a great deal was at stake in 1971 when they took over the Attica Correctional Facility. If they didn't speak out and demand to be treated like human beings, and if the power of the state to determine the workings of this nation's criminal justice system was allowed to be absolute, the American penal system would eventually be too punitive and inhumane to bear. 41. And they were correct. A close look at the state of New York in the 3 decades after Attica's prisoners were silenced clearly shows just how much worse things eventually became. Whereas there were 12,500 prisoners locked in the state's penal facilities in 1971, already so many that facilities like Attica were severely overcrowded, thanks to changes in sentencing policies and parole release rates, that number more than doubled by 1982.42. By the close of the 1990s, 72,638 prisoners were locked up in New York prisons, doing enough work for the state prison industries, Corecraft, to generate $70 million of revenue between 1998 and 1999 alone. 43. As the 21st century dawned, there were nearly 74,000 men and women, overwhelmingly black and brown citizens of that state, locked in New York penal institutions, all of whom could still be forced to work and none of whom could vote to change the system. 44. It was clear by the close of the 20th century that many of the post-rebellion calls for change to New York's prison system had been rolled back the instant that prisoner activism and thus pressure on the system was quelled. Little more than a decade after the Attica Uprising, the prison was again in the grips of a serious crisis. 45. By 1982, Attica was so overcrowded that any prisoner programming that still existed fell far short of the number of people who wanted to access it. Once again, there were too many prisoners for the medical care that was available in the facility, and that care was, once again, of poor quality. 46. In fact, there were again so many serious problems at Attica in areas such as medical care, food service, recreation, visiting, and access to court and legal materials that many there worried that there might be another explosion. 47. Although there was an inmate liaison committee that could voice concerns to the administration, by the 1980s, prisoners knew that this group had no real power, and so they refused to pretend that it did. The superintendent reported that year that so few prisoners were even interested in running for an ILC position that he cancelled the last election and selected anyone who nominated himself to serve. 48. At Attica in the 1980s, as before, prisoners who could not be heard eventually lashed out. This time, though, the response was to place them in segregation, and to make that placement far more punitive than it had ever been before. By 1982 the physical size of this area had more than doubled during the past year and now holds some 80 prisoners, according to the Correctional Association of New York. Worse, prison officials had constructed 20 brand new segregation cells that were completely encased by plexiglass and that had only small holes for ventilation, which left those imprisoned in them gasping for air and sweltering in the hot summer months. 49. Furthermore, prison officials as well as members of the new Correction Officers Union, NSCAPA, had begun clamoring again for the establishment of a so-called Maxi-Maxi unit at Attica or a separate Maxi-Maxi facility. 50. Their model Great Meadow Correctional Facility already had one of these, a so-called Involuntary Protection Unit, IPU, for troublesome prisoners. 51. Life was so difficult for Attica's prisoners who landed in its Special Housing Unit, formerly known as HBZ, now called SHU, that one of the mentally ill men incarcerated there killed himself on June 3, 1985. A lawsuit was filed on behalf of the men in that unit against the correction officers, who, the suit insisted, had hounded and taunted this man until he was driven to suicide. In this complaint, which landed on the docket of Judge Michael Telesksa, prisoners said that there had been numerous instances of physical force inflicted by SHU correction officers, the utilization of strip cells in which the prisoner is allowed no clothes or bedding for punishment purposes, the denial of adequate medical care and adequate physical exercise facilities, unsanitary living conditions, inadequate portions and unsanitary preparation of food, the improper use of plexiglass shields on the fronts of many SHU cells, inadequate access to the law library and legal research materials, and denial of the right to free exercise of religion. 52. 40 years after the uprising of 1971, conditions at Attica were worse than they had ever been. According to the Correctional Association of New York, by 2001 the Department of Correctional Services had cut over 1,200 programs providing services to inmates that were there in 1991. 53. By April 12, 2011, there were 2,152 men crammed into this facility, the vast majority of whom were African American and Hispanic, and an overwhelming 21% of Attica's prison population that year had been diagnosed with some level of mental illness. 54. According to the Correctional Association of New York, which surveyed Attica's prisoners, there was still a noticeably high level of intimidation and fear throughout the facility. And we received numerous letters describing threats and retaliation for participating in the CA survey. 55. Furthermore, the association noted, Attica inmates had the highest ratings of all CA-visited prisons for frequency of physical assaults, verbal harassment, threats and intimidation, abusive pat frisks, turning off lights and water, and retaliation complaints. Inmates also complained that retaliation materialized in the form of some officers not letting inmates leave their cells for meals. 56. It is both tragic and deeply ironic that new levels of brutality against America's prisoners have been, at least so far, the most obvious and lasting legacy of the 1971 Attica Uprising. Even though the extraordinary violence that took place in 1971 was overwhelmingly perpetrated by members of law enforcement, not the prisoners, American voters ultimately did not respond to this prison uprising by demanding that states rein in police power. Instead, they demanded that police be given even more support and even more punitive laws to enforce. Indeed, the 1960s and 1970s were all about the politics of the ironic. At the Democratic National Convention protests of 1968, Kent State in 1970, and Wounded Knee in 1973, unfettered police power each time turned protests violent, and yet, after each of these events, the nation was sent the message that the people, not the police, were dangerous. Somehow, voters came to believe that democracy was worth curtailing and civil rights and liberties were worth suspending for the sake of order and of maintaining the status quo. 57. But, while it was ironic how voters chose to respond to the violence of the 1960s and 1970s, their response was by no means inevitable. The meaning of the rebellions of that period, and what had actually taken place in them, was actively distorted by the very politicians and state officials whom these protests had targeted. Just as Kent, Ohio, Mayor Leroy Sitram had distorted what had happened at Kent State University, leading to the bloodshed there in 1970, and just as South Dakota Governor Richard Neep had distorted the events that touched off the violence at Wounded Knee in 1973, many state officials and politicians had also actively distorted what had happened at Attica in its immediate aftermath and then tried, thereafter, to cover up subsequent attempts to tell the truth. 58. And, yet, that truth could not be covered up and contained indefinitely. Not only had the prisoners and hostages who had survived the retaking of Attica never given up their fight to hold the state of New York accountable for the abuses and atrocities committed in September 1971, but they also never stopped insisting that the full story be told, and they struggled to make sure that Attica had not been in vain. No matter how repressive the nation became in the wake of the 1971 prison uprising, the men confined in Attica, and in other facilities like it across the country, never stopped fighting for their rights, for their dignity. Attica's prisoners rose up again a decade later for the same reason as in 1971. On July 21, 1984, almost 200 men smashed windows and screamed their outrage when a fellow prisoner was shot to death by a tower guard. 59. Much more recently, they have come together in another dramatic fight to be treated like human beings. On August 9, 2011, 29-year-old prisoner George Williams was attacked by an Attica sergeant and 3 correction officers in C Block. Williams was severely wounded, left with a broken collarbone, 2 broken legs and other injuries, which required his transport to the Wyoming County Community Hospital in Warsaw. 60. In this case, though, Attica's men didn't riot or rebel within the prison. Instead, they went public and insisted that the Wyoming County District Attorney investigate their claims. Undoubtedly, history told this day that Attica's men weren't going to let this new case of abuse be ignored. He not only looked into what had happened to Williams, but also then indicted the 4 correction officers, ultimately charging them with first-degree gang assault, fourth-degree conspiracy, tampering with physical evidence and official misconduct. 61. The DA said these men had conspired to assault an inmate in cell block C and that following the violent attack, the 4 prison employees prepared false physical evidence. 62. The DA's first attempt to indict these men was dismissed on the grounds that the prosecution had introduced improper evidence in front of the grand jury that heard the case. 63. The DA filed new indictments against 3 correction officers, Matthew Rademacher, Keith Swack, and Sean Warner. A 4th CO was at the time granted immunity because he had been subpoenaed to testify in front of the grand jury. The 3 remaining COs faced charges of first-degree gang assault, a Class B violent felony, tampering with physical evidence, a Class E felony, and official misconduct, a Class A misdemeanor. 64. The outcome of the case against officers Rademacher, Swack, and Warner would not be determined until March of 2015. Its ultimate disposition says a great deal about Attica's complicated legacy. When the 3 correction officers from Attica finally went to trial in 2015, they were not lacking for support. Guard unions from around the country had mobilized on their behalf, from virtually the moment they were suspended, and monies poured in to help them defend themselves in court. As Niskobpa explained it, COS from Attica and other prisons had created a new legal defense fund whose purpose it was to fight these charges now and in the future. 65 It would, through the kin drives, T-shirts, wristbands, benefits and donations, give the indicted officers the money they needed to hire top counsel and to get the public on their side. 66 Notably, the forgotten victims of Attica also sent support their way. A letter from indicted CO Sean Warner to the FVOA noted how the forgotten victims of Attica have been there from the beginning with donations, a kind word, a phone call, and countless letters and support. These men and women have been through so much the past 40 years and are still there at the sides of the current prison staff no matter what the circumstances. It is an honor to have these men and women at our sides. 67. The fact that these men had so much public support of course mattered a great deal to how they would fare in New York's legal system. Their trial began on March 2, 2015, and it ended abruptly in a light plea deal. 68 The judge had allowed each correction officer to plead guilty to a single charge of misdemeanor misconduct and none of them would have to serve any time in prison. 69 George Williams wept. No matter how hard he had fought to get justice, it still took his breath away that those who had beat him so mercilessly received little more than a reprimand. 70. Yet the fact that these men had ended up in court charged with a crime at all was important. It was the first time in the history of New York State that any guard has been prosecuted for brutality against someone in prison, as the Correctional Association of New York correctly noted right after the plea deal. 71 Indeed, that these men had been indicted also reflected perhaps Attica's most powerful legacy: prisoners' determined resistance of repression. The Attica Uprising of 1971 happened because ordinary men, poor men, disfranchised men, and men of color had simply had enough of being treated as less than human. That desire, and their fight, is by far Attica's most important legacy. This is the legacy that led George Williams to refuse to be silent, even though speaking up must have been terrifying given the retaliation he knew he could suffer. This is why he refused to give up even when a local judge tried to dismiss the criminal case against his attackers. This is why he was determined to seek justice in federal court when his attackers received only a reprimand in state court. 72 This is why the Justice Department, in March 2015, began an official investigation into brutality against prisoners at Attica Correctional Facility. 73 Attica's prisoners had refused to stay silent. That those who have endured Attica have always insisted on speaking out is something that matters. As this book goes to press, vital Attica materials at the New York State Archives remain closed to the public. State officials are still denying Freedom of Information Act requests, though there is no legal rationale to do so. Even the Attica documents that filled shelves in the Erie County Courthouse in 2006 have since disappeared. But despite state officials' continued efforts to put every roadblock imaginable in the way of journalists, historians, and filmmakers, they have not stopped Attica's history from being written, nor Attica's survivors from telling their story. From New York in 1971, when nearly 1,300 prisoners stood up against overcrowding and the myriad other injustices that had become policy, to California in 2013, when 30,000 prisoners launched a hunger strike against the repressive conditions in the correction system, to Texas in 2015, when prisoners shut down a major penal facility because of serious abuses, America's incarcerated people have never stopped struggling against this country's worst and most punitive practices. 74 The Attica Prison Uprising of 1971 shows the nation that even the most marginalized citizens will never stop fighting to be treated as human beings. It testifies to this irrepressible demand for justice. This is Attica's legacy. Thankfully for the historical record, and for the sake of Attica's many victims, Liz saved and graciously let me see countless memos, depositions, transcripts, state documents, photographs, videos, and more, a literal treasure trove of Attica's history from 1971 to 2000. My deepest regret today is that Liz. Acknowledgements. Spending almost a decade writing one book means being indebted to so many people that there simply aren't enough pages here to convey my gratitude adequately. I will, however, do my best. The very first person I must thank is my agent, Jerry Thomas, who believed in this book before anyone. Jerry, you are not only an incredible literary agent, but you are also my friend. You always cheered me when things looked grim, and you have also celebrated every wonderful research find, every writing breakthrough, and every bit of good news, with such a genuine joy. This has meant everything to me. I must also thank my editor at Pantheon Books, Edward Kastenmeier, as well as the superstar editors who work with him, Emily Gigliarino and Stella Tan. I owe the three of you everything. I also owe so much to the many people around the country who provided me invaluable Attica-related materials when the state of New York would not. Without the generosity of Attica lawyer extraordinaire Elizabeth Fink, this book simply could not have been written. Passed away before I could hand her a copy of this book. Liz, I hope I got it right, I hope I did good. Attica lawyer William Cunningham shared vital documents from the Linda Jones civil suit against the state. D. Quinn Miller shared invaluable resources on the hostages and hostage families' fight to be heard. Anne Vallone, Flo Hodder, and Richard Meisler also shared personal items that helped me to understand Attica. And then there are those who prefer not to be named, people who were willing to share crucially important materials such as the Attica autopsy reports, personal letters, and more. You know who you are, and thank you for trusting me with those. I am deeply grateful as well to the following researchers, journalists, and historians. Documentary filmmaker and research dynamo Christine Christopher sent me vital materials and included me in her own research journey as she and David Marshall made their powerful film on the Attica Uprising, Criminal Injustice, Death and Politics at Attica. Gary Craig of the Rochester Democrat and Chronicle very generously offered his time and materials to me. Not only is Gary's coverage of the Attica Rebellion and its aftermath remarkable, but I am forever indebted to him for working so hard to get his paper's priceless Attica photos included in this book. Peter Wagner of the criminal justice reform organization The Prison Policy Initiative has offered invaluable research assistance over the years. Craig Williams of the New York State Museum let me see and touch those remarkable Attica artifacts that had been hidden from view for so many decades. And finally, my historian friends have shared amazing Attica finds, especially Simon Balto, Daniel Chard, David Goldberg, Trevor Griffey, Caleb Smith, and John David Smith. Many students have also been incredibly generous with their prison-related sources and their support over the years. Several students have written theses on Attica, and one wrote a paper on the NYC jail riots, all of which taught me so much. Thank you, Jeremy Levinson, Toussaint Louverture, Ethan Sachs, and Morgan Jahan. Over the years I relied heavily on the research help given me as well by Katie Mannon, Sarah Miller, and, most recently, Mary Bridget Lee, who, in short, saved my life. Without Mary Bridget helping me to find photos and format the endnotes, this book might well still be a ragged draft on my Mac. Thank you so much. Special thanks goes out to the wonderful archivists at the following libraries and research centers for patiently photocopying, microfilming, and otherwise allowing me time to view Attica-related material that proved essential: the Labadie Collection at the University of Michigan, the American Radicalism Collection at Michigan State University, the Walter Reuther Library of Labor and Urban Affairs, special collections at Stony Brook, the Rockefeller Archive Center, the New York State Archives. Special collections at the Bancroft Library at Berkeley, special collections at Stanford University, the New York City Archives, special collections at Yale University, the Miller Center at the University of Virginia, Pacifica Radio Archives, the Vanderbilt Television Archives, the Gerald Ford Library, the Charles Blockson Collection at Temple University Library, the Schomburg Center for Research in Black Culture, special collections at the University of Rochester, and special collections at the University of Buffalo. I also want to give special thanks to David Swartz, then County Clerk at the Erie County Courthouse in Buffalo, New York, and to James Conway, then Superintendent at the Attica Correctional Facility, for allowing me to view vital uprising-related documents back in 2006. No matter how many documents and artifacts I finally got to see, I only really understood Attica after listening to the people who had experienced the uprising and its aftermath firsthand. I thank them for so willingly sharing their stories and memories with me, often at great emotional cost to themselves. Thank you so very, very much to Don Almeter, Herman Badillo, Tracy Barkley, Linda Burris, Charles Bradley, Dan Callahan, Keith Clark, Kevin Clark, James Conway, Mark Cunningham, Yomo Davis, Michael Deutsch, John Dunn, John Elfman, Arthur Eve, Elizabeth Fink, Elizabeth Gaines, Bill Goodman, Frank Hall, Rick Harcrow, Jazz Hayden, William Hellerstein, Edward Hershey, Susanna Heschel, John Dakachwea Hill, Flo Hodder, Gary Horton, Clarence Jones, Sarah Kunstler, Larry Lyons, Sue Lyons, Richard Meisler, Josh Melville, Danny Meyer, Deanne Quinn Miller, George Nieve, Margaret Patterson, Carlos Roche, Herman Schwartz, Michael Smith, Sharon Smith, Louis Steele, John Stockholm, Mary Stockholm, Tony Strollo, Michael Telesksa, Anne Vallone, Jamie Vallone, Mary Ann Vallone, Tom Wicker and Ellen Yaknin. Malcolm Bell and Joe Heath deserve special thanks. Although Malcolm made clear to me that he could not let me see his original whistleblowing documents, he nevertheless supported me when I stumbled upon them on my own and felt obligated to reveal their explosive contents. Joe offered me tremendous support as well as a keen fact-checking eye. Together these two gave me the strength to make this book brave. In order to write about Attica, I also needed to learn a great deal about American prisons, and about the history of American criminal justice politics and policing, and, to that end, I owe a great many scholars a particular debt. I am grateful for the wisdom of Amanda Alexander, Michelle Alexander, Dan Berger, Doug Blackman, Ethan Blue, Daniel Chard, Robert Chase, Miroslava Chavez Garcia, Dennis Childs, Ta-Nehisi Coates, Mary Ellen Curtin, Kalila Brown Dean, Alex Elkins, Max Felker Cantor, Benjamin Fleury Steiner, Ruth Wilson Gilmore, Marie Gottschalk, Callie Gross, Sarah Haley, Cheryl Hicks, Mark Lamont Hill, Pippa Holloway, Amanda Hewitt, James Kilgore, Nora Krynitsky, Regina Kunzel, Talitha Laflauria, Matthew Lassiter, Alex Lichtenstein, Toussaint Lausier, Glenn Laurie, Ashley Lucas, Lisa Miller, Reuben Miller, Alan Mills, Nancy Mullane, Dwayne Nash, Jessica Neptune, Michael Lee Owens, Josh Page, Deva Pager, Ann Parsons, Robert Perkinson, Imani Perry, Sherry Randolph, Natalie Ring, Margot Schlanger, Carla Shedd, Jonathan Simon, Jason Stanley, David Stein, Rubia Tapia, Jeremy Travis, Nicole Gonzalez Van Cleve, Vesla Weaver, Bruce Western, Yahura Williams, Timothy Stewart Winter, and Kianga Yamata Taylor. To my friends working on other vital periods and topics who have shouted out my work and have given me so much wonderful support throughout this book writing process, thank you, Evan Bennett, Martha Biondi, Charlie Bright, Niambi Carter, Catherine Clinton, Stephanie Cole, Catherine Connor, Nathan Connolly, Jane Daly, Marcus Daniel, Angela Dillard, Donna Gabasaya, Sarah Gardner, Gary Gerstel, Tiffany Gill, James Green, Julie Green, Cindy Hahimovich, Grace Hale, Jacqueline Dowd Hall, LaShawn Harris, Lindsay Helfman, Darlene Clark Hine, Patrick Jones, Steve Katrowitz, Robin D. G. Kelly, Robert Korstad, Max Krochmal, Kevin Cruz, Michael Landis, Stephen Lawson, Nelson Lichtenstein, Sherry Lincoln, Lisa Lindsay, Nancy McLean, Austin McCoy, Roberta Meek, Kevin Mumford, Alondra Nelson, Scott Nelson, Liesl Aranick, Chad Pearson, Wendell Pritchett, Barbara Ransby, Jacob Remes, Leah Reitriger, Stacy Robertson, Dan Royals, John Russo, Robert Self, Robert Smith, Tom Sugru, Peter Thompson, Tim Tyson, Dara Walker, Stephen Ward, Deborah Gray White, and Rakefit Zalashik. Thank you also to Dan Katz and Patricia Jurito for offering me such a warm and welcoming place to stay during those many research trips to New York. To some scholar friends I want to say a special thanks. To my dearest sister friends Karen Cox, Shannon Fristuck, Alicia Long, and Danielle McGuire, thank you for the love, support, and always needed girls' weekends. To Lisa Lievenstein, thank you for being my fiercest ally and steady confidant over this long haul. And to my friend and co-editor Rhonda Y. Williams, as well as to our amazing UNC editor Brandon Proya, thanks for keeping the Justice, Power, and Politics series alive and thriving while I was in the last throes of getting this book to press. To Khalil Gibran Muhammad, I am not sure that I have spent more time on the circuit talking prisons and policy with anyone than with you, and for that I am grateful. You continue to inspire me and I am so very thankful we are friends. And to Kelly Little Hernandez, you in particular have pushed me to think about this nation's carceral past in new ways, and for that, and our friendship, I am deeply grateful. To Donna Murch, you are my sister scholar and CO editor, and I thank you for your incredible support for being a true ally these last years. And thanks to you and Walter Murch, being in NYC has felt like being home. To Elizabeth Hinton, Jalili Kohler Houseman, and Melanie Newport, you three are not only my heart, but you're also the future of carceral state history. Thank you for pushing the boundaries. And special thanks to Brian Simon, whose get-togethers in West Philly kept me sane and motivated, and who connected our families in ways so wonderful. And to Jim Downs, who has always made me feel like a rock star, even when I felt like an exhausted bag of rocks. Peter Logan, thank you for creating the most intellectually engaged and supportive environments any historian could ask for up in the Center for the Humanities at Temple University, and for giving me refuge on the 10th floor. Beyond the scholars, friends, advocates, and allies who helped me to write this history of Attica, I am also deeply indebted to a number of institutions and organizations: the American Historical Association, the National Endowment for the Humanities, the University of North Carolina at Charlotte, the Rockefeller Archive Center, the New York State Archives, and last but hardly least, the Open Society's Soros Justice Fellowship, which was life-changing. Not only did it allow me a year of leave to conduct book research, but it also introduced me to countless advocates, activists, and fellow scholars working on criminal justice reform. These relationships changed me profoundly and bettered my book immeasurably. Thank you, Adam Cuthbert and Christina Voigt, for running such an important program and for bringing us together year after year. Among my fellow Soros recipients whom I haven't already named above, I want to specially acknowledge Neelam Arya, Sujatha Balaga, Michelle Deitch, Shayna Faisal, Mary Heinen, Pippa Holloway, Eric Lotka, Nancy Mullane, and Dee Ann Newell. Each of you is an inspiration. When it comes to getting this book written, and more specifically written well, let me also thank the godsends who have read drafts of this book and who have helped me, page by page, word by word, to get at the heart of what makes Attica so important. Thank you Terry Bisson, Megan Ritchie-Just, and particularly Beth Rashbaum for your tremendous patience and hard work with the drafts you waded through. And thank you to the 2014 committee of the J. Anthony Lucas Work in Progress Award for naming this manuscript as the finalist for this prestigious prize in 2015. I hope this is the book you all imagined it would be. Thank you to EMW. Best. Your voice brought this book to life. In closing, I must somehow find the words to adequately convey to my family just how much it has meant to me that they have given me the time, the space, the love, the encouragement, and the faith that I needed to complete this tome. To Tamara Smith, you have been there since the earliest days, and you gave so much of your time to help us settle back in Michigan. Love and thanks. To my Kansas, Colorado, Chicago, California, and Zurich family members, from those who have followed my book writing saga on Facebook and offered me so much support, to those who have distracted me over wonderful visits these last years, thank you all so much. To Agnes Spitzer, you know how much I have bent your ear about this book and how much your counsel and presence in my life means to me. You are, and will always be, my soul sister. To Dan and Betsy Wells, as well as Caroline Wells, Phil Hervey, and Bryn Hervey, you have offered me more love and support than any daughter-in-law/sister-in-law/auntie has a right to ask for. I love you all and thank you. To my sister, Saskia Thompson, and my niece Isabel Lawberry Thompson, you have both made these recent years of my life in Philadelphia some of my happiest. I miss living near you both terribly. To Ann Curry Thompson and Frank Thompson, well, you know. You are why I see the world as I do. You are why I hope to help make it a better place. Full stop. I am so grateful that you are my parents. To Dylan Thompson Erb, Wilder Thompson Erb, Ava Thompson Wells, Kimberly Brink, and Ross Hahn, Sean, Johnson, no mother could ask for more in life than to have it filled with you 5 incredible human beings. Dylan and Wilder, I am so deeply proud of you both. In fact, I am awed by all that you have each accomplished in life. I love you both more than I will ever be able to convey. Ava, I still remember the day I heard I was having a daughter, and I have been grateful for each day since. You are brilliant, and I am in awe of the kind, generous, and courageous young woman you have become. Kim, you are one of the most extraordinary women I know. Your gentle spirit, fierce smarts, generosity, and ambition all humble me and make me so incredibly glad that you are a part of our family. And Sean, you have moved mountains. You are one of the sweetest souls I have ever known, and you have made our family, and me, complete. And the last, most profound, thank you is to Jonathan Daniel Wells. John, the support you have offered me to do this book from the time you have made available to me by taking too much on yourself, to the unconditional love you have given me each and every second of every day, to the faith you had in me that I could actually pull this off takes my breath away. You are my best friend and partner for life. And now that this book is finally done, I can't wait to begin living that life again with you. I love you.